Well, good morning, everyone. What a romantic way to spend Valentine's Day. I declare open this hearing of the Senate Legal and Constitutional Affairs Legislation Committee for the supplementary budget estimates. The Senate has referred to the committee the particulars of proposed expenditure for the 2022-23 for the portfolios of Home Affairs and the Attorney General and other related documents. These are supplementary budget estimates. Proceedings and outcomes to be heard during today's estimates are from the Attorney General's portfolio. The committee has set Friday the 31st of March 2023 as the date by which answers to questions on notice are to be returned. The committee has also decided that written questions on notice should be provided to the Secretariat by 5 p.m. Friday, the 3rd of March 2023. Under Standing Order 26, the committee must take all evidence in public session. This includes answers to questions on notice. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of giving evidence to a committee, and any such action may be treated by the Senate as a contempt. It is also contempt to give false or misleading evidence to a committee. Officers and senators are familiar with the rules of the Senate governing estimates hearings. If you do need assistance, the Secretariat has copies of the rules. The Senate, by resolution in 1999, endorsed the following test of relevance for questions at estimates hearings. Any questions going to the operation or financial positions of the departments and agencies which are seeking funds in the estimates are relevant questions for the purposes of estimates hearings. I remind officers that the Senate has resolved that there are no areas in connection with the expenditure of public funds where any person has a discretion to withhold details or explanations from the Parliament or its committees unless the Parliament has expressly provided otherwise. The Senate has also resolved that an officer of the Department of the Commonwealth shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. I particularly draw the attention of witnesses to an order of the Senate of 13th of May 2009 specifying the process by which a claim of public interest immunity should be raised. Witnesses are specifically reminded that a statement that information or a document is confidential or consists of advice to government is not a statement that meets the requirements of the 2009 order. Instead, witnesses are required to provide some specific indication of the harm to the public interest that could result from the disclosure of the information or the document. I remind all senators that as we continue our work implementing the Set the Standard report, as Chair, I will ensure the proceedings are conducted in an orderly, respectful and courteous way. Officers called upon for the first time to answer a question should state their full name and position for the Hansard record, and witnesses should speak clearly into the microphones. Mobile phones should be switched off or turned to silent mode. Thank you. I welcome Senator the Honourable Anthony Chisholm, representing the Attorney General. Welcome, Minister. Would you like to make an opening statement?
No, thanks, Chair.
And I call officers from the Attorney General's Department in relation to cross-portfolio corporate and general matters. Good morning, Secretary. Would you like to make an opening statement before we go to questions?
Good morning, Chair. No, I don't have an opening statement to make.
Thank you. Appreciate that. Senator Cash, you have the call.
Thank you very much, and good morning, Secretary and Minister. I have a series of questions, and Secretary, you recall that I did write to you following the last estimates hearing, and I wrote to you on the 13th of February just requesting that the appropriate departmental people be joined at the table. I understand that that's Mr Michael Johnson.
Thanks, Senator. Chair, I just note this matter does relate to issues of the responsibility in the Integrity and International Group that's scheduled for 11:15, but we do have the officers here, so happy to answer questions if you agree.
Can I just double check with you, Senator Cash? The questions that you have, do they relate to a corporate
yes, they do.
matter?
In particular, as has been standard practice in the Legal and Constitutional Affairs Committee, when we have questions that canvass a wide range of matters, they have normally been asked in the corporate cross-portfolio. In particular, these questions go directly to what I see are failings of the department, and I'm happy to explore those failings.
Well, those, Senator Cash, whether that is precedent or not, I'm the chair today, and those matters don't actually constitute cross-portfolio corporate matters. If you are asking questions about legal matters, I think you probably do have a case that you are relating to corporate affairs.
They are about
And
legal
I'm
matters, yes.
assisting you in that.
Specifically, yes, no, absolutely.
But can I be clear? Just because something is wide-ranging does not mean that it can be covered off in cross-portfolio.
So the questions I have do relate to more than one outcome. They deal with the Attorney-General's Department contact with the Attorney-General and his office, questions concerning the Secretary and the Secretary's office, questions regarding significant legal matters, questions regarding the Office of Legal Services Coordination, questions regarding advice provided by the Australian Government Solicitor, as well as advice provided to the Australian Government Solicitor.
Okay. Again, just because something is wide-ranging does not mean that it relates to cross-portfolio corporate and general matters. The Secretary has given you some advice about where the outcome that these matters would be raised in. If what you are asking about relates to corporate matters, we can allow it in this session. Otherwise, I suggest that you come back at the appropriate outcome.
Well, ultimately, these questions go to the failure of process that occurred within the department. Senior officials incorrectly provided advice during the Senate estimate process in November, which did lead to the inability to pursue a certain line of questioning. And I would like to go to that line of questioning in terms of how that advice was provided.
Senator Cash, if you want to ask your questions so that the Secretary can give you some advice about whether she's able to answer them here,
Well, I think
the only thing I would suggest to you and to your colleagues is that we have a very structured program today and a lot of agencies to get through. And if we are using time that has not been appropriately allocated in this cross-portfolio area, it will eat into time that your colleagues have requested for a number of agencies. So I just draw your attention to that.
And I thank you. And just so then the committee is aware, I did write to Ms Jones on the 13th of February, and I did state, given the significant matters raised in your letter regarding relating to Mr Michael Johnson's evidence and his subsequent correction, that I did request that Mr Johnson and any other SES officer in the Attorney-General's Department who had any knowledge of the Attorney-General and obviously for giving the debt to the CFMMEU of $150,000 be available to answer questions on this matter during the cross-portfolio section of the program, which is scheduled to begin at 9 a.m. tomorrow. The Secretary last night did not raise an issue with me. The issue that she has raised this morning
Senator
was
Cash,
not raised
let's
with
be
me.
clear about this. I want to get this really clear so we don't have this problem over the next how many years of you coming into this committee. Just because you write something in a letter does not mean that I've made a decision as chair about whether you can ask questions in an appropriate outcome. You can put whatever you want in the letter, and it's not for the Secretary to decide whether questions are appropriate. What I've suggested to you is that you should get on and ask some questions, but that you should be mindful of the time that we've allocated for this section of the program.
Thank you, Chair. You'll recall, Secretary, that the last estimates I asked a series of questions relating to whether or not the department was aware of the Attorney-General Mark Dreyfus instructing a Commonwealth agency not to pursue a costs order made in its favour. I do want to pursue further questions in relation to that particular matter, and in particular the evidence that was given by both yourself and Mr Michael Johnson at the time. For the Hansard record, and Chair, just to remind those, this was the case brought by Lend-Lease against the ABCC, in which the CFMMEU intervened. The ABCC itself won the case. Justice Snowden of the Federal Court then ordered that the CFMMEU pay costs in favour of the ABCC, and the ABCC estimated its cost to be in excess of $410,000. The ABCC, as it was entitled to under the model litigant rules, proposed to recover on behalf of the Australian taxpayer reasonable costs of $150,000 from the CFMMEU. They had to seek the Attorney-General's approval to do this. They did not receive that approval and were in fact stopped doing this by the Attorney-General.
Well, I think that's your characterisation.
Well, the
If you
Attorney-
have a
can I just-
question,
Yep, the Attorney, I'm just making sure the department know exactly
I think they're
the
fully
questions. The Attorney-General effectively forgave the $150,000 cost debt to the Australian taxpayers from the CFMMEU, and in fact you will recall, Secretary, or at least Mr Johnson may recall, that it was in relation to an instruction to settle the case. The ABCC does not enforce the Federal Court costs order dated 31st of March 2022. Now, I asked a series of questions in relation to matters of cost orders at the last estimates hearing. And I was advised at that hearing that, to both of your knowledge, you were not aware. Can I ask again, Ms Jones or Mr Johnson, were either of you aware of this matter at the time of the last Senate estimates hearing on the 7th of November 2022?
Thanks, Senator Cash. I just wanted to note the way that you described the question that you asked at the previous estimate isn't actually in the terms that it was asked.
I'm happy to go through that as well.
Yeah, I think at the last estimates you asked a very general question. You didn't connect it to any specific matter. So at the time we weren't aware of the specific matter that you were inquiring about. Mr Johnson sought to consider, sitting there at the desk, whether or not there was an example that fit the terms of the question that you asked. At the time, he could not recall. But as I think I've already described to you in a letter that I have written to you, the next day, immediately after the estimates hearing, he went back to the office, he reviewed some files, and he realised that the matter that relates to the ABCC fell within the category of the type of matter that you asked a question about the previous day. He alerted relevant officers, including myself, and we moved extremely quickly to correct the record within 24 hours.
So the question that I posed to you was this: has the department been provided with any instruction, direction or advice from the Attorney-General or his office in relation to the enforcement by the Commonwealth or a Commonwealth entity or agency of any cost order or category of cost orders? You responded, not that I am aware of. I think the answer to that is no. Does that remain your evidence?
Sorry, Senator, are you saying that that was my evidence?
Yes, that is your evidence. Not that I am aware of. I think the answer to that is no. Does that remain your evidence?
Well, I think in light of the information that we found the next day and that we corrected writing to the committee the next day, I would say that I qualified my answer because I wasn't aware at the time. So it was correct to my knowledge at the time, but when we discovered that that wasn't correct, we wrote a letter of correction to this committee the next day.
And I just want to confirm then, your evidence to this committee is that you had no knowledge of this matter or any other matter in relation to, has the department been provided with any instruction, direction or advice from the Attorney-General or his office in relation to the enforcement by the Commonwealth or a Commonwealth entity or agency of any cost order or category of cost orders? I have a series of documents that we will then be going through.
So in terms of my direct knowledge of that matter, at the time I was not aware.
You were not aware. Okay. What knowledge did you have of this matter on the 7th of November 2022?
I think I may have seen media reporting over the course of the previous months or years that the matter was on foot. I believe that we had a reference to the matter as a significant legal issue in the incoming government brief that was provided to the Attorney-General. That didn't go to any of the specifics around the settlement, I think, but it just generally noted that this was a significant legal issue, so I was aware of it in the context of finalising the incoming government brief. and I don't believe beyond that I received a direct briefing on the matter.
So your evidence to the committee is you did not receive a direct briefing. Did you receive an indirect briefing?
No, Senator.
No. So your evidence to the committee is, despite, and I will table these documents, in particular, an email from the Significant Issues team.
Hang on a second. If you want to table a document, can you do it now for the benefit
Oh,
of...
I will table them in chronological order. I'm just referring to this document now.
Well, for the benefit of other committee members that are seeking to follow along. Have you got some copies there for us? or-
Yes, it's document 12 in my list of documents.
Can we get some copies of those documents?
Yep, I have copies of the documents. Dear ABCC and AGS colleagues, I refer to the settlement request for the matter of CFMMEU v ABCC and Oars. The Attorney-General has now considered the request and has approved under paragraph 3.2 of the Legal Services Directions 2017 the ABC seeking to settle the matter on the following terms. The appeal proceedings be discontinued, there be no order as to costs in the appeal proceedings, and 3, and importantly, the ABCC does not enforce the federal cost order dated the 31st of March 2022. We would be grateful for ongoing visibility of this matter as it progresses. Kind regards, obviously the name is redacted, Significant Issues Team, Office of Legal Services Coordination. Who's in charge of the Significant Issues Team, Office of Legal Service Coordination?
So I will ask my colleagues to provide some answers, but it's a section within the Office
and
of
who's
Legal
in charge
Services
of it?
Coordination. It's an EL2 officer reporting to Michael Johnson.
Okay, my questions are actually to you at this point in time in your knowledge.
Sure.
So you're saying that despite a settlement request for the matter being not accepted by the Attorney-General and the Significant Issues Team in terms of the Office of Legal Services Direction specifically writing to the ABCC and the Australian Government Solicitor colleagues, clearly setting out that the Attorney-General has stated the ABCC does not enforce the federal costs order dated the 31st of March 2022, and your evidence that you were aware that this was a significant legal issue. On the 7th of November, you still had no understanding or information in relation to this matter.
I was not aware of the specific information in that email that you've referred to, and I wasn't aware of the decision in relation to the settlement.
You weren't, so you hadn't been briefed by Mr Johnson in relation to the settlement of a significant legal issue?
Senator, you may be aware, at any given time there are a very significant number of significant legal issues that the department has oversight. We have oversight of all significant legal issues across the Commonwealth. So
This is within your department?
Within our department, but there are a broad range at any given time. I couldn't specify the number at any given time, but it's not unusual for there to be decisions or steps taken in relation to some significant legal issues that I would not necessarily have direct visibility of.
Even where the significant legal issue involves a costs order against a major donor to the Australian Labor Party, the CFMMEU, to the tune of in excess of $400,000. And based on the evidence that Mr Johnson gave last time, he was not aware of an Attorney-General ever not pursuing a costs order. The Attorney-General of Australia does not authorise the ABCC to pursue the costs order, and you're not made aware of that?
Sorry, Senator, that question went on for quite a bit. What's the specific question?
In relation to, there is a costs order in place for the ABCC to pursue against the CFMMEU. Blind Freddie unfortunately knows the CFMMEU is a significant donor to the Australian Labor Party. It is a significant legal issue. The evidence of Mr Johnson last time was he was not aware of an Attorney-General not instructing an agency not to pursue a costs order. And as part of a settlement in this matter, Mark Dreyfus, the Attorney-General, instructs the ABCC they cannot pursue the costs order, and you were not made aware of this and a potential conflict of interest on Mr Dreyfus's behalf?
I was not briefed at the time of the
That's
decision.
fine. I'm just establishing your level of knowledge because we'll turn to Mr Johnson in relation to his. So at the previous Senate estimates, did you have a written brief on significant legal issues?
Is that question to me,
Yes.
Senator? I'd need to take that on notice. It is often the practice that we prepare one. I don't need to take it on notice for the specifics of last estimates hearing.
If you could take that on notice, do you have a written brief on this particular matter today?
I have prepared some material in light of the letter that you prepared for me, yes.
Okay.
Wrote to me, I should say.
Did you have a back pocket brief that was not provided to the Minister or his office at the last Senate estimates hearing in relation to this matter?
Again, I'd need to take that on notice. I don't recall that I did, but I'd need to take that on notice.
Do you have a back pocket brief today, or does anybody in the department have one in relation to this matter?
I would need to check with colleagues. Yes.
Yes, you do. Are you able to table that, please, for the committee?
Can I check with the chair in relation to that?
What's the reason? Why do you need to check with the chair? You can either table it.
Well,
You have a back pocket brief. I've requested the back pocket brief.
You don't? No.
Review it
What-
before you table it.
What is
Correct.
normally the case is that if you have requested a document, that the witness would take that on notice, make sure that there isn't anything in that document that can't be tabled, and I'm sure that if there isn't, then you will go through that process. But there's usually some confidence related to those documents, so I'll give you the opportunity to do that,
thank you, Chair.
Secretary.
So, Secretary, you accept the guidance given provided by the chair, and you won't be providing the document.
Yes.
Right. So, just to confirm, is that your guidance or the Secretary's guidance, or the chair's guidance?
I will.
You're adopting the reasons
I will
given by the
comply
chair?
with
No, I'm explaining to the Secretary what the precedent usually is, and the Secretary can make a decision about what she
Well,
wants
that's
to
what
do.
I'm saying. So, I just need to understand: is the Secretary making her own decision, or is she accepting the guidance that the chair of the committee has provided to the Secretary?
Oh, it's semantics, Senator Cash, for some ridiculous reason. The,
Well,
the
no, I just need to
Secretary is quite
understand.
capable of making her own decisions.
Well, then,
and I
could
know
you
she will.
articulate the decision, please, Secretary?
Senator, I would like the opportunity to review the brief to
Perfectly
assess
reasonable.
whether there are any issues, and then be in a position to come back to indicate whether we can table or not.
And is that when do you think you can be in a position to come back?
We'll take some time later during the course of the hearings, and we could be available to provide it later on.
Thank you. The issue I have is I was unable to pursue a line of questioning last time because the evidence that was given was incorrect. To go to your letter, Mr Johnston, and I quote, misremembered. So you can understand why I'm very keen to have as much information provided today, so tomorrow I don't receive another letter saying the official at the table who had knowledge of this matter misremembered.
It's your last question, Senator Cash. If it was a question. Was it a question?
It was. Just pointing out, last time I was unable to pursue
okay, it wasn't a
line of
question.
questioning.
That's,
So
you
I'm
no
keen
longer
to
have the call, Senator Cash.
That's fine.
And given you've raised this matter in this part of the program, I have some questions that I'd like to consider. Can I just understand, to be clear, I think there has been some characterisation of this matter, but going back to the actual court proceedings and the reason that they were brought, can I just be clear that under the previous government, the ABC issued a compliance notice to Lendlease demanding the removal of a Eureka flag from a building site, and that's because under the previous government's building code, it was unlawful to fly Eureka flags on building sites. Isn't that right?
Thank you, Chair. I think that broadly accurately describes the nature of the matter, but I might just check with colleagues that they agree with that characterisation. Yep.
Right. And in response to that compliance notice, Lendlease actually commenced court proceedings in 2020 to challenge the compliance notice. That's the origin of this legal matter that we're talking about. It's all about a flag, to be clear, whether you can fly a flag on a building site or not, right? And the intervention that Senator Cash has referred to, the CFMMEU intervened in the proceeding to argue that the provision of the former government's building code that banned the flying of the Eureka flags was unconstitutional. Is that was the purpose of the intervention? Okay. And then as has been pointed out, the ABCC actually won the case. That's not disputed. How much public money did the ABCC spend on this proceeding about a flag? I'm sure you have those figures in front or around those figures because you would have been asked many times before, but it was over $500,000, wasn't it?
Chair, in terms of the total expenditure by the ABCC in relation to this matter, we don't hold that figure. Obviously, I would say it was a matter for them, but the entity no longer exists. So, yeah, so I think I would refer those questions to the Department of Employment and Workplace Relations or the Fair Work Ombudsman, I think.
Okay. I think we have had some evidence before around this proceeding going forward. I think it's about $500,000 that the ABC spent of taxpayer funds fighting a flag. Can I just check, though, in terms of the intervention and the cost order, the actual party to the proceeding was Lendlease and not the intervening party. I assume the court order also made a cost order against Lendlease. Is that right?
Senator Michael Johnson, Assistant Secretary, Office of Legal Services Coordination. First and foremost, just to be clear that the management of the matter itself was a matter for the ABCC. The role of the Attorney General, the Attorney General's Department and my part of the Attorney General's Department was overarching, and we were only involved in certain aspects of it. Saying that, I understand that there was no cost order in favour of the Commonwealth for Lendlease. I understand that there was an agreement between the ABCC and Lendlease at the outset of the matter that each party would bear their own costs.
Right, okay. Convenient. The respondents in the court judgment, there was a sentence that said the respondents do not seek any order of costs against Lendlease. They do, however, wish to be heard on the question of costs against the CFMMEU. It's quite extraordinary that a court would make a cost order against a party that intervened in a proceeding, but not against the party that actually lost the proceeding. Is
Chair,
that
just point of order? I just think we need to be very temperate with respect to our language on this committee, with respect to making comments regarding decisions of the court. So saying it's quite extraordinary that a court would make a certain cost order, I think, is getting into the realm where
it's not
we
a
need
point
to be
of
very
order.
careful.
It's not a point of order, particularly because it is extraordinary. It's a matter of fact. Like it's not an opinion. Like you can have a look at what court orders say, but I don't want to get into.
The cost
I
order.
appreciate that I'm in
It's
a position.
reflection on the court. It's a reflection on the court. You can't say it's extraordinary.
Given an opportunity to actually properly respond.
Can I just continue with my questions? You've interjected. You're trying to, I can see what you're trying to do. I'm in a position of chairing, but also needing to make sure that this is on the record. So if you could assist me in not interrupting, that would be good.
Well, sorry,
Lendlease.
point of order, Chair. Point of order, Chair. I don't accept the characterisation of my interruption. We've been sitting in these hearings for quite some time. You know, I very rarely do so. I have a genuine concern that members of this committee, especially this committee, need to be very moderate with respect to their language when they're characterising decisions of the courts of Australia. So I will let you, I won't continue with the point, but I would appreciate you not characterising my motivations, please.
Okay, well, you're not chairing the hearing and you're not making a decision on points of order. I take your interjection and I suggest you provide that advice to your colleagues as well.
Well, I'm
no,
sorry,
that's-
but I
you've-
don't take your suggestion in
Well,
relation to that.
If you want to keep interrupting, we can just suspend the hearing or I can just get on
Well,
with
we
the
might need to.
questions.
We might need to. We'll see how
That's
we
fine. I think it is very important that we understand a little bit about the way that this decision was made. A decision about a hearing, a court proceeding that was about essentially a flag. According to the decision, I want to understand in terms of the what happened after the decision. After the election, the new government repealed the provision in the building code which banned the flying of the Eureka flag. Isn't that right?
I understand that's correct, Senator, yes.
So the provision that was the provision that the ABC issued a compliance notice in relation to no longer existed, essentially.
That's correct.
Common sense prevailed. And after the decision was made, it was the ABC and not the Attorney General that decided to pursue a settlement of the court proceedings. Is that right?
That is correct, Senator. Furthermore, I understand that given it was an appeal that was brought by the CFMMEU, the CFMMEU offered to withdraw its appeal in light of the legislation being repealed. The ABCC was willing to agree to that, was open to agree to that, and as is required under the Legal Services Directions, the ABCC submitted or put a request in seeking the attorney's approval. The attorney did not instruct the ABCC to pursue or agree to an appeal, merely gave them approval to do so.
Right. Let's go over that again because I think that's very important and I suggest my fellow senators listen so we have clarity on this. The Attorney General was not involved in providing instructions. The ABCC, essentially there was a settlement process underway because there was an appeal on foot. There was a decision about how best to settle this matter, taking into consideration model litigant behaviour.
Yes, Senator, there was a decision made by the ABCC as to how to manage the matter and, in effect, seek to finalise the matter in light of its model litigant obligations and in light of its other obligations.
So the extent of the Attorney General's involvement in the matter was to approve a settlement request from the ABCC on the following terms: that proceedings be discontinued, that there be no, and by proceedings being discontinued, I'm referring to the appeal that was on foot, that there be no order as to costs in the appeal proceedings, and that the ABC not enforce the cost order granted in the first phase of the proceedings, so that there would be no appeal, that there would be no cost against the Commonwealth in that appeal, or the other party, and that the ABC not enforce the costs previously granted. And this all relates to a provision that no longer exists in law. Is that correct?
It is correct, Senator, that the attorney provided approval for the ABCC to settle the matter on those terms.
And it's
yes.
very common, is it not, for parties to agree to bear their own costs and even for a party to forgo their right to seek to have their costs paid in order to facilitate a settlement. Is that right?
Yes, Senator, it's a very frequent element of settlement to have parties bear their own costs, even when a particular party would have every right to get those costs.
There's a lot of lawyers in the room, as you can imagine, probably back there and at this table. But for the purposes of these hearings, one of the reasons why settlement would be reached around costs, am I right, is that it would facilitate a timely and cost-effective resolution of a dispute.
There can be several reasons, Senator, why a settlement or why an agreement involving a compromise of what might otherwise be a right owed to a party might be reached on costs, and you're very right. If the substantive matters of a matter have been resolved and the only outstanding issue is resolution of some aspect of the payment of costs, it's very frequent that a compromise is made on that to facilitate a timely resolution of the dispute. That's correct.
So what has actually happened here is that the two parties, not the actual party, the intervening party, the ABCC and the CFMMEU avoided unnecessary legal costs and essentially avoided dragging out the matter any further.
That is the outcome of the settlement that was achieved, Senator, yes.
And the settlement that was agreed to by the ABCC and the union, probably their lawyers on behalf of, that settlement request was approved by the Attorney General.
The terms that the settlement were achieved on, those terms were approved by the Attorney General, yes.
Thank you for clarifying that. Well, no, you will have an opportunity to ask more questions, Senator Cash,
Thank you.
I guarantee you. Thank you for that. I've had some questions about the proceedings itself. Can I understand, can you take on notice the costs of the proceedings?
I would just defer to the Secretary's comment a moment ago, which is that the costs of running the proceeding was a matter for the ABCC. Agencies don't report to the Attorney
Sure.
General's Department on the cost of individual matters, and I suspect that either the Department of Employment and Workplace Relations or the Fair Work Ombudsman, who's taken over the functions of the ABCC, may be better placed to answer that question.
Sure. Do you know how much the Commonwealth spent on supporting Clive Palmer's attempt to undermine the Western Australian COVID restrictions? Have you got a sense of how much that was?
We would have to take that on notice to the extent that we have information on that. We don't have any information on that available to us right now.
We might come back to that. Senator Shoebridge, you have the call.
Oh, thanks very much, Chair. Just quickly going back to the appeal proceedings. Actually, in this case, the Commonwealth gained the benefit of having the appeal proceedings discontinued and avoiding the uncertainty and risk of potentially losing the appeal. And indeed, the cost orders themselves may well have fallen aside on the appeal. So the Commonwealth actually gained a benefit in terms of avoiding the uncertainty and the costs and the potential peril from an appeal. Is that right?
I think that's a reasonable way to characterise the outcome.
And indeed, it would be far from
Thank you.
extraordinary in appeal proceedings where an appeal raises uncertainty and concern about the primary judgment to come to some kind of settlement on appeal which may involve forgiving cost orders. Is that right?
Yes, certainly that's not uncommon.
And from a public interest point of view, where the substantive nature of the proceedings has in fact fallen away because of a change in government policy, that would be another public interest consideration when you're considering a settlement of appeal in a case like this.
That would certainly be one of the factors to take into account.
Yeah, so far from extraordinary, what we're seeing in this settlement is the kind of usual push and pull, negotiation and resolution of what is protracted legal proceedings, the kind of arrangement that would be far from unordinary in corporations or government. Is that right?
I think that's a fair assessment, yes.
All right. Could I just quickly go to the review of Australia's Privacy Act? Can you provide, I don't know if it's best coming through you, Secretary, or through somebody else, can you provide us an update about where the review is and who's undertaking that review?
Can I,
So,
again,
Senator, we can, but again, I would note that that's...
Sorry, Secretary, can I just
Well,
intervene because I
yep.
think I know where you're going.
Yep.
Senator Shoebridge, I really do appreciate
Is
your
outcome 62? Is that
I
right?
no, I do appreciate your interest in this matter. This does relate to
That's why I am.
an outcome that we have hopefully not too far away in the program. And I am going to insist that you ask those questions there, but I'm sure you have other questions that relate to cross-portfolio matters that you would like to ask.
I do, indeed. If we're talking about appeal cases and prosecution cases, does the Commonwealth have any current estimation of the costs of the Commonwealth in the prosecution of Mr David McBride?
Senator, that would be an issue that falls under the National Security and Criminal Justice Group, and I will have officers available there. I think, if I'm correct, we have previously provided some information, but I'd need to check on that actually. Under that National Security Criminal Justice Group, I will ensure that officers are on notice to the extent they can assist with that answer that they do.
And if we're doing one of those on notice for later in the day procedures, I'll be asking similar cases in relation to the ongoing prosecution of Richard Boyle.
Thanks, Senator.
Does the, in relation to the UN SPT process in relation to OPCAT, Secretary, are you in a position now to provide some responses to OPCAT?
Well, again, Senator, that's relevant to the human rights branch that are part of the Integrity and International Group who are scheduled to appear at 11:15.
All right. Then at least I can schedule my day. What about the Crown?
Any other way, Secretary, to assist you?
Yeah, well, it's been very helpful. What about the Crown and Caleri? Questions in relation to the costs on that, questions in relation to the decision, the initial decision to seek special leave.
So that's the National Security and Criminal Justice Group, so scheduled at 1:15, the same officers that would be able to assist in relation to the McBride and Boyle matters.
And the review of Commonwealth secrecy laws, which I assume cuts across
That would be
a
later.
variety.
Well, again, it's that National Security Criminal Justice Group, so the officers responsible for that will be available during that time at 1:15.
All right. Well, let's get stuck into the substantive part of the hearing.
I would like to do that. Senator Cash, I believe you're seeking the call
I think
for
that Senator Scudder says one
cross-portfolio
point he'd
cross-portfolio
wish to raise.
matters.
Yes, I'll continue a line of questioning in relation to this matter.
And then we're
And Chair, we're sharing the call. With your indulgence in relation to this block, I just have one question I want to ask.
if your colleague allows that, I'm sure.
Secretary, and if our friend could come back to the table, please. Secretary, Senator Shoebridge sought to characterise this as something in accordance with the usual practice in terms of litigation, matters are settled, etc. Can I ask you whether or not you think the following facts are relevant in terms of imposing, or which should raise concerns, elevate concerns with respect to settlements in relation to matters involving the CFMEU and a government agency? First, that the High Court of Australia in the Pattinson case referred to the CFMMEU as a long-term recidivist law breacher. Second, they referred to their aggressive tactics, unlawful tactics in the industrial relations sphere as being regarded by them as a cost of doing business. A cost of doing business. Now, I can't remember the High Court of this country characterising the behaviour of any organisation in that way. And secondly, the fact that the CFMMEU has given millions of dollars of donations to the party currently in government, the party of the Attorney-General, and the fact that members of the CFMMEU sit on the national executive of the Australian Labor Party. Don't you think those matters would elevate a potential settlement involving the Attorney-General issuing a direction? Don't you think all of those matters...
Do you have a question, Senator Scarr, or
I'm sorry,
if you're
Chair,
making
I
a
will get to my
parliamentary
question if you didn't
speech, you can
interrupt
do
me.
that in the chamber.
Don't you think all of those matters would elevate... I'm sorry, Senator Polly, I have the call. Don't you think
Senator
all of
Polly.
those matters would elevate the sensitivity of this matter so it should be considered at the highest levels of the department, and certainly
They
should have come
didn't.
to the awareness of the highest level of the department before the last estimates hearing?
Thank you for that speech.
Sorry, it was a
Senator
question.
Curtin.
I asked a question as to whether or not all of those factors, and there were
Secretary,
quite a number
would you
of
like
those
to,
factors.
if you can, respond?
Point of order, Chair. I do not accept your characterisation of my question. These
It's
are
not a
important
point of
matters.
order.
I do not accept your
Okay, that's not a point of
characterisation.
order. It's
do
not a
not-
point of order.
I do not
That's
accept
not
your
a,
characterisation.
that is not a point of order. That is not a point of order.
We will
There
get
is
through
no
this much
standing
quicker if
order.
you did not interrupt.
There is no standing order that
You're just deflecting.
allows
Chair.
you.
You're deflecting and running interference on these important questions.
Okay, we're going to suspend the hearing there because I'm not going to allow any senator to refer to the chair in that way. We'll suspend the hearing. Thank you, and we'll have. Thank you, senators. If I can get broadcasting. Thank you, everyone. Senator Scarr, you have a question.
Thank you, Chair, and apologies for my passion in relation to this matter. You know, I feel very strongly about these issues. Secretary, if I can recast my question in very simple terms, do you consider that there was special circumstances in relation to the parties involved in this case that would justify an elevation of consideration of settlement and compromise of cost orders, which would warrant those matters being considered at the highest levels of the department for additional scrutiny?
Thanks, Senator. What I would refer to is the broad process under which significant legal matters are dealt with across the government, and there's a framework set out in the legal services directions that guide that. So the first thing to note is the matter was a matter for the ABCC. This department wasn't running the matter, it was the ABCC. We were engaged around seeking approval for the terms of proposed settlement, but it wasn't a matter that this department, in its broad policy responsibilities in the Office of Legal Service Coordination, was directly responsible for. It was listed as a significant legal matter, and we have a framework for that, but it just, in this instance, was not one that was raised directly to me.
Okay, thank you.
Thank you, Secretary. And the line of questioning I'll pursue now, we'll revisit that question at the end. In the first instance, Chair, the costs order was referred to. I will table the costs order for the benefit of the committee in the Hansard record. It's document number 2 that I have. The intervener, being the CFMEU, pay the following costs on a party-to-party basis as agreed or assessed. 50% of the respondent's cost in respect of the issue concerning the proper construction of the relevant section of the building code, and 100% of the respondent's costs in respect of the constitutional law issues from the 12th of February 2020 onwards. And that was the cost order made by Justice Snowden of the Federal Court. My line of questioning is in relation to seeking approval for the proposed terms of settlement. Mr Johnson, you gave evidence, and I just want to confirm I didn't misunderstand you, that seek to imply that the ABCC were the ones who requested that the costs order not be enforced. Was that the evidence you were given?
It was not, Senator.
It was not. So can you just confirm for the record then what the evidence was you were given?
The evidence that I stated, Senator, was that it was the ABCC that sought to pursue settlement of the matter, and requested the Attorney's approval to allow them to seek that settlement.
Did the Attorney-General of Australia approve the terms as set out by the ABCC?
I understand, Senator, that it is already on public record what the ABCC requested. I believe there were some documents released by the ABCC through an FOI process that has on public record the terms that they requested. And in my letter that I sent to you following the last estimates and in some other places, the terms that the Attorney approved are also on public record.
Sorry, is the answer to the question yes or no?
And it's clear from those documents, Senator, that the Attorney approved terms differently to the terms requested
Thank you,
by
and we will go through
ABCC.
and pursue those terms. Can I also confirm in relation to your evidence, the Secretary deferred to you when I asked the Secretary the questions on the 7th of November 2022. Why did the Secretary defer to you?
I believe it would have been because my role as the Assistant Secretary of the Office of Legal Services
Yes.
Coordination results in me being responsible for the management of significant legal issues and supporting the Attorney-General's role in that respect.
Okay. When the Secretary deferred this question to you, you responded with, "In my experience, in my knowledge, there has never been a situation where the Attorney-General has ordered an agency to not enforce a costs order." Again, are you telling the committee that you had no knowledge of this matter on the 7th of November 2022?
No, Senator.
You had no knowledge of this matter?
No to your question, Senator.
So you did have knowledge of the matter on the 7th of November 2022?
That is correct, yes.
Then why did you not answer the line of questioning that I asked?
First of all, I did answer the line of questioning, but I do acknowledge I incorrectly answered, and I do apologise to you and the committee for that. I did promptly correct that evidence. I was familiar with and I did know of the existence of the matter. I was involved in supporting the Attorney-General in his decision. When you raised your line of questioning, as the Secretary mentioned, you raised it in an abstract form. Frankly, I didn't know which matter you were referring to. I racked my brain. I went through the Rolodex in my brain of different matters that we manage, and we manage over 500 of these matters in a year. This matter, which I did vaguely remember, occurred to me, and my recollection of the matter was that the relevant settlement term was for the Commonwealth or the ABCC not to pursue costs against the CFMMEU. That was my recollection on the day. You might remember in my evidence I was particularly deliberate to state that you were asking about cost orders and not about pursuing costs, and that was the reason, because my recollection was that. When I returned to the office the following day and I reviewed the material, I realised that my recollection was incorrect, and in fact the settlement term did reference not enforcing a cost order. I then took action to correct my evidence.
You did. So the question I asked the Secretary was, has the department been provided with any instruction, direction or advice from the Attorney-General or his office in relation to the enforcement by the Commonwealth or a Commonwealth entity or agency of any cost order or category of cost orders? And your response was, in my experience, in my knowledge, there has never been a situation where the Attorney-General has ordered an agency to not enforce a costs order. Are you saying that evidence was wrong?
I have already stated that evidence was wrong, Senator.
was
I'm
wrong.
happy to restate that evidence was incorrect.
Yes, no. Can I ask, did you discuss this matter with the Secretary prior to estimates?
No, Senator.
Did you discuss it with the Attorney-General or his office?
No, Senator.
Did you have a brief in your file in relation to this matter?
No, Senator.
Okay. Can I just confirm, when did you actually become aware that the evidence you had given was incorrect?
It would have been at some point during the morning of the day following estimates. I believe estimates was on the 7th of November, so it would have been sometime mid to late morning on the 8th of November.
Okay.
Senator, can I say that as soon as Mr Johnson became aware of that, he alerted senior officers, including myself, and we took steps to rapidly put a correction letter to the committee. So there was no delay, and there was a strong commitment to correct the record immediately.
Well, with all due respect, Secretary, there was delay because I was unable to pursue a line of questioning given and I think you refer to it very nicely as misremembering. There was a misremembering. Don't worry, we've got a whole lot of documents we're going to go through that I will table for the benefit of the committee one by one, which show the exact sequencing of events, including the offer originally put by the Australian Government solicitor on behalf of the ABCC, the response from the CFMMEU, the counter offer, which clearly states we ain't going to pay a cent, the settlement request form put forward by the ABCC, which clearly sets out that it is up to the Attorney-General as to whether or not to compromise the Commonwealth's position in relation to pursuing costs. We're going to go through all of this. We're then going to go through the emails that your department sent on behalf of the Attorney-General of
Senator
Australia,
Cash, I'll just draw you to
where
a question.
it clearly states
Do you
they
have
are
a
not
question?
to pursue the costs.
Yeah. Well, that was a statement, Senator Cash.
I'm
If
just
you have,
giving the
I'm ask-
agency benefit of the documents I will soon be tabled.
well, do you have a question, Senator Cash? And I'll draw your attention to the time.
I have a series of questions.
Could you ask your question? I'd give someone else the call if you
Mr.
need
Johnson,
some time
you
to
said that
gather.
you advised the Attorney-General on this matter. I'd like to now go to the nature of the discussions that you have, etc., with the Attorney-General, and when those discussions actually commenced.
Sorry, is that a question, Senator?
You stated you advised the Attorney-General on this matter.
Yeah, we've prepared and provided a written submission, Senator, as you'll be very aware of the way that significant issue settlement requests are managed.
When did you first provide a brief to the Attorney-General or his office?
I'll start, Senator, just by noting, as I said earlier, the initial advice to the department of the existence of this matter was included in the incoming government brief that was provided, I believe, on the 8th of June.
8th of June. Okay, thank you.
That wasn't specific to the terms of any settlement. It was advising
The issue was a significant
the matter.
Issues matter.
Yep.
And so, Mr Johnson, when did you first provide a brief to the Attorney-General's office in relation to this matter? Was that the 8th of June 2022 as part of the incoming government brief?
No, Senator. In terms of the settlement of the matter, a written submission was provided to the Attorney-General on the 9th of August 2022.
The 9th of August.
We are
Okay.
due to go to a morning tea break, Senator Cash. If you've got a line of questioning, I'll let you finish it. We can come back.
I'll pursue this after the morning tea break, that's fine.
The hearing will be, we'll just suspend the hearing there for morning tea, and we will be back at 10:20. Senators, we'll resume the hearing there, and Senator Cash, you have the call for a short block.
Thank you. And just in relation to the correction of the evidence by Mr Johnson, I will table the letter that the Secretary sent, or that Michael Johnson himself sent to the Committee Secretary on the 8th of November 2022, clarification of evidence estimates hearing on the 7th of November 2022. After reviewing departmental records, etc., I wish to clarify my evidence, and it was in relation to the approval by the Attorney-General allowed the ABCC to agree to settlement of the proceedings on the following terms, one of the terms being, and the ABCC not enforce a costs order granted in its favour at the first instance phase of the proceedings. That is correct, Mr Johnson.
If you're reading from the letter, Senator, it will be correct, yes.
Yep. And I think just to clarify,
In terms of tabling that document, Senator Cash, it's essentially already a committee
That,
document.
that's fine. If the committee's happy, or if
It's
anyone
not
wanted to see
necessary
it,
to
that was
table
the reason
it.
we bought copies. And just in terms of the Secretary's letter to myself on the 12th of February 2023, I will just table that for the benefit of the committee, so the evidence is complete. And basically, as evidenced by the correction of evidence made, Mr Johnson misremembered certain details of this matter. You stand by what the Secretary stated in relation to your evidence.
I do, Senator, and it's also consistent with what I said earlier in this evidence, that I had an incorrect recollection of the matter.
When did you first realise you had an incorrect recollection of the evidence that you gave me? Or should I say you gave to the committee?
As I've already stated today, Senator, that was during the morning of the day following that estimates hearing. I believe that's the 8th of November.
So that was the 8th? Okay. So no one brought to your attention on the 7th of November at any time that you had potentially given incorrect evidence?
No, Senator, nobody did that.
Okay.
Senator,
you say-
if I could just remind the committee that the terms of the question that you asked were very general. You did not relate it to a specific matter, if it's my recollection. So at the time that the question was asked, it did not immediately connect to that particular matter. Now, I acknowledge and accept the fact that then Mr Johnson returned to the department the following day and acquainted himself with the information in order to realise that he could have answered that question differently, and then went about to correct the record. But my recollection of the question that you asked was in very general terms.
And I'll just read the question back out again. In my, the question itself was, has the department been provided with any instruction, direction or advice from the Attorney-General or his office in relation to the enforcement by the Commonwealth or a Commonwealth entity or agency of any costs order or category of cost orders? And both yourself and Mr Johnson, and you've given your evidence this morning, and Mr Johnson, in my experience, in my knowledge, there has never been a situation where the Attorney-General has ordered an agency not to enforce a costs order. That was on the 7th of November 2022. And as you said, what I found a little strange, and I'm assuming it's why you misremembered, it's a very eloquent term, misremembered, and then corrected your evidence in relation to the significant issue settlement request template provided by the ABCC clearly states the CFMME you offer is predicated on the previous costs order being vacated. The ABC Commissioner defers to the Attorney-General on this question and whether it would be appropriate to compromise the Commonwealth's entitlement to costs. And then you obviously have a series of emails which clearly set out that the ABC settlement request has progressed to the Attorney-General's office for deliberate. We're expecting a response soon. And then ultimately the email on the 8th of September, so that's 2 months before I asked this question, there is an email from the significant issues team. Did you say you head that team?
It is a team within my branch,
Right,
Senator,
within your
yes.
branch, the Office of Legal Services Coordination, which clearly states, dear ABCC and AGS colleagues, I refer to the settlement request. The Attorney-General has now approved the following. The ABCC does not enforce the federal court costs order dated the 31st of March. Were you aware, therefore, of the series of events leading up to the settlement that was authorised by the Attorney-General? Were you part of those discussions?
I'm not sure, Senator, what series of events you're referring to.
In terms of the ultimate authorisation by the Attorney-General of the settlement?
Again, I'm not quite sure what you're referring to, Senator. My branch, including myself, prepared a submission for the Attorney-General.
Yes?
To seek his approval for the ABCC to settle
Yes.
this matter. I was the relevant officer who authorised that submission, and it was provided to the Attorney-General, and he considered it and gave his decision.
Senator, could I just to assist the committee, I was going to ask Catherine Haig just to give the context of how those decisions are made, because not everyone on the committee.
I'll get to a line of questioning in relation to that.
We only have another few questions, Senator.
I just think it's quite relevant to understanding the process and the briefing of the attorney that is directly
I will
from
get to
Senator
that.
Cash's question at the moment.
Chair, I will get to that, but there is a whole series of documents I'd like to go through before we actually hit whether or not the Attorney-General is briefed on this matter. And the first is in relation to a letter of the 7th of June from the Australian Government Solicitor to the CFMMEU, which sets out the ABCC's position in relation to costs. So I understand, Mr Johnson, the AGS wrote to the CFMMEU, as I stated, on the 7th of June, setting out the costs that it had incurred as a result of the CFMMEU's intervention, and that it estimated the CFMMEU were required to pay to the ABCC following Justice Snowden's cost order, the sum total being in excess of the $410,570.27. It was claiming 75% being $307,927.70. And I will table that letter for the benefit of the committee. Mr Johnson, are you aware of this letter?
I have seen the letter, Senator, following, I understand it was also part of the documents released by the ABCC under its FOI request.
So you have said Craig Rawson, Senior Executive Lawyer, is the author of the letter. Were you aware of the letter at the time?
I was on leave at that time, Senator.
So who in your office would have been aware of the letter at the time?
I would have to take that on notice, but I would expect it would not necessarily be anybody. Again, it's important to reiterate how legal matters are managed in the Commonwealth, which I know you're aware of, Senator. The ABCC was responsible for managing this matter. The ABCC engaged the Australian Government Solicitor as its legal representatives in managing the matter. The ABCC was required, and in fact did, report the matter to ALSC as a significant matter under the Legal Services Directions. As a result of that, the ABC gave regular updates to ALSC as to how the matter was proceeding. ALSC did not and does not have a direct role in the managing of each and every aspect of the matter, so we would not have been involved in the drafting or even receiving a copy of that letter at that stage.
And I didn't ask if you were involved in the drafting or in receiving a copy. I asked if you were aware of the letter at the time. You said you weren't, you were on leave. Yep. Secretary, were you aware of this letter from the Australian Government Solicitor to the CFMMEU at the time, setting out all of the costs that had incurred as a result of the intervention, and that the costs it was seeking to recover being $307,927.70?
Senator, no, I was not aware of the letter, and as I have previously stated to the committee, this department was not the briefing department, it was ABCC, so it would not, I would not have such correspondence in relation to a matter that this department is not itself the briefing department.
Can I just confirm,
that would not
is
normally be the
AGS
matter.
part of your department?
So AGS is. So,
Yeah, that's what I just wanted to confirm.
Yeah, and I clarified that. I made that clear earlier on in terms of the distinction between the policy part of the department and AGS as a legal service provider for Commonwealth governments and agencies.
Thank you. Are you aware that the CFMMEU responded to the letter from the Australian Government Solicitor on the 25th of July 2022?
I do not have direct knowledge of that letter.
Okay, I'll ask Mr Johnson then. Are you aware, Mr Johnson, that the CFMEU actually responded to the letter from the AGS setting out the costs that the ABCC would be pursuing on the 25th of July 2022?
I don't specifically recall that, Senator, but I expect it would have been part of the documents that my team was provided by the ABCC in progressing their settlement request.
And I will table that letter then for the benefit of the committee. When did you become aware of this letter?
I'm sorry, Senator?
When did you become aware of this letter?
Consistent with my previous answer, Senator, I can see a copy of it here. I can't tell you when I first became aware of it. I expect it would have been provided to my team at some point during the settlement process.
Your last question, Senator Cash.
But I wouldn't be able to tell you the precise date that I first became aware of the letter.
Yes, but I'll continue with this line of questioning.
Senator
when-
Shoebridge, you have the call.
Thank you, Chair. Perhaps just for a bit of context, I might put some questions to Senator Chisholm, representing the Attorney-General. Senator, it would be not desirable, but far from unprecedented that evidence given in a Senate committee may have to be clarified once further information comes to hand. Is that right?
That's my experience, Senator Shoebridge, in the almost 7 years I've been in the Senate. I can recur instances where that has occurred from various people giving evidence to committees.
And Senator Cash may be aware of instances where perhaps even ministers have given answers, perhaps 5 answers on a given day, which on reflection have proven to not accurately reflect the facts, and then had to come and clarify that evidence later.
I can recall an instance along those lines, Senator Shoebridge, where I think then Minister Cash had to come in and correct the record.
Yeah, so really what we're asking for here is if further information comes to hand, you clarify it with the committee as soon as you possibly can.
I think that is always the best way to operate, Senator Shoebridge. As soon as you become aware, you inform the committee through the appropriate channels.
Yeah, and perhaps being cognisant of that recent history would be helpful in reducing some of the heat and light about the department clarifying their evidence.
Yeah, I think that is a fair conclusion to reach, Senator Shoebridge. It unfortunately does happen from time to time,
Very unfortunate.
but I think that as the department have been talking through, they took the earliest opportunity to correct the record and inform the committee.
Yeah. I might go back to you, either to you, Secretary or Assistant Secretary. I'm curious about when your department first became aware of the arrangement that was entered into between Lendlease and the ABCC, either before or at the time of commencing these proceedings in relation to costs. Mr Johnson, you seem to have the closest knowledge of this matter. When did your department first become aware that there was an arrangement between Lendlease and the ABCC on costs?
Thank you, Senator. I wouldn't be able to speak on behalf of the entire department. Personally, I first became aware of that situation, it was either 1 or 2 weeks ago from today.
And can you provide us some detail about what that arrangement was between Lendlease and the ABCC?
I have very little detail, Senator. The means in which I became aware of it was through a discussion with a colleague in the Australian Government Solicitor on this matter, as we were preparing for today. And all I learnt from that discussion was that the ABCC and Lendlease entered into an arrangement at the commencement of the proceeding that regardless of the outcome of the proceeding, who won, who lost, each party, being the ABCC and Lendlease, would agree to what's called bear their own costs, which means they pay their own costs and would not seek the the other party to pay their costs.
And this was in what is often described as a cost jurisdiction, where the ordinary outcome otherwise would be the person who wins has at least their party costs paid for by the unsuccessful litigant. Is that right?
That is correct, Senator. That's the standard approach in that jurisdiction.
And this was an instance where a construction company was actually bringing a case against a government agency in a cost jurisdiction. Is that right?
That's correct, Senator.
Was it ever explained to you on what basis the arrangement was made between this multi-million-dollar construction company and a government agency, where the government agency had agreed that win, lose or draw, they'd never seek costs from the construction company?
The basis or the reasoning for that, Senator, was not explained to me.
Have you ever seen such an arrangement before, where a corporation has commenced proceedings against a government agency in a cost jurisdiction, and the government agency at the very outset been dragged into the proceedings as an unwilling respondent, has basically put down their arms at the beginning and said, regardless of what happens, we won't pay costs. We won't seek costs against you.
Senator, there are probably several examples in the broad realm of Commonwealth legal matters where the Commonwealth may choose to take such an approach. Normally, the type of matter that would be warranted is, say, both parties wanting to put a test case forward. I'm not familiar, not to say that there isn't a matter, because at that stage of proceedings, it's managed by the agency. It's not necessarily something that would come to the attention of my department, of our department, but I'm not familiar with what might be called a contested case like this for that to have occurred.
Yeah, this wasn't a case where, for example, there was a public interest issue that was resolved and both parties were seeking the guidance of the court. This was an application by a construction company to set aside a notice issued by the agency, wasn't it?
Yes, I'm not aware that element was present in the case, Senator.
Yeah. Well,
Public
in
interest
fact,
element.
from your understanding as you sit there, that element, there was no public interest element in these proceedings, was there?
That's my understanding.
And it's
Senator.
normally only a public interest element, from your experience, which would justify that kind of unilateral disarmament on the part of a government agency when it comes to costs.
That would certainly be a prime example of where that might occur, Senator.
Yeah. Do you know if in your discussions with the AGS, was it ever raised at the time that the arrangement was made between Lendlease and the ABCC under the former government? Was it ever raised that Lendlease had been making repeated large donations to the coalition, large political donations?
I have no knowledge of that, Senator.
So you weren't aware, for example, at the time that in the same, round about the same year, Lendlease had made a $37,000 donation to the Liberal Party?
I have no knowledge of that,
Or a
Senator.
$6,800 donate, that's the Federal Liberal Party, or a $6,800 donation to the New South Wales division of the Liberal Party. And I presume you'll provide the same answer about their $11,000 donation to the National Party at the time.
That's correct, Senator. I have no knowledge of that.
Would you ordinarily expect that to be disclosed and discussed when a corporation is seeking to cut a deal with a government agency?
I expect that would be a matter for the relevant agency, Senator. Our function is to support agencies managing their legal matters through the prism of the legal services directions, and that whilst the legal services directions impose a number of very important disciplines and requirements, it doesn't go into those sorts of matters.
How was this, and they're my words, not yours, this sweetheart deal between Lendlease and the ABCC on cost, how was it documented? Was it an exchange of correspondence? Was it a nod and a wink? Was it a handshake? How was the sweetheart deal on costs between Lendlease and the ABCC arrived at?
I'm not aware, Senator. Again, that would have been a matter for the ABCC, and that level of detail wasn't conveyed to me.
All right. Secretary, do we have anyone from the AGS who's going to be appearing later who could perhaps provide us with some insight into how that arrangement was made?
Senator, we do have officers, the Australian Government Solicitor here today to appear. Obviously, there will be some issues as to client confidentiality and legal professional privilege that may arise in relation
Even if the client
to
has ceased to exist.
as a separate agency, but some of its functions have transferred into the Fair Work Ombudsman. So there is some continuing, what's the word I'm looking for, legal entity that's merged into the Fair Work Ombudsman.
Right. Mr. Johnson, when there was a cost dispute, when there was a discussion as to costs in the proceedings in the court at first instance, and the ABCC was seeking costs from the union, do you know whether or not the ABCC informed the court of the private arrangement that they had entered into with Lendlease on costs?
I'm not aware of that, Senator, whether they did or didn't.
But as a matter of ethical practice, you would expect, wouldn't you, that if a litigant was seeking to saddle just one party with costs, that they would as a litigant with the high ethical standards required of the Commonwealth, that they would inform the court about that relevant matter, wouldn't you? Given the ethical standards that the Commonwealth has as a good litigant.
I couldn't say, Senator. That would be a matter for the ABCC. They certainly are subject to the model litigant obligation and a number of other obligations. Exactly how that might be applied in the matter at hand, I wouldn't be able to speculate on.
I'm going to ask you, if you can, to take it on notice whether or not you can shed any light about whether or not the ABCC informed the court about the private arrangement that they'd come to with the Lendlease when they were seeking costs. So I'd ask you if you take that on notice.
I would say that is likely knowledge that would not be within the department, but I would happily take it on notice to confirm that.
On any view, though, it would be relevant, wouldn't it? If you were seeking to saddle just one party with costs in court proceedings, it would be relevant, I would imagine, to the court's discretion if the other parties to the proceedings had made some a priori arrangement between them in relation to costs. That would clearly be relevant to the court's discretion on costs, wouldn't it?
So that would be a matter for the court, and I wouldn't put myself in their shoes.
Thanks very much.
Thanks, Senator Shoebridge. Senator Polley, you have questions on another matter.
Yes, I do. Go back to those. Sorry, Chair.
That's okay.
Let's looking at something else. Too many papers here. Thank you. Yes. Here we go. I want to move into a different area if I can, and I want to draw your attention to the final report of the inquiry into the appointment of the former Prime Minister to administer multiple departments by the Honourable Virginia Bell AC, published on the 25th of November 2022. Secretary, have you got someone here that can answer some of these questions?
Senator, I may be able to assist, or my colleagues, to the extent that inquiry was supported by the department. So we provided administrative support, but we may be able to assist you with your questions.
Great. It is well known that the former Attorney General, Christian Porter, was the person who initially suggested that the former Prime Minister be sworn into the health portfolio, which was his first secret ministry. According to the Bell report, the Australian Government Solicitor was then consulted on this idea on the 9th of March 2020. The report quotes an email from Mr David Lewis, General Counsel, to the AEGD, to Mr Adam Cashin, Senior General Counsel at the AGS, stating, and I quote, "It does seem a bit like overkill, as any health portfolio minister will, under the protocol, need to consult the Prime Minister and other relevant ministers. I don't really see why we're trying to reinvent the process under the Act and usual Cabinet government, but there you are." The report also states Mr Lewis then wrote to the Secretary of the Attorney General's Department, Mr Chris Moratis, the same day, stating the idea of having the Prime Minister exercise the emergency biosecurity powers seemed unnecessary to me. Here you have a very senior officer of the Attorney General's Department, an expert in constitutional law, saying that what was being proposed would subvert usual Cabinet processes and was unnecessary. What action did the Secretary of the Attorney General's Department then take to raise these concerns with the Attorney General or the Attorney General's office?
Senator, in terms of the specific actions of the Secretary at the time, I think I would need to take it on notice, but I can check with Mr Lewis as to... I think the context of Mr Lewis's comments were in responding to a request from another department, which he can talk to. In terms of Secretary Moratis's actions at the time, I think the report goes to that, but I might ask Mr Gifford to speak to that and Mr Lewis to speak to the context.
Would you like me to start? David Lewis, General Counsel, Constitutional Office of Constitutional Law. Senator, I think it's right that we couldn't necessarily speak for all of the things that Secretary Moratis did in response to that email, which is extracted in Virginia Bell's report.
It was pretty extraordinary, wasn't it?
Well, you've read out the terms of my email, and that's what I said at the time.
Was that your email, David? Oh, sorry, Mr Lewis. I was going to say David Lewis, but Mr Lewis.
It was my email.
Right.
So have
I
you got
didn't
anything?
realise.
Sorry, had you finished your answer then, or you got more
Well, I was just going to
detail?
go on. I was just going to go on to say that the report does say, after setting out those emails of mine, Mr Moratis responded that it was his understanding that the government's strong preference was to have a senior minister exercise these powers.
Has that happened previously?
Sorry, has what happened previously?
Secret ministries.
Senator, I'm not aware whether there's been people appointed to ministries and not made public previously. As you know, this report dealt with a number of those. I guess I would have expected if there had been a previous practice of that it would have been something that was covered in the report.
Yeah, it's probably covered there. Did the Secretary at the time raise concerns with the Prime Minister's office or the PM&C? And if they didn't, why not?
Again, Senator, I don't think I could speak to why the Secretary did or didn't do anything the Secretary did, but you may be aware that the report then goes on in paragraph 124 to say it does not appear that Mr Lewis's view that the appointment of Mr Morrison to administer the Department of Health was unnecessary was conveyed to PM&C or the PMO.
So on page 43 of the report, it states the PM&C concluded that the Attorney General's Department was another portfolio which should be considered for additional ministerial appointments. Was this position ever conveyed to the Attorney General's Department?
Not that I can recollect, Senator, but I don't have that page of the report with me, I'm sorry.
So would you be able to come back to us if you can add something further to that today? So,
Of course, sorry, can I just ask again, what was that precise question?
yeah, on page 43 of the report, it states that PM&C concluded that the Attorney General's Department was another portfolio which should be considered for additional ministerial appointments. So what I want to know is, was this position ever conveyed to the Attorney General's Department?
Not to my recollection, Senator.
Well, if we can take that on notice and if there's anything further you can add, because what we've had is a Prime Minister who could be secret ministers, but he couldn't hold a hose. It's a bit of a contrast there. Thank you, Chair.
I just have a follow. It was a statement.
Well, I think it's a statement of fact.
There's been a few statements. I just have a follow-up.
Telling the truth.
Thank you, Senators. I just have a follow-up and then I'll hand over the call. I'm sorry, Mr Lewis, I didn't realise that Senator Polly was referring to your email. Given that you did put your advice in that email and that's now been made public, I guess, through the Bell inquiry, can I ask, did you raise your concerns with anyone else?
My recollection is that I discussed those issues with, I think, 2 AGS lawyers who were involved in the matter, and then I wrote one email which is extracted there to one of those officers, and then the second email to the secretary at the time, and it's possible I copied in 1 or 2 other people to that email, but I don't recall speaking to other people about it.
Were they people in the department or were they other departments?
My recollection is they would be in Attorney General's department.
Okay, so there's at least a few people in the department that received your advice, or you raised concerns about this process.
That seems likely, yes.
Okay, and just to be clear, were you? I mean, I want to be careful in what I'm asking you here, but you've raised some pretty significant concerns. What did you take any action when you realised that those concerns hadn't been adhered to or taken into consideration, or that the conduct and the process was going to proceed anyway? I mean, it would have been pretty alarming.
Well, as is recorded in Virginia Bell's report, I don't have any independent recollection of the events at the time. Obviously, I found the emails and I've reminded myself about the emails. My recollection is that after this involvement on this day with these emails, that I didn't hear anything further about it. So I wasn't aware whether it had happened or not, whether the appointment of Mr Morrison to administer the Department of Health had happened or not.
Yep. No one was aware. I think that's the problem. Just one last question then, Mr Lewis, in terms of your advice. Was your advice sought on any other ministries? We know that the appointment for Mr Morrison to be appointed as the Minister of Health was fairly early on, but then they're essentially... I'll characterise it in this way, but the Bell inquiry is quite clear. There became a sort of series of appointments later on to other portfolios, and I just wanted to know whether your advice was sought in regards to any of those other ministries.
Not to my recollection, and I conducted searches of my documents when I was responding to the inquiry, and I couldn't locate any advice on those.
Chair, if I could just add to that. So Cameron Gifford, Chief Operating Officer of the Attorney General's Department. As the Secretary mentioned, we provided administrative support to the inquiry conducted by Ms Bell. As well as providing that administrative support, there were a range of witnesses that Ms Bell sought to interview, all of whom actively engaged with the Bell inquiry. So the report that Ms Bell has provided is a full account of the Department's engagement with any of those questions.
I guess I'm not asking about the report, and I appreciate that you provided support to that. What I'm really asking about is that we've got the General Counsel of the Attorney General's Department raising pretty significant issues about a process of appointing a second Minister of Health, and that the Bell inquiry essentially says that those concerns weren't heeded and no one listened. And I'm just wondering why that happened, and I'm asking Mr Lewis why that happened and who received his advice, so we can understand who didn't follow it. I think it's incredibly important. I mean, I know that the report itself was pretty damning of the actions of the former Prime Minister. There's a lot of people who I think can say that maybe more should have been done. So Thank you, Mr Lewis. I appreciate your concerns and you raising them. Senator Cash, you have the call.
Thank you. And if I could just return to the matter at hand, and I will table, I was pursuing a line of questioning in relation to the letter of the 25th of July 2022 from the CFMEU Construction Division to Craig Rawson, the Senior Executive Lawyer of the Australian Government Solicitor, which ultimately set out a response to the letter that Mr Rawson had provided on behalf of the ABCC in relation to Justice Snowden's costs order of the 31st of March. And I think, Mr Johnson, you stated that you ultimately did become aware of this letter.
That is correct.
Yeah, sorry, and when did you become aware of the letter?
I stated in my evidence that I wouldn't be able to recall the exact date that I became aware. I have been advised during the intervening period that the letter was provided to my team on or about the 5th of August.
On or about the 5th of August?
That's
okay,
correct.
team, on or about the 5th of August. Secretary, just very briefly, the back pocket brief that we referred to previously, have you been able to seek any instructions on that yet to return to the committee?
I'm not in a position to return to the committee yet. I have asked for an assessment.
Thank you. And just confirming then, I think I have tabled
Senator
now
Cash,
that
can I just
document.
ask you a question about the document you've sought to table? Is this something that you've obtained through FOI or through the how?
Yes, obtained through FYI, correct.
Okay.
Yeah, and that's what the department have been referring to, documents obtained through FOI, so it's on an FOI register.
We're just considering whether we can accept them. We're doing that as you go.
Yep, that's fine. And in this letter from the CFMEU to Craig Rawson, responding to, as I said, the AGS letter, that the costs that the ABCC would be seeking, the amount calculated is set out, $307,927.70, just for the benefit of the committee. The CFMEU's proposal included that the order of Justice Snowden dated the 31st of March 2022 concerning costs be set aside. So in other words, is it correct to say they did not want to pay costs as per Justice Snowden's order?
I wouldn't speculate as to the CFMEU's intention. The letter clearly
Speaks for itself. The order of the Justice Snowden be set aside.
Senator, the letter clearly sets out an offer and a counter-offer from parties to litigation.
Oh, good. So it is a counter-offer. The ABCC are basically saying there's $307,000 worth of costs, and the CFMEU come back with their counter-offer is $0, which I have to say, ironically, is actually what the Attorney-General ultimately authorised, the counter-offer of $0. One might say the Attorney-General accepted the counter-offer of the CFMEU. When did the Attorney-General's Department become aware of the request to settle this matter? I just now want to pursue, and we'll get to the settlement process ultimately. So when did the Attorney-General's Department first become aware of the request to settle this matter?
On the 29th of July,
The 29th of July. So there was some emails on the 27th of July which basically stated, we will send the significant issue settlement request directly to OLSC and the AG's office. I'm not sure who this is because it's been blanked out. Wednesday the 27th of July 2022 at 10:12 a.m. As discussed, I think it would be appropriate for you or AGS to contact OLSC and mark the email urgent. Could you just confirm, when was this matter made a significant legal matter under the Legal Services Direction?
Which matter are you referring?
This particular matter.
No, I don't mean to be...
Yep, no, this particular matter. We're not going to deviate off this matter, I promise you.
I appreciate that, Senator. There is a first instance proceeding and there is an appeal proceeding.
So which matter was the significant legal matter?
Both were reported as significant legal matters.
And can I also just table that series of emails just for the benefit of the committee, dated Wednesday the 27th of July? They've been tabled, thank you. Can you just take me through what happens when a matter is made a significant legal matter? Are there briefings or requirements for reporting to the Attorney General's Department for such agencies?
Certainly, Senator. And I wouldn't characterise it as it's a semantic on my part, but making a matter significant. A matter is significant inherently.
Yep.
So when a matter is identified as significant, the Legal Services Directions, paragraph 3.1 specifically, imposes an obligation on agencies to report that matter to the Office of Legal Services Coordination in the Attorney General's Department as soon as practicable, and then subsequently to provide updates to OLSC of meaningful developments in the matter, and we also request agencies to update on a quarterly basis if there are any changes from the previous report.
Okay. Just in terms of the email that I've tabled, were you at all aware of this email exchange at the time?
So the date of this was the Wednesday, the 27th of July?
Yeah, AG notification, LL appeal, AG notification.
Yep. So I can't see, of course, the redactions.
No, they redacted the names.
So I don't know who were the recipients of the email. I can say that I was on leave. I was on, during a period of 2022, I was on an extended period of long service leave. I believe that looks like it was probably my last week of that leave. It was the first Monday of August was my first day back at work.
Who was acting in your absence?
I'd have to take on notice in terms of the precise dates. I believe there was a number of different people at different times.
So is that email exchange likely to have been by someone in your team?
Look, I can see that there is an @ag.gov.au email address, and so therefore I assume it was someone in the department, and if it was someone in the department, it's very likely it was my team.
We just find out, and I'm happy for you to take this on notice, who it was in your department who saw that email. Ms Jones, were you aware at all of this email exchange?
No, Senator, I was not.
No. Okay, so it wasn't brought to your attention at the time?
Sorry, Senator, if I could just observe, I would like to take this on notice because the nature of this email has a couple of aspects that are contradictory. It does seem to be from somebody at an ag.gov.au email address, but it also refers to an instruction to contact OLSC, which would be unusual for
If you
OLSC.
could take that then.
Yeah, so I think
And just to find out.
I'd rather
who.
take that on notice.
Yep.
Thank you,
No,
Senator.
I've said that I wasn't happy. I was more than happy for you. So in terms of a significant issues settlement request, how does that actually occur?
So, as we've stated several times, Senator, the management of matters of legal matters are the responsibility of the relevant agency.
Yep.
The agency, so this only occurs if the matter already has been characterised as significant, of course.
Which, yes, it has.
If the agency forms its view that it thinks pursuing a settlement is appropriate, the legal services directions say that they cannot achieve a settlement, effect a settlement without the Attorney General's approval.
Yep.
So if they make a decision that they think pursuing a settlement is something they'd like to do, they would engage with my team. There is a form that they fill out which sets out relevant details. They provide that to my team.
Did you receive a significant issues settlement request, or did your team from the ABCC?
Yes, Senator. I understand that on the 29th of July 2022,
29th of July.
The ABCC provided a settlement request to my team.
Okay. Can I just go back to the 2nd of August 2022? My understanding is the AGD asked for more information from the ABCC so they could understand the parameters of the CFM MEU counteroffer, which included that they would pay the ABCC nothing. What information, are you aware of those emails?
I am aware of emails that generally fit that description. I'm not quite sure which one you're specifically referring to, Senator.
Could I ask, do you have dates of particular emails, or are you able to
Yeah, no,
provide
I will
copies?
table its document
Yeah, that would be very
7
helpful.
in my list of documents. So Monday the 1st of August, the ABCC sent an email to, unfortunately, again, it's redacted. At the very latest, we would be very grateful for a response from the OLSC by the 15th of August, depending on the Attorney-General's position. This will give the ABCC sufficient time to communicate the outcome, etc. The Significant Issues team, the Office of Legal Services Coordination, goes back. We'd be very grateful if you can provide a copy of the correspondence relating to the letter of offer by the CFMMEU. This would be very useful for us in specifically understanding the key parameters of the CFMMEU offer, which forms the basis of Council's advice. And then the ABCC ultimately come back. Thank you for your email. Not a problem. Please see attached the following, and they forward to you the letter which I've already tabled, the letter from the CFMEU dated the 25th July, a copy of the notice of discontinuance and a copy of His Honour Justice Naden's costs orders. So again, that's what I'm referring to. Now, were you back from leave then?
I was, yes.
You were. So are you aware of this email exchange?
I wasn't previously, no, Senator. It is very common. It might be helpful actually if you did invite me previously.
Yep, to take us through.
And I answered at a higher level. It might be helpful if I take you at a slightly more granular level. I have a wonderful team.
You do?
They receive settlement requests, not uncommonly, when settlement requests and associated documents are provided by an agency. My team will review it, and not uncommonly there are missing bits of information, not that the agency deliberately left anything out, but the sorts of information that we know are relevant to the consideration, whether it be consideration by the Attorney-General or by myself as delegate to consider a settlement request, the sorts of information that are helpful to inform that. My team will review that, quite often spot things that are missing, engage immediately with the agency to seek further information, and quite often I won't have the matter brought to my attention until some little time after that, until my team is confident they've got sufficient information to pull together an understanding of what's being asked and what the relevant details of the matter are. And I expect that's what the email exchange would have been in respect of.
Would the discussions with the Attorney-General's office have commenced at this stage, considering the Attorney-General's office has now been notified?
I'm sorry, Senator?
Will discussions with the Attorney-General's office have commenced at this stage?
What I can say, Senator, I do know, in reviewing material ahead of today, even though I was on leave on the day, when the settlement request came through from the ABCC, my team did provide a copy of that settlement request, just forwarded it on to the Attorney-General's office for their visibility. That's not uncommon, and I would also observe at that time we were in the early months, if not weeks, of a new government, and so we're providing early visibility of these sorts of matters, so we pass that on, I understand, by way of email.
Did anyone in your team speak to the Attorney-General or his office at that time in relation to this?
I understand that there was a conversation following the email. So I believe the course of events was the ABCC sent an email to my team. Mm-hmm. My team sent the settlement request to the Attorney-General's office. I understand that following that, on the same day, there was a conversation between the advisor and an officer in my team to simply thank them for providing it and to say we I don't know the exact words, but look forward to the submission being provided, a nicety, if you will.
Could I get or would you be kind enough to table for the committee the email that you referred to, forwarding to the Attorney General's office the settlement request?
I'll take that on notice. Thank you, Senator.
Can I just confirm, though, that email you said was on the 29th of July? Is that correct?
That is correct.
So the Attorney General's office were first aware of the settlement request on the 29th of July, because, as you said, you had a nicety exchange of emails.
That's correct, Senator.
In terms of your knowledge, what was your knowledge of the matter at this time?
On the 29th of July, I'm probably very pleased to say I had little to no knowledge because I was still on a very enjoyable period of leave. So on that date, I had no knowledge of the
You had
matter.
no knowledge. When did you first obtain knowledge then of this matter?
The precise date, I'm not sure I would be able to narrow down. I expect it would have been very soon in the following week, which was my first week back at work.
Okay. Ms Jones, were you aware that the Attorney General's office were first made aware of the settlement request on the 29th of July?
No, Senator.
You weren't aware, okay. Were you made aware of the settlement request?
No, Senator, I do not believe I was advised on that request.
Okay. Should you have been told of the request?
Senator, I think as I've previously explained, there are a large number. I couldn't say off the top of my head, but I could take on notice the number of settlement requests that the Office of Legal Services Coordination need to administer through the course of a year. I would suggest it's in the hundreds, but Mr Johnson might correct me on that, but I'll take that on notice anyway. I don't want to speculate, but on this one in particular, it was not drawn to my attention.
That's okay. In taking that on notice, could you also separate out those that are part of significant legal issues briefs?
Yes.
Yep. Thank you very much. Could I now table a document dated Friday the 5th of August 2022? It is an email that was sent by the ABCC to AGD with the additional information and an updated settlement request form. Were you aware of that email, Mr Johnson?
I am currently aware of that email.
But at the
Senator.
time you were not aware because you were on leave?
No, I was not on leave at that time, 5th of August, but I don't recall immediately being aware of it. Again, I expect it was something that was managed by my team. I have reviewed the email prior to today, and so I'm familiar with what it looks like has happened is that the ABCC submitted a settlement request on the 29th of July. I expect in light of some of the back and forth between my team and inquiring of some of the details, the ABCC realised there were some errors and some incomplete aspects in its settlement request. And it's on the 5th of August appears to have submitted a revised settlement request to my team.
Yep. Can you confirm you have the email in front of you?
I
that
do.
is part of the additional information being provided. The ABCC confirmed that Council provided advice to the ABCC via AGS, confirming that it is open to the ABC Commissioner to seek to negotiate that the CFMMEU pay at least part of the ABCC's costs in the first instance.
There are words to that effect in the email.
Ms Jones, were you made aware of this email exchange?
No, Senator.
Okay. Was the Attorney General's office briefed in relation to this email exchange?
I don't know the answer to that, Senator. I expect it would be unlikely the office would be briefed specifically on this email exchange. As I've already stated, it's not just a common feature, it's almost universally present feature that when my team receives a settlement request, my team reviews it, there is almost always incomplete information And again, not a criticism of agencies. We look for a different thing than they look for. And my team spend several days engaging with the agency to request further information. The substance of that email and all the other emails and all the documents provided by the ABCC would have informed the product we prepared for the Attorney-General, but I expect we would not have briefed the Attorney-General on the existence of this email.
Do you normally speak to the Attorney-General's office about matters like these, or is that left to members of your team?
It varies, Senator. I am probably the predominant person in my team if a discussion is to be had with the Attorney's office other than a departmental liaison officer. I am the predominant person to have those conversations, but we wouldn't... The level of conversation and the type of conversations that we have would vary from matter to matter.
When did you first speak to the Attorney-General or his office in relation to the settlement request form?
I would have to take that on notice, Senator.
Is there a reason you need to take it on notice?
I can't recall the conversations that I had. I may not have had conversations with the office in respect of this matter. There were certainly some email exchanges between my team and the office, and between me and the office. As I said, we gave early visibility of the settlement request.
Did you ever speak to the Attorney-General or his office about this matter?
I expect I would have at some point during the course of the process, Senator.
Could you please take on notice to provide to the committee the times and dates that you spoke to the Attorney-General or his office in relation to this matter, or that members of your team spoke to the Attorney-General or his office in relation to this matter?
Certainly, Senator.
Ms Jones, have you ever had a conversation?
Senator Cash, can I just, I've given you a fair block of questions. I just want to draw your attention to the time. We're actually in the part of the program now where we should have been asking the questions under this particular outcome. It is my intention to try to keep to the program as much as possible today. For a number of reasons, not only the fact that we have a number of agencies that we need to get to, as you would be fully aware, the Attorney-General's Department has a lot of content that we need to get to, but it is not just opposition senators but also crossbench senators who've requested this time as part of the program, which was agreed to by committee members. I just want to draw your attention to the time. I'm happy to keep giving you the call unless another senator has questions for cross-portfolio, but we are going to get to a point where we need to wrap up.
Are you happy for me to continue asking
Yes,
questions?
that's what I was saying.
Ms Jones, have you ever spoken to the Attorney-General or his office in relation to this matter?
Senator, I did not discuss this matter directly with the Attorney-General in the lead up to or at the time of the decision of around the settlement. I have subsequently...
His office, you said directly with the Attorney-General.
Yep.
Did you have any discussions with his office?
No, I did not. Subsequent to the settlement, in passing, the Attorney and I have had a discussion about the matter, but that was several months beyond the time of the decision and beyond last estimates.
Could you provide the committee with the date upon which you had that discussion with the Attorney-General?
I'll take that on notice, Senator.
Thank you. Could I now go to the significant issue settlement request, which was filled out by the ABCC, and I will table that document. That is document number 9 in my list of documents. So this is a significant issue settlement request template. So the ABCC has been working through the AGS in terms of the settlement request template. It then dates the 5th of August 2022, puts forward a significant issue settlement request template. The matter's name, the CFMMEU, the Australian Building and Construction Commission. The entity is the Australian Building and Construction Commission as the respondent. The court is obviously the Federal Court of Australia. It then sets out the background to the matter, but in particular it states reasons advanced for the settlement of this claim, and it confirms that they have received advice from counsel. It then states this: the CFMEU offer is predicated on the previous costs order being vacated. And as we know, I've tabled the counter-offer from the CFMEU, which was they would not pay any of the costs that had been awarded by Justice Snowden. It then says this: the ABC Commissioner defers to the Attorney-General on this question and whether it would be appropriate to compromise the Commonwealth's entitlement to costs. They then go on to explain the counter-offer is structured to apply our discount of at least 50% of the costs, and you recall their original offer was 75%. So when the ABC Commissioner says the ABC Commissioner defers to the Attorney-General on this question and whether it would be appropriate to compromise the Commonwealth's entitlement to costs, does that ultimately mean that the Attorney-General will make a decision? The ABC is not making the decision there.
I couldn't put myself into the Commissioner's shoes, Senator, to say what he had in mind when he wrote that. What I can say is that in this settlement request, the ABCC put forward terms that they sought the Attorney's approval on. My plain language reading of that language that you've read out, Senator, is that the ABCC has acknowledged a couple of things. They've acknowledged that they're not able to settle the matter without the Attorney-General's approval as required by the Legal Services directions.
Can we just pursue, and that's the bit I just want to pursue there.
Yep,
because it is a significant issue, the ABCC can only put forward its request for settlement and the terms upon which it would like to settle, but it is the Attorney-General who can then authorise the terms of the settlement.
As set out in the Legal Services directions, Senator, an agency cannot settle a matter without the approval of the Attorney-General. So that means any terms that an agency may put forward
have
in a
to be
settlement offer
agreed to by the
approved by
Attorney-General of Australia.
The agency, I think it's a really important nuance, however, to make clear that the agency is free not to settle. They don't need the Attorney's approval not to settle. They simply need the Attorney's approval to settle.
It's great that you can be so nuanced, but misremember the important details on the 7th of November 2022.
Senator, I don't think that's fair.
I'll just take that as a
fair at all.
comment, Ms Jones. So the settlement terms included now that the order by Justice Snowden dated the 31st of March 2022 be paid by the CFMEU at an amount of at least $100,000. So the total costs were in excess of $410,000. The original offer was around $307,000. And now they've come back with what they consider to be reasonable of an amount of at least $100,000, noting that the ABCC will initially seek to have the payment of costs at or close to the amount of $150,000. And in accordance with the legal practice and principle, I assume that this is in response to a question that has been asked. Yes, we confirm we have received advice from counsel that our proposed counter-offer is in accordance with proper legal principle and practice and the ABCC's obligation more broadly under the Legal Services Directions 2017. Mr Johnson, when were you first made aware of this settlement request?
Again, Senator, I likely would not be able to say the precise date.
On or about's fine.
The original settlement request was provided on the 29th of July to my team. This settlement request, which had some amendments but was largely in the same terms, was provided on the 5th of August. I would have been made aware of this particular version not long after the 5th of August.
Okay. Ms Jones, when were you made aware of the significant issues settlement request template dated the 5th of August 2022?
So, Senator, that was not brought to my attention.
This was not brought to your attention?
No. And I think, as I've said previously, in the context that settlement matters like this are quite common, they're dealt with within the branch, and this was not raised with me.
Settlement like this is quite common.
Well, no, I said settlements. So requests for approval for settlements. Obviously, there's a large number that we deal with each year.
With terms that include that the ABC Commissioner or a question, the ABC Commissioner defers to the Attorney-General on this question and whether it would be appropriate to compromise the Commonwealth's entitlements to costs. Given the issues that were so eloquently raised by Senator Carr previously, Scar, in relation to the massive financial donations made by the CFMEU to the Australian Labor Party, in particular the comments of the High Court in the Patterson decision, the fact that you have an agency that's now saying it will defer to the Attorney-General of Australia on the question and whether it would be appropriate to compromise the Commonwealth's entitlement to costs. So I assume that means we should go after costs, but it's the Attorney-General who's going to decide whether or not the taxpayer gets its money back. This was not brought to your attention.
So, Senator, as I've previously said, there is a large number of settlement matters. Also, we have a strong process of assessing settlement applications consistent with the legal services directions and the requirement for it to follow good legal practice. So there is a sound process that goes around the assessment of these matters and any briefing of the attorney that goes with that. It was not. I think that the team considered the matter in the context of many of these matters that they deal with through the course of a year.
Can I just ask, if the Attorney-General felt that he had a conflict in this matter, given that he's a member of the government, he's a member of the Australian Labor Party, they receive large amounts of money, last financial year in excess of 4.3 million directly from the CFMEU, could he have delegated this to the department to make a decision?
Completely reject the assertions you're making there, Senator
facts.
Cash. Completely
They're
reject
facts.
that they have any impact on the Attorney-General whatsoever in
They're
his role. He
facts.
takes his job very seriously as Attorney-General, and
Highly respected.
he conducts himself accordingly. So that is a completely outrageous assertion that you're making there.
It's 11:27 and it's the first time that you've actually piped up to defend the Attorney-General. Can I just go back to, if the Attorney-General felt he had a
Because there hasn't
conflict
been
of
a need
interest
previously,
in this
Senator
matter,
Cash.
could he have delegated it to the department to make a decision?
I'll get Mr Johnson to talk to it, but I think, as you would be aware, Senator Cash, in terms of your former responsibilities, some decisions are delegated to the department.
Yep. And I just want to confirm, or if there's a perceived conflict of interest.
What I would say, Senator, is the handling of the matter in that respect would be a matter for the Attorney-General. As you know, Senator, there is a delegation in place that allows settlement requests to be considered by officers in the department. But as you also know, Senator, Attorneys General, a series of Attorneys General do consider settlement requests personally, notwithstanding that delegation.
Interesting. So, is there a delegation in place in relation to these particular matters?
I'm sorry?
Senator, what do you mean by particular matters?
Well, settlements.
Yes, Senator, as I just said.
So I just want to confirm that I'm not going to verbal you in any way.
Yes, there's
Yes.
a power under paragraph 3.2 of the Legal Services Directions to approve settlement. and that power has been delegated to officers in the department.
Could I get you, on notice, it's fine, to table a copy of the delegation?
Certainly.
Yep, thank you very much. So just to confirm, should the Attorney-General have so wished, he could have delegated this matter to the department for any reason. He had a conflict of interest, they received he could have delegated this matter to the department.
Well, Senator, without accepting the premise, but there is the fact that a delegation is in place and it is possible.
Yep.
Without accepting
No, but he could
your
have
arguments
delegated
as to why it might happen.
Yeah, he could have delegated it to the department, is what I'm saying.
Well, there are circumstances where that does happen.
Yes. So, how many settlement decisions have come before the Attorney-General or before the department since the government was elected?
We'd need to take that on notice.
That's fine.
Senator?
Can you also confirm for me how many of the decisions have been authorised by the Attorney-General?
We can take that on notice.
You can take that on notice. Any indications on the top of your head, or you'll take that on notice, I'm assuming?
I'm not going to hazard a guess.
Then that's fine. Just confirming on this particular one, the Attorney-General did not delegate it to the department?
That's correct.
Correct. He could have, should he have chosen to, delegated it to the department? That's the evidence of the committee, yes. But he made the decision personally in terms of the settlement terms that were ultimately proposed.
Senator Catherine Haigh, First Assistant Secretary, Legal Services and Royal Commissions Division. I can assist you with that question. The settlement approval was considered in accordance with the provisions of the Legal Services Direction, in particular the principle that the Entity Act, in accordance with legal practice and principle, as that phrase is further expanded in Appendix C of the Legal Services Directions, which sets out a number of criteria to be taken into account when settlement requests are being considered.
Senator Cash, can I get an indication from you in terms of timing of questions that you are not able to put on notice? You were
around another half an hour.
Well, you were aware of the program when we started the day.
And as you stated, we're now really in.
No, we are behind, and we are severely behind. And you are not the only, and you're not the only senator that has requested opportunity to ask questions. We will need to get to the first outcome that we need to deal with, which we are now very far behind. I'm going to, respect for our fellow senators. I think if you've got some more questions that can't be put on notice,
and they can't. It could have been pursued last time, as we know, but there was a misunderstanding or some misinformation, which has been cleaned up. But that has now obviously meant that there are questions today which need to be answered.
You had full opportunity to come and discuss with the committee prior to today your intentions to ask questions. You didn't do that. We have given you a bit of leniency about where those questions are, so you could ask them in the cross-portfolio. If we need to suspend to have a private hearing to talk about the program, we can do that.
And I've said I have approximately 30 minutes
you
left.
have some crossbench. There are crossbench senators who have questions, who they want to ask those questions in outcomes. They are working across different committees. I'd encourage you to get your questions asked in a very short amount of time so we can move on.
And as I said, these are very important questions. It goes to the integrity of the Attorney-General and the decision-making process.
We're not debating whether the questions are of any use. That's a matter of opinion, which I do not agree with. But what I'm saying to you is you're entitled to ask these questions. What you should do, though, is have some consideration from the program, the officials in front of you who have come prepared to answer questions on other matters, and the crossbench senators who have requested time, which you are now preventing them from having. Please consider that as you ask your questions, and I draw you to the time.
Yep. Thank you very much, Chair. If I could now go to then an email which I'll table at document 11. It is from, first dated the 19th of August. Dear, the name has been blanked out. It's from the ABCC to the department. Further to our email last Friday, just wanted to check in and see whether there is any update regarding the Attorney-General's decision for settlement on the above matter. And then on Friday the 19th of August, someone from the AG's department sends a message back. Thank you for your email. ABCC's settlement request has progressed to the Attorney-General's office for deliberation and we are expecting a response soon. Can I ask, on what date was the Attorney-General provided with the brief in relation to the decision on the settlement?
I believe I've already answered that, Senator. It was on the 9th of August 2022 that a written submission was provided to the Attorney-General regarding the proposed settlement.
Thank you. And from the 9th of August, were there any discussions with by the department or the Attorney-General and his office in relation to the settlement issue?
No discussions were had with the Attorney-General, Senator.
Discussions with his office?
Yep, I've already taken on notice, Senator, about the details or the dates, I believe, of any discussions between my team or myself with the Attorney's office.
Who signed off on the brief that went to the Attorney-General?
So the submission, Senator, was cleared by myself as Assistant Secretary. It was also cleared by the then First Assistant Secretary, so my boss, who was Tony Pirani.
And Secretary, did you have any oversight of this particular brief?
That brief did not come to me for clearance.
It did not come to you for clearance? No. Okay. On what date did the Attorney-General provide instructions to the department in relation to the terms of the settlement?
Senator, the Attorney approved the settlement submission, so signed the settlement submission on the 8th of September 2022.
The 8th of September. And can you confirm that that was advised to the ABCC and the AGS?
Yes, Senator, it is correct that my team, following receiving the information that the Attorney had signed it, conveyed to the ABCC and copied in AGS because they were the representatives for the ABCC to convey the fact that the Attorney had approved the settlement. That's the normal course. They can't effect the approval if we don't communicate it to them. That's
Exactly.
the entire
and I
normal
will
course.
table the email of Thursday the 8th of September 2022 at document 12. Dear ABCC and AGS colleagues, I refer to the settlement request for the matter of the CFMEU re ABCC and ORS. Just to confirm, the Attorney-General has now considered the request, so he has considered the settlement request put forward by the ABCC and has approved under paragraph 3.2 of the Legal Services Directions the ABCC seeking to settle the matter on the following terms: the appeal proceedings be discontinued, there be no order as to costs in the appeal proceedings, and the ABCC does not enforce the Federal Court cost order dated the 31st of March 2022. Do you recall that email, Mr Johnson?
I do, Senator. I'm copied into that email,
Yep.
Senator.
Did you settle that email?
I did not settle it, Senator. My team is quite competent to take the terms of what was conveyed to us and convey that to the agency.
Ms Jones, are you aware or were you aware at the time of this email?
No, I wasn't, Senator.
Okay. Was it brought to your attention at any time?
No, Senator.
Okay, that's fine. Just in terms of the actual cost, the actual settlement request itself, can I confirm that the Attorney-General did not accept the terms put forward by the ABCC?
Senator, I've previously stated today that the terms that the attorney approved in the settlement submission were different from the terms that the ABCC put forward in its proposal.
Senator Cash, can I just clarify something that I've just said? You said, were you ever aware of that email? I was not aware at the time, but in the course of considering a response to your letter to me of last week, then I became aware of that email. So I just wanted to make sure that it's clear that I had seen that email prior to today's hearing, but that was in the context of considering a response to your letter to me of last week.
Okay, so not at the time, but in response to the email of last week.
Your letter.
My letter.
Your letter to me of last week, and considering how I would respond to that. So today is not the first time I've laid my eyes on it, but it was last week was the first time.
Again, given the issues that Senator Scarr raised at the outset of today's hearing, have you given any direction to anyone in the department in relation to keeping you informed going forward of these types of matters?
Senator, I have a lot of confidence in the team, both the Deputy Secretary, the First Assistant Secretary and the Assistant Secretary. They have a strong sense of matters that should be brought to my attention, and I have every confidence that they do that appropriately.
Okay. So that didn't unfortunately answer my question. Have you had any discussions with anyone in your department, including Mr Johnson, in relation to the way this matter was handled and whether or not it should have been brought to your attention at any time along the way?
No.
You haven't, okay. Do you think you should have been told, given the significance of this issue, and in particular given that the Attorney-General was effectively, as I've stated and as Senator Carr has stated, this is a significant decision. The Attorney-General of Australia has signed off on a submission overriding a government agency on a settlement request.
Well, that's not a correct way to characterise it.
It
was the ABCC that ended up putting forward the submission that the Attorney-General ended up signing off on. So that is not a correct characterisation of events.
Well, it is a correct. It signed off on a submission that did not accept the terms that the ABCC put forward, which was to enforce a costs order from Justice Snowden that it was entitled to enforce to the tune of, in this case, it was around $150,000, a significant compromise on the in excess of $400,000. The Attorney-General did not excuse himself from this matter.
Senator Cash, as most people you have a way of characterising this. The Minister doesn't agree. You don't need to have a debate about this, about your positions, because I think that's fairly clear. But he's entitled to correct you if you have misstated something. He's done that. Can you go to your questions, because you are running desperately out of time to be able to deal with this matter in the room?
Well, I'm going to disagree with the Minister's characterisation of what I said. The ABCC... I'm saying that doesn't... If you have questions to ask, you should put them. But if you want to have a debate in the chamber, which I'm sure you'll do on many occasions, about the union movement, we can do that in the Senate chamber. What you should do is put your questions to the officials if you need to ask them, so we can move on. Well, then I will just merely clarify to ensure that
You're not giving evidence, though, is what I'm saying. You should put a question if you have a question to ask. That's what estimates is for.
The significant legal settlement request that was put forward by the ABCC that was ultimately given to the Attorney-General, who determined that he would be the person to oversee this brief. They had, in that particular brief, said they defer to the Attorney-General on the question of whether it would be appropriate to compromise the Commonwealth's entitlement to costs. The Attorney-General, I can only see, decided it was appropriate to actually compromise the taxpayer.
Do you have a question, Senator Cash?
Yes, I'm just confirming I've understood the difference in the terms.
Do you have a question?
I do. As I said, I'm just trying to clarify what the actual terms are. That was not accepted by the Attorney-General. The Attorney-General ultimately put forward the appeal proceedings be discontinued, there be no order as to costs in the appeal proceedings, and the ABCC does not enforce the federal cost quarter dated the 31st of March 2020.
That was put forward by the ABCC.
It is a government agency.
No, Senator Cash.
I understand that, but that was put forward
Minister,
by the
can you just give me a moment to respond? Senator Cash, if you insist on asking questions with lengthy preambles, with a lot of content, the Minister is entitled to respond, to answer your question, to refute the basis of your question, to do that in a way that gives him the opportunity. Senator Cash, I know you're not showing a lot of respect for this committee. If you could show a bit of respect for the chair while I'm speaking. Please don't interrupt the Minister when he's responding. You've had a chance. Please let the other people on the other side of the table have their opportunity. Minister, I'll go to you, and then if the Secretary needs to answer the questions, she can.
And the point I was making, it was the ABCC that put forward that submission. As Mr Johnson said earlier, the ABCC had the option, I presume, to not pursue the cost order or settlement, but they chose to after taking on that advice.
Well, so, hold on. Well, this opens up a whole new line of questioning now, Senator Chisholm. Are you saying that a government agency that expends taxpayers' funds when it has a costs order made by the Federal Court of Australia in favour of the Australian taxpayer ultimately should not pursue it? Is that what you're saying?
Well, I'm saying that, as Mr Johnson inferred earlier, that was an option for the ABCC.
So hold on, I've just got to understand this. Are you saying that, in your opinion, as the Minister sitting at the table, if a government agency that expends money on behalf of the Australian taxpayer wins a court case, has a federal court judge issue a costs order in its favour, it writes a letter to the person that the costs order is made against, in this case the CFMMEU, clearly sets out, we incurred in excess of $410,000, we'll compromise and accept just over $300,000, but ultimately, in the submission to be reasonable, says we'll actually accept $150,000 after seeking counsel's advice that it was able to do this. Are you saying a government agency, regardless of whether or not it is the ABCC, should not pursue a costs order made in its favour?
I was merely reflecting what the evidence that Mr Johnson gave earlier. The reality is that the ABCC chose to settle. The attorney agreed to their settlement request.
Oh. Did the Attorney-General of Australia agree to the terms of settlement put forward by the Australian Building and Construction Commission?
Ultimately, that's how it was resolved, yes.
No. Yes or no? Did the Attorney-General of Australia, you've opened this line of questioning up,
sure.
Did the Attorney-General of Australia agree to the terms of settlement as put forward by the Australian Building and Construction Commission?
Well, ultimately, yes, that's how it was settled.
Well, we're going to be here all day if this is the answers that you are giving. So we're going to go back to have a look at, if you could have a look at the settlement request form that was put in place by the ABCC. It clearly states the CFMEU offer is predicated on the previous costs order being vacated. Just to remind you, Senator Chisholm, the CFMEU said we're not giving back $1 of money expended by the Australian taxpayer which is consistent with the Patterson decision as a recidivist offender. Cost of doing business. They could have paid this money over in 2 seconds. They chose not to. It says here the ABC Commissioner defers to the Attorney-General on this question and whether it would be appropriate to compromise the Commonwealth's entitlement to costs. Lo and behold, the Attorney-General of Australia accepts a CFMME offer and compromises the Australian taxpayer's position in relation to costs. So can I ask you again, is your evidence that a government agency that expends taxpayers' money, that has a valid costs order made in its favour by a federal court judge, are you saying they should not pursue this?
I know you want to try and build to a big crescendo, Senator Cash, after wasting a couple of hours on this morning. I was merely reflecting the evidence of Mr Johnson earlier about the options.
Don't blame an official and throw them under the bus.
Senator Cash,
this is your
Senator
evidence,
Cash.
Minister Chisholm.
Senator
The
Cash.
reality is the ABCC chose to settle. The attorney agreed to their request to settle. These issues have been canvassed by this committee and department previously. I've got nothing further to add.
Well, you are actually misleading the committee by stating that the Attorney-General of Australia agreed to the terms of settlement because he did not. Mr Johnson, can I ask you, in the brief, did you recommend that the government accept $0 on behalf of the Australian taxpayer?
Senator, the department wouldn't ordinarily reveal the detail of advice that we give to the Attorney General.
You've released legal advice before. There was a line of questioning pursued by Senator Polley earlier, and legal advice in that matter, I'm assuming for political reasons, was released by the government.
Sorry,
So
which
are you
matter,
saying
was that, Senator?
the ministry issued the legal
It was
advice?
the Bell inquiry.
The legal
Are you
advice was
mischaracterising the
released
Bell inquiry
by
now?
the government.
Extraordinary. Like,
Are you saying that you will not release that advice, advice you gave to the Attorney General?
We would need to take that on notice and consider it as to whether or not we would make a claim.
In relation to the legal advice that was released pursuant to the line of questioning in the Bell inquiry, did you provide a brief to either the Attorney General or the Prime Minister or any other government minister in relation to the release of that advice?
I'd need to take that on notice, Senator.
Seriously?
Yeah,
You didn't provide...
I would need to take that on notice.
Mr Johnson, were you in any way involved in a brief being provided to the Attorney General, the Prime Minister or any other minister in relation to the release of the legal advice?
That matter wasn't managed by my team, Senator.
Ms Jones, who was that matter managed by?
Well, we provided administrative support to that. Senator, before we move to that, I want to clarify some information that I provided to you. I want to make sure I can do it now before we move off from this line of questioning. So it's been brought to my attention that when the settlement request that was received from the ABCC on the 29th of July, when that was forwarded to the Attorney General's office, and I think Mr Johnson has given evidence to that effect, I was in fact CC'd when that was sent to the Attorney General's office.
So you were CC'd. Did you read it at the time?
I don't recall. I don't believe I did, Senator. But I amongst several people, was CC'd by the Acting Assistant Secretary at the time.
So you were aware of the settlement request?
Well, I certainly was copied in on the notice that settlement request had been received and gone up to the Attorney's office, and I need to make sure that that's clear on the record here.
So your evidence was that you knew nothing about the matter on the 29th of July. Is your evidence now that you did know something about the matter on the 29th of July?
Senator, I genuinely do not recollect that email or reading it, but I was CC'd.
Okay. Did anyone from your office bring this email to your attention?
Not that I recall, but I have been advised in the course of the last 15 minutes. And my one other point that I would make is that I generally receive what we call drop copies of any submission that goes up to the department, and I tend to review them on a block, and I may have reviewed the drop copy that went up to the Attorney's office.
Can I just interrupt and seek clarification from the Chair, please? Are we going to continue on to the lunch break with this outcome before we actually try and move to something else?
About half an hour ago, Senator Cass said she had about half an hour of questions, so I'm hoping she will be drawing to a close very shortly. I've reminded Senator Cash that there are many senators with many questions for many outcomes, and we will be having a private meeting at lunch to deal with the program.
Can I just on that, and Chair, with all due respect, Mr Dreyfus is the Attorney-General,
Yes, he
is on the record time and time again as stating, and I'll read out one of his quotes, "The Albanese government is committed to restoring public trust and strengthening standards of integrity in our federal government.
That's right.
Open
For a very
access
good
to
reason after the
information
Morrison
is
government.
essential for good
Very
decision
good
making,
reason.
genuine engagement in democratic government and combating corruption." So I would have thought a
Senator
line
Cash-
of questioning in relation
Senator
to
Cash,
the
I'm
Attorney
speaking
General
and I'm the
signing
chair.
off.
Senator Cash, please don't interrupt me. You've had the better part of the morning, hours and hours of transparency and opportunity, and all of your questions have been answered or taken on notice in the usual way. I'd say that the officials at the table are being very transparent, open and accountable. And if you want to have your questions answered, I'd encourage you to put them to them quickly so we can get to the other questions that your colleagues and your crossbench Senate colleagues also want to ask.
If others have questions in this outcome, I'm more than happy to refer to them and then come back. That's fine.
That's not what I'm asking, Senator. You're aware of that. If you have a question, please put it.
The settlement request brief, which I tabled, said the ABC Commissioner defers to the Attorney-General on this question and whether it would be appropriate to compromise the Commonwealth's entitlement to costs. Mr Johnson, was a brief put together for the Attorney-General in relation to the settlement?
Senator, I believe this will probably be the third or fourth time I've answered this
So
question.
this is the brief of...
Submission, Senator, was prepared and provided to the Attorney-General to support his decision on the requested settlement that was put forward by the ABCC.
Ms Jones, can I just confirm again that despite everything that's been raised today, you have not had any discussions with the department in relation to putting in place better processes going forward to ensure that you are kept appraised, in particular of matters like this, where the Attorney-General does not accept the terms of settlement put forward by an agency, in particular when it comes to compromising the taxpayer's position on costs?
I don't think you could say this compromised the taxpayer's position on cost, Senator Cash. That is not an accurate reflection.
Well, it's an accurate reflection of what the ABCC put into their settlement
Well,
request.
you don't know that, what they were
Well, I
meaning
do.
when they put that
I have it
in
in
their
writing.
settlement.
It's in writing.
That's your interpretation of what they've said.
Well, how can it be my interpretation when it's the exact words that the ABCC said?
Well, that's not necessarily what the interpretation would be. You're just trying to assert that that is the case.
No, it's in black and white.
Well, I
Senator
disagree.
Chisholm, it's in black and white. Sorry, Secretary, have you put in place, just confirming you haven't put in place any processes going forward?
Senator, I'd repeat what I said earlier. I think all officers in the department have a strong sense of those matters that should be brought to my attention. I reiterate that this settlement was one of many, and I have taken on notice to come back to you with the volume of settlement requests that come through to the department each year. I think the relevant officers have a good sense of what should be raised with me, and I will continue to have confidence that they will do that into the future.
Can I just take you through the schedule of documents that were not released by the department in relation to the Freedom of Information request FOI 22-316, and I will just have that distributed. Basically, in relation to the majority of them, the email from the ABCC to the OLSC, the initial settlement request, an email from OLSC to ABCC confirming receipt, refuse access, email from the OLSC to Industrial Relations Group, Minister Burke's group, consulting on the settlement request, refuse access, email correspondence between OLSC and AGO flagging forthcoming settlement submission, refuse access, email from ABCC to OLSC containing revised settlement request and information, refuse access, email from OLSC officers to officers of AGD senior executives, refuse access, email from the Secretary's office on the 6th of the 8th, 2022 to OLSC regarding clearances, refuse access, PDMS record of MS 22001069 submission from OLSC to the Attorney General on the settlement proceedings dated the 9th of August 2022, refuse access. 10th of August 2022, email from AGS to OLSC in relation to a meeting to discuss the appeal, refuse access. Email from OLSC to AGO DLO following up on submission, refuse access. Email from OLSC to AGO DLO following up on submission, refuse access. Email from AGS to OLSC regarding federal court order and settlement decision deadline, refuse access. It goes on and on and on. Email from DLO to OLSC advising submission had been signed on the 8th of September, refuse access. Email from AGS to OLSC advising of discontinuance, refuse access. Email from AGO to OLSC acknowledging upcoming settlement request, refuse access. It goes on and on and on. Attachment to document 72, significant issues report, refuse access. So I'm confirming I didn't get any of those documents. In light of the comments of the Attorney-General, and in particular, the Albanese government is committed to restoring public trust and strengthening standards of integrity in our federal government. Open access to information is essential for good decision-making, genuine engagement in democratic government and combating corruption. Can I just ask you to take on notice and reconsider whether or not any of those documents can actually be provided?
Senator, I can take that on notice. I would say that normal principles were applied in relation to the consideration of that FOI request, particularly as it relates to matters that raise legal professional privilege and other issues, but I am happy to take that on notice.
Thank you. And I'll just also then, for the record, it was actually the Attorney-General of Australia in relation to FOI who said this: the government strongly supports the effective operation of the FOI Act to ensure that it continues to meet the objectives of increasing scrutiny of the government's activities, developing further the quality of political democracy by giving the opportunity to all Australians to participate fully in the political process, improving the quality of decision-making by government, enabling individuals to have access to information about them that is held on files. I just have a series of questions, Chair, in relation to the model litigant rules, but I do know that there are some other senators who have cross-portfolio questions.
I don't think those are relevant to cross-portfolio, unfortunately.
I will continue with those questions when they arise. Then it's in relation to the same matter, so we can pursue it at another time.
Yep, we can pursue it at another time.
Chair, just to assist with the intent of assisting the committee manage the business, and I know we're going to have a discussion with respect to the program. With your indulgence, I'd just like to check whether or not certain matters are within cross-portfolio or in another outcome. If they're another outcome, I'll quickly move on. I just want to check that. I just don't want to lose the officers in terms of the cross-portfolio.
Secretary.
So, Secretary, in terms of savings from external labour and savings from advertising, travel and legal expenses, is that something in the cross-portfolio or somewhere else?
We had expected that if there were to be questions on that, that would be under Enabling Services Group.
Which is?
So that's currently scheduled for 2:15 p.m.
Okay, so I'll hold that to there.
Yep.
Hikvision and Daewoo devices and issues relating to that.
Again, in that same group.
Thank you. This is very good. Clarification of responsibility for determinations around bail of federal offenders.
That would be in the National Security Criminal Justice Group.
Okay. And I think we checked questions in relation to the voice would be in the next section.
Next group, yes.
Okay. And just some clarification again, just to assist me to assist the chair. In relation to questions on the review into the AAT or the replacement of the AAT, we obviously have a block with the AAT. Is it going to be more convenient for the department for me to raise questions in relation to the proposed restructure of the AAT or replacement of the AAT at that time, or were you expecting me to raise those questions somewhere else?
We have questions on that as well, and the intention was to raise them during the AAT session if we get to it today.
I'm happy to be guided. We could be available.
I'm happy to do that, Chair.
Either we had anticipated it would be when the next group is on, but equally we can answer them when the AAT is on.
I'm happy to hold it over to the AAT if that was your intention, Chair. And sorry to, this is very helpful for me, hopefully for everyone. In relation to the Australian Law Reform Commission, and in particular its analysis in relation to discrimination laws and religious freedom, I asked some questions during the last inquiry in relation to the selection process for the Commissioner. I also have some questions in relation to their consultation paper. How is it most convenient to deal with those? Just with the Australian Law Reform Commission, can we deal with those questions all in that block?
Yes.
I think when the Integrity and International Group is on, so that's the group after the next one, they have responsibility in relation to supporting the ALRC and should be able to assist you then.
Okay, thank you. That's it.
Senator Cash, do you have any more questions for this outcome?
I will just defer to other senators at this point, but I should
I'm
wrap up
asking you
very
if you
shortly.
have any more questions on this outcome.
I do, but they won't take long, and I know there are other senators who have questions.
Chair, Senator
I'm more than
McKenzie
happy
had
to.
a very short question that she wanted to put to the Secretary. I wasn't sure which area, in good faith,
Hand on heart.
which area it falls within.
As you said, Sue, it's your call.
So it might be convenient if we can just deal with that quickly.
Senator McKenzie, do you need guidance on whether that is genuinely cross-portfolio? Because if it's not getting asked today, right now.
My understanding is it is. It's quite a simple question that the Secretary will be able to do this. And then I have a series of questions that I've asked the APS Commissioner and other secretaries today that I would like the Secretary to answer.
You have a very short amount of time to do that.
Thank you, Chair,
If
for the
they're not
indulgence.
cross-portfolio questions, they are not being asked in this session.
I thank the committee for their indulgence. Secretary, I have been, we've got a High Court filing from AGD on behalf of the federal government, Van der Stock and Anor versus the State of Victoria. When I went to the Climate Change Department yesterday, they said they didn't know anything about it. When I went to the Infrastructure Department, who were supposed to be partnering on this, they said they provided some advice to Attorney Generals. All I'm wanting to know is, can you advise which agency across government is the leading that litigation?
So,
or the instructing department, shall I say?
Senator, I can answer that quickly. I just note to the Chair that it does come under another section, but we can give you a very quick answer because it is this department.
What I want you to do is answer questions in the outcomes that are appropriate. So if there's Senator Mackenzie can come back.
I'm
during
happy
that
for you to
outcome.
answer that in the appropriate place. I won't be able to come back, but if you could just put it out there, I know my team will pick up. In cross-portfolio, more specifically, though, I do seek your advice, Secretary, on behalf of your department. The Public Service Act under Section 10 states the APS is apolitical and provides the government with advice, obviously in a frank, honest, timely manner, best available evidence used. With regard to the upcoming referendum, I'm wanting to understand how your department will fulfil their obligations under that section. What circulars have been sent around, etc., what advice, what protocols amongst the agencies and the divisions within your department?
Sorry, Senator, I just need to understand, because obviously we have a significant role from a constitutional law perspective, working with the National Indigenous Australians Agency.
This is in your role as managing APS staff,
right,
and the agencies within this portfolio area as well.
Right. To date, I'll ask my Chief Operating Officer to come to the table. We have not provided any broad advice to officers. Obviously, we're conscious of the fact that the issue will be of interest to a range of staff, particularly First Nations staff in the organisation, but we haven't provided any specific advice in relation to the referendum.
So, in terms of protocols, guidelines around how the APS should fulfil their obligations under Section 10 with respect to being apolitical and therefore behaviour around either side of the referendum. This is not a matter, what people do outside of work is obviously their business.
Are you talking like internal communication that...
I think the Secretary knows what I'm talking about, Assistant Minister. Mr.
Senator
Guilford?
Cameron Gifford, Chief Operating Officer of the Attorney General's Department. As part of my role, I sit on a committee called the COO Committee, which operates across the APS. It is currently developing some materials for internal publications within departments and agencies to be shared to inform officers of the conduct of the referendum and assist them in terms of making sure that they understand what the referendum mechanisms are and the conduct of the discussion in a respectful manner.
Fantastic. Secretary, I understand from that answer that work is going on within the APS more broadly so that code obligations are clear with respect to the referendum. Can I ask if there's been any internal discussion around the distribution of posters, collateral, internal memos, chain emails and social media within the workplace, obviously only, advocating one side or the other of the forthcoming referendum? Has that been a topic of discussion for you and your staff or the agencies within this portfolio?
We haven't had a specific discussion of the list of the issues. I mean, obviously we are conscious of the requirement, as you said, set out in Section 10 of the Public Service Act. We are aware that the APSC has and the COO Committee are looking at this to provide guidance. Once received, I will distribute that to the department and make sure that everyone in the department is very clear of their responsibility as public servants.
Thank you. And just finally on Australia Day, can you, maybe on notice given the time constraints of the committee, provide me with the data of the number of staff in your department who sought to substitute Australia Day on the 26th of January to come into work, and whether they did so in writing and in accordance with your enterprise agreement?
Take that on notice.
Thank you. Thank you, Chair.
Thanks, Senator Mackenzie. We'll actually suspend the hearing there for lunch and we'll return at 1:15. And we'll resume our hearing there. I just wanted to give the committee and senators and officials a bit of an update. There are no more questions for cross-portfolio corporate matters, which means I will be calling officers from the Justice and Communities Group of the Attorney General's Department. We also have a couple of agencies this evening that we're very respectful of their time, but we don't have any questions for them this evening. So we won't be requiring ACLEI or the Commonwealth Ombudsman at this stage. There might be others later on. And again, Secretary, we've really appreciated your advice about where is best to ask questions for certain programs, because I think particularly in the Attorney General's, what I'm learning as a new chair to this committee is there is some overlap in issues and programs. So senators are going to probably continue asking you for some advice about programs, but we'll stick to where those programs are. And I think when she's ready, I think Senator Liddell has the call and has some questions for you, Secretary.
Thank you. My question relates to the Northern Territory and it having the highest imprisonment rate in the country, with recently, back in November, a record of 2,000 inmates in custody. I'm wondering if this is the right place to talk about the role of your department in responding to those figures.
Thank you, Senator. Yes, we'd be happy to talk to you about those issues. There's a range of ways in which we are involved with other agencies to seek to address issues around issues associated with the high rates of First Nations incarceration nationally as well as in the Northern Territory. So there's work through the standing committees of Attorneys General. There's work we're doing through Closing the Gap and the Justice Policy Partnership. And also, most significantly, we are taking forward work around justice reinvestment projects. It was a commitment of the government around establishing 30 justice reinvestment projects around the country. And we're in the process of starting to develop the framework and engage with community, and we're prioritising the Northern Territory in that regard. So we can give you detail across those specific areas, as well as the contributions that our portfolio is making in the measures that have been already announced by the Prime Minister and the Chief Minister around actions relevant directly to Alice Springs.
So my question more relates to not the programs that have been in place, but the response to what has actually happened to families and individuals in the Northern Territory since July. So I'm interested in understanding what your role is in responding or increasing your work in trying to get those rates down so that we have an impact in the right direction on the Close the Gap statistics and the horrific injuries that we've seen to individuals, not just physical, but also their lives in the Northern Territory.
Thanks, Senator. I might ask my colleague Tamsin Harvey to assist with that.
Thank you. Thank you, Senator. Tamsin Harvey, Deputy Secretary, Justice and Communities Group. So in terms of the work that we've been doing around incarceration in particular this year, the Secretary did note the election commitments that we are working to implement, and whilst you asked about kind of immediate things that we've been doing, that has very much been a focus of the work that we as the Commonwealth have been undertaking. So in particular, you'd be aware of the election commitment and the funding around justice reinvestment, which really aims to find other solutions often outside of the justice system, but not always, to reducing contact with the justice system to reducing incarceration. And so for that measure around justice reinvestment, we've undertaken a couple of preliminary pieces of work that I might get my colleague to talk about in a bit more detail in a moment. And that's really aimed at making sure that we are engaging with communities to understand what communities want, what measures they want to take forward through justice reinvestment, because it is very much a community-led style of work, and that will be really important. So we've already been engaging with communities in a range of places. For example, Catherine and Alice Springs. We've been through Darwin as well. We're also then looking to set up the broader program that will enable those communities to then be funded to put in place projects in particular areas.
I'm interested in you mentioning about funding because, and I'm happy if you want to direct me or provide a list of those programs and organisations that you're directly engaged with. Aboriginal community controlled, have you had any instruction that all of the funding that's actually available or all the activity should be with Aboriginal community controlled organisations?
So we engage a lot with Aboriginal community controlled organisations, and for example through the Justice Policy Partnership there are 5 Coalition of Peak organisations that we work closely with through that. In terms of where the funding will go, we have been engaged in a process to engage a partner, a community partner, to help us design the program and to work with communities. And then we're also establishing a grants program. We haven't been engaging directly yet with who will have that money. Understand the importance of Aboriginal controlled organisations, and I think in communities that may well be the model where we get to, but at the moment we're very much still in that design phase. If it would be helpful, I could get my colleague Ms Carolyn to talk a little bit about that setting up work and how we're working. Sorry, apologies.
I'm actually interested more so in, given the amount of investment that's being pushed towards Central Australia and the Northern Territory at the moment, that the department recognises Aboriginal community controlled and Aboriginal led, where perhaps the resources and the capacity of a different organisation to respond to the immediate issue right now for people who are living in these circumstances may not be an Aboriginal community controlled organisation. It might be another organisation that is Aboriginal-led in its solutions. Yeah. Does the department recognise the difference between those two things?
The department is doing a couple of different tracks of work, and some of it is more immediate. There's another election commitment that we're implementing, particularly in Alice Springs, that my colleague Ms McCaig might be able to go to, and that again will be a grants program which may well see. I don't think that Ms McCaig might be able to talk about the grants program that is currently being established, but I don't know that it is going to set out in detail about who can and cannot be funded in the way that you might have described. I think we appreciate that community-controlled organisations are often best placed to come up with the solutions and to provide services, but through a grants program, of course, there'll be a range of applicants who might wish to apply.
Sitting on the Senate committee that looked at this back in December, it was clear from the witnesses that about their alarm at the impact already on Close the Gap, particularly the representation of change in the Northern Territory that would contribute to that end statistic. Can you advise, did you provide advice to the government that you were concerned an increase or a decrease in the alcohol availability, or an increase in its availability rather, would have an impact not just on the Close the Gap targets, but importantly on those targets that fall within your area of responsibility?
Senator, I think those questions might be better directed to the National Indigenous Australians Agency, who I think might have been more closely involved in that.
Right. But you didn't receive, you didn't give specific advice because of your concern with the impact on justice statistics?
I don't know that we were involved in that particular issue around the alcohol bans. I certainly happy to take that on notice to see if there was anything provided, but I think it would have been the National Indigenous Australians Agency.
It's the last question, Chair. Have you done any mapping on, given we've had the last 7 months, we've got some funding commitment now, but there will be a timeline in between that and the next, and the actual response to that investment. Have you kind of mapped whether you've got enough space in jail for people that might continue towards that trajectory in the meantime? Or how do you intend to respond to that immediately?
Senator, I would say in terms of issues around correctional facilities in the Northern Territory, it's very much the Northern Territory government responsibility. We work closely with the Northern Territory government around both funding of organisations like the Aboriginal Legal Services and other providers, but issues that go directly to the capacity of correctional facilities in the Northern Territory are very much a Territory government responsibility.
Okay, thank you.
Thank you, Senator. You don't have any other questions? Senator Antic, you have the call.
Thank you.
You're welcome.
This microphone up. Thank you for that. This is probably a broad ranging question, but in light of the fact that we're about to embark on a referendum with respect to the voice, obviously it raises issues of identity, becomes a very critical issue. So I'm wondering, straight off the bat, if someone can tell me who is it that decides who is Aboriginal and how do they do it?
Thank you for that. We've got relevant officer coming to the table. What I would say is that there was a test around Aboriginality that was set out in the Mabo decision, the 3-part test, and that has continued to guide the Commonwealth Government and other governments in terms of the definition of Aboriginality. But I'll just see if Mr Lewis has anything to add to that.
The only thing I would add to that, Senator, is if the... I think the Secretary is quite right. There's a legal test that's been recognised in a number of cases. I think it's also the case that the Australian Government might not applies a different approach sometimes in relation to different programs, depending on what's considered to be appropriate. I'll leave it at that.
So do you want to step me through that? And what does that look like? So somebody says, I want to go to Parliament under the voice, and I'm Aboriginal. How does that work?
Well, if the question is directly in relation to the voice, I mean, I guess I'll just start by saying that the agency that's leading the policy work on the voice is the National Indigenous Australians Agency. But my understanding is that at this stage there's been a draft constitutional amendment proposed by the Prime Minister, and questions such as who would be eligible to be a member of the voice or who would participate in choosing members is a matter that would be dealt with in any legislation establishing the voice or in the establishment of the voice in some manner.
So that sounds very complicated. Under normal circumstances, there is, what, a 3-part test based on dissent, identification and acceptance by community in broad terms? Is that's basically it?
That's right.
So is that likely to be, I mean, that is the generally accepted and I would say difficult assessment of, it's adopted by the legislation, some of the court decisions?
Mr Lewis, I think there's 2 parts to the Senator's questions. One is a general question, and then the second part is around the voice. So I think the general question hasn't been answered yet.
Thank you, Chair. So I think the general question is that what you've outlined, Senator, is a summary of the test that's commonly applied. The question of exactly what the arrangements will be for the voice is something, a matter for the government in consultation with others, and I understand that no decisions have been made about that at this stage.
And so in relation to the three-part test, though, how is a person going to ever be able to prove their descent? What is that going to look like? Is it going to look like having one grandparent or a great-grandparent that was Aboriginal, and how is that going to be proven in enough to satisfy any constitutional provisions that may be required in order to enter that body?
Well, Senator, again, I would say that the question as to how these matters will be determined in relation to the voice.
Let's say right now, as of today, you want to establish your lineage as a person. How would that work today?
Well, Senator, as I said, my understanding, and it's not an area within my policy responsibilities or even the department, but I understand that for different purposes, different types of tests are applied. If there is a test that requires an element of descent, then that might be shown by reference to documents provided by the Aboriginal person in question.
Right at the moment now, we're dealing with agencies including First Nations justice policy and so on and so forth. There has to be somebody in this room, there are about 60 people in this room here, all looking very important. There has to be someone in this room that can answer the question, though, of how someone goes about physically proving or practically proving their lineage for the purpose of whatever it may be. Let's put the voice aside for a moment. What percentage does somebody have to be of Aboriginal descent to be deemed Aboriginal or Torres Strait Islander?
Senator, I think I wouldn't be using that type of language, which...
Well, if you're 95% Irish, Scottish, are you going to be 5%? Are you going to be eligible for the voice to Parliament?
I think getting into a conversation about percentage is not appropriate. There is a very long-standing test that's been set out in a High Court decision that everyone takes regard to.
My question is, how does that operate practically? And no one can seem to tell me the answer to that. We haven't even got to the second and third limbs of that test yet. You can understand how there'd be cause for concern when we can't even identify what it is on a practical basis that will identify someone as of a particular ethnic category. That is of concern, I would have thought.
What I would say, and what I think what my colleagues have indicated, is this test goes back to the Mabo decision.
Sure. I understand
it has been
the history.
utilised.
Senator Antic,
I understand the history of it.
Senator Antic, you will
But
let
I'm
the
asking the
Secretary...
question.
Senator Antic, please let the Secretary finish her answer.
What I am saying in a practical way, that has guided how people can interact with a whole range of Commonwealth programs for decades now. I think officers at the National Indigenous Australians Agency will be able to give you much more detail of how that happens practically, but that has been the guiding test for decades now.
The Attorney General's Department, the department that is given the responsibility of overseeing legislation in this country, cannot tell me what I would have to do in order to identify as Aboriginal for the purposes of any of these. Just give me one example.
Well, I think, as I've said, it's set out here. It's around establishing ancestry. It's about being accepted by the relevant community, and it's about self-identification.
So what happens then if the community, for political purposes, simply rejects someone on the basis of their descent?
I think you're putting forward hypotheticals.
But your government, Minister, is in the process of legislating, or trying to legislate, taking to a referendum one of the most important constitutional reforms of our lifetimes. And nobody can tell me how we define the category we're looking for.
I think that's an important point you make there, that we are hopefully going to be legislating this one day. And
and hopefully you'll have some answers.
As a member of Parliament, you will have the opportunity to have input into that.
Yeah, I would like to if there were more information, but there is. What happens?
You're talking in hypotheticals and riddles.
No, we're not talking in hypotheticals.
I know what you're seeking to achieve, quite frankly, it's borderline racist, some of your questions that you're
Wait, is
putting
it,
here.
is it really?
Yeah, it
to
is.
ask the question
It is.
about how someone identifies and how it is that the legislation, the framework does that in a practical, that's racist, is it?
Borderline, yes. in
Borderline
terms of
racist, is it really?
The path that you're going
Is it
down.
really? Yeah.
If
Well,
that's
I mean-
where you want to head, Senator Antic,
Well, I just want an
and make
answer.
use of
I mean,
the time.
what I'm looking for is a simple
We're
answer.
here. The department have given you
No answers
an
whatsoever.
answer to this. It might not be one that you're satisfied.
Well, it's not an answer.
but
I'm
it
not
is
satisfied
being,
with no answer.
one that is being answered by the Secretary and the department.
So look, I'm going to wind this up because this is really not helpful. But is it the case that therefore that you cannot tell me that if I have a 10% lineage as a person, an Aboriginal Torres Strait Islander person, that will be enough, or in order to qualify for any of these legislative provisions? Nobody here can tell me who actually is an Aboriginal Torres Strait Islander person for the purposes of the law in this country.
I don't think that's correct, Senator. And as I said, there is a long-standing Commonwealth Convention. It's that three-part test, and that test is utilised, has been utilised for decades to, in legal contexts, in the context of access to programs, and is well established.
Here's a final question, Chair. Are you concerned that this process is going to lead to people who wrongly identify themselves as Indigenous or Torres Strait Islander or Aboriginal becoming qualified for The Voice, for whatever other program it may be?
I think you're sort of asking a question that is based around a hypothetical.
Right. The whole thing's hypothetical.
Sorry?
The whole thing's hypothetical. There's not a single answer. There's just not a single... nobody seems to be able to tell me what qualifies for the purposes of this categorisation. So it could just be anybody. Anybody's just going to be able
No,
to...
you have to meet the three-part test.
Which you can't describe.
I think I have.
described it, Senator.
You haven't described it. So, Minister, in practical terms, what does it look like when you say what does it take to prove dissent in this country?
Well, I think
what does it take?
Secretary had said, there's legal precedent in that regard.
What does it take, Minister? What do you have to do
Senator
practically?
Antic, the Minister is answering your question.
he's not
if you'd
really.
like to let
Round
him
and round.
answer it. You might not like the answer, but he's going to be able to
hard to
give
like
it.
it.
I appreciate that. You might not like the answer, but the Minister is answering
In practical terms, what does it look like?
Senator
a genealogy
Antic,
statement?
do not interrupt me. I haven't given a ruling, but I've given you a clear direction to stop.
As the Secretary was saying, there's been well-established legal precedent in this regard and how it applies to government policies. It operated under your government when you guys were in power.
We weren't legislating
and nothing has
for a
changed it.
race-based division.
Well, that is just completely untrue.
Well, were we?
Huh?
Well, so we were.
What I'm saying is the
legislating
legal
for-
precedent was applied when you guys were in government, and it's the same one that still applies today.
Your government.
In terms of The Voice,
Okay.
what we have said is that further details would be legislated after hopefully a successful outcome in the referendum.
So
the opportunity for opposition members of parliament is to engage in that process in good faith.
So that's what
I
we're
don't
trying to
see a
do.
lot of
That's
it
what we're
from
trying to do
Senator
today
Antic.
to get a simple answer. Just thank you, Chair. My last question.
Last
This
question,
is
Senator Antic.
quite extraordinary in the sense that I could sit here for the better part of 10 minutes, 15 minutes, and still not be able to have that question, that simple question about what it would take to identify as an Aboriginal or Torres Strait Islander in this country, and nobody in this room can answer it.
Senator Antic, you were given an answer. If that is your last question, I can hand the call.
Thank you, Chair.
Thank you. Senator Polly.
Thank you, Chair. I want to go to something else that's a bit more productive. What kind of consultation occurred under the previous government on judicial appointments, particularly to the federal court? What's the normal process that was undertaken by the former government?
Under the formal government, what was the process? Ms Harvey will be able to assist you on that.
Thank you, Senator. My recollection of the process under the former government was that the process would be that there would be an identified vacancy coming up. We would generally be advised in the department about who the the nominated person to be nominated was, we would then conduct contact with that person, so we would make sure that they had completed the relevant forms that are required for the government to then appoint them as a judicial officer.
So would you be consulted about candidates?
In my experience, we were generally not consulted about candidates, no.
So what percentage of federal court judges appointed by the former government who were women? How many women were appointed under the former government to the High Court, to the federal court?
To the federal court? Senator, I'm not sure we have that detail in front of us, but I would be happy to take it on notice.
Okay, so what percentage of federal court judges appointed by the former Attorney General, Mr Porter, were women?
Senator, again, I'd have to take that on notice. I just don't know.
Can you provide the committee with statistics on the number of judges and registers appointed to each state registry of the federal court over the period of 2013 to 2021, broken down by gender of the appointees?
Let's see if any of my colleagues have some of the broader detail available, but I don't know that.
Good afternoon, Senator. Alice Lineker, First Assistant Secretary, Courts, Tribunals and Commercial Division. We don't have that breakdown with us. We can certainly provide it on notice, but I can tell you that there are currently 177 commissioned judges. Of the 53% are male and 47% are female.
So you'll come back to us with the breakdown?
Yes, Senator.
Okay. In 2021, The Age reported that between 2013 and 2021, there were 9 men and 7 women that were appointed to the Victorian Registry of the Federal Court. This was described by eminent female lawyers at the time as disappointing and nonsensical. Was the department not able to identify any qualified female candidates in Victoria during that period?
So, sorry, Senator, can you just give me the period again?
This was reported by The Age in 2021 that between 2013 and 2021 there were 9 men and 0 women, that's no women, were appointed to the Victorian Registry of the Federal Court.
Yeah, as I mentioned earlier, Senator, my recollection of certainly the appointments that I had visibility of during that time was that we were not involved in identifying candidates.
Yes, you did say that, but you'd be aware of that report?
I have some recollection of it, but it is a little while ago now.
Okay, so I understand that during the period of 2008 to 2013, a formal structured process was in place for the appointment of federal judicial officers, which was specifically aimed at getting more diversity into appointments. Why was that process terminated in 2013?
Senator, I wasn't involved in that change of program, so I don't know, but I would perhaps think that there was a change of government in 2013.
Could it be that they had a different disposition to diversity and appointing women?
It may have been a different process that was undertaken.
It's right, isn't it, that in the process hadn't been terminated in 2013, there might have been more women judges appointed to the federal court under the former government?
I just don't think I can speculate, Senator.
Well, Secretary, do you have a view?
Thanks, Senator. I think my colleague Tamsin Harvey is absolutely correct. We couldn't speculate on that, but what we can do is take on notice to give you any information about the conclusion of that program and any statistics that flow from that.
Would it be fair to say, though, that the courts and the appointees during that period of time certainly didn't reflect the Australian community.
I think you're asking for an opinion, and I probably won't provide.
I think the facts and the appointees speak for themselves, really. Yes. So, yes. Can you tell us about the reforms to the judicial appointments process that the Attorney General's Department has been implementing since the current government was sworn in?
Thanks, Senator. Yes, and there's been quite a lot of work that my colleagues have been leading on, and I will get them to expand on what's happened in both judicial appointments, and we can also talk to changes around other appointments as well. But who should I hand to? Who's next?
I'll start and then I'll defer to my colleague for some of the details. So, in accordance with the ALRC report 138, without fear or favour, judicial impartiality and law and bias, there are two recommendations, Recommendation 7 and Recommendation 8, around the government developing a more transparent process for appointing federal judicial officers on merit and collecting and reporting annually on statistics regarding the diversity of the federal judiciary that the government has agreed to and is currently working on developing processes to meet those recommendations. In terms of judicial appointments process, government has agreed to implement a more transparent and consultative process for the federal judiciary and is currently engaged in recently engaged in a number of appointment processes that fulfilled that requirement. So in December 2022, 10 judicial appointments were made to the federal courts, and that was after the Attorney General consulted with almost 40 key members of the legal community.
I'm sorry, how many?
40, and convened a series of advisory panels to consider expertise of candidates. That's one example. And then in terms of diversity, the department is actively working with courts to understand and report on the diversity on data collection and reporting on characteristics of the judiciary.
So a very different set of processes to go through. So if we unpack that a little bit, taking the recent appointment of Justice Jane Jago to the High Court, what kind of consultation did the Attorney General and the department undertake? Just so we have a very clear view of what is happening now as opposed to what's happened in the past. By the former government.
Senator Liam D'Emanuel, Assistant Secretary, Courts and Tribunals Branch. So with the appointment of Justice Jago to the High Court, the attorney consulted quite broadly, so he wrote to key stakeholders in the legal community, heads of jurisdiction, to receive their nominations for potential candidates for that position. And that consultative process informed the attorney's consideration for the ultimate appointment that was then progressed through government.
So could you outline to us the kind of consultation that occurred last year in relation to the appointments to the federal court? Was it just a similar process?
So, Senator, in terms of that process, so I think my colleague Ms Lineker touched on the formation of advisory panels in that process. So for the federal court appointments and then also two recent appointments to the Federal Circuit and Family Court of Australia, there were advisory panels convened, which included a departmental representative, the Chief Justice of the relevant court and another member that assessed potential candidates and provided a report to the Attorney General to inform his consideration.
To give us an overview of the panel and the qualification of people appearing on that, can you give us an overview of how people got selected to be on that panel?
I'm happy to assist with that, Senator. So for the Federal Court panel, it was the Chief Justice of the Federal Court, Justice Alsop, and a retired member of the retired judicial officer from the Federal Court, and myself as the Deputy Secretary of the relevant part of the department that then looked at those, assessed the nominations that had been received as a result of the Attorney seeking those nominations. For the panel looking at appointments to the Family Federal Circuit and Family Court, it was the Chief Justice of the Federal Circuit and Family Court, and the previous Chief Justice of the Family Court, and again myself on that panel. Similar process.
Thank you. I appreciate that. What did the Australian Law Reform Commission find in its report on judicial impartiality and bias about the importance of merit-based appointments?
I might have to take the detail on notice, but certainly they recommended that the government develop a more transparent process for appointing federal judicial officers on merit, and referred to the importance of public confidence in the integrity and the impartiality of our judicial officers.
Well, after the morning that we've had with evidence previously, I think it is important to get those facts on the record in terms of transparency, accountability, and demonstrates what consultation should be done with those important appointments. So if you've got anything else that you want to add, I'd appreciate that on notice. Thank you. Thank you, Chair.
Thanks, Senator Polley. Senator Scarr, you have the call.
Thank you, Chair, and I'd like to pursue Senator Polley's helpful line of questioning a little bit further, and I actually want to take it to our most senior court, which is the High Court of Australia, and I note, Secretary, it's true, isn't it, that we actually have a majority of justices on the High Court of Australia are women?
That is correct, Senator, yes.
And that's a wonderful thing, isn't it? Well, I'm sorry, I don't want to ask you to.
You are asking me an opinion, but
I'll use my comment as a preamble for my further questions. I believe that's a wonderful thing, and I've just been going through the appointments in relation to those justices on the High Court. And of course, we Queensland senators, Senator Chisholm. Sorry, I was going to include you in a compliment to Her Honour Justice Kiefel here on a parochial Queensland basis.
Like me.
The Minister and Senator Green and I are, of course, senators from the great state of Queensland, and Her Honour Justice Kiefel has served the High Court in great distinction, both as a Justice and a Chief Justice. When was she appointed, Secretary?
Now, I need to check on the exact date.
Actually, I might be able to help you.
I think it was probably 2014 or
No, actually it was earlier, 2007 actually, by Attorney General Ruddock. Attorney General Ruddock, who was a Liberal Attorney General.
Yes.
And then of course, when was Justice Kiefel made Chief Justice?
Well, that I think is possibly around about 2014, but I'd need to check.
And that was when my good friend Attorney General George Brandis, a Liberal Attorney General, was Attorney General. Is that correct from your recollection?
I think I do. That is correct from my recollection, yes.
And then Justice Gleeson, who of course comes from an extraordinarily eminent legal family in the Australian legal context, was appointed in March 2021. Who was the Attorney General then? Ms Jones?
March 2020.
I think it was Attorney General Christian Porter.
It did go through actually. A few there, Senator Starr.
And my last one, Justice Gordon. Justice Gordon, do you know when she was appointed Secretary? I'll be able to help you if you need it.
I would appreciate your help on the exact date.
No, that was June 2015 under Liberal Attorney George Brandis. So presumably by a simple analysis of applying basic mathematics, given 3 of the 7 justices were appointed by Liberal Attorney Generals, without those appointments by Liberal Attorney Generals, we wouldn't have a majority of women on our High Court, would we?
Right, I think in terms of the facts of the numbers, that's correct.
Okay, thank you. Thank you,
And
Secretary.
the Women of Australia repaid you in spades at the election, Senator Scarr. Have you got any other questions?
Of course I have other questions, Chair. I would like to go back to the Voice, so if we could have our friend from... I've got some documents I want to table, and I'm not sure I need to table these, but I'm just doing it for ease of reference as much as anything. The address to the Garma Festival by Prime Minister Albanese, and that's dated 30 July 2022. Letter from Prime Minister the Honourable Anthony Albanese to Honourable Peter Dutton, 1 February 2023. And then an article by another eminent Justice, His Honour Robert French, and Jeffrey Lindell, which appeared in the Australian Financial Review on 4 February 2023, entitled Voices Low Risk but High Return. And then lastly, a transcript of a press conference including comments from the Prime Minister 9 February 2023. So I'll just hand those up to be circulated, just so everyone's got a copy of those as I walk through. So just as they're being circulated, I'll talk to the relevant parts of each of the documents as we walk through. So the address to the Garma Festival, 30 July 2022, our Prime Minister said, our starting point is a recommendation to add 3 sentences to the Constitution. And then he listed 3 sentences. 1, there shall be a body to be called the Aboriginal and Torres Strait Islander Voice. 2, the Aboriginal and Torres Strait Islander Voice may make representations to Parliament and the Executive Government on matters relating to Aboriginal and Torres Strait Islander peoples. 3, the Parliament shall, subject to this Constitution, have power to make laws with respect to the composition, functions, powers and procedures of the Aboriginal and Torres Strait Islander Voice. So that's in the Garma address. On page 4. Then there's the letter to...
Sorry, Senator Scarr, can I just... these questions for the Attorney General's Department or PMNC, are they...
Oh, I think they all go to the...
You'll get us
the
there?
boards. Yeah.
To
Just
how they're
bear with me.
relevant?
I'm setting it up to try and make it easier.
Make it relevant, that would be good.
Try and...
Thank you.
I'll do my best. So then there's the letter from the Prime Minister to the Honourable Peter Dutton, where he says... He includes the draft wording on page 1 of the letter.
Sorry, Senator, we've been given a document that's a transcript of a press conference.
Yeah, I haven't got to that yet.
The childcare one?
So we don't have the Garma speech.
So you should have the Garma one. Does someone else have the Garma one there?
Okay.
No.
Sorry, do you have the Garma one?
We have it now, Senator.
You have it now?
Yep.
Okay,
Thank you.
sorry, I might just let you all get squared away. My intent is to make this easier.
Yep, thank you.
Okay, so you've got the address to Garma?
I do, thank you.
Okay, so then the next document chronologically was the letter 1 February 2023 to the opposition leader. And on page 1, it lists the 3 sentences, you might see, which are replicated in the Garma statement, but then it's got a preamble, or a chapeau. I think lawyers might call it a chapeau to use elegant language. In recognition of Aboriginal and Torres Strait Islanders as the first peoples of Australia, and then it lists the 3 sentences, right? And then I go to the article by Robert French and Jeffrey Lindell, which was in the Australian Financial Review, and I've read the article and I compliment the authors on the article, as I compliment all the former Chief Justices of the High Court and Superior Courts who've been participating in this debate in a very measured and appropriate way. On page 2 of that article, it says the proposed draft amendment to the Constitution to establish the voice provides : and then His Honour Ex-Chief Justice French refers to the 3 sentences that were in the Garma statement, but doesn't refer to the introductory words. Right? You following so far?
Yes.
And then in the transcript, 9 February 2023, the Prime Minister says on page 6, and I quote, "So if anyone has, as I said, I await any member of the House of Representatives or the Senate to examine the question and the draft changes that I put forward at Garma last year." So the Prime Minister refers back to the Garma statement, which had the 3 sentences. So what I'm trying to work out is, as we're here today, and I'm looking at these 4 documents, and there are 2 variations included in the documents. And I must say, I'm given some comfort that if I've misunderstood something, I'm in the company of His Honour ex-Chief Justice Robert French, with respect to the actual current draft wording of the referendum question. So what is the current draft wording of the referendum question? Is it the 3 sentences in the Garma statement, or is it as which are replicated in His Honour Justice French's, ex-Chief Justice French's question, or the wording in the letter to the opposition leader?
My understanding, Senator
sorry.
Scarr, is that this topic was traversed in PM&C estimates yesterday, and I think it is going a little bit to semantics, but I will do my best to answer in good faith in the tone in which you put the question.
Yeah.
I would point out to you in the Garma speech, the preceding part to the first dot point is in recognition of Aboriginal and Torres Strait Islanders as the first peoples of Australia, which is exactly reflective of the letter that he put to
exactly,
Mr. Dutton.
Minister.
Yeah.
And if I can,
and
if
I
think,
I think you yourself referred to that as introductory remarks.
I did.
I certainly am not a legal expert and don't proclaim to be, but I think that is a fair summary of the position.
So
Minister... Sorry, as Chair, can I just interject for one moment to say I really do want to make sure that the questions being put to the Secretary are relevant and that they can answer them because of the work that the Department does or is assisting. But any questions outside of their remit will have to be put to other departments.
Well, sure. And I'm putting these questions in good faith, Chair. And
Not just generally because they know about the law, but because they're working on...
I thank the Minister for the spirit of his response, and that's the spirit in which I'm presenting the question. Because I noticed the same thing, Minister. I noticed those introductory words in the statement, but then I was confused because ex-Chief Justice, His Honour Robert French, did only refer to the 3 sentences. So I wasn't sure whether or not those introductory words are actually part of what we're talking about in terms of the draft changes to the Constitution, or they're an argument or justification for to the draft changes. So is anyone able to provide clarification on that?
I'm happy to make some comments,
Sure, Mr. Lewis.
Senator.
Thank you.
Thank you for providing all those documents.
And you followed the... Yeah.
I did, thank you. And so, as I think you indicated, those introductory words were immediately preceding the 3 sentences in what the Prime Minister said at Garma. And as you've referred to, those words are included in the letter that the Prime Minister sent to the Leader of the Opposition on the 1st of February this year. I don't know that we can provide much by way of commentary and interpretation of sort of a speech of the Prime Minister.
Oh, sorry, I'm not looking for you to provide interpretation. I'm just seeking clarity as to whether or not those introductory words are part of the current draft constitutional question that the Prime Minister has asked for feedback on.
And the point I would make, I suppose, Senator Carr, is that the Prime Minister...
Senator Scarr, sorry.
Senator Scarr. The Prime Minister at Garma and subsequently, and indeed in his letter to the Leader of the Opposition, has said that these were a starting point, and he is open to discussion and suggestions on that as well.
So just so we can round this out, should we take it? Is it the words that were actually in the letter to the opposition leader? Is that the current draft wording?
That is my understanding, and I don't. Apart from maybe an apostrophe or something else.
No, sure. I'm not talking about.
I don't see much. It's word for word what was in Garma.
No, but it's just whether or not those introductory words are actually part of the draft change to the Constitution.
Well, that is my understanding, yes.
And that's your understanding, Secretary?
I think the formulation as set out by the Prime Minister in his letter to the opposition leader is currently what is being discussed and considered. But as the Prime Minister subsequently has confirmed, there is ongoing consultation through a range of mechanisms, the expert working group and the constitutional legal expert group,
Sure.
as well as he has invited other parliamentarians to provide any suggestions to him. So that is the current starting point, but he has invited any further suggestions.
Sure. Is this form of words available anywhere else? Does the Attorney General's Department have somewhere where you can go on and say, this is the proposed draft words to amend the Constitution?
The National Indigenous Australians Agency has established a website,
Right.
which is the central point of information and communication around the voice.
Okay. So, should anything be interpreted in terms of the... I am a lawyer by background, right? So, should anything be interpreted in terms of the nuances I've drawn out here? Is His Honour Justice French, ex-Chief Justice of the High Court, was he as confused as I was in terms of the introductory words, whether or not they're part of the constitutional amendment or not? In which case I feel relieved. I'm in good company.
I won't speak to whether or not a former Chief Justice of the High Court was confused. I think, to be fair, he was focusing in particular on the three specific questions had been set out. But as you have noted, and as the Minister has noted, the Prime Minister in the Garma speech, so from the very beginning, prefaced made reference to in recognition of Aboriginal and Torres Strait Islanders as the first peoples of Australia. So I think right from the commencement of the discussion around this, those words were there.
Oh, and I accept that in terms of the justification for it. It's just whether technically they were part of the amendment. Mr Lewis, I'll move on. At our last estimates hearing on 7 November 2022, I asked you a question. What advice did the Attorney General's Department provide? What role did the Attorney General's Department play with respect to the drafting of those words? And in that context, I was asking about the words in Garma, and we've dealt with the is there a difference or not, so put that to one side. You advised our department didn't provide any advice on the drafting of those particular words. I just want to get an update in relation to the Attorney General's Department and your role in relation to this from that point on. What has been the role of the Attorney General's Department from that point on in terms of giving assistance with respect to, for example, the drafting of the letter to the opposition leader Peter Dutton in February that I tabled, and anything else in relation to the proposed constitutional amendment?
I'll ask Mr Lewis, who has really taken the lead in
Sure.
the department because of his expertise in constitutional law, and we have a team both within the department as well as officers that have been seconded to the National Indigenous Australians Agency to help progress the work associated with the referendum and the voice. So Mr Lewis can talk to that without necessarily going into the specifics of input into every document, but
No, can I just be clear, Secretary? I don't want to put Mr Lewis in a difficult spot. I'm not interested in I know there are limitations with respect to what you can tell me with respect to the content of advice.
Yep.
I'm more interested in the role and whether or not what advice is given with respect to what.
Thank you.
Senator, consistently with what the Secretary said and with what you'd expect, we're assisting primarily the National Indigenous Australians Agency with the legal aspects and the legal policy aspects of the referendum. So, as you'd be aware and the Secretary's referred to, the government is taking advice from a referendum working group, and advising that working group is a constitutional experts group. The support for those groups and for the engagement group is directly provided by the National Indigenous Australians Agency, but as you'd expect, we're quite closely involved in the work of the Constitutional Expert Group, which is chaired by the Attorney General and Senator Pat Dodson.
Right.
So we've provided a range of support to the Attorney General and to other agencies in the government in relation to that work.
So are you actually providing legal advice on the proposed draft wording or the consequences or effect of any proposed wording to the Constitution, as opposed to providing general support?
I'd certainly say that there's legal content in the work that we're doing, but as I said, the government is taking advice from the Constitutional Expert Group, so we're assisting, supporting that group. There would have been pieces of assistance that we've provided to the Attorney General that would be a type of legal advice, yes.
Okay, and does that legal advice go into the impact of certain words, phrases, if they're actually used to amend the Constitution, and what legal consequence could flow from that?
As you indicated before, Senator, we wouldn't normally go into the content of legal advice.
So I'm not seeking, I guess, I'm trying to keep you on ground you're comfortable on. I'm not seeking the content of the actual advice. If you do A, then B may occur. I'm just seeking to have an understanding as to, in the way you've explained it very well, Mr. Lewis, the demarcation of responsibilities, if you like, between the, I think you refer to them as the referendum working group and the constitutional working group. So whether or not either of those two groups are making the call as to the wording and the impact, or whether or not you have a role on that and you're just providing assistance to them. That's what I'm trying to get an assessment of. Does that make sense, Secretary?
Yeah, it does make sense, and I think certainly what we can say is we support the consideration of the Constitutional Legal Expert Group that the Attorney General chairs. They provide advice to the working group, which is comprised of a number of First Nations people, and is therefore that working group is then providing broader advice back to government.
Okay, so my understanding, tell me if I'm wrong, and it's been helpful for me to get my head around the process, is really the primary legal advice that is being provided to the government in relation to the consequences of any change to the Constitution, as has been proposed, is primarily coming from the Constitutional Expert Group to that working group, rather than the Attorney General's Department providing advice to the working group. Any advice you're providing in relation to this matter is going to the Constitutional Expert Group to be considered as part of their considerations, and then they give advice to the working group. Is that correct?
I think that's broadly correct. I just would clarify the point around us providing advice to the expert legal group. It's more that we support them in,
so how would you
their deliberations.
sorry, you are characterising it. Sorry.
We provide.
So what does that mean in essence? What sort of activities?
Well, we assist in
research briefs.
To some degree, yes.
Senator Scarr, you asked a couple of questions.
And broad support for their meetings when they come together, ensuring they've got appropriate material in front of them in order to be able to provide, consider and then provide advice.
Okay, so really the Constitutional Expert Group's the driving force in terms of providing the legal advice to the government on this. Is that correct?
Well, certainly they're, obviously the Attorney General convened them because of their eminence and
I'm aware of that.
the authority they can bring to the advice. So they're certainly very influential in supporting the Attorney and the government.
Okay. Sorry, Mr. Lewis, please.
Can I just add, Senator, in case this provides a more complete picture, the Attorney General has also indicated that the Solicitor General has provided some advice to the government on the draft changes.
So did that go to the Attorney General or did it go to the Constitutional Expert Group?
Or both? To the Attorney General.
So that was a copy given to the Constitutional Expert Group?
No.
It wasn't? So is the Constitutional Expert Group aware that, maybe you're not aware of this, Mr. Lewis, as to whether or not the Attorney was getting separate advice from the Solicitor General, which is entitled to do?
My understanding is that the expert group is aware of that. Yes.
Okay.
Senator Scarr, this is the last question in this block for you.
Okay, last question. Did the Attorney-General's Department have any role in relation to preparing this letter for the opposition leader, Peter Dutton?
Not to my knowledge, Senator.
Secretary?
Not to my knowledge, Senator.
Okay, thank you very much. That's been very helpful. Thank you.
Thank you, Senator Scarr. I'm about to hand the call over to Senator Shoebridge. I do want to remind senators we wanted to get through the next outcome before the break at 3:15. That only really gives us an hour to wrap up this outcome and to get through the next. Senator Shoebridge, you have the call. I understand you've got a number of matters to raise here, but I'm seeking to move to the next outcome very soon.
I've got a few more issues on this outcome. I'll be as quick as
We'll
I can.
have to...
Thanks, Chair. And I note your encouragement.
It's more discouragement, actually, Senator Shoebridge.
Rather than us debate it,
But
I
you
meant
take it how you
encouragement
want
to
it.
be rapid. Has there been some consideration given to providing a copy of that Solicitor General's legal advice, not just to the working group, but more broadly, to address some of the kind of the rumours and challenges going round on a legal basis or a quasi-legal basis to the Voice?
Senator, that would be a matter for the Attorney-General. I'd refer that to the Attorney-General.
All right, well, can you take that on notice? Obviously, more transparency is better in this space. And, as best as you can, if you can avoid the argument that the government is hiding something,
It's not...
have those considerations been taken into account?
One thing I would note is the expert legal group produces a communique at the end of each meeting indicating the issues that have been considered and any further issues that are likely to be considered. So there has been significant focus on ensuring that the work of that expert legal group is
has a degree of
understood.
transparency.
Yes.
I accept that.
Yeah.
I accept that. And I'm not being critical of the decision making that's gone to date. I'm just thinking going forward, more rather than less transparency is the way of addressing some of the rumour mill, if you like.
Sorry, Senator, can I just add to it? The Secretary's answer there. In relation to the communiques, the procedure, the exact procedure has been that the expert group has prepared documents setting out its views, which is provided to the working group, which has then included those views in the working group's communique, rather than the expert group itself providing communique.
No, I think
that might be a fine
useful
point.
No,
but
no,
I
it's
just want to let
actually
you
a
know.
useful clarification. Thanks, Mr. Lewis. Has either the working group or the expert legal group done a review of past referendums and how they've worked in practice? And I suppose I'm particularly referring to the way in which yes and or no cases may or may not be prepared in past referendums. Has anyone done that work?
Certainly there's been reference to previous referendums. I think I may have mentioned this at the last estimates, but Mr Lewis himself worked on the 1999 referendum, so has personal lived experience of being involved in providing advice and support, and has been able to show me copies of documentation from back in that time. But also I would say the Attorney-General is alive to many of the referendums that have happened in the past, and certainly we've drawn from the types of processes. There has been different approaches in relation to most referendums in one way or another. But there's lessons to learn from all of them.
There are, but to assist the public debate, having a considered summary of the practice in different referendums would obviously be of some assistance. For example, very few people know that there was no case associated with the 1967 referendum.
That's right, yeah.
Yet I think that would be a useful contribution to the public debate.
Yep.
And I'm very glad there was no case for the 1967 referendum. It would have been appalling. But I think having some kind of carefully considered, balanced review of the practice in past referendums would actually be of assistance in the public debate. Has the department considered doing that?
Certainly, what I can say that I think goes to that issue a bit, there has been consideration about what further communication and education can be undertaken about constitutional referendums and about the Constitution itself. So there is consideration of that, and potentially working with relevant groups to assist in that broader education along the lines that you've suggested.
All right. I've got some questions on e-safety, online safety for children.
So that would be in the next group.
Mine has family safety branch. Mine has family safety branch in my list here.
The family, there are elements that could be in the family safety branch and elements that could be in the National Security Criminal Justice group. So,
well, I suppose I'm thinking about the online codes of conduct. The E-Safety Commissioner has been leading that.
Yes.
The 8 draft codes of industry codes of conduct. I'm seeking to understand what, if any, role the department has had in supporting the E-Safety Commissioner, providing advice to the E-Safety Commissioner and the like.
So we do...
There's a volunteer. I see a volunteer rising at the back of the...
I might just ask Adam to come over.
So I think this is from the next group. So Mr. Knott is from the next outcome, not family safety branch.
Well, if it cuts across the two, can we just deal with it efficiently in one go?
I think it is very much in the next group in terms of the work that Mr. Knott's branch is leading. So
right.
I'm trying to be.
We'll deal with the Knotty branch in the next group.
All right. I think you've now just established a new name for that branch.
Okay. Yep.
If we get there.
Then I also had some queries about the privacy, the review of the Privacy Act. And again, I got lost in this list of various subgroups in the department.
Sorry, Senator, I think I did mention previously, so that's in the next group, the Integrity and International Group.
I'll tell you what we'll do. We'll get to that as quick as we can and I'll hand it back to the Chair.
Thank you very much. Yep. Senator Scarr, do you have some remaining questions for this outcome that we can deal with now?
Well, I do.
Thank you.
I just want to check I'm in the right outcome.
Yeah, fair enough.
The religious discrimination inquiry.
So...
Not me.
No, that's...
Not you?
No, that is in the Integrity and International Group.
So that's not this outcome?
Not this outcome.
Okay.
The next.
All right, so got that.
Fantastic.
So hang on. Just 2 quick follow-up questions for my previous line of questioning. If Mr. Laws could come back to the... I've been reflecting, Mr. Laws, on your lived experience of the last referendum. I'm not going to ask you any questions on that, but I'm sure it'd be an interesting discussion. You referred to the Solicitor General providing advice to the attorney, and of course the attorney's entitled to seek advice. I do note Senator Shoebridge's suggestions, which I do concur with. What was the date when that advice was provided? When was that advice provided? And the reason I'm asking, I'm keen to know the timing in terms of the Garma statement, and whether advice was provided by the Solicitor General before the Garma statement or after the Garma statement, or both.
I think we'd need to take that on notice.
I can say the date of the Solicitor General's advice. So there's been 2 pieces of advice from the Solicitor General on the draft provision. One was on the 26th of September 2022. One was on the 23rd of January 2023.
Sorry, what was the first date again?
26th of September 2022.
Okay, so both the Solicitor General has provided advice on both occasions after the Garma statement. That's correct?
Yes.
Do you know who was advising the attorney before then in relation to the wording?
Senator, as I think I might have said in the last estimates, the draft provision that the Prime Minister announced at Garma was very similar to previous drafts by other eminent legally qualified people, including in submissions made to the 2018 Joint Standing Committee inquiry. And so there'd already been a sort of many years of public discussion of constitutional recognition, including a whole range of draft provisions that might establish a voice.
Okay, but in terms of the, and I just want a final question on this topic, then we can move on from this topic.
Thank you.
I just want to clarify, in terms of the Attorney General's Department's role and the Solicitor General's role, is it correct to say the Attorney General's Department has not, you've mentioned one aspect of the Solicitor General, so that's recognised, so that's outside the ambit of this question. Has the Attorney General's Department provided any advice in relation to the 3 sentences or the 4 sentences, including the introductory words?
Sorry, Senator, during what time period are you asking about?
Well, so this is in the period, I guess, leading up to Garma, and I think your advice, the evidence you gave last November was the Attorney General's Department had not provided any advice with respect to the three sentences at Garma. That's correct, isn't it?
That's right.
So after that period, after November 7, the Attorney General's Department has not provided any advice with respect to those introductory words that we referred to being part of the question. Is that correct?
As I described to you before, we're providing support to the Constitutional Expert Group. You might be aware there's also a Constitutional Recognition Committee of the Cabinet. So we've been involved in work for that committee as well.
Okay, but just specifically in relation to the wording of the question, including those introductory words, have you provided advice?
Senator, the way I would frame it is, so we're involved in the policy support that goes to the consideration of those three points. You keep using the phrase advice, and certainly the Solicitor General has provided advice. We've been supporting the discussions, so ongoing involvement, ongoing engagement with the attorney, and we will continue to support that through both the Cabinet process and the work of the expert legal group.
So you haven't given any advice as to whether or not those introductory words should be part of the referendum question and attached to the 3 sentences?
I think just in terms of the specifics of what we do, we are, the focus of the expert legal group is really goes to those issues, and we support that group.
Okay, that's fine. I'll move on. I just want to clarify, Chair, so I finished with that topic.
Thank you.
I just want to clarify the appointment of the, and I'm not sure what title he's given, an associate member of the Australian Law Reform Commission, the gentleman who's actually conducting, who's playing the key role in terms of the religious discrimination amendments. Is that in this outcome, or is it also in the next outcome?
That is in this outcome.
Okay, so I need to canvass the appointment in this outcome and then the process in the next outcome. Is that correct, in terms of the consultation process? I just want to make sure I'm in the right outcomes for it, or can I deal with both issues in this outcome as a matter of convenience?
So we, this outcome, certainly we look after the ALRC as a portfolio agency. Are you talking about a particular inquiry being made by the ALRC?
Oh, absolutely. I'm talking about the inquiry which is being led by His Honour Stephen Rothman.
So, and which inquiry? Sorry, the religious discrimination inquiry. So the religious discrimination issue doesn't sit in this group. That's why I'm just trying to.
But what about his appointment?
So I'm not sure, Senator, that that I'm going to be able to assist you a great deal.
His appointment as a part-time commissioner.
I may be able to assist. If you've got any specific questions, please.
So do that now?
Yep, I'm happy to answer them now.
Is there a reason
Why don't we go
You
into
wouldn't
the
ask them all together? Or?
Well, I'm happy to ask them all together, Chair, as long as the Secretary... I just don't want to get in a
think
position...
for convenience...
I'm very happy to ask them all together if the Secretary is comfortable with that.
Very comfortable with that.
Does that, sorry, Chair, does that mean we're moving to the next
Oh,
group?
well, I don't think we're quite there yet.
okay, sorry.
Senator Scarr has a few issues to raise, and what we've been doing throughout the morning is getting some advice as we go about what is the appropriate outcome.
Okay,
But we might be there.
we're dealing with the AAT holus bolus under the AAT, so I've got that right. So we'll deal with the religious discrimination inquiry and the appointment of the Commissioner in the next segment, so I'm happy with that. Let me just quickly go forward. Bankruptcy reform, where's that?
That is here. You're in the right
There you
spot.
go.
Okay. All right. This will be pretty quick, I think. As I understand it, and Ms Harvey, you're going to know far more about this than I, there was consultation on possible reforms to the bankruptcy system that closed on 25 February 2022. Has there been any developments with respect to consideration of those potential reforms to our bankruptcy laws? And I should note, one of the reasons I ask this question is I'm involved in a review of Australia's corporate insolvency laws, so I'm interested to know what the progress is with respect to those bankruptcy law considerations. You're probably waiting for our report.
Certainly, Senator. Sorry,
Don't laugh too hard.
certainly was not about the waiting for the report. This certainly very conscious of the consultations that you referred to in early 2022, and the inquiry that you also referenced, and some of my colleagues appeared before the inquiry, and I think Ms Lineker or Ms Presley might be able to assist you with some more detail about the work that's been going on in the bankruptcy space.
Hello again.
Hello, Senator. In respect of the bankruptcy space, the Attorney-General is hosting a roundtable in Sydney on the 2nd of March. At that roundtable, there'll be a range of attendees from across and stakeholders across the industry, and that will be a conversation to determine, together with potential outcomes from that inquiry, as to what next steps might look like.
And the outcomes of the Whittaker report, is that on the agenda in the near future?
The outcomes, the Whittaker report, as you're aware, is a very large report with 394 recommendations, which government is carefully working through. There are, as you know, Senator, a range of interconnections between those recommendations and bankruptcy, and government is continuing to consider it.
Okay, thank you very much. That's all the questions I have on that. Thank you very much. I had one quick question in relation to legal assistance, and this is my last question, this outcome.
Thank you,
legal
Senator
assistance, legal assistance funding for political purposes, and the Attorney-General's announcement on 29 November 2022. You can help me on that.
Are you able to give me a little bit more detail? I'm not quite sure. Legal assistance purposes.
So the Attorney-General announced on 29 November 2022 that he was removing the ban on recipients of Commonwealth legal assistance from taking part in political advocacy and lobbying.
This is the right spot for that.
Yes, that is.
It is the right spot.
Yep.
Right. So, Ms Wang, you're across the content of the National Legal Assistance Partnership?
I'm aware there was a clause in the National Legal Assistance Partnership. Sorry, Ms Lei Swan, Assistant Secretary in the Legal Assistance Branch.
Right. So what I'm interested to drill down on, and again, this is probably an overly pedantic legal question, right, so bear with me, is the only thing that's prevented in the definition of lobbying in that National Legal Assistance Partnership Agreement is, and I quote, an effort to unduly influence Commonwealth decision-making in terms of, or undertaking political campaigns. So it was quite within the ambit of the National Legal Assistance Partnership on the basis of those decisions for a member of the National Legal Assistance Partnership to actually advocate, to lobby the government, as long as it wasn't doing it unduly. So I interpret that as meaning making submissions to inquiries, such as inquiries by this committee, I don't think that would have been out of order. Unduly influenced means stepping over, doing something outside the ordinary course, I think, which isn't appropriate, or engaging in political campaigns. Do you agree with that that interpretation? So I'm just trying to work out what members of the partnership were prevented doing prior to the Attorney General issuing his statement in November, and what has changed. What has changed? That's what I'm trying to get down to.
Paul, I might just take a point of order. I think you're asking this official to provide basically a legal definition or legal interpretation of the term unduly. And I, for one, think A, we shouldn't put an official in that position, and B, your unduly and my unduly and Ms Wang's unduly might be totally different. For example, a press conference or the like might be considered unduly. But my principal point is I don't think you can ask Ms Wang to provide
Let me
a legal
rephrase. So I respect Senator Shoebridge's point, so let me rephrase. What has been the practical difference between what the situation was prior to the Attorney General's statement and the situation now in terms of what recipients of Commonwealth legal assistance can do?
Senator, I do take regard to what Senator Shoebridge said, and not offering an opinion on unduly and what it really means. What I can say that some of the stakeholders, some of the organisations funded under the Legal Assistance Partnership would raise this as an issue, that they weren't entirely sure of what the definition of unduly meant in those circumstances.
Oh, were they? Okay.
So I can only speak to what was raised over time with the department, and they were the ones that raised concerns.
Okay. So on the basis of that answer, I'm not going to unduly press that line of questioning, and I'm finished with this outcome, Chair.
Thank you, Senator Scarr. I appreciate your persistence to get through those questions. So we can move on. And so I do call now officers from the Integrity and International Group of the Attorney General's Department. And I'm going to hand Senator Waters has some questions, and then she needs to head to another
Thank you. Is that okay?
committee. So I will just wait till we've got the officials at the table, but then Senator Waters, you have the call.
Thanks very much, Chair. Thanks to my colleagues. Just to help with the relevant officials, and hi everyone, my questions are about costs under the Sex Discrimination Act and then also about the lobbyist register. Great. Thank you. So starting off with the costs issue, I'm hoping to get an update on the work that's being done to approach cost protections under the Sex Discrimination Act and the Fair Work Act. Can you let me know whether that review is in fact underway, where it's at and who you're talking with and when it will be finalised?
Thanks, Senator. Mr Clark will be able to assist with that.
Thanks, Mr Clark.
Thank you, Senator. Jessie Clark, Acting First Assistant Secretary, International Law and Human Rights Division. Very happy to provide you with an update on that. Senator, as you may know, the relevant provision was pulled from the Respect at Work legislation, and the Attorney asked the Department to take forward a review. We're doing that at the moment. I can give you the steps that we plan to undertake as part of that review. The first will be the release of a consultation paper, which is being prepared by the Department. We also plan to invite online submissions in response to that consultation paper. We're envisaging virtual roundtable sessions with key stakeholders, and on that basis we will prepare some advice and options to government on the preferred model.
Okay, thank you. And what time frame are you working to on that?
We intend to have that process completed by May this year.
Okay. And have you identified the key stakeholders that you'll invite to the roundtables?
Not specifically in terms of which stakeholders to which roundtable, Senator, but obviously we'll conduct a very broad consultation process, and those stakeholders are well known to us through the process by which we've considered this model
Yes.
over the various stages.
Yes, thank you. Will there be any budget implications for the decision on costs?
Not that I'm
Yeah,
immediately
I can't
aware of.
foresee any either, but I'm just wondering with the May timeframe whether you need to get it done before budget or not.
No, Senator, that timeframe isn't aligned to a budget
Yes.
process.
Okay. All right, well, look, thank you. I'll look forward to following that process and engaging with it and hopefully getting a good outcome that empowers people to stand up for their rights at work without being worried about cost orders. Can I move now to some questions about the lobbyist register? I'm interested in the work that the department might do to identify lobbyists who are engaging with government or MPs who aren't on the lobbyist register. So I just want to start off with some preliminary questions so I understand the process. What does the department do to make lobbyists aware of their obligations to register under the lobbyist register?
Senator, I might start and then pass to colleague Simon Newnham, Deputy Secretary, Integrity and International Group. Senator, what I can say is that there is I would describe it as a proactive engagement by the department on this front, and I particularly point here to the website that we have that's regularly updated, that's had in, I think, 2022, just under 18,000 visits from about 8,000 users. We engage with lobbyists regarding their obligations via fact sheets and information documents on the website. We respond to email inquiries and, of course, take a series of questions from potential lobbyists or current lobbyists. And equally, I would note we would monitor information that's available in the public realm as to whether or not there needs to be further action taken.
Okay, thank you. Is there a process for regularly reviewing the register and identifying anyone who you know is a lobbyist but isn't on the register?
There is, Senator, and I'll pass to my colleague, Mr. Reeve, please.
Thank you, Senator. Parker Reeve, Acting Assistant Secretary, Transparency and Administrative Law Branch. So yes, Senator, we do regularly cross-check the lobbying code against the Foreign Influence Transparency Scheme, which also regulates lobbying.
Sorry, could you speak a little more slowly? Cross-check the...
We regularly cross-check the lobbying code and lobbyists registered on the register against the Foreign Influence Transparency Scheme that regulates lobbying activities in a different context.
Yes.
We regularly review media activity, media reporting that purports or alleges lobbying activities to determine whether persons should be registered on the code and engage with them proactively. And we receive and respond to reports from other government officials where they have concerns that a person may be engaged in lobbying activities and is not registered on the code.
Okay. And would you undertake any sort of investigation, and what would the nature of that be if you became aware through whatever means, whether it's from media or notification from other MPs that you've just mentioned, would you investigate if you became aware that a lobbyist was not registered?
Certainly, Senator. So we do regularly undertake investigations where there is some sense that a lobbyist may be engaging in unregistered lobbying. Of course, the nature and extent of that investigation will depend on the facts of each case.
Yeah, just out of interest, if that's a regular thing, how many have you done, say, in the current financial year?
Thank you, Senator. So in the 2022 calendar year, rather than the current financial year, we've investigated 10 matters under the code.
Was that roughly about the same for previous year?
I would have to take that on notice, Senator,
Yes,
on the
please.
detail,
Thank
but I suspect
Thank
it
you.
is roughly about that.
And what do you do if you find out that a lobbyist isn't registered, but they've actually been lobbying and they're not on the register when they're meant to be?
Certainly, Senator. So the starting position is that we do then either request or recommend that lobbyist register under the code, and then depending on the circumstances, we would consider other action.
Are there any sort of penalties or legal action that is available to you? And if so, have you done any of that?
So, Senator, unregistered lobbying constitutes a serious breach of the code. That's set out in Section 5 of the code. There are penalties available under the code, which include the option for the Secretary to deregister lobbyists from the code or to bar them from registering in the future. And that has a flow-on implication then to their ability to meet with government officials where they are not registered on the code. We have not exercised that power to bar lobbyists from registering under the code. That was introduced in February 2022, following some amendments made by the former government. We haven't had a case that has arisen to date that we have concluded that has required that level of response.
Sorry, what was that last sentence, please?
We haven't had a case that has arisen
Have
to
not
date.
or have?
Have not.
Have not. Okay, right. So that's are they the only penalty mechanisms? There's no further action you can take? Rather, is there any further action you can take?
No, Senator, those are the
that's it.
deregistration or barring from registration are the available options under the code.
Great. Okay, thank you. Well, that's been useful context. Can I go now to a few specific situations? Last year, the media reported that a company called Synergy 360, led by Mr David Milo, was meeting with former Cabinet Minister Stuart Robert. And at that time, Mr Milo was not registered as a lobbyist. Did the department take any action to ask Mr Milo if he should register as a lobbyist? And if so, what was the outcome?
Senator, I can start on that line of questioning. As you may be aware, Synergy 360 is not currently registered on the register. There is an active consideration of that matter by the department. We have requested information from Synergy 360, and we will continue to analyse and assess that information as it's received, and we'll take that into account before determining what further steps may be necessary.
Okay, when did you request the information?
We wrote to Synergy 360 on the 25th of November 2022. We received a call on our register hotline that same day, and we have since written again to Synergy 360 on the 7th of February this year.
Have you received a substantive response?
To this point, Senator, we have not.
Okay.
That was only a few days ago.
Yes,
Yep.
that's true. So without registration, how does the department have any way of knowing how often either Mr Milo or Synergy 360 met with people in this building?
Senator, it's a mechanism that works best when there is cooperation with those in which we have engagements, and so we're seeking to take that exact same approach as we would with any matter with Synergy 360, and we'll draw from the information they may be able to provide to us. I would note that separately, Services Australia and the National Disability Insurance Agency are reviewing some of the procurement and contracting practices that were reported in the media, and of course we've engaged closely with them both on the terms of reference and in the conduct of that inquiry, and I would characterise it as we'll take our inputs then from both Synergy 360 but also once Dr Watt, who is heading up that process, provides some findings in relation to that and then determine next steps.
Okay, thank you.
Senator, if I can just, I mean, Mr Reeve noted it. I mean, one of the things that is really important is that all members of Parliament are aware of the requirements around the lobbyist register, and we do. There have been several examples of where we've been contacted by members of Parliament who have concerns that people have contacted them that they aren't on the register. So it does rely a little bit on the understanding of members of Parliament and their preparedness to engage with us as well.
Chair, I've got about 5 more minutes of questions and then I'm finished. Are you
have
okay if I continue?
minutes.
Yeah, thank you. Just another example now. Former Labor Cabinet Minister Graham Richardson was registered as a lobbyist in November of 2022, I'm informed, and yet the Australian was reporting in March of 2022, some 8 odd months prior, that Mr Richardson had commenced work at lobbying firm Premier State. So does the department have any insight or understanding into why Mr Richardson did not register until that 8 or 9 months after it was reported that he'd started with the lobbying firm?
Thank you, Senator. I think I'd need to take that on notice on the detail of the answer, but my recollection of the matter, there is a delay in the registration process.
Sorry?
My recollection is that there was a delay in the registration process.
Well, there was clearly a delay, but was the delay at your end or his end?
I'd need to take that on notice, Senator, on the detail.
Okay. Which raises the question of whether there are ever processing delays at the department's end?
Senator, we have some performance metrics in place around the timeliness of registrations. Just jumping to those. I would also need to take that on notice, Senator,
That's
around the
fine.
timeliness,
Thank
but
you.
we do have metrics.
Okay, yes, I'll look forward to those. Thank you. Did the department contact Mr Richardson at any stage to advise of his obligation to register?
I'd need to take that on notice, Senator, but I understand there was engagement with Mr Richardson.
Okay. Do you know when there was that engagement and
I
what
would need to take
nature
that
it
on
took?
notice, Senator.
Okay. And do you have any record of how many meetings Mr Richardson held with ministers or shadow ministers between that time of March 2022 and November 2022 when he registered as a lobbyist?
Senator, I'd need to take that on notice to see if we have details of that.
Yes.
I think,
and if so, how you are able to, because as we had this discussion, if it's a bit circular and you're relying on people disclosing and yet they're not on the register, it's pretty hard to have oversight of something that you don't have oversight of. So if you can, on notice perhaps as well, advise me how you tackle that somewhat pernicious situation. Sorry?
The known unknowns.
That's right. It's very Rumsfeldian, if I can dare to put that on Hansard. And can you advise me, please, if that delay in registration breaches the lobbying code of conduct? Mr Richardson's delay, not any departmental delay that may or may not have happened?
I can take that on notice, Senator.
Okay. And are there any sanctions for either Mr Richardson or Premier State relating to the delay?
I would have to take that on notice also, Senator. Of course, that would depend on the facts of the case.
Okay, so you're still waiting for the response. You've sent the 2 letters now. It's been a week since the second letter, and you'll then decide what to do once you get the response?
Senator, I think that's not an unreasonable characterisation. I would just, parking for a moment the specifics of Mr Richardson, which I don't have details on, what I would note is you asked earlier about the number of complaints that had been received, and the answer to your question there was 10 in the calendar year. And just to give you an idea, in some of those cases we found no breach of the code. In other cases we were unable to make a determination, and in one case at least there was a confirmed breach, but it was determined that no further action was required. It was an accidental and of a minor nature. So there can be, a range of different circumstances in play. As to your sanctions question, we've mentioned already the option, I was going to say rarely used but not used yet, for the Secretary to bar a lobbyist. But I would also note there are deregistrations of existing lobbyists as well. So, and there are statistics on that as well. So again, I'm not commenting on the specific case, but I'm just giving you a sense of the way that framework operates.
Yes, thank you. How many, so you said of the 10 there was only one actual breach, and that was in the 2022 calendar year.
That's right.
Can you provide for me on here, if you can, or on notice if not, the numbers of actual breaches for, the last 5 calendar years?
We can certainly do our best.
And again, is it a similarly low quantum?
We can certainly look at that, Senator. The department assumed administrative responsibility for the code.
That's right. There was a complex
transition
changeover and it was
period.
back and forth and it took forever to transition. Yes, I remember
so
that.
for that period that it was administered by the Department and Prime Minister and Cabinet.
Okay, well,
I'll
just
need to
you
see
do
if we
your
hold
bit
that
and
as
I'll
records.
take it up with
Do our
them.
best.
Thank you.
Yep.
And just lastly, in-house lobbyists, that was a glaring hole in the code. Has that been fixed yet?
So, Senator, the code at present requires lobbyists to register in relation to activities they undertake on behalf of third-party clients.
Yes, okay, so that loophole is still there. Perhaps this is one for the Minister, or I'm not sure what I call you, Senator Chisholm, Acting Minister, person representing at the table, who I now have to ask. Is there any discussions about closing that loophole whereby in-house lobbyists who work directly for the company as opposed to working for a lobbying firm are not actually covered by the lobbying code of conduct, because it's such a farcical exemption?
Thanks, Senator Waters. Happy to take it on notice and provide a full response from the Attorney General.
Great. Thanks, Senator, Minister. Thanks. Thank you, Chair. That's all from me. And can I just say to Ms Chidgey and the integrity team, well done on persisting. I'm very pleased that we've finally got an ICAC. So thanks to everyone in your team for all their work on that.
Hear, hear.
Thank you,
Senator.
I'll make sure everyone in the team, but under Sarah's leadership, was a great job. Well done.
Thank you, Senator Waters. Senator Scarr, you have questions in this outcome? You think?
Yes. Can I... Secretary, I think I might have failed miserably my colleague, Senator Mackenzie. I can't remember. Remember, Senator Mackenzie came in and she had a short question she was seeking an answer for. Was that in the previous outcome or this outcome?
Mr Lewis would be the relevant person to assist on that.
I think Senator Mackenzie's coming. Are you happy, Chair, for us to give Senator Mackenzie a chance to ask that question?
If she's here before other senators have exhausted their questions, but if you have questions on this outcome, you should put them.
Okay. Well,
otherwise,
I'll do
Senator.
So I just want to put a peg in the ground.
Senator Shoebridge has questions. If you.
Oh, I've got questions.
Okay.
So, yeah.
Let's get to them.
So, Australian Law Reform Commission. We're talking about that now? Okay. First document, I've got a copy of, assist you, Mr Newnham. The process by which the Attorney-General went through in selecting the Honourable Justice Stephen Rothman to act as a part-time commissioner at the Australian Law Reform Commission. During the last estimates, I think the Minister took a question of mine on notice, I asked the process the Attorney-General went through in relation to the selection of the Honourable Justice Stephen Rothman to act as part-time Commissioner of the Australian Law Reform Commission. Senator Chisholm, you helpfully answered, as the Secretary outlined, I went through the normal process. If you want a copy of this, I've got it. But, if there's anything the Attorney-General wants to add to that, I'll make sure that we include it. And I made the point I wasn't reflecting on the selection, and I continue not to reflect on the selection. I was interested in the process. And then the answer I got was simply an endorsement, if you like, with respect to the suitability of the Honourable Justice Stephen Rothman to be a part-time commissioner. So, which was a non-responsive answer to my question, which went to process. It didn't go to the Honourable Justice Stephen Rothman's suitability, and I was very clear in that respect. Can I once again ask, what was the process the Attorney-General went through to identify and then to determine that the Honourable Justice Stephen Rothman should be appointed a part-time Commissioner of the Australian Law Reform Commission?
Sorry, Paul, I just have to make a short declaration here. When I was at the bar, Steve Rothman was my floor leader when I was at the bar, and for a good many years when I was at the bar and that prior association, I can assure you I was no part of the selection.
Okay, all right. Well, I've got an answer from a committee member. I'm actually looking for an answer from the Minister at the table, actually, or from the Deputy Secretary. Can you assist?
Yeah, Senator, I think we can. If it's all right, I might ask Mr Clark, because your question goes specifically to process.
Correct.
We can certainly talk about the framing and orthodoxy of the appointment, but let me throw to Mr Clark.
Correct.
Yes, Senator, happy to assist you with that. So obviously Justice Rothman's appointment was for a part-time ALRC Commissioner for a time-limited inquiry, and we followed past practice in relation to that. His appointment will expire at the conclusion of that inquiry. So I just wanted to make that point, because it may be a different process, but I can come more directly.
Please keep going.
I'll come more directly to your question. So what I can provide you with is some information about the department's role in that process. So between the 29th of July and the 30th of September last year, the department provided the Attorney-General's Office with advice and information on a range of potential candidates, and they were candidates with expertise in human rights or anti-discrimination law who might be able to assist the Commission in the conduct of that inquiry. And I can confirm that the Honourable Justice Stephen Rothman AM was a person included in that process. It was then on the 27th of October last year that the department was advised by the Attorney-General's Office that the preferred candidate was Justice Rothman, and that he was available to conduct the inquiry, and that availability had been confirmed.
So that was the department's role in assisting the attorney with the process.
So, Mr Clark, did the attorney communicate to the department prior to its compilation of a list of potential candidates that Mr Rothman should be included on the list?
It was afterwards, Senator. So just to go back, it was between the 29th of July and the 30th of September that the department provided advice in relation to potential candidates. That included Justice Rothman, and it was the 27th of October that the attorney's decision was communicated to us.
Okay, so there was no consultation with the Attorney General's office with respect to identification of Mr Rothman as a potential candidate prior to the Attorney General's department compiling the list of suitable candidates?
Not by the department, that was the department's role.
No, there was no communication from the office as you were compiling the list?
Not that we're aware of, no.
Okay. The attorney is on record of characterising certain members of the Administrative Appeals Tribunal as failed Liberal candidates. Are you aware of that commentary, Mr Clark?
Broadly, though, I am at risk of being outside my responsibilities for my division, but yes, Senator.
Okay. Were you aware that when you were compiling this list of potential candidates for this position, that Mr Rothman had in fact stood as a Labor candidate for the federal seat of Wentworth in 1984 and achieved a swing against him actually of 5.3%?
I can confirm, Senator...
even one back in 1984, going back a while.
Were you aware of that? Were you alive then, Mr Clark?
I'm quite tempted to give you an answer of my lived experience of these things to follow in Mr Lewis's footsteps, but I'll refrain.
He's quite vocal in preschool as well.
I should, however, in seriousness say, in terms of my recollection, I was not responsible for the division at that time, so I'd have to take that on notice.
Okay. Is Ms Jones, is there anyone here who can advise us whether or not they are aware of Mr Rothman's previous political candidacy?
I'd need to take that on.
In 1984.
In 1984, but as I said, the Attorney General has called members of the AAT failed Liberal candidates. I will not use that term with respect to Mr Rothman. I actually admire the fact that he put up his hand as is right in relation to Australia's democratic processes, and I make no judgment with respect to Mr Rothman in that regard, and it gives me confidence that he was the floor leader for Senator Shoebridge in relation to his prior life. But I just make the point that Mr Rothman was a previous candidate for the Labor Party, had a 5.3% swing against him actually, but probably not a bad result, Minister Chisholm, based on your experience for a by-election, 1984. So I just make that point. I'll move on then to what is actually occurring in terms of the inquiry itself. So who's actually assisting Mr Rothman in terms of this process, in terms of, from the department's point of view with respect to the preparation of the report?
Well, Senator, that's being conducted by the Australian Law Reform Commission itself, so the department doesn't have a direct or substantive role in relation to the inquiry itself.
So I want to table, and I think it's convenient to deal with this here because I have some questions for the Minister. First, a media release from the National Catholic Education Commission, dated 31 January 2023. And secondly, an article from the Australian Today, 14 February 2023. Oh, here we go. I've got copies and I'm on here. So that's the Australian article. And would you like to do anything else with that? Oh yeah, so you've got copies of that. Yeah, so if you want to distribute those. Minister, do you have a copy of both documents?
I read the Australian already, Senator.
First thing I do every morning.
I read it last night, actually, if you're really
So do I do,
dedicated.
actually. Oh, 1 a.m. Thank you. And you've got the media release?
Yep.
Okay. Minister, I quote from the media release, the National Catholic Education Commission is extremely disappointed with the proposed reforms outlined by the Australian Law Reform Commission in its current inquiry into religious educational institutions and anti-discrimination laws. National Catholic Education Executive Director Jacinta Collins said if the reforms proposed in the ALRC consultation paper were to be adopted, it would be a major blow to authentic faith-based education in Australia. Quote, at the National Catholic Education Commission meeting today, our education leaders across Australia were very concerned by the narrow approach taken in the ALRC paper. The proposed reforms failed to provide real protections for religious schools to effectively operate and teach according to their religious beliefs and ethos, Ms Collins said. And the statement goes on. I'm not going to read any further from the statement. It causes me grave concern that such a reasonable and well-considered education leader as Ms Collins, who served with distinction in the Australian Parliament, would make those sorts of comments, which I'm sure have been deeply considered. What is the attorney's response in relation to those comments which have been made by Ms Collins and the National Catholic Education Commission?
Thanks, Senator. And I think the important thing to note, and it was reflective in the statement put out by the Catholic Education Commission, is that this is a consultation paper. So it is one that has been put out where we are engaging, or the ARLC are engaging in consultation. It sets out a number of propositions with preliminary views on issues that have been referred to it. We understand some stakeholders, particularly in the Christian school sector, have reacted negatively to the consultation paper, but it's important to reflect that this is a consultation paper. It's precisely that. It's not finalised its advice to government, and it is part of the process that they're going through, which the Deputy Secretary might be able to add more as to that consultation process.
Senator, happy to add to that. Thanks.
Yes, please.
Thanks, Minister. I would really just acknowledge, of course, that this has got a process that's got a way to go. It is the first stage in the consideration of these issues. It is an input to government's consideration of future legislative changes. And just to map for you, Senator, the terms of reference, of course, were provided to the ALRC on the 4th of November. On the 9th of January, survey opened with individual views and experiences. The 27th of January was the consultation paper you've referenced and which is reflected in the press commentary. The 24th of February is actually when the submissions on that paper close, and then the 21st of April is when there's a final report. And I suppose, Senator, it's worth just noting the ALRC was asked to look at this, was asked to look into its terms of reference, will operate and take soundings on the issues from a range of stakeholders and bring that together with a set of recommendations for government in April. And we would just acknowledge that that process has a way to run at this point.
Okay, thanks, Ms Newman. Minister, when I was reflecting on this, and I read this statement and I read the article in The Australian, the thought occurred to me, under the previous government, we had the Ruddock Review, which you'll be aware of in relation to religious freedom. And as part of that review, there were actually a panel of 5 experts. So you had a previous Liberal Attorney General, but you also had people such as the current President of the Australian Human Rights Commission and other notable experts. What consideration, when he went down on this path, did the attorney give to actually setting up a sort of Ruddock review process where there was more than one eminent expert actually involved in preparing consultation process and engaging in the process we're now engaged in, to make sure that there were inherent checks and balances so that, to be frank, we wouldn't end up in the position we seem to be in today?
Well, I wouldn't preempt the position we're being in. As I said, we're going through the consultation process. I would have to come back to you on notice with details about what thought process the Attorney-General went through in terms of deciding this to go through, unless the department had anything they had to add on that.
Well, Senator, I could offer a little bit of background on the way those terms of reference came about and the consultations that led to them and then what's expected ahead. And what I could say there, Senator, is that those terms of reference, I think we might have said this last time, but worth repeating, were developed by the Attorney-General's Office in consultation with stakeholders, and they included religious organisations, the education sector, unions, legal experts, other civil society representatives, and in particular meetings with, well, there's actually a big list, I'm happy to go through it, Senator, but a range of peak bodies. The direction to the ALRC to undertake targeted consultations expressly noted they should involve, for example, civil society representatives, etc. So I suppose, Senator, what I'm getting to here is both in the creation of those terms of reference and then the expectations about the conduct of the ALRC, and Justice Rothman is the head of it. It is expected to have appropriate and wide-ranging consultations and submissions taken, which would then go to an input to government, and the government can make its mind up about what it does with those inputs.
But Mr Newman, you take my point. There's a difference, a fundamental difference between the Ruddock Review and the review consultation which is being undertaken by the Australian Law Reform Commission, insofar as the Honourable Philip Ruddock was president of an expert panel of 4 or 5, I just can't remember, eminent experts considering the matter, as opposed to a single commissioner taking the lead. There is that inherent difference with respect to the structure of how these two reviews are being undertaken. Isn't that correct?
Senator, I absolutely accept your characterisation, and I understand that, and there are different ways in which these can be put together. I would just, again, note that this appointment is anchored in orthodoxy. This is a part-time appointment of somebody of eminent stature, which does reflect the way in which other appointments to the ALRC, as I understand it, have been affected, but also noting the inputs then into that process are expected to be wide-ranging and therefore draw from, I would say, a range of views.
Mr Clark, do you have anything you want to add?
Senator Scarr, just quickly. I think the obvious point would also be that the Ruddock Review didn't lead to a successful outcome either.
Oh, and I don't disagree, Minister. And in fact, sitting on this committee, I was intimately involved with the discussions with respect to the previous draft legislation. So I'm well aware of how fraught this issue is in terms of competing stakeholders and the complexity of it. Which is, to be frank, why I'm disappointed we seem to be heading to the same spot.
Well, I think you're sort of prejudging an outcome, which I think is too early to do so.
Okay.
Some people's view would be, well, that shows that the process is working, and concerns are being highlighted as we go through the consultation process.
Okay. Well, let's talk about that.
Sorry, Senator Scarr, I don't want to interrupt you. We do have to suspend for afternoon tea, so if you want to come back to these questions, if you have more to go, or you can put a few of them now, it's really your call, but we will be breaking.
I'm happy to suspend and come back.
Okay. Thank you. The committee will suspend and we'll return at 3:30. Senators, we'll resume the hearing there. We are still with the current outcome, the Integrity and International Group, and Senator Chandler, you have the call.
Thank you very much, Chair. I have some questions regarding the...
Sorry, Senator Chandler.
Apologies.
Sorry to interrupt, Chair.
Yeah. Oh, good.
We just had a clarification we wanted to provide.
Excuse me. Thanks.
If we could just have provide a clarification to Senator Scarr on something relating to the ALRC.
Thanks very much, Chair. To repeat my name again, Simon Newnham, Deputy Secretary, Integrity International Group. Look, just three quick points for you, Senator Scarr, just to be sure that we've given you the accurate picture. I would just note in the terms of reference on the religious educational institutions anti-discrimination laws, the consultation paragraph within those does explicitly reference the ALRC having regard to the extensive consultations previously undertaken, and in particular directing the ALRC to review submissions to previous inquiries and tailor their consultations accordingly. So I wanted to make sure that was clear in previous comments I'd made. The second point is, just in the time that we've canvassed not only the officers at the table but colleagues watching back in the department in relation to your question about knowledge of Justice Rothman previously running for the seat in 1984, and the answer is yes for the Labor Party, and the answer is no one that we were able to canvass in that time had any knowledge of that. And there is a third issue too, Senator, I might just throw to my colleague Mr Clark.
Yes, thank you, Mr Newnham. So, Senator, just to come back, I gave you some dates where the department played a role in the process of assisting with the attorney's decision on the appointment of the commissioner. And I just wanted to make clear that that was quite a fluid process. It was a process of back and forward and exchange of potential names, candidates, information and advice about the process. And it was in that context that information about that Justice Stephen Rothman was provided. And as Mr Newnham has said, that information did not include any reference to a standing for office in 1984. It wasn't something about which the department was aware.
Well, I'll have some follow-up questions just in relation to that clarification. Can I just thank whoever's listening who provided that that clarification? It's deeply appreciated because I think it helps the committee work very effectively. So thank you, officers. Sorry.
No, thank you. Thanks, Senator Polley. We're going to Senator Chandler now. Thank you.
Thank you very much, Chair. I have some questions, as I was saying, regarding the potential terrorist listing of the IRGC and the department's advice regarding it. I was wondering whether I'm best putting these questions now or waiting until the National Security Group section.
So it is the responsibility of the National Security Group that's coming next.
Right. I just don't want to get into a situation where I sort of ask the questions in National Security Group and then we say that they should have been addressed in this section. But if you're confident that that's the best place to do it, then I can wait until the next section. Thank you very much.
Thank you, Senator Chandler. Senator Scarr, you had some more questions in this outcome.
I did. So in relation to Senator Mackenzie's question from earlier today, can we take this opportunity, Secretary, to clarify who's the instructing department in that context?
Yes, I can, Senator. So it is this department. We are instructing in this matter as it raises a constitutional issue relevant to Section 90 of the Constitution and the role that the Section 90 of the Constitution provides for the Commonwealth to raise excise taxes, and so we've intervened on the basis of addressing that issue.
Okay, so it's wholly contained within the Attorney-General's department. You're not liaising with any other department in terms of the decision made to, in the case we're talking about just for Hansard, is Van der Stok and another versus the State of Victoria, correct?
That is correct. So we have been engaging across government with Treasury, with infrastructure and environment at different points in the process, but ultimately it's the key issue for the Commonwealth was the issue around the constitutional interpretation, and so we are the instructing department.
So this is your lived experience, Mr Lewis? Sorry, you don't have to answer that. Okay, thank you very much. I've got some more questions then in relation to the religious discrimination inquiry, if I can, and thank you, Mr Newman, for your points of clarification. So I've got some questions just flowing from that, if I could. So you mentioned the first point, you mentioned the terms of reference. So I'm interested to know, how were those terms of reference formulated? Was that something, did the department actually prepare a brief for the attorney? If so, when? Were there other options considered in terms of the terms of reference, including whether or not perhaps the matter should be considered by something similar to the Ruddock Review instead of going to the Australian Law Reform Commission?
Senator, thank you. And maybe I'll start,
Sure.
but I'll call on colleagues with a little bit more detail if that's available. I'll probably just return to the point that they were developed by the Attorney General's office. That was done so
in the first instance?
Yes.
Right. Before the department got involved?
That is my understanding, and I'll make sure I've got nods from colleagues. Please.
I'm just noting everyone's nodding, so that's everyone's understanding. Thank you.
What I was just going to go on to say, Senator, was that was a process taken in consultation with stakeholders. It wasn't done in isolation, and a series of religious bodies, education sector unions, legal experts and other civil society representatives were involved.
So at what stage, Mr Newman, were they involved? Were they involved as part of the Attorney General's office, ministerial office, coming up with the terms of reference, or were they involved after the department was brought into the loop?
Senator,
what I'm saying?
I think the safest bet would be to ask my colleague, Ms Nawaz, to come in on this, please.
Senator Aisha Nawaz, I'm the Assistant Secretary in the Human Rights Branch. Senator, I can confirm that the consultation that was undertaken by the Attorney General's office occurred around the development of the terms of reference.
Before the Attorney General's department got involved?
Yes.
Correct?
Now, Senator, can I just add the Attorney General's department attended those consultations, and there is a quon that we put forward in response to Senator Rice's question at the last estimates that I can also draw to your attention about the department's involvement, but it was the Attorney General's office who ran the consultations, and the purpose of those consultations was to consult on the terms of reference.
Okay. Do you know when the final decision was made around the terms of reference?
Senator, the terms of reference were actually issued by the attorney on the 4th of November.
Right, so the final decision was for November, is that
Yes.
how I interpret that?
Yeah, and that aligned with the announcement about the ALRC review and Justice Rothman's appointment as well.
Okay. Do you know, so presumably it's consultation, and that's good. Were there changes made to the terms of reference through the period of consultation?
I'll have to take that on notice.
Could you
Senator.
take that on notice? I'm just interested to know if if the consultation was positive in the sense that there were tweaks made to the terms of reference, and also interested if you could take on notice whether or not the consultation included the way in which the inquiry would proceed, in terms of whether or not it was appropriate for it to be led by a single commissioner under the Australian Law Reform Commission, or whether or not any of the stakeholders suggested another route, such as, for example, the way the Ruddock Review was conducted. Could you take that on notice?
Senator, I'll take that process on notice, but my recollection is that the consultations related only to the terms of notice. I'll double check. Sorry,
Okay.
terms of reference. I'll double check that.
And I'm just trying to, Mr Newman, dovetail that process with the appointment of Justice Rothman. Was he selected prior to that process of settling the terms of reference occurring?
So, Senator, what I can say is that we were advised on the 27th of October that Justice Rothman was the preferred candidate to head up the review. But I can't answer precise. I know, of course, that is before, I think it's the 4th of November is when the terms of reference were issued. I couldn't speak to the moment at which they were decided. I just know that there's a 27 October decision on the appointment and a 4 November release of the terms of reference.
Okay, so if you could take on notice whether or not Justice Rothman himself was involved in terms of settling the terms of reference, or in terms of the consultation on the terms of reference before a final decision was made. If you can answer it now, that's fine.
Well, I think, yeah, we're happy to take that on notice.
Okay,
Senator.
all right. All right, I want to now turn to the issue with respect to the knowledge around the candidacy And in fact, I should say, and we talked about the 1984 Wentworth by-election, Mr Rothman was also a candidate for pre-selection for the seat of Debelle in 2003 for the Labor Party. Were you aware of that, Mr Newman?
I certainly wasn't, Senator, and we could do the same process again by checking with colleagues if that would
if you could,
help
if
the
the colleagues are listening.
At the office, they knew nothing about it.
No, we're at Dobell now. 2003. So this is, and look, I return to my initial comment around His Honour Justice Rothman. He's right to run as a candidate, but I note that he was a candidate in an actual election in 1984 and then stood for pre-selection to be the Labor candidate in Debelle nearly 20 years later, which does indicate a long...
Still 20 years ago.
No, true, but it does, Minister, it does indicate a long-term interest in terms of politics. So can you just take me back to you had no knowledge, the department had no knowledge with respect to that involvement?
Well, what I could say, Senator, is that the straw poll of those at the table, I can confirm that no one at the table was aware of that, but I would have to do the same thing we did a moment ago, which is just check with colleagues. But I think I know the answer, but I'd like to await confirmation from colleagues.
I'm happy for you to wait. That's absolutely appropriate. And then you talked about, Mr Newman, when you gave the three helpful clarifications, you talked about it was an iterative process.
Yes.
Can you just drill down, what does that mean in practice? So I guess just to give you a hand, and I'm not looking to put words in your mouth, the question in my mind is, an iterative process could be the department comes up with the list of 10 potential appointees, that goes up to the Attorney-General, the Attorney says, gee, not sure about 1, 2, 3, I like 4, 5, let's have a discussion about that. Or it could actually involve the Attorney actually proposing some additional names to be considered. So I'm interested to know whether or not the Attorney-General's department proposed additional names and whether or not one of those was His Honour Justice Rothman.
Thank you, Senator. I think it's a bit of column A and a bit of column B in this circumstance, that it was an exchange, and some names came from the Attorney-General's office and some names came from the department, is my understanding, and that there was requests for information and advice about candidates and their experience and their background, and I highlighted before their experience in relation to human rights or anti-discrimination law. I wasn't personally involved, so I'm just going to be a bit cautious about what I say, so I can take the details of that on notice, if that's all right, Senator.
Yeah. So the general question is whether or not it was a situation where the department provided names and the Attorney-General's office provided additional names for consideration. The more particular question is whether or not Justice Stephen Rothman's name originally initiated from the Attorney-General's office or from his advisors, or whether or not it initiated from within the department itself, without any communication between the Attorney or his office and the department. Do you understand?
I understand the question, and it's a very clear and direct question, and I'd want to take it on notice to make sure I'm right in
and you're
responding.
absolutely entitled to. I'll just ask a few quick additional questions just in relation to this, just to flesh it out. Mr Newman, did you have anything you wanted to add?
Oh, no, sorry, I was just getting handed some documents.
Oh, okay.
No, sorry.
Was the role publicly advertised? So as part of the Attorney-General Department process, did you actually publicly advertise the role or not?
No, it wasn't advertised.
Okay,
Senator.
thank you. What were the selection criteria? Did you have an actual list of selection criteria you're working to?
So perhaps if I can step back, and why I prefaced my answer previously to emphasise the point about a part-time commissioner and for a limited inquiry. So I wanted to distinguish that from a permanent appointment to an office in the Australian Law Reform Commission. The requirements for that appointment are set out in Section 7.2 of the Australian Law Reform Commission Act, and that process, or those considerations and requirements, were addressed.
So what's the, if I can just hold you there, what's the difference in terms of the process between the appointment of a part-time commissioner as opposed to a full-time commissioner. So presumably it's a less rigorous process because it's a part-time position. Is that correct? Can you just highlight the difference in process if you could?
I'm conscious of getting outside my lane, Senator, but let me say this. In relation to part-time commissioners and time-limited inquiry, there is a past practice, and in that circumstance, it was we consulted the APSC Merit and Transparency Guidelines, where there are relevant exemptions for the requirement to run a full selection process, where there's an urgent requirement to fill a position, as well as the availability of an eminent person. They were the kinds of considerations I had in mind when answering the question.
Well, if you can take on notice, and if there are any other decisions, the actual appointment itself, is there a difference between the appointment itself? Does it, in terms of the formal instrument and who does that?
Yeah, that's the bit that's outside my lane, Senator, so I will take that on notice.
Okay, all right, if you could. In the process of you compiling your list, did you approach candidates directly? How do you compile this? Presumably you've got to talk to people before you put them on the list or soon thereafter. When do you actually talk to candidates?
So my understanding is in this process, it wasn't the department that was doing that direct engagement with candidates. So as I mentioned earlier, for example, the availability of Justice Rothman to do it was communicated to us by the Attorney General's office. Our role was to consider potential candidates as a department. For example, my team, I understand, reached out to others areas of the department that might be involved in similar appointments. You'll appreciate that one of the categories of potential appointees is a serving judge, as I understand it. So we would have done that kind of consultation internally, but to my knowledge, there wasn't. It wasn't the department's role, and we weren't requested to do that direct engagement with potential candidates.
So how many candidates did you consider as a department?
I'd have to take that on notice.
Can you take that on notice? Thank you. And was there a final submission that went up to the attorney for sign-off with a recommendation, or how did the end process occur?
That's outside my knowledge, Senator. I'll just pause and see if Ms. Nawaz has any information about that, or whether we'll take it on notice.
But
yeah, we'll take it on notice.
And maybe it's a chronology of all the steps, just stepping us through that would be good. And also whether or not as part of that there was any requirement for any of the candidates to provide a list of potential conflicts as well as part of the process.
We can take that on notice, Senator.
If you could. What's the salary for a part-time commissioner? Oh, you can take that on notice too if you need to. Okay. All right, so interested in the engagement between the department and the Attorney's Office throughout the process, so if you can detail that, that would be excellent. As well as Her Honour Chief Justice Susan Kiefel being an outstanding Queensland legal mind, there's also Justice Sarah Darrington, who is also an outstanding member of the legal fraternity from Queensland. When did her appointment as Australian Law Reform Commission President end?
I may be able to assist this.
Thank you, Secretary.
Minister. I'm sure someone can assist me with getting that date. I can get that for you. I am chairing a panel to progress the appointment of a new president of the ALRC.
So is Her Honour Justice Darrington, she's no longer the president? Her term has ceased?
She's concluded.
Okay. Did she... Oh, sorry, are you waiting for...
Senator Scott, while the official comes to the table, you're at the end of a time allocation very shortly. I don't know if you can or might be able to find some questions to put on notice. Senator Shoebridge has a few more questions in this outcome, and then we were hoping to...
Yeah, I know. I've got about 5 minutes.
We'll have to come back to you.
Okay.
Senator
I'm happy for you to come back to me and for us to... It won't take me long to close it out.
Senator Shoebridge.
Oh, thanks, Chair. I might just go back to one point that Senator Scarr was addressing. You recall he's asking questions about the critique to the the Australian Law Reform Commission's discussion paper. the critique that came from the National Catholic Education Commission, and I think also from the Catholic Archbishop of Sydney, Anthony Fisher. Do you recall that line of questioning?
Yes.
Yeah. And I think the concern, Senator Scarr was reflecting back the concerns that I think the National Catholic Education Commission had, that somehow it would be an inappropriate restraint on their ability to employ teachers. Do you recall that line of questioning?
Yes.
When you're putting out a discussion paper, the purpose is to get an understanding of perhaps both sides, or even more than both sides, of a complex issue like this. Do you agree?
Yes, and I think Senator Mr Newman outlined the steps that were being taken, and I think the Minister also identified that the Attorney is very keen that everyone who wants to express a view does so during that consultation process, and that the paper is intended to facilitate that process.
And that would include the very many civil society groups who say it is deeply inappropriate that a maths teacher could be sacked from a school simply because they're in a same-sex relationship, or a chemistry teacher could be sacked because they identify as gay or bisexual. That it's trying to reflect those concerns in the community as well, that you put out this kind of discussion paper, correct?
Well, yes, I think, again, as Mr Newnham outlined, the terms of reference speak to a wide variety of groups, including civil society organisations, that the ALRC is directed to consult with. And Mr Newnham identified also a number of those stakeholders that were consulted on the development of the terms of reference themselves.
And indeed, society is a lot bigger than just the views of the National Catholic Education Commission, and very many Australians would be concerned about teachers being sacked for those persons, and indeed I share those concerns. But you would accept that very many Australians are concerned at the prospect that teachers could be sacked for those reasons.
Indeed, Senator, and that is why that this consultation process builds on a number of reports, inquiries, consultations that have gone before it, where indeed we've seen a range of views being expressed on these issues from a very broad section of society.
Thank you. Now, I think that we've finally got to the e-safety codes. Is that right?
It's the next group.
It's the next group?
So once this group is concluded.
All right. Give me 1 second. I'll go back to Paul. You've got 5 minutes, and then I'll just reflect through here.
Senator Scarr?
Thank you.
5 minutes.
And I'll go through this very quickly. Just taking on board Senator Shoebridge's point, I acknowledge that there are different stakeholders who need to be consulted, and there are very passionate views, strongly held views in this space. I deeply acknowledge that. The Australian article, which I tabled, I should note, there's a reference to a letter from 30 leaders from the Christian, Jewish and Islamic faiths. Do you have a copy of that letter? Could you provide that letter on notice, could I ask you? Or maybe the Minister, maybe I need to ask the Minister. Does the Attorney General's Department have a copy of the letter?
You'd have to take that on notice, Senator, in terms of...
I'm happy for you to take it on
notice. Letter went to be honest. Yep.
Minister, you correctly said that this is a consultation process, and the consultation is continuing, and to some extent you expect the differing views to be aired through the consultation process. I do note, and I do want to quote from that Australian article and just get your response to this. And this is said to be an excerpt from the letter that was provided to the Attorney. Quote, "We are doubtful that the ALRC process can reach any balanced outcomes as contemplated by the terms of reference by starting with these proposals." End quote. So the concern I have is there seems to be a lack of faith or confidence amongst significant religious leaders with respect to the process itself so far. How does the Minister propose to address those concerns? Not my concerns, but the concerns of these faith leaders.
Sure, thanks, Senator Scarr, and obviously as many people have said, that this is a complex issue, and the previous government had an attempt to put forward legislation that they abandoned in the lead up to the election. It was an election promise that we made from opposition that we are delivering on in government that said we would refer this to the Law Reform Commission. I would note, just in regards, I just wanted to touch on Justice Rothman. He's a judge of the New South Wales Supreme Court. He was appointed, I think it was in 2005, to be the judge on the Supreme Court. Someone with enormous experience when it comes to the law. He also has experience in the Jewish education sector as well. And he was also awarded an Order of Australia Medal for his work in the Jewish community in 2007. So I think, and I'll be careful with how I say this to Senator Scarr, but
and I've been very careful, Minister.
I understand that, but I think you are skating very close there. But this is someone who has enormous experience, and I don't think an association 20 or 40 years ago should lead people to judge his work. He has a difficult job. The government have tasked him with that through the Law Reform Commission. We've invited people to make submissions. That is exactly what the consultation paper is for. That's what the Catholic Education Commission have taken up. I'm sure other people will, as Senator Shoebridge mentioned as well. They will be listened to, because for us to get this legislation right, we need to listen to all people who have a view on this matter.
Okay, noted. And just for the record, I don't make any reflection on His Honour. I made the comments in the context of comments which have been made by the attorney with respect to members of my side of the politics who have exercised their democratic rights to seek election. Mr Newman, I just have a few final questions, two final questions in relation to the consultation paper itself. Did the department actually have any role in terms of reviewing the consultation paper at all?
No, Senator, the answer to that is no, and appropriately so. This is an arm's length independent analysis that the terms of reference have provided to the ALRC to conduct its work.
Okay, and Minister, did the Attorney General's office have any role with respect to, and you can take this on notice if you like, with respect to providing comment on a draft of the consultation paper?
I have to take it on notice.
Okay, thank you. Thank you, Chair. Thank you. That's no more questions.
Thank you, Senator Scarr. Senator Shoebridge, if you can finish us up on this outcome.
I thought that this was privacy, is that right?
Yes.
Cool. Can you give us an update on where the department's up to on its privacy review?
Senator, thank you, and I'd be very happy to commence the answer, but draw on inputs from a couple of colleagues. What I can certainly offer, Senator, is on the 16th of December, the department's report of the Privacy Act review was provided to the Attorney General. As you would be aware, Senator, review draws on 2 years of consultations on potential reforms, the most comprehensive review of the Act since its inception. Government's currently considering the report, including appropriate next steps to inform future privacy reforms.
Is it intended that the draft legislation will be sufficiently rigorous to enable Australian businesses to apply for an adequacy ruling in Europe under the GDPR, the General Data Protection Regulations? Is that an intended goal of the privacy review?
Senator, I'm going to start this answer, but I'm going to ask Ms Galluccio to come in behind it, because what I would say is, of course, this is with government. It is with government for consideration. Those 2 years were spent talking to a huge range of stakeholders and receiving a large amount of submissions. And the sorts of issues that you've raised in your question were certainly part of that process. And were certainly very closely looked at, as were many issues across the board. In terms of the themes, though, Senator, for your benefit, some of the themes that were coming through was the coverage and the protections in the digital age, noting the world has moved on and this legislation has aged, of course. The extent of transparency control that individuals have over their personal information. ensuring that handling practices are fair and not harmful, and also the extent to which the privacy regulator has enforceability powers and the strength of that role. So, Senator, I know, of course, it's with government, but I will just check if Ms Galluccio wanted to add to my answer.
Julia Galluccio, Assistant Secretary, Information Law Branch. Not too much to add other than the terms of reference for our review didn't specifically task us with looking at that specific question about whether to seek adequacy under EU GDPR. We were looking, I guess, more discreetly at the particular protections under the Privacy Act and looking at a whole range of options for improvement to those protections and looking not only at EU GDPR but other countries as well.
But surely, before the Parliament would engage on, legislating in this space, we would need to know whether or not the proposed reforms would meet that adequacy standard. I mean, the EU is still our third largest trading partner, and it would be I think you agree, it would be unnecessarily complicated if we reformed our privacy laws and then we still didn't meet that standard, and any corporation or entity that was trading in the two jurisdictions had to separately meet the two requirements. That would be an unnecessarily complicated outcome in an already complicated field, wouldn't it?
Senator, let me come in on that. I mean, I think what I would reiterate is this is a series of recommendations to government with government. It is wide-ranging. The point you make is well noted, and markets across the world are grappling with the different standards that they have to meet in relation to privacy protections in different markets around the world, and of course, a consideration then of the extent to which Australian entities are bound by different standards in different jurisdictions is relevant. But I certainly wouldn't be able to preempt a hypothetical consideration of this in the future, Senator.
Well, it's hardly hypothetical because it will be immediate. As soon as the legislation is out for the draft legislation is out for consideration, businesses in Australia, people in Australia are going to be testing whether or not it meets that adequacy standard for the GDPR, and it's going to be a bit of a pass-fail test, isn't it, for the legislation? Because if it doesn't, we're sort of back at base one, where we're requiring Australian entities to separately register in two different jurisdictions for their privacy controls.
Senator, I understand. Thank you. I understand the point that you're making. Why the reason for my answer is this was a comprehensive review. It covers a wide range of suggestions for government to take into account and take into consideration, including potential future reforms to the Act. At that juncture, when those reforms are brought forward, the points you've made then about judgments, including for Australian entities' compliance with other markets, would certainly be a relevant consideration. But until that point, Senator, it would be preempting the ways in which those reforms will be developed.
Well, I could have been wrong, but I heard in Ms Galluccio's answer that it was very much a domestic focus, looking at domestic remedies and the adequacy of domestic laws, when clearly a core part of what any review should be is how our domestic laws would fit into a developing international privacy framework. But I'm happy for Ms Galluccio to correct me if I misunderstood that.
There is a section in the discussion paper that was publicly released which did talk about how to improve cross-border data flows and did talk about the GDPR. So that is something that the Privacy Act review did consider. It's just a little difficult for us to talk about the final outcomes of the report when it's currently with government for consideration.
Is there a time frame that you've been given to complete this work, at least to the point where it moves to some draft legislation or potentially bill?
I think what I can say is the attorney has indicated this is a really significant priority. I have to say that the review, which is something I think is really an exceptional piece of work and very comprehensive, but it's quite large. It will take quite some time to work through. But I would suggest, Senator, that the attorney has set that as a priority. So I would expect that in the not too distant future you'll hear more about next steps in the process.
Secretary, you would be aware, wouldn't you, that the UNSPT met last week to discuss Australia's suspended visit and non-compliance with the extended OPCAT deadline?
I am aware, Senator, and if I can just, we'll just get the right people at the table to assist me in answering any questions.
All right. First of all, how is it that you became aware of that?
Became aware of the
Yes.
SPT.
I'm assuming the SPT gave notice to the Commonwealth that was meeting, but perhaps you
Yes,
could take us through that.
We've continued to engage with the SPT and the subcommittee as we have sought to resolve various issues. But I'll refer to Mr Newnham, who can give you some of the detail on that.
Senator, thanks for the question. In terms of when I precisely became aware of when the committee would next look at this issue...
This isn't some sneaky question to find out if it was Wednesday or Thursday.
No, understood, Senator. But what I would note, though, is we did appear before the Committee Against Torture in November, and whilst they were imprecise with their dates from memory, they did foreshadow re-looking at this in February.
And is there a record of that appearance available to this committee or the public?
It was certainly broadcast live online. I just can't be sure if there was a transcript. It was a long couple of days.
I had a hunt and I couldn't find one, that's all.
No transcript. There was certainly a communique and some findings.
That's what
Yeah.
In terms of the communique and the findings, when were they provided to the Commonwealth?
Check with colleagues, Senator.
And just by way of sense, if you've got them there, if you could provide a copy.
Senator, I can say that the concluding observations on the 6th Periodic Report of Australia is a publicly available document, and we can provide that to you.
Yep.
As exactly when that was provided to us, I think I'd have to take that on notice.
All right. As I understand it, the SPT has indicated that they'll be making a public statement in relation to this matter as early as next week. Is that your understanding?
I'd need to check.
Mr. Clark seems to be nodding.
We had a sense that not long after their meeting, but the last advice I had was that we didn't know precisely when they would issue a statement, but it would come within a matter of weeks.
Mr. Clark?
That's correct, Senator. We have engaged as a department with the Secretariat to the SPT on a number of occasions between the suspension of their visit and in the lead up to their meeting, which was last week. During that process, I think it was in our last meeting in late January, they indicated that they were likely to consider this issue during their session last week, but it could be a matter of a week or two after that before any decision was communicated to us, and we've had no further indication from them since that time.
Given they were denied access by state jurisdictions, I think we can safely assume there's going to be conclusions as to non-compliance by the SPT. Is that the assumption you're running on?
Senator, we don't arrive there automatically, actually. We've had very productive engagements with the SPT Secretariat in person in Geneva and 3 times over the course of recent months, and I expect that will continue. We are certainly working very hard to assure members of that committee of our commitment not only to the convention but actually seeking to have the visit resumed. It is the case, Senator, as you know, we've certainly faced some headwinds there, but what I can say is this is a matter that the attorney has raised with counterparts, that we are speaking to all states and territories regularly about. We're keeping the Secretariat informed, and Senator, we'd like to think we can make progress and get the visit resumed. I would not jump to the conclusion that there will be a finding of non-compliance, as is formally understood at the UN.
Well, as I said, there's a very high likelihood they'll confirm that they're terminating visit to Australia, not just a suspension.
Senator, that is certainly not the advice they've given us.
What if, has New South Wales now committed on the record to providing untrammelled access to the SPT if they return?
Senator, New South Wales has not offered that commitment to this point, but we continue to engage with them and all jurisdictions on this and other issues under the Convention.
Has there been any advice given to the attorney in the event New South Wales continues to be obdurate and not provide that assistance to Commonwealth legislative intervention to require them?
Senator, I wouldn't go into the nature of advice that we've provided to the attorney, but what I could say is that we are in constant contact, both formally through written submission and in various phone calls, etc., with the attorney's staff, but also with stakeholders elsewhere. What I would say, Senator, is a clear judgment has been made about the best way for us to comply with these treaty obligations, not just on the SPT visits, but actually on the creation of the NPMs. And in a federated system like ours, with the expertise, the operational capability, and frankly, a number of oversight mechanisms that already exist in state and territory level, this is definitely considered the best option forward. I would just say as a final point, Senator, because I can see you want to move on, very many of the jurisdictions did receive the SPT during their visit before it was suspended. And those that did not, to the best of my knowledge, indicated they would have been very willing to receive that, except for one, as you know, New South Wales. But we continue to work closely with all
Perhaps if you could provide on notice any communication that you've had with New South Wales, you or the Minister have had with New South Wales in relation to this, and any further details you've had of the exchange between the Commonwealth and New South Wales on this since we last met.
Senator, very happy to take that on notice. I can't promise the substance of those communications because we would, of course, be checking with relevant stakeholders, but we'll do our best.
Thank you, Senator Shoebridge. No other senators have questions for this outcome, so I thank officials and call officers from the National Security and Criminal Justice Group of the Attorney General's Department. By way of update, as those officials make their way to the table, a number of senators have questions in this outcome. I understand that we are about 3 hours behind schedule now. There are agencies that have arrived in the building. Welcome. We are ambitious and we believe we'll be able to get to most of our agencies after the dinner break. It's the usual practice of the committee to have a discussion during the break about whether there's any agencies we no longer required, but we will try to do that as soon as we possibly can. Thank you, Secretary. I have some questions and then I'll hand over to other senators. I wanted to ask some questions about the Safer Communities Fund program under the former government and grants that were provided under that program.
Thank you, Chair. Ms Chidgey is here and other relevant officers will come to the table.
Thank you. I thank the officials. This program, the Safer Communities Fund, there's been quite a lot said about it, particularly by the Auditor General. I just want to go back to those that report and to the earlier rounds of this fund, if I can start from there. The Auditor General report award of funding under the Safer Communities Fund noted that applications for this fund were mostly ranked in accordance with the grant opportunity guidelines published for particular selection processes, and that a transparent and consistent approach was not employed to individually rank applications that had been awarded the same overall assessment score. Just in regards to round 6, Mr. Warnes, I think you might be able to answer this question. Infrastructure ranked each application in accordance with grant opportunity guidelines, is that correct?
Thank you very much, Chair. Andrew Warnes, First Assistant Secretary, Criminal Justice Division. Yes, that's correct.
Thank you. And in terms of on notice, possibly, can you provide the ranking for each of the grants?
Happy to take that on notice.
Is that something you will be able to provide? Do you have that information?
I think we will be able to provide that, Senator, yes.
Okay. In terms of round 6, the early intervention program, were those projects ranked in accordance with the grant opportunity guidelines?
Yes, Senator.
Okay, and I've obviously got the same question. I assume that there is a ranking that the Infrastructure Department gave for each application?
Just checking. Yes, there's also a ranking for those as well.
Okay, and can you provide those on notice?
Yes, Senator, happy to take that on notice.
Thank you. I just want to go to the announcement of some of these grants. And I do want to make clear from the outset that I think the commentary of these types of programs, it's fair to say, in general, is not a criticism of the organisations that were given grants, whether it's under Safer Communities or whether it was the sporting rorts that we saw. I think I just want to make that clear from the outset. These are community organisations mostly, and I don't think they had any involvement in the granting of the program or even the way that they were announced. It's disappointing, I think, for those community organisations that it went, that what we now know through the Auditor General's report is that the rankings were not adhered to. But this awarded grant I want to talk to you about was for the Islamic Society of Victoria. They were awarded $250,000 to fund security infrastructure for the Preston Mosque in March 2022. This is in round 6, Mr. Warnes. In a now deleted Facebook post, Mr. Wood announced that, the former minister, Mr. Wood, announced that I am proud to have intervened in the Safer Communities grant to provide funding. What did Mr. Wood mean when he said he intervened to provide funding?
In relation to the specific grant, Chair, I think we'd have to take that on notice. I wasn't aware of those comments.
Do you know, Mr. Warnes, if what the intervention referred to was that the Preston Mosque infrastructure grant was not recommended to the minister?
I would again have to take that on notice. There was 2 projects that were funded against the department's recommendations under Safer Communities Round 6. I'm just thinking if Ms McKee can assist me with which ones they were and whether it was the one in question.
Which ones were those, Ms McKee?
Senator, Susan McCaig, Assistant Secretary, Criminal Law Policy Branch. It's not my recollection that was the grant that you mentioned, but if you can just give me one moment.
Well, what were the 2 grants where there was a difference in opinion, so to speak?
So I've got
considerable detail here. If you can bear with me for one moment. Page 41. Sorry, I have that information for you now. The two projects funded against the department's recommendation. The first one was Casey City Church Incorporated, which was approved for its Hope Australia Soccer Academy, Bringing Australians Together project. And the second one was the Queensland African Communities Council, which was approved funding for a youth engagement and mentoring project.
And did Mr Wood...
Point of order, Chair. I'm just obliged to advise the committee in terms of conflicts, that I was heavily involved over a period of months advocating for the Queensland African Youth Council and my friends on the Queensland African Communities Council, including Mr Benny Bowl, in relation to funding for those youth centres, which I think provide an invaluable service to our African community and larger community in what I should note are two Labor are in Labor
That's not a point of
electorates.
order. You've provided your you've declared a conflict. I think it sort of goes to the point of what we're suggesting, that there was... Did Mr Wood intervene?
Well, sorry, I object to the characterisation of my involvement, which was simply based on the fact of the great work that community organisation was undertaking. So,
And Senator
I've
Scarr,
declared,
sorry,
I
Senator
just
Shoebridge,
appreciate
Senator
no
Scarr,
characterisation of my involvement,
Senator Scarr, my comments were not about your involvement. My comments reflect the evidence just given to us by the officials that was one of the grants where the department did not recommend that.
Chair, can I just...
Yes, you should clarify.
Clarify?
Well, you're not...
I think Senator Scarr did, and I don't think it's right for the chair to recharacterise it as a conflict. And I do think that's important.
Yeah.
And because we often make declarations, but I don't think they should be recharacterised through the chair. I'm not trying to run in interference in any way, but
No, and Senator Shoebridge, I appreciate that, and I didn't declare it as a conflict per se, but I just think it's in order for me to advise the committee that I was involved in that project. I'd hate for it to come out afterwards without my having mentioned my advocacy, so that's why I said what I said.
Might come out in these questions if I'm allowed to ask them. Are you two done? Yeah, good.
Can I say
you might want to clarify that.
So just to clarify that both those organisations that I just mentioned, Ms McKee mentioned, were assessed as eligible and suitable for funding, but were not ranked highly enough compared to other applicants in order to be recommended for funding by the department. Under the Commonwealth Grants Rules and Guidelines, so paragraph 4.12, the former minister provided a statement of reasons outlining the basis for the approval of the grants, which were not recommended by departmental officials. And under subparagraph 4.12 of those grants guidelines, these reasons were reported to the former Minister for Finance. So
Thank you.
Just to give
No, I appreciate that. And those grants that we're referring to, are those the grants that Mr Wood intervened in regards to?
Again, I'm not sure I could comment on Mr Wood's statement that you referred to
Facebook
previously.
post
Yeah,
about intervening in the
I don't think I can
grant process.
comment
Okay.
on that. Yeah, so the Casey City Church Incorporated was approved for $1,498,713, and the Queensland African Communities Council was approved for $850,000.
And I'm sorry, can we get the spelling of the first entity?
Casey City Church Incorporated.
That wasn't the spelling. I hate to tell
Oh,
you.
sorry,
Yeah.
sorry, I misheard that.
Yeah. Spelling?
The spelling of Casey, C-A-S-E-Y.
Yep. Yep.
Thank
City
you,
Church.
Senators. I have the call. I just want to go back. We do have Senator O'Neill, who's sitting next to me here, actually put some questions on notice to the department, and I just want to refer to one of those It's a question on notice from the 3rd of November 2022, number 1044. I do have a copy, I believe. I'll just double check. Do you have a copy of that question on notice? Okay. Thank you. I just noticed some unusual answers or information provided in that question on notice. I wanted to double check them with you now. The round 6 early intervention round of the program closed on the 5th of August 2022, and yet there's a 6-month wait until anyone is notified of the outcomes. And then there's this series of dates which, in my understanding, is unusual. There are 3 dates for decisions being made: the 23rd of February, the 27th of February and the 31st of March. Can you enlighten the committee as to why there's 3 different dates for decisions when it came to this round of early intervention grants?
Senator, 3 different dates because there were different tranches of funding.
Okay, and can the department identify which grants were decided on which dates?
We'd have to take that on notice.
And were there any additional applications submitted after the application closed in August that were awarded on the dates of the 23rd of February, the 27th of February or the 31st of March?
No.
Are you sure about that? Yep. You don't need to take that on notice, or you?
No, I don't need to take that on notice.
I'm just wondering about recommended programs that could have been missed out when decisions were being made. Were there any applications on the 23rd of February, 27th of February or 31st of March put to the minister that were denied?
I think we'd have to take that on notice to check that detail.
Okay. And in terms of applications recommended to the minister that were denied, I think you've taken that on notice. I appreciate that. Probably a follow-up question. Can you identify which applications those were?
If there were any, I guess the answer, yes, happy to take that on notice as well.
Okay, I've just got one set of questions and I'll hand over the call, and then I think my other fellow senators have some questions on this as well. Due to decisions being made up until the 31st of March, which, as you'll recall, was very close to the election period, it meant that we had this unusual situation where a number of grant recipients were being notified of the fact that they'd received a grant during the election campaign. Mr. Warnes, do you know how many grant recipients were informed during the 2022 federal election campaign that they had been successful for a grant under this round of the Safer Communities Fund?
I don't believe I have that detail, Senator. I've taken on notice. I think what I can say is the decisions were taken prior to the caretaker conventions commencing.
No, I understand.
There were certainly some that were notified during.
Very close to the caretaker period, I think, is how I would characterise it. But can you provide a list of those that were announced or were notified during the caretaker period?
Happy to take it on notice and see what information we can provide in relation to that, Senator.
And I'm also interested in the total value of the grants that were announced during the election campaign. So if you take that on notice.
Announced or no? Oh, did you mean notified? The ones that were notified during the election campaign. Sorry, Senator, just to clarify.
Yes, thank you. Can I just understand, what is the process for an outcome notification? It can be different depending on the portfolio or the particular minister. How are grant recipients notified? Was it done by email, phone call, person?
Ms. McKee, do you want to
The notification is usually provided through the Grants Hub. We use the Business Grants Hub at the Department of Industry, Science and Resources. So I'd have to seek advice as to how that is communicated.
So can can I take it from that it can be different depending on the different grant recipient, that some people might be notified? I mean,
Chair,
is everyone notified by an email once the grant's decided? How do people find out?
Chair, I think, as Ms McKee explained, it's done by the Business Grants Hub, not us, so we would need to seek their advice. They may have a uniform process, but we would need to seek their advice on what they do.
And as far as you're aware, how, aside from the Assistant Minister who made the decision for these grants, is there anyone else that's informed of the outcome as a matter of process?
We advise the Grants Hub once the decisions are made by the Assistant Minister.
And then is the local federal member informed of the decision?
The department doesn't make that notification, whether that notification comes from the relevant minister.
Okay.
That's not something that the department is involved in.
Are senators in the state where the grant is allocated informed of the decision?
Not by the department.
Okay. And what about candidates in an election for a party? Are they informed of an outcome of a grant?
Not by the department.
Okay. I might leave it there. I think there's more I want to come back to. Senator Chandler has some questions, so we can go to you now.
Can I ask a clarifying
follow up.
The Business Grants Hub, where does that sit in the constellation of responsibilities?
So under the Department of Finance rules, government agencies who manage grants are required to use one of the authorised grants hubs for whole of government. And so the department, for the purposes of the Safer Communities Fund, has engaged Business Grants Hub to do the administrative processes associated with managing these grants.
And that's under the Minister for Finance?
The Minister for Finance sets the policy process which requires agencies to use a grants hub. So we don't manage the administrative processes in-house. We have policy responsibility for administration of the Safer Communities Fund, but the detailed business assessment of a grant, communication with applicants, monitoring of projects is done by the Grants Hub.
Thank you. Yep, Mr Warnes, did you need to add
I'm just
anything?
going to, just to be clear, that's in the Department of Industry, Science, Resources. So that Grants Hub sits there, and as Ms McKeag said, they do all of the assessments. So just to be very clear, it's not the department that does the assessment. We will then provide the advice to the Minister for decision subsequent to that assessment.
Thank you.
Senator Chandler.
Thank you very much, Chair. As I foreshadowed accidentally in the previous outcome, I have some questions regarding the potential terrorist listing of the IRGC and the department's advice regarding that. On what date did the department come to the view that as an organ of a nation state, the Islamic Revolutionary Guard Corps is not the kind of entity that is covered by the terrorist organisations provisions in the Criminal Code?
Senator, we need to take the exact date on notice, but it was late January.
When did the department start considering whether the IRGC could be listed under current legislation?
We'd need to take that on notice.
And when did the department start work on its submission to the Senate Committee inquiry into the crisis in Iran, which was made on the very last day of that 3-month inquiry?
I think it was the day before we made that submission.
So the submission was made on the 31st of January. You started writing it on the 30th, which would make sense because it is not a lengthy submission. And then the report for that inquiry was tabled on the 1st of February. That's correct?
Yes, Senator.
Thank you. On the 17th of January 2023, just 2 weeks before the submission was made by your department, the Department of Foreign Affairs told the Senate inquiry that it is the Australian government's long-standing practice not to comment on the possible listings of terrorist organisations under the Criminal Code, including whether or not a particular entity is under consideration for listing. Was the timing of the Attorney-General's Department submission and its eventual lodgement on the 31st of January discussed with any minister or their office?
It was discussed with our Minister's office.
With the Attorney-General's office?
That's right.
On what date did the department communicate its view on the listing of the IRGC to the Department of Foreign Affairs, Defence and Trade, particularly given on the 17th of January they said that these are things that we don't publicly talk about?
We'd had conversations with Department of Foreign Affairs and Trade in late January, but advised them of our submission the day before it was lodged.
I would appreciate if you could come back to the committee either today or on notice of the specific date of when those conversations started, because late January may or may not include the 17th of January 2023, and like I say, it was on that day that Foreign Affairs advised the Senate committee that we don't talk about these things, so I'm just interested in establishing exactly what that timeline was.
Can I just, sorry, Senator Chandler, just want to get a point of clarification. I'm just seeking some advice about whether these questions, although they relate to the Attorney-General's Department, because they relate to an inquiry conducted under another committee, whether they're relevant and in order. We're seeking that advice now. I think the Secretary is trying to be helpful to you.
I think she absolutely is. And you can rest assured I will be pursuing similar questions with Foreign Affairs as well.
Of course, but what I'm aiming to do is to make sure that the questions asked here are dealing with the estimates procedures that we're seeking to prosecute, and I'm getting some advice for you, but I'm happy to let the questions continue. I think you might find yourself in a situation where this isn't the appropriate forum, but I'll let it continue for now.
Well, they are.
Senator, can
Yes,
I
Ms. Gigi.
just add something that might assist? So we would still stand by that statement that DFAT is made. It is and it continues to be the practice that we wouldn't comment on organisations under consideration. I think what's different in this case is we're talking about the scope of what those provisions can actually cover. So as compared to organisations that could fall within that definition that might be under consideration.
Sure. On what date did the department communicate the aforementioned view regarding the IRGC to the Minister for Home Affairs, the Minister for Foreign Affairs, and you've covered off on the Attorney-General, apologise, in the previous question?
Sorry, Senator, was your question about us communicating with other ministers? The department didn't communicate with ministers. We did with...
Only
so
with the
I
Attorney
communicated
General.
with my counterparts on our submission the day before at Department of Foreign Affairs and Trade and at the Department of Home Affairs.
Did the Department of Foreign Affairs discuss with your department its earlier answers to the inquiry stating that they wouldn't comment?
Yes, we have. We were in touch with them, so I think broadly speaking we had discussed that.
Thank you. I assume that was probably as part of your broader conversations in late January that we discussed earlier. Has the department at this stage provided any briefings, minutes or advice in any other form to government on potential legislative options which would enable the IRGC to be listed as a terrorist organisation?
No, Senator, we haven't provided advice on legislative amendments.
Thank you. What prompted you making the submission on the 30th of January, or writing the submission on the 29th of January and providing it, or the 30th rather, and then providing it to the committee on the 31st?
Senator, we had understood from our office that it would be helpful to be able to provide a view on that organisation, given we had a view on whether or not it could be covered under those provisions and the considerations of the committee.
What prompted you to think it would be helpful?
We'd had conversations with the Attorney-General's office.
And those conversations were initiated by the Attorney-General's office, not by the Attorney-General's department?
Yes, I mean, we were in communication about these issues over time, but spoke to them about actually putting in a submission.
But when you say that you're in conversations, it's fair to assume that that was in the couple of weeks, let's say, leading up to that submission arriving on the 31st of January?
Yes, about the general issue, Senator.
Okay. That's all the questions I have. Thank you very much, Chair.
Thanks, Senator Chandler. Senator Shoebridge, I know you have questions. Senator O'Neill, I'm going to give her the call and then we'll come to you.
If you just want to get rid of Senator O'Neill,
I'm very happy to...
There's such
I also have some
such
Yeah, and then we'll come back to
amicable
you,
relations
Senator
between the
Scarr.
New South Wales senators there.
I assure the committee that is not the case. She just does have another committee to go to. So, Senator O'Neill, you have the call.
I want to echo the comments of the Chair with regard to how important it is for communities to feel that they can participate in democracy and that they can approach their government transparently, and that, you know, committees get together and they burn the midnight oil to get together a submission. They put a lot of effort into complying, etc. And I know Senator Green got some answers to her questions that make me very concerned about how that process doesn't appear to have operated in a way that people in the community would generally expect. So my questions are going to go to round 7, and I just want to be clear that I cast no aspersions on any of the entities that were caught up in this. It's not their fault if processes failed, and I think that it might become clear that that's the case. But I just want to put that on the record as we commence. So throughout the election campaign, a number of curious events occurred, and they involved a number of Coalition MPs and Liberal candidates who were announcing election commitments to the public, to voters who were going to determine the outcome of the upcoming election. And they appeared to come from a future round 7 of the Safer Communities Fund that Senator Green has been asking questions about. Keen to get a sense of the status of the round 7. So can the department confirm that there was no round 7 actually announced and that no guidelines had been published for these Safer Communities Fund round 7?
So, Senator, I can confirm there were no guidelines for a round 7, and a round 7 had not been in any way announced or progressed by the department. I should note that prior to the election, responsibility for this program was then in the Department of Home Affairs, and it transferred into the Attorney General's Department following the machinery of government changes following the election.
Okay.
But Mr Lawns can give more detail on that if it's needed.
Okay, so just to be clear, it now sits with the Attorney General's, which is why you're answering questions, but prior to the election, this was the Home Affairs Department, and there were Safer Community Fund disbursements that had occurred for previous rounds, but there was no round 7. There never was a round 7.
Senator, I'm not sure that's how I'd characterise it. There was money set aside in the budget for a potential round 7, but as you say, no work had progressed on that. There was no grants, guidelines, etc.
No announcement, no guidelines. Okay. So if I could refer to a number of occasions. So let's start with May 2022, in the course of the election, Senator Sarah Henderson and the Liberal candidate, Manish Patel, announced a $500,000 election commitment to invest in security systems at the Geelong Gurudwara Sikh Temple, which would come from the Safer Communities Fund. Are you aware of that?
Not in the detail, but aware generally, and I should say, to be clear, that we track these election commitments that are made throughout the course of these things happening, and generally both sides make election commitments, and then we provide advice to the incoming government about how the commitments that are made.
This is the government was calling this a grant. it was announced that it was round 7 and a grant.
I don't think I can comment on what certain government members, the former government members, might have been calling it. All I can say is, at that time, it wouldn't be considered a grant in terms of the departmental processes. The department would advise an incoming government on commitments they had made and how they might be able to fund those commitments. One of the ways to fund those commitments might be through a grants process.
So, but there was no round 7 and there was no grant guidelines. So my question is really, why were Liberal candidates using what was meant to be an open competitive fund to make election commitments for a grant round that hadn't opened?
I'm not sure that's something I can comment on, Senator.
Comment on that, Senator.
Did the department receive any direction about a possible grant under a future round of the Safer Communities Fund for the Gurudwara?
No, Senator.
And I'm struggling to understand how you can stand up something that doesn't exist and then go out and report it to the media as if it's a done deal. Like, that seems to be a gross abuse of government and knowledge that applied to Liberal candidates. Were there special rules for the Liberal candidates in the election?
Senator, I think I've given my advice about how we look at the election commitments and then provide advice afterwards about how those can be funded. I think that's the best advice I can provide you on that.
Can we go to another model of this operating? In May 22, the Assistant Minister Jason Wood, MP, about whom we've heard some descriptions this afternoon, the Liberal candidate for Calwell, Tim, stake a gun, and the Liberal candidate for McEwen, Richard Welch, along with Senator Greg Mirabella, stood up to announce a re-elected Liberal government would provide $500,000 to Kalimata Amanda Craigieburn to increase safety and security for members and visitors to the temple. How and why were Liberal candidates using an open competitive fund to make election commitments for grant round that hadn't opened yet?
I think I'd have to refer you to my previous answer, Senator.
Did the department receive any direction about a possible grant under a future round of the Safer Fund for this particular temple?
No, Senator.
Okay, let's go to the seat of Patterson in New South Wales, my own home state, not far from where I live. Brooke Vitnell announced with the then Attorney General, Michaelia Cash, that if Miss Vitnell was elected, whether it's, and I'm quoting here, whether it's CCTV, whether it's bollards, whether it's lighting, it's all about Brooke working on the ground with the communities to then put in that application to the fund to ensure that the community is kept safe. Why were Liberal candidates using open competitive funds to make election commitments for grant round that hadn't been opened yet?
Senator, again, I think I'd refer you to my previous answer.
I'm becoming more disturbed as I understand the fullness of what you've said and the myth that was stood up by the previous government declaring these as grant round recipients when that is not anything like what these were. These were election commitments.
Senator, again, I don't think I can provide any further advice.
Were there communications about how to apply for the Safer Communities funds distributed to all parliamentarians or just to Liberal members?
I'm not sure what you're referring to, sorry, Senator.
Was there any back process? Was there any backroom process where there was actually a covert opportunity for Liberal candidates and Liberal members and senators and former Attorney Generals to advance local community claims for funds under the Safe Communities Fund?
I don't think you'd be expecting me to be able to answer such a question, Senator.
No, and Senator, as I said, whilst this program was in the Department of Home Affairs at the time, I think that it would not be appropriate to expect that public servants would have any understanding of that, any knowledge of that.
Okay, let me just, because really it's the same question for each of these announcements, but just let me see if you've got any further information about the then marginal seat MP for Reid, Dr. Fiona Martin. She announced that a re-elected Liberal government will provide $200,000 for new security fencing at Rosebank College 5 Dot. The Liberal government is continuing to improve community safety around Reid. This commitment, right, that's the language, this commitment builds on our record investment in CCTV and security infrastructure in our community.
I think that's consistent with the evidence I gave previously that we consider these to be commitments, and the department, then the Department of Home Affairs, would keep track of those and advise an incoming government about how they might fund those commitments that they'd made.
Without the announcement of Round 7 and without the announcement of grant guidelines, they were still making these announcements.
I think I should be clear, it's not unusual, and it's happened in multiple elections where both sides make commitments and then advice is provided about the funding of those commitments to them afterwards.
It's very different, I'm sorry.
Go for it,
It's
Senator.
very different making election commitments than going out to the community and promising that any grant application is going to be successful. That's very different to giving election commitments. That's basic 101 for any political candidate to know the difference between grants and election commitments.
I'm not sure.
Yeah, I'm not sure we can add anything on what exactly was said. I think, as Mr. Warnes has said, we were recording them as election commitments, and the department would have provided advice accordingly to an incoming government, as we do on all election commitments.
But you can understand why this could be very misconceived by the recipients who basically think that they've got a grant under Round 7.
Senator, I just can't comment on how they were described in any of those announcements.
So could I just ask you for any, the matters that I've raised with you, if you can refer to the former department and see if you can find out anything at all.
Senator, there's nothing we'll be able to add to the answers given.
What about the stand up with former senior staff member to Jason Wood, Liberal candidate for Holt, Ranj Pereira, announced with his boss that a re-elected Morrison government would provide $1 million of funding to the Buddhist Vihara temple in Berwick to provide much-needed security fences, remote control gates in the 4 entrances, CCTV cameras at entrance, footpath lighting, security system for the new language school building currently under construction. These are very detailed announcements. It's not like they just had a discussion and said, look, here's $1 million. People were, I would say, deceived into thinking that they had put in sufficient information and this was a done deal.
I think you referenced there was no application, no grants guidelines. They would have come subsequent, so I don't think there's any further advice I can provide.
So to be clear, there was no decision making around the grant funding because there was no application process, is that correct?
Again, I don't think it's a question of decision-making around grant funding. As I said, the department was tracking these as election commitments and the department would have provided advice to the incoming government. That advice would have set out how they could have been funded, whether those commitments were consistent with the draw on the confiscated assets account under Section 298 of the Proceeds of Crime Act, and how grants guidelines could therefore be developed for any funding round, and then a process by which we would usually recommend is gone through for either an open round or a closed round. There can be various types of grants rounds, and we provide that advice for the consideration of the relevant minister.
So the complexity, yes, please, Ms Jones.
As to how those commitments were communicated by either sitting members or candidates, that's not something that we would have visibility on or have been involved in.
I guess in your responses, the fullness of your responses, Mr Warnes, and I appreciate that very much, that you're making an effort to make this clear, it becomes more and more apparent to me that people who are engaging with a grant process for the first time in good faith with somebody who's representing themselves to them as, I'm going to help you get a grant, and that seems to be the flavour of what was going on, is a gross act of deception that the department can't be responsible for. But just to give you a sense of the construction of the narrative in the community, In an interview with the Daily Mirror, a news site, the candidate and staff member, I'm referring to Holt's candidate, the Liberal candidate for Holt, Mr Range Pereira, he said, "I've been working as a Chief of Staff and a Senior Advisor to the Assistant Minister for Customs, Community Safety and Multicultural Affairs." First thing, I'm an important person is the code that people are getting. "And during that time, I've worked hard to assist all communities. I played an instrumental role in supporting many temples and community organisations through government assistance and grants." It's clearly implied that this is a grant. Was Mr Pereira directing the department to allocate grants under the Safer Communities Fund?
I don't think he would have had a decision-making role, and no, not to my knowledge.
Certainly not the unannounced round 7 that we
given
know
all the evidence I can on that.
was, as mythical as Brigadoon. Under round 6, did he have any instrumental role in supporting community organisations through government assistance and grants?
I don't think I can comment on anyone's particular role in an office, and I don't think you'd expect an official to. All I can say is the decision maker was Assistant Minister Wood on round 6.
So you were not directing the department? He was not directing the department?
I wasn't aware of these comments, and I'm not sure if Ms McKee was, as the relevant departmental officials. I don't think us not being aware of them, no.
Okay, so at this point of time, the declaration that he was instrumental would seem to fall short of the actual facts.
Again, I don't think I can comment on that, Senator.
Thank you very much. Thank you, Chair.
Thanks, Senator O'Neill. I do want to hand the call over to Senator Shoebridge. You'll have plenty of time. Can I ask 2 follow-ups, please? Thank you. Thank the committee. I just wanted to, I asked about the round 6 grants.
Yes.
These were the ones prior to the election, but were announced quite close. Caretaker.
Some before, some during.
Yeah. Some before the election, some during the election. So these are the ones that there was a grant guideline and a grant process. Round 6 was decided, but the evidence that you've given today is that there were 2 grants awarded that went against the recommendation of the department because they weren't ranked as high as other grants.
That's correct. There was 134 grants assessed under round 6, I believe. I'll just check on that to get Ms McKee to correct me if I'm wrong on the stats. 134
It might be 187.
were awarded funding, 2 of which were awarded against the department's recommendations because of the ranking.
Can you give me those numbers again? Sorry, 134 applications?
No, 134 organisations that were awarded funding.
And how many were decided against?
2 of those 134 were.
So can we just talk about those 2 briefly? And if I'm just seeking a little bit more information. If you have it, you've agreed to take some information on notice. Just the grant to the Queensland African Communities Council. I note in regards to that grant, it was actually the former Minister for Home Affairs, Karen Andrews, Senator Scarr, who's obviously here, and a candidate for Blair at the time that were at the announcement of that grant, a $1.7 million package for the council. Even though it wasn't assessed highly enough for that department, was there any ministerial intervention on the part of this grant?
Sorry, Chair, I'm not sure I've fully
Minister Wood has referred to intervening when it comes to Safer Communities grant, and I'm wondering, you probably don't have this information in front of you, but before the election, the seat of Blair was on a 1% margin, and we've got the minister and the candidate for Blair rocking up and announcing a round 6 grant that was actually awarded against the recommendations of the department.
I think all I could say in response to your question is that Assistant Minister Wood made the decision.
Okay, against the recommendation. And just the second grant, I'll just deal with that, Senator Shoebridge, and then hand to you. The second grant that you referred us to was for the Casey City Church. I think that was for $1.5 million. That's information I have. And again, at the announcement was Assistant Minister Jason Wood and also Senator David Van. They announced that grant. And I've got two questions. Again, why did the minister intervene on behalf of that organisation?
Do you have the statement? 1 second. Why the minister made the decision? You asked
Yeah,
just
why
to clarify.
did they provide any written reasoning for the decision? I'm aware that they have to.
Just checking to see if I can provide you that advice now or
Thank
take it
you.
on notice.
And if you have similar advice for the previous, I think you might have already given that to us, but if you've got the reasons for the intervention or the different decision against the recommendation of the department, I would love to hear it.
Yeah. I might just take it on notice and provide it on notice, Chair.
Because you don't have the answer, or you want to check whether it's...
Yeah, but the reasons themselves.
I can assist. At the time, the Assistant Minister would have made a statement, and they would be the Assistant Minister's reasons.
Yes, I'm asking for those reasons.
Yeah,
We can obtain.
I think we'll provide those on notice.
We can obtain a copy
Would it
of
be,
them.
would it be
and provide.
possible to just provide it later in the course of today's
Yeah, I
estimates
think
hearing?
I don't think it'd be
rather
that
than delay
difficult
this?
to find.
I'm sure
Yeah.
we can try and lay our hands on
Yeah,
it.
and to be clear, just for your comfort, Mr. Wands, I'm asking whether you are taking that on notice because you don't have that information or whether it's just you don't have it with you right now. And
We will, as I think I said in my previous answer, Chair, the Minister did provide a statement of reasons. I just don't have it in front
Okay.
of me. So, Assistant Minister, sorry, provide
I'm
it.
very eager to understand why the minister made that decision and then went on to announce that grant with the Judy Senator. Okay, thank you, Senator Shoebridge. I might have to come back.
Thanks,
and,
you, Chair.
And you'll be next, Senator Scarr.
Just quickly, you said that there are 100, on that same topic, you said there are 134 grants made. Is that right?
Yeah, under
Yep.
that round 6, yes.
Sorry,
Under round
if I
6?
could clarify, there's 187 under round 6, 134 I think we referred to is in relation to the early intervention stream.
Thank you.
All right, so the Casey City Church, was it in the early intervention stream or the round 6?
Casey City Church was under the early intervention stream within round 6. So round 6 had two streams. One was an early intervention stream and one was a security infrastructure stream.
And together there were some 300 grants made.
187 grants.
Oh, so
across-
134 of those were made in the early intervention stream, and then a further 53 of them were made later. Is that how it worked?
I think your math sounds about right.
Yeah,
Yes.
well, even if I'm out by one or two, that's
Roughly,
how it
yes,
works.
correct. Correct.
All right. Well, for the early, and the Casey City Church was in that early intervention stream. I assume that there was a departmental assessment of grant applications for the early intervention stream.
Yes, there was.
Do you know how many applications there were for the early intervention stream?
Yes.
623
600
eligible
and-
applications were received.
623?
Yes.
And were they ranked?
Yes, they would have been ranked.
yes.
What ranking did the Casey City Church get?
We're
think we-
now talking about the security infrastructure stream. The Casey City Council and the Queensland African Communities Council were both under the early intervention stream.
Yeah, so how many applications were there for the early intervention stream? That was my first question. And I thought
420.
420.
applications for that stream.
And again, I assume they were ranked when they were assessed.
I think that's correct, Senator. I think I took on notice to the Chair to provide that.
So, but can you, if you're hunting for the statement, can you also seek to find today where they ranked out of 420, Casey City?
I will endeavour to, without committing to. I'll do best endeavours to see if we can track that down as well.
And it would be really of real assistance, I think, to the committee if you could, on notice, provide all the relevant documents the department has in relation to these two grants. Would you
Happy to take that on notice, Senator, absolutely.
All right, thanks very much. I was going to ask some questions on tranche 2 reforms. That might mean you can jump out, Mr. Wands, or are you still stuck there?
Still me, Senator.
Okay, terrific. Where are we up to in terms of Australia adopting or not tranche 2 financial reforms?
I think the answer I can give you, Senator, is it's under consideration.
Well, when you say it's under consideration, is there a process? Is there a working group? Is there some kind of structure in the department to consider them?
Yes, Senator, we've undertaken some work to consider these entities, both in relation to obviously our international obligations under the Financial Action Task Force, which I know you're well aware of, and also in relation to the recent Senate inquiry, which recommended expediting consideration of those. So we've provided advice on that, and the government is considering the matter. Has the department provided advice on the Senate committee's recommendations? Yes. When was that advice provided? Oh, I do have that date. Just give me 2 seconds.
It's an excellent report, Senator O'Neill.
But the second Senator.
Senator, we provided advice specifically on those recommendations. I think it was the 19th of December last year.
Does the department have a view? Sorry, I'll take that back. Has the department provided any response to the Law Council's continued opposition to the legal profession being covered by tranche 2 reforms?
I think historically, Senator, we've engaged with the Law Council amongst a number of other stakeholders. Obviously, there was submissions provided by various parties to the Senate inquiry. The Senate inquiry's made recommendations, and we've provided advice on the basis of that.
Has the department considered responding to those concerns from the Law Council by reviewing how tranche 2 reforms have been successfully implemented in countries like Canada, New Zealand and the United Kingdom, which have very similar legal structures and ethical requirements of the legal profession to Australia?
Senator, I think what I can say is we have absolutely looked at those international comparisons in considering implementation of regulation that you speak of.
And it'd be fair to say, wouldn't it, that, and I'll use again those 3 countries which have broadly comparable common law legal structures to us, Canada, the United States and the United Kingdom, first of all, that they've implemented the tranche 2 reforms. That's correct?
Correct.
And secondly, that the sky hasn't fallen down for the legal profession and they've been able to maintain their ethical obligations. Would that be a fair summary?
I'm not sure I'll comment on the sky falling down for other countries, but certainly it seems to us like it's continuing, like those obligations are in place, I think is the best answer I can give.
Well, I went to the UK over Christmas. The sky was firmly up. If that's of any assistance. Yeah, it was quite low. This is true. It was quite low. Could I ask, what, if any, in terms of so is there currently a commitment from the government to implement tranche 2 reforms?
I think again, and there's a recent quote from the Attorney General's spokesman in today's media, I think actually that this is a matter that's under consideration.
So do I understand from that there is no current commitment from the government to implement tranche 2 reforms?
As I said, I think the best answer I can give you is it's a matter that's under consideration.
All right. Is there any time frame that we can look to for there to be a decision in relation to Tranche 2?
Timing for a decision is a matter for government, Senator.
Are you aware of the repeated concerns from law enforcement agencies, federal and state, that the lack of implementation of Tranche 2 reforms is leaving Australia as a target for international money laundering?
Yes, Senator, aware of concerns raised by agencies.
Those are legitimate concerns, aren't they?
I would say yes, Senator, of course, legitimate concerns. I think it's worth stating that Australia does have a generally effective AML-CTF regime, and we can see with the recent AFP operations, we are still able to take action to address that, but that doesn't mean there can't be improvements. I completely agree.
When it comes to tracking down international money laundering, and one swallow doesn't make a summer, does it? Like prosecuting 6 people, given the scale of the international money laundering that Australia is dealing with, is hardly evidence of systemic success, is it?
Wouldn't disagree with that statement, Senator. I think, as I said, always room for improvement.
Has the department undertaken any analysis of the extent to which laundered funds have found their way into the Australian real estate market?
Yeah, it might be something that goes more to questions to AUSTRAC potentially in terms of the analysis of illicit financial flows. The department, not to my knowledge, Senator, but I can check that and correct it on notice if that's not correct.
All right. But sitting as we do now, you're not able to point to a current commitment from the government to implement those Tranche 2 reforms, is that right?
I think, Senator, as Mr Wands said, government's very actively considering that.
All right. I might just move on to whistleblower prosecution costs. This one.
Waited a very long time to ask these questions.
Thank you, Chair.
Yeah.
Who's best to answer that? Is that you, Ms. Gigi?
I can answer those, Senator.
So what are the current, what's the best estimate or the best figure that we have for the Commonwealth's costs, legal costs for the prosecution of David McBride?
Senator, the figure I have as at the 30th of January for external legal costs for the Commonwealth were $1,875,348.
And that figure of $1,875,000, can you identify which that was, I assume, to a law firm and perhaps counsel, is that right? Do you have a breakdown?
I don't have a breakdown of that. It would be for AGS largely, and also captures external legal costs, not internal, for the Commonwealth Director of Public Prosecutions.
Right. And in the Richard Boyle matter, the prosecution of poor old Richard Boyle?
The external legal costs there for the Commonwealth Director of Public Prosecutions, and as at the 30th of January, the figure is $233,171.
So more than $2 million of external legal fees have been expended by the Commonwealth on just prosecuting just those 2 whistleblowers. Is my maths correct?
Senator, obviously those costs are about the prosecution, but also protection of information.
But all of those costs have been expended in the prosecution of just those 2 whistleblowers, $2.1 million. Is that right?
Senator, I think they would encompass things like public, there's a number of related matters that are related to the prosecution.
Repeated efforts from the
yeah.
repeated efforts from the Commonwealth to keep evidence secret and to prevent it being given to either Mr McBride or Mr Boyle or permitted to be used in their evidence.
I would not characterise it in that way.
How would you characterise those repeated applications
the
in relation
Boyle
to
matter,
evidence?
there is no National Security Information Act orders.
So the repeated secrecy efforts are in relation to Mr McBride's prosecution?
Senator, that's your characterisation. We've been seeking appropriate orders in order to protect national security information in the McBride matter.
Is there any point at which the eye-watering cost to the Commonwealth of continuing to prosecute, in this case, David McBride, will provide some kind of, will lead to some kind of review about the use of public money to try and put a whistleblower in jail? Is there any point? Is it at $1.8 million? Is it at $2.5 million? Is it at $10 million? Is there some point at which we say your department reviews the lavish use of public money to jail a whistleblower?
Senator, I'm not sure I would agree with the characterisation of lavish. It's significant.
$1.875 million.
It's a significant amount of money, but...
Can we agree on eye-watering?
No, I would only use
All right.
significant.
Criminally large?
No, I would only
All right.
use significant.
Okay.
And Senator, obviously the prosecution decisions made by the DPP is an independent agency, and they continue over time to have regard to the prosecution policy of the Commonwealth and whether it continues to be satisfied, and that includes consideration of the public interest.
Do you have a current estimate for what the costs are expected to be to continue the prosecution of Mr McBride?
No, Senator.
Do you have a current estimate for what the costs are likely to be to continue the prosecution of Mr Boyle?
No, Senator.
Do you accept the characterisation of Mr McBride as a whistleblower? Does the department accept that Mr McBride is a whistleblower?
Senator, I don't think that's something we would comment on. Obviously, Mr McBride withdrew public interest disclosure proceedings. I can't comment on any characterisation.
And I presume you'll give me the same answer about Mr Boyle, is that right?
Yes.
Could I ask you about the costs? What were the total costs of the Commonwealth in the matter of the Crown and Callery?
Again, as at the 30th of January, for Callery and Witness K, the total external legal costs were $5,510,829.
All right. So we now have collective Commonwealth costs for monster and whistleblowers at $7.6 million. Is that right?
I'm not happy for you to do the maths, Senator.
But that's about right, isn't it? $7.6 million.
I'm not sure, Senator. I haven't added it up.
Can you... What was the controversy from the Commonwealth's point of view in the Court of Appeal decision in Callery and the Queen? Why did the Commonwealth seek special leave on that?
This is on the content of the judgment and protecting national security information in the judgment. Is that what your question relates to, Senator?
I'm asking why a special leave application was filed in the High Court in respect to the Court of Appeal decision in Callery and the Queen. The Commonwealth filed one. What was the rationale for it?
For that reason, to protect national security information in the judgment.
Why was it withdrawn?
Because the nature of the special leave application, the High Court had deferred its decision until the ACT Supreme Court made a decision on final orders, and then once the Callery matter was discontinued, there were then no final orders, so the Commonwealth withdrew its special leave application. We're now dealing with those issues with the Court of Appeal.
That's the Court of Appeal, the ACT Court of Appeal, is that correct?
Yes.
What was the cost of that ultimately futile application in the High Court?
You need to take that on notice.
Senator
Is the-
Shepherd, you've got a couple
And
minutes.
Senator, I should say, as part of that, we'll have to consider whether we can actually extract that from the general costs of the matter.
I understand. My understanding is the Callery matter, the Witness K matter, is listed for hearing this coming next week in the ACT, is that right? Has it got a listing?
Not that we're aware of.
Has it got a hearing date?
No, Senator,
Senator Elizabeth Brayshaw, Assistant Secretary, National Security Information Branch. My understanding is that I'm not aware of a listing next week. The Court of Appeal had reserved its decision in relation to the publication of its judgments on the 23rd of September last year.
All right. And again, the controversy in that matter is an ongoing application or potentially series of applications by the Commonwealth to keep significant aspects of the court's judgments secret. Is that right?
It continues to be about making appropriate redactions to protect national security information.
These are redactions of the court's judgment?
That's right.
All right.
Senator Shoebridge, I do have to hand the call to Senator Scarr. If you've got one final question, I just also...
No, I'm happy for it to go to
I know you have a certain style of asking questions, but if the official does give you an answer, I don't think it reflects on you to then change those words or put words into the official's mouth.
It's a matter for you, Chair,
Yeah, well,
to say what you like. But if you want to hand it to Senator Scarr, I'm
Well, if you
comfortable
want
with
to
that.
listen to what the officials have to say. Senator Scarr, you have the call.
Chair, just before I start, I might get a bit emotional as I ask these questions because I care deeply about our Australian African community and I care deeply about the need to have intervention programs to assist youth at risk in these communities. And I have so much admiration for the people I've worked with in the Queensland African community. And what they do and what they achieve is, in my view, more outstanding than anything I've done in my life. So I just, if I get emotional, it should not be a reflection on my fellow senators. They had every right to ask the questions which they asked, but I have a deep emotional commitment to this community, and I know what many of them have been through and what they do, notwithstanding that that background. I'd first like to ask some questions in relation to the grant that was issued to Casey City Church for the Hope Australia Soccer Academy. And this was an amount, as I understand it, if the relevant officers could come to the table. Thank you. Mr Warren, Mr Warnes, sorry. I first want to describe the project amount. Is it correct that the project amount was $1,498,713?
Yes, Senator.
Thank you. Can I describe the project and could you please confirm whether or not this conforms with your understanding of what the project is? The Casey City Church Inc. is a not-for-profit organisation located in and I'm not sure the pronunciation, Warren, Victoria, approximately 40 kilometres southeast of Melbourne.
Warren.
The applicant runs various local community support programs, including the Hope Australia Soccer Academy. This project will focus on supporting at-risk youth, primarily from refugee and migrant backgrounds, to develop positive behavioural changes through sport, mentoring and virtues-based psychology. This project will target up to 200 youth in Western and Southeast Melbourne. These participants will be sourced through the applicant's academy, a current waiting list and from referrals from local schools. Is that an accurate summation of that project?
Senator, I think you have more detail than me, but yes, accurate.
Okay. Did the Assistant Minister provide written reasons for approving a grant against the department recommendations?
Yes.
He did. Thank you. Has the Assistant Minister had previous engagement with the organisation whose grant was against departmental recommendations?
I think I'd have to take that on notice.
Okay.
Unless Ms. McKee-
Are you aware that the Assistant Minister was supportive of the organisation's application under the Muster Program 2019, specifically with regard to their work with high-risk youth in the South Sudanese and Muslim communities? Were you aware of that?
I think the department had some awareness of the muster program, yes.
Are you aware of the testimonials which were provided to support the grant awarded against the Department of Home Affairs, including a testimonial from Mr Nick Hatzaglo, again, excuse me if my pronunciation's incorrect, Head of Diversity and Inclusion Football Victoria, who said, with the tagline, bringing Australians together, Hope Australia Soccer Academy is very much in line with what we in Football Victoria want to see happen in our communities through football in terms of diversity and inclusiveness. We are excited that HASA is expanding to the west. Are you aware of that commendation?
I was certainly aware, I think not of the details, but aware that there were various supportive statements, yes, Senator.
And that's an example of one of the commendations, correct?
Correct, Senator.
Okay, thank you very much. Were you also aware that this project had previous funding, as I said, under the Muster program, and that there was a serious concern that here we had a program that was working, that was from an early intervention perspective, exactly what we should be doing more of. It was actually providing outstanding support to youth at risk. It was working, and there was a considerable fear that if it was stopped, then there would be ramifications flowing from that. Were you aware of that?
Yes, I was aware of those concerns, Senator.
And is that a reasonable factor for a minister to take into account when deciding whether or not to actually make a decision which approves a grant against department recommendations? Is that the sort of thing you'd expect a minister to consider?
I'm not sure it's up to me, Senator, to comment on that, but these grants are ultimately at the discretion of the minister, and the requirement on the minister is to furnish reasons if he or she makes a different decision.
Okay.
Which was done, as I said, was done in this case.
I want to ask you some basic questions in relation to the Queensland African Communities Council application. As I disclosed before I knew my name was going to be mentioned, I was Sorry, Chair, you're taking a point of order?
I think I just want to let you know, Senator Scarr, so you understand around your name being, just for your personal reflection.
Sorry, Chair, I don't need any personal background in that respect.
Well,
I'd just like to ask my questions, please, without interruption. Without interruption, please,
okay,
Chair.
You don't want, well, Chair, you're welcome to answer. My information might assist you in your questions, but if you just want to
I know everything I need to know about the Queensland African Youth Council, and I suspect I know considerably more than you know, including with respect to engagement, with Labor, very senior Labor MPs.
Sure, I did not know that was the grant.
Well,
that would
you just had to ask me, didn't you?
No, I had to ask the officials because that's my job at Estimates.
Anyway, can I continue with my questions, Chair, without interruption?
You can.
Thank you. In relation to the Queensland African Communities Council, are you aware that they go into the Queensland juvenile justice system, working with the most at-risk youth in our community, young children who are in our juvenile justice system with cohorts, including our African youth, overrepresented in our juvenile justice system, and do great work assisting those young people turn their lives around? Are you aware of that?
Senator, I think the best answer as I can give is we got a lot of that information during the grants application process, so the department would have been aware of the work of Casey City Church, yes.
Are you aware that a leading professor at Queensland University of Technology, who is involved with an outstanding Queensland organisation called QPAST, actually did a research study in relation to the outstanding contribution being made by this organisation and the direct impact, positive impact it was having with respect to the lived experience of these young people at risk?
I was not aware of that, Senator. I'd have to take it on notice if the department was aware, but we may well have been aware, as I said, through the application process. I'd have to check that.
When the department actually considers these grants, do they actually go and visit the people who are providing the service, actually engage go on the ground, talk to young mentors, talk to young professionals in the relevant communities who are volunteering their time and making a difference to their community.
Senator, thank you for your question. I'd refer back to my previous answer where it's not actually the department anymore that makes the decisions in relation to these grants. It's the Business Grants Hub who gets the applications, assesses the eligibility criteria and makes the decisions, which is why it's difficult for me to answer what we were aware of. We provided the recommendations that came from the Business Grants Hub up to the Minister for consideration. It's actually another department and the Business Grants Hub in that department that assesses all of those eligibility criteria and factors in those considerations.
Has the department undertaken any analysis on the difference in cost to the taxpayer of a young person, a youth at risk, spending considerable time in incarceration as opposed to a young person who has maybe committed an offence and is then assisted with the guidance of their community to go on the right path, the correct path, and lead a productive life? Has the department undertaken any analysis with respect to the benefits, both economic, social, human, to the community with respect to that early intervention approach?
Thank you for your question, Senator. I'm not aware of any analysis, but I think you can see this Community Crime Prevention Grants program is targeted at exactly doing that and funding a range of organisations in relation to the early intervention stream. Here, 134 organisations were funded with, I think, the end goal of doing exactly what you've described, that early intervention to try and divert youth away from ending up in the criminal justice system.
So the return to the community and from an economic perspective, let alone considering the great human return, which can't be calculated in a spreadsheet or by a calculator, is absolutely, there's no question that a successful early intervention provides a greater return to the Australian community than a person who remains on a path of imprisonment, criminal behaviour in a long term. Is that correct?
Look, I'm cautious of answering that in the specificity, but I think, again, I'd go back to the fact that this has been a long-ranging program which has had a lot of grants awarded with that very purpose in mind. Yes, Senator.
Are you aware where the Queensland African Youth Community Centre is actually located, which federal electorate it's actually located in?
I am not. I try not to know these.
Are you aware that it's actually on the border of the seat of Blair and Oxley? And in fact, it may be, though I'm not absolutely sure, the road cuts through the border of those two electorates. Are you aware of that?
I'm not, Senator. I think your knowledge of Queensland electorates is far greater than mine.
Are you aware that the seat of Oxley is a very safe Labor seat?
No, Senator.
Are you aware that funding from this grant also went to the Labor seat of Moreton, where I think it was last year I had the delight with my colleague, who I deeply respect, Mr Graham Perrott MP, the Labor member for Moreton, of opening the African village in Moorooka?
I think the best answer I can give, Senator, is the department and the Business Grants Hub, who assesses the grants, doesn't take into account the electorate in which the grant is being awarded in.
Okay, thank you. I should say then, in relation to the questions I had with respect to the Casey City Church program, which from my perspective has a resonance quite similar to the Queensland African Youth Communities program, that actual project is located in the Labor-held seat of Bruce?
I think I can only refer you to my answer earlier. We don't break this down by our electorate.
Okay, thank you. I'd like to now turn to some of the questions that were made with respect to what were and should be properly characterised as election commitments. I have a number of documents which I wish to table, and the first is in relation to the Sri Lankan Buddhist temple at Berwick. Mr Warnes, what do you see in large red type at the top of that document which I've just presented?
I believe you're referring to the words election commitment.
Correct,
Senator.
election commitment. And in the answer to questions you received from my colleagues, you were, and I noted following your testimony, you're very conscious of the fact that all parties in an Australian election context make election commitments. Isn't that correct?
Yes, Senator.
And the department, it appears, has a practice of keeping a log, do you, of election commitments as they're made during the course of an election, so you can work out how you're going to implement those election commitments. Is that correct?
That's standard practice for all departments, Senator.
And that is different, quite different from a grant process. Isn't that correct, Mr Warnes? And you seem to make a very sharp distinction, which certainly I picked up, between election commitments on one hand and grant applications on the other. Is that correct?
I think I was quite clear in my evidence, Senator, that we considered these things to be election commitments, and we would have provided advice to an incoming government about how they then might fund and the process for funding those election commitments, yes.
Okay, I have another document which I'd like to table. This is an announcement from Mr Jason Wood MP, Federal Member for La Trobe, then Assistant Minister for Customs, Community Safety and Multicultural Affairs.
Yours is a bit different to ours, Senator Scarr. Your document that you're... Is that the same document?
That's my document.
Yours is
Which
different.
document?
So yours has the crest of the government on it. Sorry, I might have handed,
Sorry,
you
that's
handed
not,
me the wrong document.
that's not my document.
Yeah, got it. It was the second page. Apologies. Are we tabling these?
Yes, I am tabling those. Sorry, have you just got the second page?
Yeah, that's what
I've
they
got
handed
two
me. That's why I
pages.
was confused.
I've got 2 pages.
I've got both pages
Sorry,
now,
I've got
Senator
2
Scarr, and if you, very
Yeah,
happy for you to table
So
those.
did you give everyone on page 1 and 2? Yep. You have? Yep. Okay. So, Mr Warnes, I just want to make sure you get pages 1 and 2, please.
Thanks very much.
Mr Warnes, in that document, is there any, I'll give you a chance to have a read of it, but it clearly states that it's an election commitment with respect to the a promise to provide $1 million of funding to the temple to provide much needed security fences, remote controlled gates at the 4 entrances. That's on paragraph 3, is that correct?
Yes, that's correct, Senator. I can see the
So
funding
that
you
would be
refer
in the
to.
nature of a pre-election commitment or an election commitment which you would log in the usual course. Is that correct?
I think it's consistent with the answers I've given, Senator. Absolutely.
Totally
These
consistent with the answer
announcements
which you've previously
would have been
given.
recorded.
Okay. Are you aware of any such commitments being made by the Australian Labor Party during the course of the election? Of a similar nature?
I think not specifically in relation to it, but there was a commitment to fund $14 million in Central Australia, 11 million of which I think would go through a grants process.
Okay. Were you aware that Mr Julian Hill MP made an election commitment, and I'll make no reflection upon him for doing so, absolutely none, of $700,000 to the Sikh Volunteers Australia organisation?
I'd have to go back and check the records on whether we logged that as a crime prevention one that was within. I'm not sure what exactly that was in regards to.
And I should note that that election commitment was, for the sake of Hansard, as I understand it, matched by the Liberal Party as an election commitment. You're not aware of that?
Not aware of that one, not to mean we didn't.
I'm going to ask you a general question to take on notice at the conclusion of this. Are you aware that the Liberal Party made a commitment to the, again, excuse my pronunciation, the Basin Ganesha Temple, Sri Vakrathanda Vinayagar Temple of $1.5 million during the election?
Again, I'd have to take that on notice to refresh my memory about the election commitments that were made, Senator.
Were you aware that that election commitment was actually matched by the Labor Party?
As per my previous answer, Senator, I'd have to take that on notice to check.
Can I ask you to take on notice and provide a list of all election commitments that you tracked as a department, made by all parties, independents and Greens, and anyone else during the election campaign?
Just to be clear, Senator, are you happy if I confine that in relation to the grant space that we were tracking in the division in relation to...
Well, given the discussion about what constitutes a pre-election commitment or an election commitment, which I have a particular view, and the blurring or conflation of that with the grants process, I'd ask if you could prepare a list of all election commitments that you logged during the course of the election campaign.
Just a little
Senator, maybe if it's possible to say if it relates to safer communities or community crime prevention as a topic.
Well, Ms Chidgey, I'm very wary in terms of the language I use, because I do not want it suggested that any of these election commitments, whoever they were made for, were actually an election promise or something to make a grant under a particular program and therefore pre-decided what the outcome of a grant would be. So if I could, you understand, I think, what I'm after.
Yes.
Perhaps if you
Yes.
could do your best, make your best effort to do something which does not impose an unreasonable burden upon you and upon the department, and we'll see what that generates. And then if I've got further questions, I could perhaps follow that up at the next estimates. Does that help?
Senator, it does. I think, just to be clear, because of the Secretary's information she gave before about the machinery of government changes, like a lot of those, we recorded them as the Department of Home Affairs back then, so I think it's best I give you what I have, and then we can go from there. So happy to take that on notice. I think we understand what you're after.
Okay, thank you very much. I'd like to refer to the local...
Another couple of minutes, Senator Scott. I won't cut you off yet.
I'd like to refer to the Local Multicultural Projects Grant Opportunity Guidelines, which opened on 7 February 2023 and closed on 20 February 2023, and the results... Well, actually, I just refer to the guidelines. Do you have a copy of the guidelines there with you?
No, I don't, Senator. I'm not sure that's our program.
What's it called, Senator?
It's called the Local Multicultural Projects Grant Opportunity Guidelines,
Sounds
which
like it
were
might be
issued
Minister
on...
Giles.
I'll just provide a further description of it if I could, which were provided on 7 February 2023, and it closes actually on 20 February 2023, and it actually has a list of pages on pages of invitees. And this is actually attached to the guidelines at the time they were issued. Are you aware of that?
Senator, I don't believe that's a program in the Attorney General's department.
Okay.
It may be Department of Home Affairs.
Okay. Is this, Mr Warnes, you said in certain cases when you actually track election commitments that are made by parties, the department after the election has to come up with a reasonable process to actually make good on the election commitments. So in the event that someone, say I, go out into the community and make an election commitment with the authority of my party, how do you translate as a matter of execution that election commitment into delivery?
Yeah.
That's your last question, Senator Scott.
Describe it in the broad, Senator. Like there's a number of ways that it can happen. So, as I think in the previous answer I gave, oftentimes in this space, in the community crime prevention space, the confiscated assets account provides a vehicle by which that money can be distributed through a grants program, and Section 298 has some clear purposes for which the Minister has discretion to provide funds, and so one of those is crime prevention under the Act. So that is one way. If it doesn't fall within that kind of category and it can't be funded under the confiscated assets account, then we provide advice about potentially budgeted rounds that can happen outside of the confiscated assets account.
Thank you,
So
Senator
it's
Scott.
a-
That was your last question. And I've
Sorry,
given
I
you
just had one follow-up,
I've
if I
given you a
could.
couple of warnings if you want to ask one final question.
So in that context, there's a pre-election commitment, and that pre-election commitment is made good through a grant process, which presumably only has one outcome. Is that correct?
Not necessarily. I wouldn't jump to the conclusion
Well,
it only has
how would
one
you
outcome.
characterise?
But there's a grants process, and oftentimes people who have who commitments are made to are informed of that process and can apply through the process and have to meet the eligibility criteria under the grants guidelines and be assessed.
Okay, thank you.
Thank you, Senator Scott. I just have one follow-up and I'll hand to my colleague, Senator O'Neill. Mr. Wansley, you took quite a number of questions on notice around lists of round 6 and early intervention, the ones we've been talking about. And I tried to make this clear to the Senator previously, we don't know what grants were involved in that grant round or which ones were recommended or not recommended. Today's the first opportunity we've had to learn that information. Can we get a list of all the projects for that grant round that were recommended, please?
I think that's consistent with what I took on notice
Yeah, sure.
previously. So
I just wanted to make sure I
happy to-
had asked the right question.
I think that's right, but yes, happy to take that on notice.
And do you know, or could you take on notice, how many applications there were in total?
Under round 6, Senator,
Yeah.
So I
You've
think we
given
gave.
us the number of
Did you give that to?
I think we gave that to Senator Shoe.
Okay.
We gave the 2 numbers to Senator Shoebridge.
So that was oversubscribed, essentially.
It was very much oversubscribed.
Okay. And again, can I just put on the record, these questions don't relate to the entities themselves, the organisations, or the work that they do in the community. They are questions about public process and about the way that they were decided and announced. And I think I just want to put that on the record. Senator O'Neill, you've got the call.
Thank you very much. I note the documents that have been tabled by my colleague, and I guess we all face a situation where many things are oversubscribed and many worthy participants don't get up. So no reflection on the senator, but the reality is these things are limited, that there's not often the capacity to meet every single demand, and they're competitive in nature. Just the way in which some of these things were characterised, if I could go to the declared election commitment, I'd like to table documentation here about the announcement for the Gurudwara Sahib Geelong Sikh community that characterises that announcement in a very different way, not as an election commitment, but indeed as a funding commitment. We've got the lovely Banks commitment, which is on the materials from Senator Henderson. On her webpage, it looks like, she declares a re-elected Morrison Liberal government will commit $500,000 to invest in security systems and other community safety infrastructure at the New Geelong Gurudwara Sikh Temple to be constructed at Lovely Banks. The Morrison Government Safer Communities Fund. There is a clear implication that it's from the fund, not an election commitment. So there's quite a gap between the way these announcements seem to be made. I acknowledge the Senator's got one that's an election commitment, but this one looks like it's a funding announcement. I also point to...
Did you want to... Sorry, Senator.
Can I table those? There's more to table as well, if I can do that.
The Secretary will make copies if you...
Thank you, if that needs to happen. Could I also table a Facebook post from Mr Richard Welch about the announcement to which I referred earlier with Assistant Minister Jason Wood MP, Tim Staker-Gunn, Liberal for Colwell, and Senator Greg Mirabella. I also seek to table a statement, a Facebook statement from Mr Jason Wood's MP's Facebook page relating to announcements that were made of funding, not election commitments. I'd further like to table a news article that features Senator Cash and Ms Brooke Fitnell that refers to questions that I was asking earlier. Could I also table the Facebook page of Dr. Fiona Martin, just so that people who want to have a look can make up their own mind about whether this was characterised to the people of these relevant electorates as an election commitment or as a funding allocation from a particular program that was not announced and about which there were no guidelines published. And similarly, another article about the commitment involving the Sri Lankan Buddhist community of Melbourne. I'm sure very worthy recipients, but I'm sure they appreciate being told the truth about what was really going on. And one that I referred to earlier, the Daily Mirror Online, Mr. Raj Pereira, who claimed he was instrumental in delivering funding for to support temples. And I don't think that the evidence that we received earlier bore that out. And if I can just refer to the release that my colleague Senator Scarr has put on the record from Jason Wood MP together with the Liberal candidates for Bruce and Holt. I think the officials probably would have a copy of that. It refers to a $1 million funding announced. $1 million of funding to the temple, much needed funding. I'm struggling to see anything about election commitment anywhere in the quotes that are attributable. Indeed, the past tense has been used in a quote attributable to Raj Pereira, Liberal candidate. I'm delighted the vibrant, dedicated Buddhist Vihara temple in Berwick has been granted this fantastic funding opportunity to improve the security measures at their premises. And I'm very mindful of my interaction with many community groups about the way they would receive this information, filled with hope, dedicated civil servants for their community, highly engaged in participating in good governance structures, and believing and trusting in their public officials as they have a right to, that they would be delivered a project, that it's all said and it's all done and dusted, that it's not an election commitment if we get in, it's has been granted. And no doubt that spread like wildfire throughout those communities, and I think it bears out my description of this whole process under the former government as a gross deception and a failure of good governance.
Isn't that what intervened means as well? We still haven't got the definition of intervened.
Senator O'Neill, have you finished tabling those documents?
That's all I have to table.
Okay.
I'd just like to put on the record in the short time we have before we break an opportunity for the officials here to see if they have any further information about similar sorts of announcements that were made by Mr Jason Wood with the former Prime Minister, Mr Morrison and Mr Hawke, announcing election commitments of $500,000 for the Officer Sikh Gurdwara in Latrobe to upgrade their security structure. Did the department receive any direction about a possible grant under the future round of Safer Communities for the Gurdwara?
I think consistent with my previous answers, Senator, no, we didn't receive any direction that I'm aware of.
Thank you. There's a now deleted media release from former Liberal Senator ACT Zedza Zelja, who secured $500,000. Well, that's what he described it as, secured $500,000 for a new Hindu temple. Did the department receive any direction about a possible grant under the future round of Safer Communities to fund for the Gurdwara?
Not that I'm aware of, Senator.
Okay. These were all members. Liberal candidates got in on the act and started making some announcements as well. Could I go to the Liberal candidate for the marginal seat of Parramatta, Maria Kovacek, who announced $18,000 for security upgrades for the Buddha Light International Association? Did the department receive any direction about a possible grant under a future round of the Safer Communities Fund for the Buddha's Light International?
Similar to my previous answer, Senator, not that I'm aware of. We were tracking election commitments as they were made.
And closer to home for me in New South Wales, on the Central Coast, in a seat that's now held continues to be held by my good friend Miss Emma McBride. The Liberal candidate for that marginal seat of Dobell, Dr Michael Fennelly, announced $60,000 for security upgrades and to support the Glen for women. And I just want to give that fantastic institution a plug. It's a rehab centre for men and also now women, doing quite remarkable work. I'm sure that they would have appreciated what they thought was a funding allocation that was characterised as such, not a maybe promise. The Liberal candidate said the security would upgrade would improve the facility, provide a protected environment for volunteers to serve the community. It's all about, and guess what they used? Creating a stronger, safer community, referencing the very fund that didn't exist as a round 7 funding opportunity. Did the department receive any direction about the possible grant under a future round of the Safer Communities Fund for the Glen?
Not that I'm aware of, Senator.
And there are, I think, a couple of additional items we might be able to table with regard to that. They might be on there. Thank you very much, Chair.
Thanks, Senator O'Neill. Can I just, before we go to the break, we will try to move on, I think, when we come back. So just while we've got these officials here, I just have a question in regards to, you asked about a submission you made to an inquiry for another committee. I think it was in regards to the Committee on Foreign Affairs, Defence and Trade. Senator Chan asked you those questions. Was the Attorney General's Department called to present evidence to the committee?
No, Senator. I believe not.
Can we just take that on notice? I often receive letters from committee chairs inviting us to appear. I don't recall
I think we
this
weren't called. My colleagues have just confirmed.
No.
We weren't called by the committee.
No, is the answer. Yeah, no. Hansard doesn't pick up shakes of the head, unfortunately. And listings under the Criminal Code, however, they are the Attorney General's responsibility.
Yes, they are.
The committee, I mean, I have to say I'm a member of that committee, and we didn't get any evidence around a decision, who was the key authority on, and decision maker on the Criminal Code to provide evidence. The committee didn't actually seek to have information relevant to that question because they didn't ask the department information. Is that right?
That is correct, Senator.
Okay. And that goes to whether the IRGC is a terrorist entity under the Criminal Code. That's specifically a matter for the Attorney General's Department, and you weren't, as you've told the committee, you weren't asked to actually give that evidence.
That's correct, Senator. I should have stated my name, sorry. My name's Brooke Hartigan. I'm the First Assistant Secretary of the Security and Counter-Terrorism Division.
Thank you.
It's our understanding we were not called to give evidence to the committee.
I appreciate that. Thank you very much. We will break now for dinner. We'll be back at 7 o'clock and we'll have some updated information around the program. We'll have some short discussions and hopefully some agencies get some clear guidance. I think we will be returning to this outcome.
So, Chair, I just wanted to clarify.
Senator Shoebridge has some final questions on this.
But, I mean, that would be very brief, probably
very
3
briefly.
minutes. We could do
There's
it
no chance
super
of knocking them
quickly.
off now so I can let relevant officers go.
It's up to Senator Shoebridge.
I'm very happy to do them as quickly as possible. It's really just 2 short issues.
Do you want to do them now?
If you don't mind, Chair, that would be great from our perspective.
Sorry?
No, I'm going to
Sorry,
ignore
we
that.
don't have quorum anymore. We'll
Oh.
have to do them when we come back. Thank you.
Okay.
Oh.
Sorry.
Thank you for considering.
Yeah.
Thank
Sorry.
you.
No, I think the opposition's
Opposition.
You are.
Thank you. We'll resume the hearing there. And we are still with the National Security and Criminal Justice Group, but if I can provide a small update. No senators have questions in the room. They might have some questions on notice, but we don't require officials from the Enabling Services Group. We thank you for hanging around all day, but we've tried to get you out of here as quick as possible. So all of those officials are free to go. And we'll keep proceeding on the program. We're trying to aim to get to the Australian Human Rights Commission by about 8 o'clock, and we think we can get through most agencies. But if there are agencies through in the next hour or so that we don't require, we will let you know as soon as possible. Senator Scarr, you have some questions. Senator Shoebridge, you had 2 more you wanted to ask, and then Senator Scarr has the rest of the call, and that might be this outcome dealt with. Okay. Senator Scarr, Senator Shoebridge has given you the call to begin with.
Thank you, Senator Shoebridge. You aren't chair, you know. But you'd have to respond to that. Secretary, can I asked you a question earlier today in relation to parole, and the question was, can I confirm that parole is dealt with in terms of the post-restructure, which group now deals with parole? Where does that fall?
It is the group that's on now.
Okay, all right. So, post-restructure, have there been any changes in terms of how parole decisions are made, or submissions which are made by the Attorney-General's Department with respect to parole?
None resulting from the restructure, Senator.
Is there, Ms Chidgey, is there anything resulting from anything else?
Well, we can. I think.
It just begged the question. Your answer.
I think just in terms of like who, at which level, department or minister decisions are made.
Thank you, Senator. Sorry, struggling with the chair here. Tari Inverarity, First Assistant Secretary, International and Security Cooperation Division. The only change has been in which decisions the Attorney-General has indicated he wishes to make personally versus those which he is happy to have made within the department. The current Attorney-General has indicated he wishes to make parole decisions about terrorist offenders. Previous Attorneys-General have also wished to make decisions about other categories of federal offenders, such as child sex offenders. So that's the only change.
So the only change is a decrease in relation to the number of alleged offences which the Attorney is seeking.
The number of parole decisions that are being made personally by the Attorney-General.
So they're now just those relating to terrorist offenders, correct?
Correct.
Okay, thank you.
Although we will always discuss on a case-by-case basis with the Attorney-General's office any high-profile or other offenders to ensure that the Attorney-General is given the opportunity to make decisions where he may wish to do so.
Okay, thank you. Just my last question in relation to this outcome is in relation to the Hikvision and Daewoo device issue. In question time on 9 February, my colleague Senator Patterson asked a question of Senator Watt, Minister Watt, in relation to an indication from Deputy Secretary Mark Ablong on 28 November 2022 that the government had then, at that stage last year, not taken a decision in relation to those security devices. And he said, what I can advise the Chamber is that the Attorney-General has requested advice on whether a government-wide ban is required to address protective security risks. Of course, the Albanese government takes national security seriously and we will always act in the national interest, end quote. So the question is, has the Attorney-General come to a decision in that regard, noting that there are a number of actions which appear to be being implemented as we sit here today in estimates?
Thanks, Senator. I'll ask Ms Chidgey to start and others will join in.
So we're preparing advice for the Attorney-General on that issue and are working with other relevant agencies, particularly ASD, ASIO and Department of Home Affairs on that issue to provide advice on, as you mentioned, the possibility of a ban, but also other ways we could improve arrangements to deal with equipment and technology.
Okay, thank you, Ms Chidgey. Has the Attorney set a time frame for when the advice is to be provided?
I'm not aware that the Attorney has, but we'll be doing that as soon as possible.
Okay, all right, thank you. I'll put the other questions in relation to that on notice. Thank you, Chair.
Thank you, Senator Scarr. Senator Shoebridge?
Does the department have any answers about why the report by Dr. Emily Corner in relation to the then Department of Home Affairs tool for assessing future community risks of terrorists was not provided in the Ben Bricker case?
Thank you for the question, Senator. Brooke Hartigan, First Assistant Secretary of the Security and Counter-Terrorism Division. This matter is currently before the court, so given that, I think it would be inappropriate to comment any further.
Well, has the department undertaken an investigation as to why it was that that report, which was deeply critical of the tool used by the department, was not provided to the court? Have you undertaken an investigation?
We have considered this issue, Senator, and we've recently provided affidavits to the Supreme Court of Victoria and Mr Benbricker's legal representatives explaining the circumstances of the non-disclosure of the Corner report.
Who undertook the review?
Senator, I don't think I'd describe it as a review. We've obviously been working in the department and with other agencies to gather that information and then provide the necessary advice to the court and Mr Benbricker and his legal representatives.
So who undertook that inquiry, investigation, search, however you want to describe it? Who undertook that action?
I think it would be this department working with Department of Home Affairs and AGS.
And the Australian Federal Police.
I think, Senator, what I could say is probably all four of us sitting at this table have had some engagement on that issue.
Is the department intending to publish Dr. Corner's report?
Senator, at this stage I don't think it's the department's intention to publish a report. It is a matter for the government if the government would like to publish it. Home Affairs sought the report, so it may also be a matter for them.
What was the essential critique of Dr. Corner of the tool being used by the Department of Home Affairs in its assessment of future community risk? What was the nature of the critique?
Senator, I think it's fair to say one of the criticisms was the lack of evaluation of the tool.
When was that report provided to the Department of Home Affairs?
Senator, I believe it was June 2020.
Is the tool still being used by the Commonwealth to assess future community risk? Is the same tool being used?
It is up to expert assessors. It is not mandated. It's a choice for the psychiatrist or psychologist should they wish to use that tool.
So for 2.5 years, the Commonwealth has known that this tool is seriously flawed and has continued to use it to assess the future community risk of
Senator, I
detainees.
think we wouldn't accept that description.
Well, you by all means tell me how you would describe Dr. Corner's critique of the tool.
Senator, I think there are other reports on that tool as well, and it is not the only thing used to make assessments, and as Ms Hartigan said, it's up to the relevant expert to determine whether they're using that in combination with other methods to make assessments.
But Dr. Corner identified serious flaws in the tool, didn't she?
Senator, I think there's not much more I can add to the answer I just gave.
Well, I'm going to press my question because I don't think you have answered it. Dr. Corner identified serious flaws in the tool, didn't she?
Ms Hartigan has indicated some of the
Ms.
issues
Hartigan
that
is
she
nodding.
found.
I think Dr.
Nodding
Corner,
doesn't turn up though on the
sorry, Senator. I
transcript.
think Dr. Corner expressed an opinion about the tool.
And her opinion was that there were serious flaws in the tool.
Senator,
we'd have to check that description as to whether she used that language.
Ms Hartigan's indicated some of the issues she identified with the tool.
Who then has been tasked with using or not using the tool for the purposes of the Commonwealth Risk Assessment?
Senator, it's my understanding that no one is tasked to use the tool. It is a tool that is available for use should an assessor choose to use it.
So on how many occasions since June 2020 has an assessor used the tool for a future community risk assessment?
I wouldn't have that information. I'd have to check with Department of Home Affairs, so I'd have to take that on notice.
All right. Are those assessors provided with a copy of Dr. Corner's report when they are also given the option of using the tool to make the assessment?
They are now, Senator. So we have given the report to a psychologist in a recent matter. So it will be our practice going forward to share that report.
So it's been done once?
We'll take it on notice whether it's been done more than once.
Well, can you identify, if you can, when was the earliest occasion that was done and the circumstances in which it was done?
Yep. Yes, we'll take that on notice. We'll need to check with Home Affairs as well.
Has an unredacted copy been provided to Mr. Ben Breaker's legal advisor as per the order of Justice Hollingworth?
Yes, it has, Senator.
And has an unredacted copy been provided to the court?
Yes, it has.
What is the government's position regarding the Witness J report from the Independent National Security Legislative Monitor? And I think when I said there was a case next week, I think I had Witness K's and J's mixed up in my brain, and I think it might be Witness J that's next week.
Yes, that's correct.
Okay, so what is the government's position regarding the provision of the Witness J report from the Independent National Security Legislative Monitor or Legislation Monitor for the purpose of those proceedings?
It's publicly available.
Yep, we've tabled the response.
I beg your pardon?
We have tabled the government response.
And the Inslam's report is a publicly available document.
Right. In full?
Yes.
What is the purpose of the hearing next week in the Witness J matter?
Sorry, Senator, can you repeat that
What is the
question?
purpose of next week's hearing, if there is a hearing?
Senator, we just need to check.
Yes, Senator, so you're referring to the Inslam's report from his review, or are you referring to a court judgment?
The question I have...
I think you referenced the Inslam report, which is
Correct.
a public document.
Yes, so what's the issue in proceedings between the Commonwealth's position in the Witness J proceedings that's for this next week's hearing?
It's about the publication of the court's judgment or remarks in that matter.
All right. And what is the Commonwealth's position on the publication? Is it another case where you're seeking significant redactions?
It's ultimately the Commonwealth's position that it's a matter for the court to determine that, but we have sought that hearing in order to enable a decision on publication of a judgment.
And my final question is, I was asking you about the costs of different matters. What has been the cost today in the Witness J matter?
We'll have to take that on notice, Senator.
Thanks, sir.
Thank you, Senator Shoebridge. That's all the questions we have for that outcome. I now call officers from the Australian Government Solicitor Group for the Attorney General's Department. Thank you.
Just checking, Chair.
Otherwise, I think
If someone else has questions and they want the floor.
Yeah. Senator Shoebridge will begin with you.
Call. You're not the chair.
We're very collegiate.
Touche. Touche.
Oh, sorry. What are the two agencies?
I have
And just for the
I have
information.
no questions for the AGS.
Okay, good. We have two agencies that we are not going to require this evening. The Australian Financial Security Authority, thank you. We won't be requiring you in the room tonight. And the Federal Circuit and Family Court of Australia. Thank you very much.
Thanks, Chair.
And Senator Shoebridge, you have the call.
I thought another senator had called the
They
Australian
have.
Government Solicitor, because I want
And
to be
they
clear.
are not here
I have some
yet.
questions, but I probably... But anyhow, I'll ask a brief line of questions.
If you could.
Yes, Mr.
Otherwise.
Kingston, thanks for your attendance. I was going to ask you a series of questions in relation to submissions that the AGS makes in relation to parliamentary privilege. There was a very recent coroner's case where I believe the AGS made submissions asserting that parliamentary privilege would prevent certain material being put before the, I think it's the Tasmanian coroner. Are you aware of that matter?
Michael Kingston, Australian Government Solicitor. I have a possibly unreliable, distant recollection of something arising in Tasmania about parliamentary privilege, I would guess a few months ago now.
All right. Well, I think the matter came to a head more recently in Tasmania. And again, the AGS made a very, I'll call it robust, but perhaps a better description might be expansive submission in relation to the use of parliamentary privilege and how it would prevent parliamentary reports, government responses, critical material being put before the courts. You would be aware that this is not the only case in the last 2 years or so where the AGS has made submissions in relation to parliamentary privilege in, say, royal commissions and the like. Is that right?
Correct, yes.
And indeed, you'll be aware it's a long-running issue, for example, in the Royal Commission into veteran suicides.
Yes, well, it's certainly come up, yes.
Yeah, and the AGS has on repeated occasions made submissions in relation to certain documents, the use to which it can be had, whether or not it can be tendered in that Royal Commission. Would you agree?
What I suspect will have happened, without being able to necessarily speak to every instance you have in mind, is what government lawyers tend to do on those occasions is simply remind the tribunal or the commission, whoever's being required to make a decision, of the way parliamentary privilege could apply to that document. It's then up to the tribunal or the commission to make its decision about what it's going to do in light of that position.
When you're making submissions about parliamentary privilege, who's your client?
Well, it'll be whoever we're acting for on that occasion. So in the case of the Defence Veteran Suicide Royal Commission, it's the Commonwealth.
Well, when you say the Commonwealth, do you take instructions from a member of the executive?
It's the Commonwealth principally instructing us, in the case of the Royal Commission, this department, the Attorney General's department.
Yeah. Well, it's not the executive's privilege, though, is it? It's the privilege of the Parliament.
Well, parliamentary privilege is not, at least in the realm we're talking about now, a privilege like legal professional privilege where you can assert it or waive it and it sort of belongs to someone. Parliamentary privilege, as set out in the Act, is sort of a rule of law. It's not something that one can choose to press or not, and that's partly why I say it's not like the government lawyers in those circumstances are claiming privilege. They're simply drawing the tribunal's attention to the relevant law, and then the tribunal makes a decision.
When you're asserting the extent and or the consequences of parliamentary privilege, and you're seeking instructions on the positions you're putting forward, who do you seek those instructions from?
Well, normally, again, I can't speak for every case, but normally it would be at least in the case of the Royal Commission and this department, instructors within this department, and on parliamentary privilege and other occasions, we'd often, even if this department were not our client, we'd often, perhaps always, but often consult with this department because of the particular nature of parliamentary privilege and its constitutional implications.
Mr Kingston, the proper officers to seek instructions for on parliamentary privilege wouldn't be a minister or a secretary, but indeed it would be the President and the Speaker, the two presiding officers of the Parliament, wouldn't it?
Well, again, Senator, I think it depends on context. And it goes back to what I was saying before, at least in the context of the Royal Commission. Aspects of parliamentary privilege, it's called parliamentary privilege, but they're actually sort of rules in an act which say what may and may not happen. And those rules have to be complied with by whoever to whom they're applicable in the circumstances. So it isn't, at least in the situation I think you're talking about, a matter of someone deciding to apply them or not.
No, but when you're seeking instructions on matters that are open for debate and value judgment, the extent to which those privileges operate, the way in which they would have an impact or otherwise on how a court could, or a tribunal or a Royal Commission could or couldn't use a document, the appropriate officers in our constitutional framework to seek those instructions from are the presiding officers of the Parliament, the President and the Speaker. Have you ever sought instructions from them in relation to your assertion of parliamentary privilege?
Well, I don't accept, certainly in all circumstances, perhaps at all, the premise that they're the people who should be expressing the view in all cases. From time to time, AGS has liaised with parliamentary officers about privilege, in particular where the relevant parliamentary officers may have consulted us about where they have wanted to assert privilege in certain circumstances. But on other occasions, as I indicated, and the Royal Commission's an example, our instructions have come from the Attorney General's Department.
Have you ever consulted with the clerk of either the Senate or the other place on the issue of parliamentary privilege, its reach and extent? Have you ever sought instructions from or consulted with either of the clerks?
I would want to take that on notice to be sure, but as I did indicate in my answer to your last question, there have been occasions in my recollection, but I want to take it on notice just to be certain about it, where we have been assisting the parliamentary officers in relation to parliamentary privilege, and if my recollection about that is right, we would certainly have consulted with them on those occasions.
Are you aware of the fact that the clerk of the Senate holds contrary views to the position adopted by your office in material aspects as to the manner in which parliamentary privilege is being asserted by the AGS? Are you aware of that fact?
I have seen a letter from that officer, I think it's from that officer, in relation to one of the Royal Commissions, which you could certainly read it as in some respects taking a different view, yes.
So I come back to the point. Have you consulted, have you sought the views of the presiding officers when you're making these bold assertions on the extent and reach of parliamentary privilege, knowing now as you do that one of the key officers of the Senate has a contrary view to your office on the extent and operation of parliamentary privilege?
No, in relation to the context that you're talking about, as I understand it, the Defence and Veteran Suicide Royal Commission, we have not done that. We would not regard what we have done as I think you said bold, it might have been bald, assertion. We have thought again about our position in light of that, and we have, without wanting to go into detail of what we said to our client, being the department, because they would need to speak to that. We have discussed it with our client.
Ms Jones, has the department consulted with either of the presiding officers before it provides instructions to the AGS on the nature and extent of parliamentary privilege for the purposes of such things as the Veterans Royal Commission?
Senator...
And just to get to the chase, if not, why not? So as we...
Yep. So I'd have to take it on notice in terms of the specific amount, times, if there have been, where we've done that type of consultation. Over the last several years, there have been, I think, a lot of engagement, if not directly with the presiding officers, with their officers and people there in the context of discussing a range of issues associated with parliamentary privilege. So there is an ongoing engagement. I think in terms of the very specific question you've asked about whether in relation to particular matters we seek their view before we assert parliamentary privilege, I'd need to check that with Mr Lewis, but I can't recall recently, but he can confirm for me.
David Lewis, General Counsel, Constitutional Office of Constitutional Law. I apologise, Senator, I've missed the start of the conversation about parliamentary privilege. Was your question about the extent to which the department consults the presiding officers when putting a position on parliamentary
Correct.
privilege?
And then to make matters quicker, I'll also be asking the same question about the clerks in each house. So if you can answer the two together, that would be helpful, Mr Lewis.
And, sorry, just so I understand, what's the context in which you're asking in relation to the positions we're forming, in the context of litigation or...
in the context of litigation, tribunals and royal commissions, where parliamentary privilege is being asserted by the AGS to have an impact on the use or admission of evidentiary material.
And the letter from the clerk recently.
Thank you, Senator. So, as the Secretary has mentioned, we do have some ongoing conversations, particularly with the deputy clerks, about certain aspects of parliamentary privilege. I don't think it's the case that the department consults the clerks or the deputy clerks or any of the parliamentary officers in relation to every instance where there's a issue of parliamentary privilege raised, either in litigation or in a royal commission. It is the case from time to time there is consultation or discussion about particularly the position to be put in litigation. But as I said, it wouldn't be in every particular case.
Well, Ms Lewis, I'll put the proposition to you that I've put to Mr Kingston. It's ultimately the Parliament's privilege and the appropriate officers to go to seek instructions on the extent to which that privilege runs are the presiding officers of the Parliament, the President and the Speaker, not some officer of the Executive. That's right, isn't it?
Well, it's certainly right that the presiding officers and the clerks have important responsibilities in relation to parliamentary privilege. I guess, particularly when you're talking about the application of the Parliamentary Privileges Act, that's an act of the Parliament, and whenever a question comes up about the application of that act in litigation, it's just something that those acting for the Commonwealth or those acting for anyone need to take a view on what the legal meaning of that act is.
But you accept, don't you, that there's often a conflict between the position and between the interests of the Executive and the interests of the Parliament when it comes to, for example, the use to which a parliamentary report, which may be deeply critical of the Executive, can be used in the proceedings. If you take in instructions from the Executive, they may have an interest in squashing it and not having it admitted and used. Yet if you were taking instructions from the presiding officers of the Parliament, they may have quite a different interest insofar as asserting that the document should be used and available in the proceedings. You accept that there's quite often likely to be a substantial conflict between the interests, don't you?
I think that
Questions always does turn into 2 or 3 minutes.
I never made an assertion there's been 2 questions.
Sorry. Has someone mentioned that? Yeah. Well, no, they haven't. It's the letter from...
Yeah.
Sorry, Senator. I might say there may be a difference of interest, but...
A conflict?
I'm not sure where the conflict arises, but...
One wants it used and one wants it hidden.
Yeah,
it's a conflict.
Oh, I thought you meant conflict in that someone was faced with a conflict of interest.
Well, there's a conflict between the interests of the Parliament in wishing to have their reports have utility in the real world, including litigation and proceedings, and the interest of the executive, who may want a parliamentary document or report that's critical of the executive squashed and not used.
Well,
There's a
that's
conflict
where I
there.
said
How
there
do you
might
resolve
be
the conflict?
a difference of interest. But what I was about to go on to say was that is not relevant to the view of the law. That is, what is the meaning of those provisions in the Parliamentary Privileges Act that lawyers at AGS have to come to, and whether that view of the law happens to suit the interest of
your
person
client
A or person B is not relevant to our view of the law. And frankly, to suggest otherwise is to suggest dishonourable conduct.
No, I'm suggesting that your office has not turned its mind to an obvious conflict of interest. I'm not suggesting you've acted dishonourably. I'm suggesting you haven't turned your mind to an obvious conflict between the interests of your client, being the executive, and the interests of the Parliament, and you haven't turned your mind to that conflict. That's what I'm suggesting, Mr. Kingston.
But how does that... Well, I shouldn't ask a question. It's not clear to me how that affects how we come to a view of the law.
Well, we haven't got time to go through the kind of ethical step through of what you do where you perceive a conflict in this hearing. But perhaps we'll come back to it in another place.
We can do that, Senator Shoebridge. Is that the last of your questions? Senator Scarr, do you have... I feel like you might have questions on the same matter, so I'll go to you next and then we'll go to Senator Roberts.
Secretary, I have an intense interest in this issue, and I've looked at this issue very, very deeply, including looking at the submissions made on behalf of the President of the Senate in the Crown v Murphy case, which was the genesis of the introduction of the Parliamentary Privileges Act in 1987. Mr Kingston, are you aware that at the time that Act was introduced, the intention of the Parliament was that it was not to extend the privileges beyond those which were contained in the 1688 Bill of Rights in terms of parliamentary proceedings not being subject to question or impeachment, but simply to assert what was always considered to be the position with respect to parliamentary privilege?
Broadly, I wouldn't say whether I thought that applied in every single way, simply because I'd have to go back and remind myself, Senator.
Has there been any Superior Court consideration of the ambit, in particular, of the particular section of the Parliamentary Privileges Act, which is consistently being relied upon in the examples given by Senator Shoebridge in relation to the ambit of section 16(3)(c), which provides, in proceedings in any court or tribunal, it is not lawful for evidence to be tendered or received, questions asked or statements, submissions or comments made concerning proceedings in Parliament by way of or for the purpose of C, drawing or inviting the drawing of inferences or conclusions wholly or partly from anything forming part of those proceedings in Parliament.
Yes, subject to, again, being corrected that I'm not confusing the subsections, my answer to that is yes, I think there has been, but what I'd like to take on notice is just drawing those cases together. But yes, my recollection, including from some relatively recent reading, is yes.
Can you, in the course of drawing those cases together, can you please consider whether or not the current interpretation of the law is that, for example, the Senate's report called Constant Battle in relation to veteran suicide could not be tendered as evidence before a Royal Commission or a coronial inquest into the suicide of a veteran for the simple purpose of proving A, that the Senate committee actually produced a report, and B, that report contained a number of recommendations.
I'm happy to take that on notice, Senator, as part of your earlier question.
Mr Kingston, are you aware that in the Jessie Bird coronial inquest, and I have a copy of the extract which I'm happy to table, a Senior Sergeant Brumby was cross-examining a Miss Cosson from the Department of Veterans Affairs, and during the course of that cross-examination, Miss Cosson referred or invoked parliamentary privilege with respect to a Productivity Commission report in relation to Veterans Affairs, and parliamentary privilege was therefore used as a base to exclude any reference to that Productivity Commission report in that coronial inquest.
I'm not aware of that, Senator.
Were you aware of who issued the instructions in relation to that
No.
matter?
All I would say, though, is I imagine, without knowing the matter, that the effect you've just described would only have arisen because the coroner accepted the point that was being made about parliamentary privilege.
So the question, Mr Kingston, though, is if one took a very shallow, and I'm in no way reflecting on the coroner, view of those words without considering their context, without considering their history, without considering their purpose, one might come to an immediate conclusion that, it must be subject to parliamentary privilege and has to be excluded. Whereas taking on board Senator Shoebridge's case, I would have thought, especially given the sensitivity of some of these cases, those submissions, where the Commonwealth is in any way involved, should be carefully considered by the Commonwealth to make sure the concept of parliamentary privilege is not being mobilised or used in a way which, in my submission, is contrary to A, the intention of the Parliamentary Privileges Act, and B, the effect of that Act.
Well, I certainly don't disagree for a moment, Senator. It needs to be carefully considered and thoughtfully considered and not misused.
My next question is in relation to a coronial inquest which is currently taking place in New South Wales with respect to a veteran, the death of a veteran, Ian Turner, who was a Special Forces soldier who took his own life, and that is before the New South Wales State Coroner as we speak. The family has gone through 5 weeks of hearings. Initially, that Senate report I referred to called The Constant Battle was included in the briefer material, but I've been advised that an objection has been raised in relation to the inclusion of that Senate report being included in that brief of material. Are you aware of that?
I'm aware of the inquest. I'm not aware of the particular point you're making about that.
Could I please implore you, Mr Kingston, to look into this matter as a matter of urgency and at a high level get the highest levels of the department to consider whether or not parliamentary privilege should be invoked for the purposes for which that report is being tendered or was being tendered for evidence in that coronial inquest. Could you do that, please?
I will, Senator.
And
Sorry, just while we're here, for the record, Ms Kingston, I apologise. I was putting my questions to you without my notes. It's that it wasn't a Tasmanian matter. It was that same New South Wales matter that I referred to earlier. So I don't want to send you down a rabbit hole, and I apologise.
Thank you, Senator.
My last question, Secretary, could you please take on notice whether or not the department has a position with respect to the claiming of parliamentary privilege, whether or not any guidance has been issued with respect to the nuances between simply the submission of a parliamentary report in evidence for the purpose of evidencing that a report was undertaken and recommendations were made, as opposed to collateral purposes which involve questioning the evidence of witnesses appearing before the Commission or the Committee of the Parliament, which are reported in the report. Could you please take on notice what the department's position is with respect to how proceedings of Parliament which fall within the realm of committee reports, etc., can be or can't be used in evidence in accordance with Section 16(3)(c)?
Senator, what I can...
Tell me what you can do.
I recognise this issue, and since I've been in this role, it's obviously with several royal commissions on foot at the moment, it's an issue that we have had discussions and consideration about, and I would just like to make the point that notwithstanding the assessment of the position of the law around parliamentary privilege, I think it is universally the case that Commonwealth representatives nonetheless try to do everything they can to work with Royal Commissions and other, well, particularly with the Royal Commissions, to find some ways to ensure that the substance of the information that they want is able to be referred to in reports. That's not answering your question, though. I take your question, and I think it is a significant issue that's arising in many areas, and I'm happy to take on notice that we will look at that issue.
Thank you, Secretary.
Thanks, Senator Scarr. Senator Roberts.
Thank you, Chair, and thank you all for appearing today. I was very disturbed to read an article in the mainstream media, the mouthpiece media, specifically the Australian, and also articles by Janet Albrechtsen and The Guardian, about an expenditure that's been reported in the media. Now, I'm not conversant with legal practices. I feel a little bit daunted here. I'm not conversant with legal practices, principles, or process.
Supported.
I have a barrister in my office who joins me in being very horrified with what we've read in the media. And when we get onto the case in a minute, I don't want details of the case, just the process. So I don't want any details on the case. First question is, why are ministers provided with separate legal advice from the Australian government solicitors, who I understand represent the government?
I'm not sure. Senator, you might be able to assist me by the context of that question.
Why do ministers provided with separate legal advice from the Australian government solicitors also get it from, get the same advice from to the government? What's your role in regard to considering ministers and also the government?
Almost always we act for the Australian government in some form, whether it's on instruction from a department or it might sometimes be an agency. Sometimes if a minister has made a decision and litigation is properly brought against the minister in their name or the attorney in their name, we act for the minister or the attorney, but it's not in their personal capacity, it's in their public ministerial capacity. So I can't imagine a situation in which we would act for a minister in some way where the minister's interest conflicted with the interests of the Commonwealth.
What about past ministers and the current Commonwealth government?
I'm sorry, I missed that, Senator.
What about situations involving past ministers and the current government? How would you behave then?
On occasions we might, and I can, if someone's being sued and the Commonwealth's being sued and perhaps a minister who's now a former minister is being sued because of what they've done in their public role, not what they've done personally, we might find we're acting both with the agreement of the Commonwealth, both for the Commonwealth and the former minister, but it would normally be on a basis, and I'm not aware of a situation where it hasn't been, that the way the minister's case is presented has to be consistent with the Commonwealth's interests. So that again, we're not facing a situation where we have a conflict between what might be in the interests of the Commonwealth and what might be in the personal interest of the minister or the former minister. They are relatively rare cases, though.
So if there were past ministers who were aggrieved by what the government was doing, who would you work for? Could you work for both?
No.
Thank
So if a past minister's cross about something and wants to take some action, we wouldn't be acting for the past minister.
Thank you. How does the Australian government solicitor conduct legal matters? In-house or outsourced?
All the solicitor work is done by lawyers employed within the Australian Government Solicitor Group, which sits within the Attorney General's Department. In terms of the advocacy, the counsel work, we have a small number of what we call in-house counsel, that is counsel who are actually employees of the Attorney General's Department, but it is more common for the counsel advocacy function that we brief barristers at the private bar.
Okay, thank you. What does it mean for the Commonwealth to be a model litigant? Good question.
Well, that's a question on which, thousands of words have been spent, Senator, but and so I will not attempt to do that justice in this answer, but a long time ago now, about over 100 years ago, someone referred, and I won't get this quote exactly right, but to the standards of sort of fair treatment that a citizen has a right to expect from the Crown. And I think to some degree that's a good starting point for thinking about what model litigant might mean, but it's only a starting point. There is some guidance about that in the legal services directions, and then there are a number of court cases that refer to what the courts might properly expect of the Australian government when it is, when it is a litigant.
So would it be fair to say you are if you're acting as a model litigant, you are the absolute example of what should be done legally, principles, processes?
Look, I might, if I thought about it hard enough, come up with the odd qualification to that, but in broad terms, I wouldn't disagree with that, Senator.
Can you please explain the process involved in being a model litigant?
Well, I think it's not like when one starts out running a case as a plaintiff or an applicant or defending it or something else, one does different things in a mechanical sense, but it is, I think, being aware from the beginning and perhaps even before one issues the proceedings or decides what one's defence is through to the very end, being conscious of what you've just made about adopting the highest standards that can be expected of a litigant in each of those things that one does, and in trying to ensure that the lawyers who are running the relevant matter are aware of that. It doesn't prevent a proper defence, for example, of the government's position or a proper advancement of its positive case if the government's a plaintiff or applicant, but it does say those things have to be done in a way that, in terms of the effect on the court or the effect on other parties, in a way that one might say is exemplary.
Thank you. That's a good word, exemplary. Does it apply to all civil matters that the Commonwealth is involved in?
Yes, pretty much, subject to trying to remember if there are some parts of the Commonwealth to whom the legal services directions don't apply, but broadly speaking, yes.
Thank you. How do you act on behalf of finance and the ministerial and parliamentary services in relation to claims by staff, MAPS?
Well, we don't always do that, but we would perhaps sometimes, I can't think of a recent example, but I dare say we are probably sometimes instructed in relation to those matters.
Who gives you that instruction?
Who would?
Yes.
Well, in the case you've come up with, I would have thought the Department of Finance would.
Okay. Do model litigant requirements apply in claims made by MPs' staff?
Who is the party? Is the Commonwealth a party there?
Yes.
Well, then the model litigant would apply in relation to the Commonwealth's conduct, yes.
How does Finance Department or the Australian Government Solicitor validate and test any claims by staff against members of Parliament or other staff?
That would be, well, I can't speak for finance in terms of what they might do before things get to litigation or, contemplated litigation. Once they've got to that point, that would be very much, I would have thought, Senator, a case-by-case matter. I don't think I could say there's some universal approach there.
But Senator, I think in terms of how claims are managed on the spectrum from when they first may be reported through to potentially being before the courts, that is a matter for the Department of Finance.
Okay, thank you. Can you explain, Mr Kingston, how recent high-profile claims against former government ministers were handled? Not the detail of the claims, just the process. They involve specifically Senator Linda Reynolds and Senator Michaelia Cash.
No, I'm unable to. I'm not even sure, sitting here right now, the extent of AGS's involvement. It might have been quite limited or more than quite limited, as in zero, and in any event, to do so would involve, if I were able to do so, it would involve me revealing information that's confidential to our clients. So I think if we had one. So with respect, Senator, I think that would be a matter of to be addressed to some other part of the Commonwealth, certainly not to AGS.
Okay.
The Secretary is saying the Department of Finance.
I think you would have to ask the Department of Finance those questions, Senator.
I've got about half a dozen questions left. So confidentiality clauses. Okay. Do members, senators, ministers and other staff subject to these allegations have the opportunity to contest the claims?
Well, it's really not with respect, Senator, a question for AGS, who are not policy setters. They do not administer these things. They do not instruct. They're the lawyers to assist people.
I think this is a matter of principles of law. I'm not qualified to talk about them. That's why I'm relying on you.
Well, clearly, if it gets to a court, there's room for contest. But in terms of the way it's handled before that, I'm not in a position. I'm not the right person to try and describe that.
Well, either you or the Secretary, in relation to the allegations against Ministers Cash and Reynolds, can you explain the process? I was disturbed to read, and this is what triggered me and the barrister and my staff, when I found out that the former ministers, according to the media, were prevented from or threatened with financial repercussions if they appeared at a mediation session.
Yes, well, that really has nothing to do with AGS, Senator. I don't know.
Senator, I'll just see if my colleague Catherine Haigh may be able to assist, at least to some degree, about the process.
Thank you, Secretary.
Can I, as Chair, I appreciate Senator Roberts has waited a long time to ask a variety of questions. We are in the AGS part of the program, and we need to be asking questions relevant to AGS if we can. Thank you. But if you've got something to assist, but we're not traversing back past outcomes we've already done.
Thank you, Senator. I believe I am able to expand on what's been said. And in relation, Senator, to the particular matter that you've referred to, I can confirm that what legal assistance was provided under the Parliamentary Business Resources Regulations in 2022.
So you can confirm it was?
I can confirm that, Senator, yes.
Can you explain the process in relation to the allegations against Ministers Cash and Reynolds?
So that was the process provided for under those regulations was followed, and in this particular instance, the decision under the regulations was provided by the then Minister for Finance.
Who was?
That was the Senator, the Honourable Simon Birmingham.
Thank you. When was the claim against Ministers Cash and Reynolds filed, and in what jurisdiction?
Senator, I would have to take that on notice.
Okay. In the interest of continuing to end the questions, let's continue. Were there any statute of limitation issues given the age of the complaint?
Senator, again, not that I'm aware of, but I would have to take that on notice.
Who attended the mediation?
Senator, that would be privileged information and not appropriate for me to share.
I read a newspaper article saying that Senators Cash and Reynolds were reported as being not allowed to attend. Why would that be?
Senator, there's a provision in the regulations, section 89, that enables the Attorney-General to exercise a discretion as to how the claim should be managed. And in this instance, that discretion under section 89 was exercised.
So the Attorney-General directed them to not attend?
The Commonwealth formed the view that it was appropriate in this instance that the Commonwealth should control the conduct of the Senator's defence of the claims.
Okay. So, as I understand it, in being a model litigant, testing is essential to establish whether there's a reasonable prospect the case would succeed. And only then would it be settled. But that was not available because two former ministers, two senators were excluded.
Senator, this was a matter that the Commonwealth essentially was responsible for running the matter, and the matter was conducted in accordance with model litigant obligations and legal principle and practice.
I would have thought, now I'm a layman when it comes to the law, that it would have been important before the case was settled for all parties to be heard. Yet according to the newspaper, that's not the case. So how could the government settle without getting all the information?
Senator, as I've said previously, this was a matter that was conducted under Section 89 of the relevant regulations, and under that section, a decision was taken that it was appropriate for the Commonwealth to control how the claims were defended.
So was advice prepared, given to the government, advising settlement?
Senator, as I've said previously, this matter was conducted in accordance with legal principle and practice, and as part of the legal services directions, in all such matters that are litigated involving the Commonwealth, it is standard practice to obtain legal advice.
Chair, I would just note that this all does, we're now relating to matters that were covered under the Office of Legal Services Coordination when they were appearing earlier today.
Thank you. And Senator Roberts,
I'm almost done.
the officials have been really generous to you and your questions, but you are traversing back over an area that was covered earlier today, and we've got a pretty tight program to keep going. So if you can finish up, or you've got something relevant to the AGS, then you can ask it. But
So it seems to, last question. So it seems to me that the case was settled without the facts, and that Minister Gallagher is the minister responsible. Did she approve it?
I don't know the answer to that, Senator, but we can take that on notice.
Okay, well, and part of that, wasn't she vocally supportive of Ms Higgins and involved with her before the trial?
I wouldn't agree with your characterisation of events there, Senator Roberts.
Thank you, Minister. Thank you, Chair, and thank you all for
Senator Roberts.
being patient with me.
Thank you so much. I think that might be all the questions we have for the Australian Government Solicitor, so thank you very much to the officials.
Chair,
yes.
If you wouldn't mind, he's going to hate me for it.
You've got a question.
I just wanted to note, after 6.5 years as the Australian Government Solicitor, Michael Kingston has announced his retirement from that role, and I just wanted to acknowledge the enormous contribution and the leadership he's provided both within AGS, the Attorney General's Department, but broadly for Commonwealth legal matters.
Thank you, Secretary, and thank you, Mr Kingston. Senator Scarr?
Chair, just on behalf of the Coalition, if I could thank Mr Kingston for the way in which you've approached your engagement with this committee during the course of estimates. You've always been extraordinarily helpful and cooperative, and I thank you for that.
Thank you, Senator.
And on behalf of the government as well, Mr Kingston, we hope you get to the bottom of parliamentary privilege before you finish.
I was going to say that, Senator Chisholm.
You've got a little bit of time left.
All of us wish you well in your next phase.
Yes. Okay. All right. Thank you.
Thank you, Senators. Thank you, Mr Kingston. You're welcome to return and any time you want, but I think you're very glad to be leaving. Thank you. I now call... Thank you. I now call officials from the Australian Human Rights Commission. Yes. I think Senator Waddell has some... 15 minutes now. Yeah.
And who else?
I think Senator Scarr. Senator Faruqi. Yeah, there's a bunch. Like I'm trying to get it done in an hour, but before... Sorry. Apologies. Thank you. Can I just... Well. Thank you, Senators, and in the interest of time, I think we'll continue. I think it goes without saying, for our agencies that are appearing this evening, firstly, can I say thank you for sticking with us. We are a little bit behind time. And thank you. I know most of you will be intending on tabling your opening statements if you have one. But President, I understand you have a very brief statement to make. Thank you.
Thank you, Senator. Chair, for the Hansard, Professor Rosalind Croucher, President of the Australian Human Rights Commission. Chair, as this is the last appearance for the Sex Discrimination Commissioner, Kate Jenkins, who leaves the role in April, I would like to read a short tribute into Hansard. Commissioner Jenkins has made a significant and enduring contribution to the protection of human rights in Australia and to the work of the Australian Human Rights Commission over her 7-year term. The work conducted by colleagues under her leadership has led to unprecedented action to address sex discrimination in Australia, including through a national review into sexual assault and sexual harassment at Australian universities, prompting action for positive change, 2 national surveys to provide better understanding of the nature, prevalence and reporting of sexual harassment in Australian workplaces, and the Respect at Work report tabled in Parliament in March 2020, including 55 recommendations to reduce workplace sexual harassment and create safer, more respectful and productive Australian workplaces, the implementation of which by the current and past Attorney-General and the Department is well advanced. Commissioner Jenkins also led the inquiry that produced the landmark Set the Standard report and has worked closely with government to implement all recommendations. Commissioner Jenkins has also made special contributions to anti-discrimination and cultural change in sport, including through guidelines on equal opportunity for women and girls in golf and independent reviews of culture and practice at all levels in the sports of gymnastics and basketball in Australia. Commissioner Jenkins has also fostered long-term partnerships to improve workplace culture with the Australian Federal Police, Australian Defence Force, and now also Australian Border Force. As Commissioner Jenkins' term comes to a close in April, her tireless work will continue to have positive impacts for Australians into the future. On behalf of the Australian Human Rights Commission, I acknowledge her substantial contributions. Thank you, Chair.
President. I also have a short statement to read. I'm sure the Minister won't mind on behalf of the government. And of course, my fellow senators. Kate Jenkins has been the Sex Discrimination Commissioner since 2016. In that time, she has completed multiple vitally important reports, including Change the Course, National Survey, Sexual Harassment and Sexual Assault at Australian Universities in 2017. Of course, the Respect at Work, National Inquiry into Sexual Harassment in Australian Workplaces report in 2020. Change the Routine, a review of gymnastics in Australia 2021. Set the Standard, the independent review of Commonwealth parliamentary workplaces in 2021. She has also worked in partnership on cultural reform with the ADF, AFP and the Australian Border Force and chairs the Respect at Work Council. It is no exaggeration to say that Ms Jenkins' time at the Sex Discrimination Commission will have a lasting impact on all Australian women. In particular, her Respect at Work report has now almost been fully implemented by the current government and will transform women's safety at work. And as a woman who has worked in this building for many years, can I say safely that the Set the Standard report will change the halls of our most powerful place in the country and the lives of the women that walk these halls forever. On behalf of the Albanese government and the Australian women, I want to say thank you to Ms Jenkins. Senator Scarr.
Having valiantly defended your base remuneration at the last estimates hearing, but I'll get those jokes out of the way before I say some formal words. Commissioner Jenkins, on behalf of the opposition, I commend your extraordinary contribution in this space. I thank you for the courtesy and the intellectual rigour with which you have engaged with this committee, as we've all seen on a number of occasions. On a personal level, I want to refer the Change the Routine report you did in relation to gymnastics, which, when I read it, I was extraordinarily moved by the content of that report, Your empathy shone through that report, your intellectual rigour as you gave a voice to the voiceless. So I deeply commend you and wish you all the best for your future.
I won't repeat them because it would take too long to summarise all your achievements and the support that you've been not only for this place but workplaces and organisations around the country. And I know for a fact that Senator Waters would have very much appreciated being here and would have reflected on behalf of our party very personally her gratitude for your work.
Thank you, Senators, and thank you, President, for your statement. Senator Scarr, you have questions for the Commission, I understand.
I think Senator Little has the
Senator
Coalition's first round
you
of
have the
questions,
call.
and then I have just 3 minutes of questions.
Thank you.
Thank you. My first question is to Anne Hollins as the Commissioner for Children. I want to read you a statement from the report from the Office of Central Australian Regional Controllers, recent report about Alice Springs. I'm going to paraphrase in quotes: "We cannot continue to accept the levels of domestic and family violence. The children who unanimously voice their hatred of alcohol and the harm it inflicts on their families. These are simple aspirations. They are to live in a normal place, have jobs when they are older, and be able to support their families with basic needs." It's a pretty powerful statement, and I think I've heard it a couple of times this week, with universal aspiration expressed of children. My first question is, what actions have you taken in recent months advocating for children in Alice Springs and elsewhere who are contending with living amongst alcohol-induced violence?
Look, I've been to Alice Springs several times in the 2 years, 2 and a bit years I've been in as Commissioner, and I was there late last year. I have met many times with Minister Burney, Attorney General Dreyfus, Minister Anne Ali, and other ministers too, where I've raised concerns about First Nations children.
Commissioner, can I just pause you for one moment? We're just going to see if we can get the volume up a little bit on your audio so we can hear you very clearly. Thank you. We might be able to do that. We'll see. Thank you.
Can I continue?
Thank you, Commissioner.
Yes, thank you. So I was saying, Senator, I have throughout my time as Children's Commissioner met with the various ministers who have a responsibility for children, for justice, for Indigenous Australians and so forth. And most recently, after I was in Alice Springs last November, I met with officials about child protection issues and youth justice issues there, and met with Minister Burney immediately afterwards. I did spend some time with Darrell Anderson, who is now the new regional controller, and she took me took me on visits into the remote communities and so forth, and it helped me to really understand much better from the local perspective. And of course, now she's in that important role. It helped me really to understand the failure of the systems that are not able to prevent the escalation of concerns to children in the area. And I'm really pleased that that she has an important role in leading the change there.
Are you working with the Aboriginal and Torres Strait Islander Social Justice Commissioner, June Oscar, on this issue, or is it being deferred mostly to her? How are you working together on this issue?
So June Oscar and I do jointly advocate for First Nations children and families, and we have a number of joint media statements and positions that we've put out together.
Now, the Central Australian Regional Controllers Report makes a couple of recommendations. It doesn't talk about continued engagement with the Human Rights Commission specifically, or either yourself or Commissioner Oscar, given your long history working in this area and respected history. I just want to ask, what are you going to be doing to insert yourself into this space, given that wherever the money flows, there are a lot of experts that go, and I want to understand how the Human Rights Commissioner is inserting itself into this conversation to ensure that your voice is listened to as the money is rolling out for these programs to respond to these issues.
Senator, that's a really good question. It's a very complex situation. Of course, we have in the Northern Territory a Children's Commissioner as well, so a territory-level Children's Commissioner, Nicole Hucks, where our responsibilities are at different jurisdictional levels, but we work very closely together, as do all the Children's Commissioners around Australia. And so what I've tried to do over time, for example, I've attended what's known as the Tripartite Forum, which is where the Territory Government, the NGO representatives in the Territory and the Commonwealth all meet together as part of the reform process that's in place in the Territory. I have attended that and I've presented at that, and so I try wherever I can to contribute in a productive way in what is a very complex situation. And of course, I'm not there on the ground, and I have very limited resources to be able to, I have to spread myself around the whole of Australia, as you would understand, and I have very, very limited resources available to me. But I am deeply, deeply concerned, as Minister Burney and the other ministers know. I'm deeply concerned about the issues in Alice Springs and in the Territory generally.
Do you believe that you should be a critical part of this conversation, given we're talking about young children who are significantly traumatised and their families?
And the fact that, these problems have not been solved despite our best efforts for many decades, as we know. Yes, I would very much like to have the resources to play a more significant role. I've offered whatever assistance I can to the government in this situation. I've offered the help to Dorrell Anderson directly, but the resources are just not there for me to be able to do this. And I'm concerned really from an end-to-end perspective, if I can put it that way. Of course, the youth justice issues, the youth crime that we hear a lot about in Alice Springs is a very deep concern, and obviously the way the youth justice system is in crisis there. But I'm very concerned about we're not doing enough to stop kids ending up in that situation, and the fetal alcohol syndrome rates have risen in Central Australia, and in all the media reporting, there's been very little said about that, except on one day I noticed that was being discussed, and I really applauded that, because we really have to start much, much earlier to prevent the escalation of these problems in the community. And the health services, the education services, social services generally are incredibly fragmented, and they need to listen to what the families and the kids and the families say they need, and to redesign the way they operate and to allow more control in the design of these services locally.
Thank you very much, Commissioner Hollands. My next question is actually to Commissioner Oscar, if I can turn to Commissioner Oscar. Hello. Hi. Look, I just want to, I know again your work in the area of working with women and in addressing some of these complex issues in communities is very well known. You would also know that with the resultant increase in the last 12 months of arrests of people in custody, people being incarcerated, the family disruption that comes with that, the child protection issues that come with that, and we're talking about, if you think about the Northern Territory, a 51% increase in commercial break-ins and 26 or 27% increase almost in property damage. So one would expect that following that would be more people coming to the attention of the police. I'm just wondering about what you're intending to do to continue to work in this area with a focus on the Northern Territory, but also recognising, in recent days we've heard about issues in Ceduna, in Kununurra, in Kalgoorlie, as well as the Northern Territory. Looks like you've got your work cut out for you in the next few years.
Thank you, Senator, and congratulations, and it's lovely to see you in this forum. As always, as you rightly point out, these issues that are presenting now comes from such complexities, so it's never ever straightforward. And sadly, some responses to the root causes have not appreciated that. And I think that is to do with the case that leaders and community members are not being listened to and included in zoning responses to these complex issues. And until we seriously invest in our communities, our community-controlled organisations, and the leaders of our families, we will continue to see much of the same. So my focus has been, since my term, to elevate the voices of Aboriginal and Torres Strait Islander women in all of our diversity across this country. And the last time there was a national effort around that was over 34 years ago with the Women's Business Report. So in 2020, the Women's Voices Report was tabled in federal parliament, and the report elevates the voices of the solutions that women and girls have identified.
I think you're dropping out. There's a bit of an issue with the technology. I'm not sure whether you can hear me, but I wanted to...
I can hear you.
Okay. I just wanted to ask you about, you mentioned about Aboriginal community-controlled organisations, and one of the concerns I have is, while there's a big focus on Aboriginal community-controlled, and I don't dispute that Aboriginal-led is important, I also think it's important that programs are actually funded on the basis of evidence, on the basis of capacity to deliver, on the basis of evidence of deliverables previously, rather than just being about Aboriginal community control. But I do agree with you, or would you agree with my submission, that Aboriginal-led is also crucial, not necessarily only Aboriginal community controlled?
I believe Aboriginal-led. It's important that any programs that's targeted to Aboriginal and Torres Strait Islander people involve the very people that it's meant to provide benefits and solutions to. So it's critical that it's Aboriginal-led and designed. And these programs, I have, like yourself, it's all too familiar that effective programs are invested in only on short-term timeframes, and that's been a struggle for many communities across our country where programs do work, that the investments are removed, and failures then fall on the laps of basically Aboriginal and Torres Strait Islander people in the first instance. And the attempts to convince others who are making these decisions at a policy level, at agency levels in government, whether in the Northern Territory, whether in Perth or Canberra or elsewhere in this country is an all too familiar story. And I'm glad that you're raising these issues in the manner in which you are, Senator.
Thank you. I'd also like to ask the question, I'm not sure whether it's one for you at this point or it's one for President Croucher. I'm just wondering what your organisation's position is on expressly campaigning for voice.
Thank you, Senator. Rosalind Croucher,
In
President.
terms of the institution, I would defer to the President
Thank you.
on this question, Senator.
Thank you. I'm happy to make a quick response. You asked a question about campaigning, and the position of the Australian Human Rights Commission is to contribute in a constructive way going forward in relation to the proposed referendum. We have an important mandate in our statute that speaks of education, and we take our community education role very seriously. And in the context of the referendum, we would see ourselves as being able to have a primary focus of raising an understanding, particularly as the Human Rights Commission, the human rights obligations, commitments of government, how they are expressed through the mechanisms that are being considered in relation to the voice. Our role is not as a campaigner, that is not our position. We are an independent, impartial agency with an important educational remit, and there's much we can contribute to through our international human rights understanding in terms of promoting respectful and informed dialogues in the referendum process, through providing reputable and expert education materials, and raising public awareness about relevant human rights issues, and perhaps addressing misinformation. So that's how we would see our role, Senator.
Right. So I just want to raise specifically a speech that was done by Commissioner Oscar a little while ago that was significantly, I guess, talking about voice. I'm happy to table this if that's useful. It talks. Sorry.
Obviously, Commissioner Oscar won't have the benefit of that
No.
document, but I'm sure you'll be able to.
I can just paraphrase it if you like, if that speeds
Yeah,
things
just
up.
maybe refer to the date so she
Okay.
has an awareness of.
So the speech was the Sir Wallace Kyle oration back on the 24th of August 2022. But given that we're hearing a lot more conversations about voice, and this speech, when you read through it, talks a lot about voice, but it also talks about the result of the May election. It talks about proudly celebrating the diverse voices, the movers and shakers, the speaking out, putting forward various positions on how to achieve climate and gender justice, confront and overcome racism, strengthen industrial transparency, institutional transparency and integrity. And it ends, and the reference is to Greens, Teals, women and 11 First Nations parliamentarians. The end comment is, there are, as always, a few voices rallying against these progressive propositions. I'm just wanting to ask, how close do you think that is to a political endorsement, and is it consistent with the mission of the Human Rights Commission? I'm happy if you'd like to answer it, President.
Perhaps I'll just make a brief comment. Each of our commissioners has a particular statutory mandate. Our Social Justice Commissioner, June Oscar, is one of a long series of social justice commissioners who have spoken strongly for the improved consideration of Aboriginal and Torres Strait Islander voices across the nation in all policies and decision making. The reflection of the Social Justice Commissioner in her speech is also anchored in a long history of engagement on these issues by social justice commissioners within their clear portfolio of responsibility, speaking as an Aboriginal and Torres Strait Islander Social Justice Commissioner. So I would see those comments within that long history of advocacy for increasing the voices of Aboriginal and Torres Strait Islander peoples across the board, particularly in policy making and particular decisions.
So as we move towards closer towards when we may see a referendum, are we likely to hear from more speeches that are quite pro-voice and involved in that discussion, or are we just going to see, what are we going to see in future or hear in future?
Well, if I may, a number of commissioners have been strongly supportive of the increased representation of listening that is involved in the creation of a voice to Parliament set up by the Parliament, with the beginning, the anchoring in the amendment to the Constitution, which is the proposal that's going forward. But insofar as the commissioners themselves are reflective of their portfolios and speaking to the significance of the Uluru Statement as framing the process that is going forward, that is a reflection of a long developed process. It's not a flash in the pan moment interjection of any kind. This is a long period of advocacy by not just the Social Justice Commissioner, but the Human Rights Commission as a whole over time. We can give you a long list of engagement on these issues. So to suggest that suddenly this is becoming perhaps a moment of political campaign, I think completely misconstrues the role of the Human Rights Commission over the many decades, 4 decades of its existence, and particularly in the context of Aboriginal and Torres Strait Islander issues.
Thank you for that clarification.
And if I may, it would be unfair of me to finish on this point without also deferring to our Aboriginal and Torres Strait Islander Social Justice Commissioner, Ms Oscar, who is online from the remote part of Western Australia in the Kimberley. So it shouldn't be my voice that finishes on this point, Senator and Chair. May I please request that I defer to Commissioner Oscar.
Commissioner, would you like to add?
Yes, thank you, President. Senator.
Well, unfortunately, parliamentary NBN is not going to allow us to.
Of the diversity of voices. Hello?
Get a message to the Commissioner about the connection.
Excuse me, Chair, if I may. Commissioner Oscar, may I suggest you perhaps drop off your video and just go to the audio? We're getting a bit of break-up, and I don't, for myself and your colleagues in the room, we don't want to miss any words that you say.
Thank you, Commissioner. Without the video, it is probably a lot easier to hear your voice. Are you able to take yourself off mute? We'd like to hear your contribution.
Thank you, Chair. Just in response to Senator Little, I'm absolutely support the diversity of voices across all political settings. I listen to all of these voices, and I don't have a problem with that. The voice, in my view, is a human rights issue, and it is above politics. So I'll just end there.
Thank you, Commissioner. And thank you, Senator. Thank you. Senator Scar, I think you had some questions. Thank you.
Just quickly, is Mr Chin Tan here, or?
Chair, if I may, through you. Mr Tan had a very recent bereavement in his family, and with the permission of the Chair and the committee, he has gone back to Malaysia for that. But Senator, I will take his questions and answer as best I can on
thank
his
you.
behalf,
Thank
or
you,
take whatever
President.
we
And-
can on
and
notice.
can I just give my personal sympathies to Mr Tan? He's a frequent visitor to Queensland, so I really do compliment him with respect to his engagement. President, I want to refer to the report on anti-Semitism in Australia 2022 issued by the Executive Council of Australian Jewry. I'm just going to read a paragraph from the executive summary and one example, and then I'm going to seek your response, if I could, with respect to what the Human Rights Commission is doing. So the executive summary, page 6. During the 12-month period from 1 October 2021 to 30 September 2022, there were 478 anti-Semitic incidents logged by a number of agencies. In the previous 12-month period ending 30 September 2021, these same bodies logged 447 incidents. Accordingly, there was an increase of 6.9% in the overall number of reported anti-Semitic incidents compared to the previous year, 2021, which had a 35% increase over the number of recorded incidents in 2020, end quote. So there was a 35% increase year on year, 2020 to 2021, and then a 6.9% increase 2021 to 2022 year on year. And I'll just read you one example which struck me. And this is reported on page 46. Anti-Semitic incidents of abuse during the period in review at schools in Sydney include, one of the examples given, I quote, "A Jewish boy was forced into a locker and sprayed with deodorant to simulate a Nazi gas chamber while other students laughed and filmed the incident." And this occurred at a Sydney private school early 2022. President, are you aware of the rise of anti-Semitism in this country in recent years, and what strategies is the Human Rights Commission pursuing to, in some way, trying to stop the scourge of anti-Semitism?
Thank you, Senator, for your question. For a start, I should say that I am very familiar with the work that the Executive Council of Australian Jewry does in tracking anti-Semitic incidents of a range, and has done so for many years. And it's a key example of collecting evidence that can be used to create a picture of the prevalence of racist incidents across the country. And one of the things, there are two prongs to the answer. One is the work of Commissioner Tan and his leadership of the anti-racism strategy, which is being supported by government. The anti-racism strategy has as one component the need to build an evidence base to improve a clear sense of data collection. Now, what the ECAJ reports do is provide an example of how racist incidents pertaining, or I should say, religious or racist incidents pertaining to people who are Jewish, that how that can be used as a model. There is an absence of prevalence data using consistent criteria in the context of racist incidents. So that is one component of the work, is to try and advance the need to build the understanding of the absence of data, and also to use better data, capture better evidence building across a range of, particularly those that are associated with religions. I know there's some work in relation to anti-Islamic incidents of, like the anti-Semitic incidents, there are similar in the Muslim community, and they're tracking as well. But to try and get better capture of information, you need better data. And that's one of the strands of the work. So that's one thing. And I suppose a related issue is the advancement of religious discrimination protection. It is a missing piece in the federal architecture of discrimination laws, and even to the point where people of Muslim faith and people of Jewish faith do not get direct protection by virtue of a religious affiliation. Jewish people get some protection in the limited way through being an ethno-religion, as do Sikhs, but there is a big gap in terms of religious protections. And we do have some information that we could provide in terms of complaints that we receive, because...
Could you take that
yes.
on notice, President? And I'd be interested, as I'm sure all senators would be, in relation to any breakdown of complaints.
Yes.
Across all parts of our community. So that would be very useful if you could take that on notice. I just had one final question to you, and you mentioned, and it just came to mind when you mentioned, of course, the issue with respect to our Muslim communities suffering hate crimes and violence. Are you aware that and my fellow Queensland senators may be aware, that the mosque in Toowoomba that was the subject of a vile arson attack is in the process of being rebuilt and is nearly rebuilt with the support of the whole of that community? Has that come to the attention of the Human Rights Commission?
Yes, it has. And I mean, an institution such as a mosque, synagogue, a church, a Sikh centre, areas that are focus for religious activity are often a focus for a much greater community engagement. So yes, it has come to my attention, and I'm aware particularly of Commissioner Tan's interest in a whole range of communities that he engages with. So the importance of both a mosque as a religious place, but also as a community space, is very much on Commissioner Tan's agenda, radar, and similarly of the Human Rights Commission.
I'm sure the mosque and the people of Toowoomba would welcome a high-level visit from the Human Rights Commission to celebrate that landmark. And finally, Ms Smith, I have no questions to you in relation to remuneration matters.
What a relief. Thank you, Senator Scarr. Senator Polley, you had a short bracket of questions, and then we'll come to you, Senator Roberts.
Yes, I do. Thank you very much. And can I, from the outset, just associate myself with the comments in relation to Commissioner Jenkins. And can I say, before I came to this place, I worked across a number of different sectors, and unfortunately too many women in lowly paid jobs have been victims in the past. So we can't emphasise enough what your report means. So if I go to some questions, the Anti-Discrimination and Human Rights Legislation Amendment Respect at Work Act 2022 was passed by both Houses of Parliament late last year. The key reform amended the Sex Discrimination Act of 1984 to include positive duty on employers to take reasonable and proportionate measures to eliminate certain forms of unlawful sex discrimination, including sexual harassment as far as possible. Have employers been given any guidance on how to make sure that they are compliant with this positive duty?
Thank you very much for the question, Senator. Kate Jenkins, the Sex Discrimination Commissioner. And I might, before I answer that question, just acknowledge those very kind remarks from everyone on the committee and also from the President. I am at the end of 7 years. It's been the greatest privilege of my life to be in this role, and I hope I've contributed, and I very much appreciated those kind words. But I also recognised, as Senator Scarr mentioned, the work that I've done is really the voice of a whole lot of people that I could somehow turn into some action that I'm really optimistic about going forward. And that is one of the pieces of action that I'm very optimistic about. The positive duty, I think, is such a significant change for women and for sexual harassment and sex discrimination. And I hope in the future for all the discrimination legislation, it seems a basic obligation and expectation that employers will be protecting their workers from sexual harassment and discrimination. We have, up until now, been producing materials, particularly at the Human Rights Commission and at the respectatwork.gov.au website, resources for employers on what was found in the Respect at Work report and recommendations for employers' action. When the legislation was passed, we were also funded and we are rapidly building a very capable team to put in place all the steps needed for the 3 new functions that the Commission has. One of them is the positive duty. Just today, we were getting together to make sure that we could prioritise some even more clear guidance for employers on exactly what that might look like for them, including for small businesses. The enforcement function that we will have starts in December, and ideally we would have produced the perfect guidance on the day that the legislation was passed. However, we learnt of it at the same time as everyone else. So there are materials available. I would direct people to the respectatwork.gov.au website and also let them know that in we're aiming in April or May to be producing more just really straightforward, clear guidance on what they need to do so that they will be fully prepared by the time December comes around when that duty it becomes enforceable. And our objective is absolutely to help employers of all sizes to meet that duty and to make sure that it works also well with the work health and safety duties. So thank you for the question.
Thank you for your response. Can you explain what the good practice indicators are and how they will help business to comply with the positive duty?
Yes, the good practice indicators were published just before Christmas, and they are a piece of work that was actually led by the Attorney General's Department, but in consultation again with the Respect at Work Council. We found when we did the National Inquiry on Workplace Sexual Harassment that employers were using the wrong measures to determine whether they were preventing sexual harassment. The most common measures that are used for employers to know whether they have sexual harassment is numbers of complaints. They were also recording whether people had attended training, and we found that those measures actually didn't indicate whether there was sexual harassment in the workplace or not. So the piece of work that we recommended through Respect at Work was that there was some work done to identify what were good measures for employees to know that they were preventing sexual harassment. So the good practice indicators fit in the 7 domains that we discuss in Respect at Work, including culture, leadership, knowledge, a whole range of factors. It's a broader policy piece so that if you're a large or small employer, to start, and really, hopefully you're already doing this, you can look at that as evidence of what types of things you might be measuring to make sure that you are addressing sexual harassment. So there might be surveys that look at, anonymous surveys that look at prevalence of sexual harassment, but it also might be indications of how many times an employer raises the issue of sexual harassment, what sort of after complaint supports are provided to people who might have complained of sexual harassment. So those good practice indicators are there to help employers, they're there to help policymakers, and we will be drawing on them very heavily to then really come down to some really concise guidance for employers to know what they have to do to meet the duty. I would say the good practice indicators tell you what you'd be doing to be a fantastic employer to meet the duty. We won't be expecting fantastic employers. We will be expecting some really important standards to prevent sexual harassment.
Thank you for that. I'm going to push my luck and go to the next report because I think it's only fitting while you're still here, Commissioner, to speak about the adoption of the Set the Standards report. I think it's very relevant to this place, obviously. But the annual report on the implementation of the recommendations was tabled last week, setting out the progress that's been made thus far. Are you happy with that progress?
I'm really happy with that progress. I'm really impressed with both the commitment across the Parliament to embrace those recommendations, put in place the action. I recognise the hard work of the Parliamentary Leadership Task Force with 8 members across the whole Parliament and led until recently by Kerry Hartland and a great team in the task force. And in particular, that piece of work, from my point of view, was one of the most amazing opportunities to be able to come to this place and to be trusted to learn about how it works, but also to really call out what wasn't working and describe what the solutions would be. I would say that what happened there, and that is a lesson for other workplaces, is that report was accepted across the board, action started. So 12 months on, people often say change takes time, but with an election in the middle and a whole lot of new processes, systems, and a whole lot of engagement, significant change has happened structurally, but actually also people are telling me it has changed. And if I think of two examples that happened on the 8th of February, so the 8th of February was exactly 12 months from the day that it was accepted and the acknowledgement or apology was provided. Since that time, there have been 3 different occasions in one year where parliamentarians in both houses and the Federation Chamber have stood up and talked about this issue. I can't think of a corporate workplace that would have been so symbolically acknowledging the leadership role and the importance of that. And I also note that on that day, the Prime Minister proposed 3 codes of conduct, and the fact that this Parliament has never had a code of conduct that applies to all parliamentarians and staffers, that is a very significant step, and I know staff quietly are telling me what that means to them and how important it is. So I think I've given a long answer to say yes, I'm very pleased. I think the momentum needs to continue. I acknowledge that there are people here now who are not having a good experience still, and some who are still living with bad experiences. I don't belittle that, but I think the progress and the momentum is important.
Thank you for that response, and obviously we do set the standard for the rest of the country, so I think our expectations should be high. The presiding officers of Parliament made a joint statement with a list of expected outcomes for the next 12 months. One of those items is the endorsement by the Parliament of Codes of Conduct for all Commonwealth parliamentary workplaces. How important do you think Parliament is in the process to actually endorse that conduct?
As I've mentioned, one of the things we found in Parliament that was a real challenge for people was the lack of clear and certain standards of conduct. So across the Parliament, staffers did not have clear standards, public servants did, but everyone had a different sort of set of standards. Whilst there are things we need to do to improve diversity and support performance, at a base level, every workplace really needs to have clarity about what you can expect when you come to work, how people should behave and how they should not behave. The codes that were presented, which were put together by a really diverse and talented joint parliamentary committee, were really straightforward. They asked how parliamentarians should behave with integrity, trust, respect, and that they shouldn't engage in bullying and harassment. That's pretty understandable. During the inquiry, we found that people said because there wasn't that clarity, they first of all weren't sure what they could complain about, they weren't sure what they should expect, and many of them said, look, we believe that we either have to put up with this behaviour or leave. So the standards themselves are very important for clarity and sending a message, and I've noted some of the Senate committees have been starting with an acknowledgement that these are the standards that you're working to, but also it then creates an ability to hold people to account, and that's the next piece of work that I know is on the agenda for the Parliamentary Leadership Task Force, is to establish the Independent Parliamentary Standards Commission.
Thank you again, and can I just again put on the public record our appreciation, and I think fair to say you have left your mark, but I like the fact that you still acknowledge that there are women in this place who are still living with the consequences of their experiences.
I most certainly recognise that.
Thank you, Senator Polley. Senator Roberts, you have some questions?
Yes, thanks, Chair. Thank you all for appearing this evening. What is the Human Rights Commission's current advice on COVID injection mandates?
Perhaps, Chair, through you, if I may suggest that Commissioner Finlay join us to speak to this matter.
Thank you very much for the question, Senator. Commissioner Lorraine Finlay, the Human Rights Commissioner with the Australian Human Rights Commission. I should preface the answer by saying that myself nor the Australian Human Rights Commission profess to be medical experts in this regard, so we don't give medical advice in relation to the efficacy of vaccines. Our advice relates to the international human rights framework that governs restrictions in times of emergency and the human rights impacts that they have. And in giving that advice, we've been consistent throughout the pandemic in terms of saying that it really is a matter of striking the right balance between the obvious need to address community health and safety concerns, recognising particularly that there are sections of our community who are particularly vulnerable to COVID-19, whilst also balancing the individual human rights issues that arise. And the starting point in relation to not just vaccine mandates, but all human rights issues relating to the COVID-19 pandemic response is that in a time of public health emergency, governments are able to restrict human rights in many circumstances, but all of those restrictions need to be justified, necessary and proportionate. And that's why, as Human Rights Commissioner, I've been guided since commencing in this role at recognising that whenever you talk about broad vaccination mandates, there needs to be a note of caution, because you do need to make sure that the approaches are targeted to risk. But again, I would emphasise the fact that we're not medical experts providing advice about the efficacy of the vaccinations. We instead can provide guidance about the overall human rights framework within which government decisions can operate.
Thank you. I'm not a medical expert either, but I've sought the best medical advice in the world on this issue. But continuing, boosters are recommended at least 6 months apart. Yet the latest data shows they may only provide additional protection for 12 weeks. Other medical data appears to indicate they're provisionally approved vaccines, injections, provide essentially no protection against infection from the variants that are now circulating. How does this information affect the Commission's view on mandates?
Well, again, Senator, thank you for the question. The Commissioner's view on mandates is guided by those broad principles that I mentioned before, that any restrictions on individual rights need to be necessary, justified and proportionate, and that really when we're talking about vaccinations, we're balancing out the need to ensure community protection, again recognising the fact that there are particular groups in the community that are particularly vulnerable to the effects of COVID-19, with individual human rights risks or individual human rights and restrictions on those. And from the medical perspective, we would look to the assessment that's been made by the TGA. And I note, for example, in their most recent report dated the 9th of February, it was that the protective benefits of vaccination far outweigh the potential risks. We do think in terms of vaccinations that it's important to always be open and transparent about these issues so that the public can have confidence in the decisions that are made. But at the end of the day, our advice and our guidance in relation to both mandates and broader human rights issues around COVID is guided by those general principles.
So the principles are given life by advice from the TGA?
No, Senator. What I'm saying is I'm not qualified to speak to the medical assessment that the TGA make about the effectiveness of vaccine. But in terms of assessing the human rights implications, we fall back on those principles about government decisions relating to restrictions that may be imposed as a result of the pandemic and the risk that's posed need to be guided by those principles.
But the advice you're getting on the medical side is from the TGA?
No, Senator. The Human Rights Commission isn't getting medical advice outside of the advice that's provided to the general Australian community.
No, that's what I mean. You've just mentioned the TGA as being the source, so you can weigh up the potential benefits and make sure they outweigh the risks. So you're getting that from the TGA?
That's general advice. It's on the public website.
Yeah.
Senator, and available to the entire
I'm not accusing
public.
you of having something sinister or conspiracy or anything like that. I'm not accusing you of that. I'm just saying you get your medical advice from the TGA.
No, Senator, I'm not getting particular medical advice. I'm saying that in assessing the human rights principles that you've raised, that we've raised, the authority in terms of Australia, in terms of assessing the efficacy of vaccinations, is the TGA.
Okay, thank you. So the authority is the TGA, right. So I'm interested then in how the Human Rights Commission, who are meant to be the tip of the spear in talking about and taking action against protecting the human rights of Australians, yet they're now running cover for people who want to infringe on human rights. How can the Human Rights Commission come to the position that injection mandates are still justifiable, given we know they cannot stop transmission? The only way you could say that could be justified is if they stop getting others infected. 11 million COVID cases later in Australia, we know they do not stop transmission. I knew that from the Chief Medical Officer's response to me in Senate estimates in March 21. At best, it's a personal health choice, and we know they don't guarantee protection there either. How can you still be providing advice that mandates might be justifiable in a human rights context?
Well, Senator, I'd reject the premise of your question in two aspects. The first, the Human Rights Commission I wouldn't characterise as running cover for anybody in relation to this issue. But in relation to the second aspect, the Human Rights Commission isn't providing definitive advice about vaccination mandates. What the Human Rights Commission has said consistently in relation to human rights in COVID-19 is that where rights are restricted, those restrictions need to be justified, necessary and proportionate, and that can be seen through a variety of work that we've done on this particular issue.
So in what ways do the failed injections meet those criteria?
Well, again, Senator, I would reject the premise of that question and simply go back to the statement I made before about how risk is assessed from a human rights perspective, and recognise that I'm not qualified as a medical expert to provide advice on the efficacy of vaccinations.
The last 3 years, we've seen some of the largest wide-scale infringements on human rights in Australia's history.
Senator Roberts.
Sorry, Chair.
We just have a couple more minutes if you've got a couple more questions, and then I think we'll be able to let the Commission go after your questions.
Sure.
Thank you.
The last 3 years, we've seen some of the largest wide-scale infringements on human rights in Australia's history. Yet there's barely been a peep out of you to criticise the government or even question the government. Are you concerned that your funding would be under threat if you spoke out against the government's COVID mismanagement?
Well, again, I'd reject the premise of the question on two fronts.
So you're not concerned?
No, the first is that the Commission has not felt ever restricted in terms of what we have said in relation to COVID-19 and the pandemic response. And secondly, I would say that the Commission has done a great deal of work in terms of COVID-19 and the pandemic response. And I could point you to work not only that I've done, but that my Commissioner colleagues have done across their portfolio areas in relation to a whole range of issues to do with the human rights response arising out of the pandemic, and that we continue to do in relation to that.
Could we get that on notice, please?
I'm sorry, Senator?
Could you send that to us on notice, the work you've done?
The entirety of the work that the Commission has done?
Well, just the summary, if you like. There's no need to go to a lot of trouble. I just want to get a picture of what you're thinking.
Certainly, Senator, of course.
Thank you. Just finally, Chair.
Thank you.
There's a paper just recently been released called Did National Security Imperatives Compromise COVID-19 Vaccine Safety? It's been written by 7 doctors. Philip Altman has had, 5 doctors and 2 experts with the pharmaceutical industry. Philip Altman, who is a doctor but not a medical doctor, he's a doctor of pharmacy, has had 40 years with the big pharmaceutical companies as a contract research organisation. He's worked with them, he's worked with the TGA. James Rowe has done similar with 40 years experience in manufacturing of pharmaceuticals.
Senator Roberts.
So the point is that using government data and peer-reviewed medical papers and scientific papers, they've explained why some people are not affected by the vaccines at all, by the injections, and other people are dying in large numbers. They also explain that the injections have not been tested. They're a Department of Defence initiative in the United States, and that's been documented. They're not complying with good manufacturing processes, and death rates are leading to very high excess mortality, and they're calling on the government to stop injecting at all, let alone mandating. Are you aware of that paper?
Well, Senator, I can't comment on the particular paper that you've referred to, but what I would refer back to is information in relation to both adverse impacts in relation to vaccinations and vaccinations administered, and simply note that while there have been approximately 137,000 adverse cases reported in Australia, to my understanding, that needs to be placed in context of over 64.7 million vaccinations being administered. So I certainly understand that there is a need to continue testing vaccinations and continue improving our understanding of how they work. but I would also return to the assessment that's been made by the TGA, who are expert in these things in a way that I am not, and who have concluded that the benefits do far outweigh the risks.
You're aware in the American VAERS system that has recorded 34,000 deaths and rising from these injections, and that's grossly underreported. They know that, and they're estimating good
Senator
estimates
Roberts,
saying over
we might be getting
200,000
in.
dead.
Yeah, we might be traversing into a bit of a futile discussion. Apart from the
No, I'm
fact that
finished, thank you.
well, no, I not your. You're very passionate about these topics, but just the ability of the Commission to actually provide you with answers you're happy with. And we do need to go to a break. So
Could I just add
you
one
can
more
respond,
thing to
and
that
then I think
answer?
that might be it.
Only to acknowledge that certainly we should add our complaint handling work to the information that we will provide on notice about the totality of the work the Commission has engaged with in relation to the pandemic response.
Thank you. Thanks, Chair. Yeah.
Thank you, Senators, and thank you, President. Thank you, Commissioners. Again, thank you, Commissioner Jenkins. We're going to have a short break until 10, or we'll probably make it 12 past 9, and come back to the Administrative Appeals Tribunal.
So that concludes
you.
for us.
Yes, it does.
Thank you. Thank you, Chair.
very much.
Thank you, Committee.
There, and before we start, just give me a moment, sorry. Before we start, I just wanted to let, we've got another agency that I think senators have agreed to put their questions on notice to the Federal Court of Australia. So thank you for sticking around, we appreciate it. Apologies for keeping you here. Thank you so much. I now call officers from the Administrative Appeals Tribunal. Thank you, Registrar. Do you have an opening statement that you'd like to table?
In the interest of time, Senator will pass.
Thank you very much. I'm going to hand the call to Senator Scarr.
Thank you, Chair. I'm not sure whether or not this question goes to the Registrar or the Chief Operating Officer or someone else, so just feel free to make your contribution. As Minister Chisholm knows, I am an annual report guy, so I do like to go into the detail. Could you please tell us about what processes the AAT has in place with respect to user experience ratings, and what the user experience ratings were in the last annual report for the Administrative Appeals Tribunal, and in particular, visa reference, I refer to pages 31 and 32.
Yes, thank you for your question, Senator, and good evening, Senators. Michael Hawkins, Registrar of the Tribunal. I will defer to one of my colleagues for more specific details about the process. At a top level, I can say that our users result is 74, which exceeds our own goals of 70. As for the process, though, I might defer to my Chief Legal Officer.
Chris Matthews, Chief Legal Officer, Administrative Appeals Tribunal. Senator, the user experience rating is derived from a feedback survey that's administered by an independent market research company. Arima Research has done the surveys for the last few years. So all parties and representatives in cases that have been finalised between a particular period, so in 21-22 it was between 1 December 2021 and 31 March 2022, where we had an email address or mobile phone number, were invited to complete an online questionnaire. The questionnaire covers a range of subjects, so the process of applying for review, our website and written communications, dealings with staff, conferences and hearings, as well as perceptions of the review process overall. The user experience rating is then calculated from taking the average proportion of strongly agree and agree or always unusual ratings for responses to questions about the different aspects of the review process.
So I noted on page 31 that the data which is analysed and put in tabular form on page 32 was received from 2,109 parties and 439 legal and other representatives. So is it correct to say that your survey calibrates and considers the results received from both individuals who are either self-represented or represented by a party, but also receives feedback from representatives who presumably are legal practitioners or advocates?
That's correct, Senator. So it can be, yes, legal representatives, disability advocates, veterans advocates, the range of people that can represent people in the tribunal.
And in fact, the ranking, the satisfaction rating from legal practitioners, representatives, advocates, as you described them, is in fact higher than the rating from individual members' parties. Is that correct?
That's correct, Senator. And that largely relates to the effect of the outcome of a review that it can have on the satisfaction ratings of the parties. So it may not surprise to hear that those parties who had a successful outcome in the tribunal tend to rate the tribunal higher than those parties who did not get a successful outcome.
Okay, so the result, the 74% overall result, needs to be considered in that context, that if a party, and it's human nature, goes through the AAT process and doesn't get the result they want, then there's a stronger likelihood, presumably, that they're going to be dissatisfied. Is that correct?
That's correct.
And in terms of this performance rating, this key performance indicator, is it correct to say that you outperformed, the AAT actually outperformed the benchmark which it set for this KPI? Is that correct?
So we'd set a target of 70% user experience rating.
Okay.
And it was, a 74% result for 2021-22.
Thank you. I want to move on to the next KPI, which, from my perspective, lawyer, I guess I'm always interested in, and that is the proportion of appeals against AAT and IAA decisions which have been allowed by the courts. What can you tell us about the results in that regard for the year ended 30 June 2022?
Senator, we have a target of that the proportion of decisions in relation to which the appeal is allowed is less than 5%, and the performance achieved for 2021-22 was 1.9%.
So that's quite a overachievement, if I can put it that way, in terms of the benchmark. Has it ever been lower than 1.9%? How does that, and I'm not sure how far back you have the figures, but I'm interested to know how far back you go and how that compares on a historical basis.
So, Senator, the figures we have here today are only for 2021 and 21-22, and in 2021 it was 2.3%.
Okay,
so I need to take on notice the
if you can take on notice. Registrar, do you have any comment in that respect as to whether or not there's been a material improvement over time, or whether or not it's been reasonably stable at about that the late 1% or early 2%? Do you have any further insight you can provide?
To beat your own target, Senator, gives you a great deal of satisfaction, and I think it's a reflection on the members themselves and their commitment to the task, and also to the professional development and training that we give members, no matter what their background, when they join us after their induction.
Okay, and how does this appeal rate compare with other tribunals or lower courts, Federal Circuit Court, magistrate courts perhaps, which can be appealed to the District Court? Do you have any data on that?
We might need to take that on notice.
Okay, if you can
Senator.
take it on notice, I'm interested to know, because it seems to me to be quite a compelling result, positive result from my perspective. So we've got the customer satisfaction levels exceeding benchmarks. We've got successful legal challenges falling year on year based on the evidence we just heard, and certainly considerably under the benchmarks. Yet the attorney announced on 16 December that, and I'll quote from his media release, which I can table. Minister, do you need a copy of his media release, or do you have it? No. Secretary, do you need a copy of the Minister's media release, or do you have it?
That would be helpful.
Oh,
yes.
okay.
Thank you.
Just keep one copy. Thanks.
Thank you.
So the attorney in this media release, dated 16 December 2022, I quote, said he would replace the AAT, replace it with an administrative review body that serves the interests of the Australian community, end quote. From your perspective, Registrar, in terms of the data that's just been presented and the other data, the objective evidence that's actually contained in the annual report of the Administrative Appeals Tribunal, is it your view that the AAT is in fact serving the best interests of the Australian community?
Senator, that's probably not a question for me to answer, probably one for the department to answer on behalf of the attorney.
Secretary?
Senator, I won't provide a commentary on the attorney's press release, but...
No, I'm not, sorry, just to be clear, I'm not asking you to. I'm asking you to provide perhaps your observations as Secretary of the Department in relation to the objective evidence that is reported in the AAT annual report.
I think in terms of the evidence in the AAT annual report, I want to commend the Registrar and his team, who I think have been working to address a range of challenges in the tribunal with significant backlogs across various very important jurisdictions that have been ongoing issues for the tribunal over a period of time. I think they've also been grappling with issues associated with issues around the different divisions in the tribunal and different procedures, the lack of a single case management system that can help support the tribunal operate effectively. So whilst I recognise their efforts and the efforts of the members, I think that there have been some real challenges with the performance of the tribunal, and I think that's borne out by some of the statistics around caseload and the workload of the tribunal.
Secretary, do you recognise that some of those issues with respect to case backlog are potentially due to factors outside the control of the AAT, including with respect to the challenges of, for example, one jurisdiction where caseload is increasing quite considerably is in relation to NDIS challenges? Do you recognise that that is a manifestation of policy decisions and administrative decisions which are being made and then causing an increase in cases going to the AAT?
I think that's a fair assessment, and in the department we have, for some time now been working not only in relation to other relevant stakeholders in the disability jurisdiction, but also in the migration jurisdiction, recognising that there's a complex set of factors that a downstream agency like the AAT is affected by, many things that happen upstream. So I think what you've said is a fair comment.
Minister, why is it that in the Attorney's media release he doesn't make any reference to those two areas of objective evidence that are contained in the annual report, namely appeal rate success rates and also customer satisfaction, nor does he make any reference to the matters which the Secretary just elucidated upon then in terms of some of the reasons for backlog?
Because it seems like he's chosen to focus on the record of your government when you were last in power, and the fact that you appointed dozens and dozens of ex-LNP staffers, ex-LNP candidates, and really didn't have the relevant experience or expertise to the AAT. I think that therefore undermined the AAT's standing in the community, and that was really a substantial reason why the Attorney-General took the decision that he did in my reading of his press release announcing the abolishment of the AAT.
Minister, if the AAT's perceptions of the AAT in the community had been undermined by the matters which you referred to, why is it that the user experience rating is so high, including that of legal representatives and advocates?
I don't necessarily think that is a absolute accurate reflection of the standing of the AAT in the community, as articulated by the Attorney-General in his statement.
Minister, if the appointees do not have the relevant skills to discharge the obligations which are conferred upon them as members of the AAT, why is it that the proportion of appeals against AAT and IAA decisions allowed by the courts is only 1.9%, less than the 5% target?
Well, I'm happy for the department to have anything to add to that, but what I do know is that the Attorney-General in his statement said that one of the keys to reforming or setting up a new body will be a independent process that will go through to ensure that appointments are merit-based. And I think that is really important in terms of rebuilding community confidence in having a system that the Australian community can have confidence in.
In terms of that independent process, is someone at the table who can walk us through what that proposed independent process, which is nominated by which the Minister has referred to and which the Attorney has mentioned, what it comprises of, and in particular, who will actually be sitting on the panel that will be making a determination as to whether or not a recommendation should be made to appoint someone or reappoint someone who's actually on the AAT at the moment?
Thanks, Senator. We can certainly provide you with information on that. I might go first to Ms Harvey and then we can hand over to the team. I should note, Senator, we've established a task force within the department to lead the work associated with this reform, and Ms Samios and Ms Virtue are key members of that team along with others.
Congratulations.
So they can talk to the work of the task force.
So in particular, I'm interested in, I understand that vacancies are to be publicised, etc. In particular, I'm interested in who will actually sit on this independent selection committee who will make decisions.
Yes, Senator.
Or recommendations.
Certainly, and just I guess just to go back, the Attorney-General has published a set of guidelines that will be used for appointments to the tribunal, and that sets out selection of non-judicial members of the AAT, and there'll be selection criteria in there, expressions of interest to be sought through a public advertisement. A non-judicial member assessment panel will be chaired by the Attorney-General's Department Secretary or their delegate, and will include the AAT President or delegate and a member nominated by the Attorney-General.
So that's just 3 members?
Yes, Senator.
So just walk me through who the 3 members are.
So there will be, it'll be chaired by the Secretary of the Attorney-General's Department or the Secretary's delegate. It will then have the AAT President or delegate and then a member nominated by the Attorney-General.
Only 3 members?
Yes, Senator, which is not an unusual composition for a panel of this nature.
Well, I know one is either the Secretary of the Attorney-General's Department or their delegate. Another is a nominee of the Attorney-General, him or herself. A third is the AAT President. Why is it if, and I support the concept of an independent panel, why is it that there isn't at least either a majority of independent members who are people of high standing who have maybe been ex-Superior Court judges or other people who don't necessarily hold a position and could perhaps bring a more independent assessment? What was the thinking behind these 3 as opposed to having a panel with a majority of independent members?
Senator, the Attorney-General's delegate may be an ex-judicial officer, as you have indicated.
But they're appointed by the
another
Attorney-General, correct?
They have to be, if it's a statutory appointment process like this, obviously the appointment would need to be made by the relevant minister.
Right.
I have to hand the call over very soon. I just wanted to give you a bit of warning about that.
Sure.
I know you've got a run of questions you want to get through.
Minister, do you have any comments with respect to why the selection panel couldn't have perhaps a number of further independent appointees?
I think as the department outlined, I think this is reasonably standard for this sort of process.
Okay.
One last question.
All right. I might just, to the registrar or perhaps one of the other members, senior executives from the AAT, obviously there's been all this publicity, all this commentary, very strongly worded, and I'm being moderate with my language, media release from the Attorney-General. What is this doing to the morale within the AAT, and what is it doing in terms of staff retention with respect to, say, associates, other key employees within the AAT who are actually crucial to the workings of the AAT?
Senator, the announcement was made on the 16th of December, and here we are in February. It's probably a little too early to assess the effect it's had on retention of staff and recruitment of staff. In terms of the announcement itself, whilst the timing probably wasn't ideal, it has in fact provided some certainty against a lot of speculation about the future of the tribunal in relation to the tribunal itself. In relation to the response within the tribunal, I would say that the response of APS staff, given the comments the Attorney has made about the retention of those staff, it has been by and large quite positive.
So those comments?
Pardon me?
Those comments? What were those comments?
To retain the APS staff.
Right.
Yeah. So it's been quite positive, and there's a sense of wanting to be engaged in the process. The view of members is probably as diverse as the number of members itself.
Okay. All right. Thank you, Chair.
Thank you. And just to follow up on that, I think the Attorney-General said that all ongoing and non-ongoing APS employees employed at the AAT will transition to the new body on equivalent terms and conditions when the AAT is abolished. What are you doing in the meantime around ensuring that staff are supported during that transition, given they are all, if they want to, moving to the new body?
So, Chair, I have three priorities at the moment. The first is the user experience, to ensure that users continue to enjoy first-class merit-based processes and get decisions quickly. The second priority is to our members and staff to ensure that they receive the welfare and encouragement that they need to perform their jobs. And my third priority is to support the department in providing it with operational information that will inform their policy decisions in relation to what the role of the tribunal is, what our practices and procedures are, what our funding is and ought be. Now, in relation to the staff themselves, we have set up a page on our intranet to ensure that staff are regularly informed of statements by the Attorney-General and the department. It contains statements from the Acting President and myself. Any news items on the reform. Obviously, there's a little in the media. We have contact information with the Attorney-General's department so that questions can be asked of the department as to the process. We've got links to the Employee Assistance Program. The department's task force itself has invited staff of the AAT to apply to be involved with it. And of course, we have asked the department to consult widely, including with members and staff of the tribunal itself.
Thank you. Appreciate that. Senator Shoebridge.
Oh, thanks, Chair. And thanks all for your attendance today. I suppose my question is to the Secretary or Ms Harvey. In the event the AAT is abolished, there's been a commitment to the retention of the non-member staff of the AAT in whatever future body replaces the AAT. Absent some statutory or other policy intervention, what would be the effect on the non-judicial members of the tribunal if the tribunal was abolished? Is there a requirement to pay them out for the period of their initial appointment, or does their service just end on the day of abolition?
So I'll ask Ms Samios to talk to that.
So Senator Sara Samios, First Assistant Secretary, Administrative Review Task Force. The government's considering a range of matters to do with the establishment of the new body, including arrangements for members who might not be appointed to that body. There isn't. It's under consideration.
Yes, but I'm not asking what the government's intention is going forward. I'm asking, as the law currently stands, if the AET was abolished, what would there be an obligation to pay out the members for the balance of their, if they've got a 5-year appointment, the balance of their 5-year appointment? What would be the requirement at law, absent some other statutory intervention? And I'm asking here about the non-judicial members.
I think what I would say is I understand the straightforward question that you're asking, and that is something that we're obviously giving consideration to, but there are a range of potential options as to what may occur with members, depending on selection processes, recruitment processes, merit-based recruitment processes that are underway, where existing members will have the option of being able to apply and go through that process. So there's a range of options that may be available.
But Secretary, this is just the most basic baseline starting point. If you abolish the AET, what's the position of the non-judicial members? Do they have an entitlement to be paid out the balance of their term, or do their entitlements end at the abolition of the AET?
I think it will differ between full-time members and part-time members. There'll be a range of scenarios there.
Obviously, those who only have sessional appointments, those sessional entitlements will end.
Yep.
But why don't we start with full-time members? I mean, this is just the most basic initial question. Surely the department has an answer to this.
Senator, I think we're trying to answer your, respond to your question without going into looking like we're providing kind of legal advice here. Certainly, members will are covered by determinations at the moment set by the Rem Tribunal. But then, as to
but if the
what
tribunal
will happen
ceases to
after
exist, what happens? I mean, it's just the most basic starting point for the inquiry, and
Yes.
I'm surprised if we don't have an answer to it.
So, as the Secretary and Ms Samios have said, this is something that is under consideration at the moment, but the terms and conditions of employment are of course set out by the Remuneration Tribunal. So,
But that's only while they're a member of the tribunal. And if the tribunal ceased to exist, my assumption, my starting assumption would be that the entitlements cease to exist if they're appointed as a member. But I'm assuming you have an answer to this because, as I said, it's a sort of foundational starting point if you're trying to work out what to do when you replace the AET. And so I'm surprised you don't have an answer.
Senator, I think the best answer we can give you right now is there are a range of issues that we are working through on this issue. I recognise it is an important issue to be able to give advice, but it's the options are under active consideration, and I don't think I can say too much more than that at this point.
To be clear, I'm not asking about what policy decisions the government may or may not. They may want to transition everybody across to a new tribunal. They may want to allow expressions of interest. They may want to do all of that. I'm simply asking, what's the baseline? Absent any policy determination being made by the government about it, if the AET is abolished, as the Attorney General has said he wants to happen, and I see enormous merit in the policy direction taken by the Attorney. If that is implemented, what is the effect on the appointment of the current members, of the non-judicial members of the AET?
Well,
I'm not asking you to speculate about what policy decision. I'm just asking what the effect of the outcome predicted in the Attorney's media release would be.
I think they understand the question.
what I just don't understand. I
Sorry.
don't think you may understand the question, but the answers are oblique and not addressing the question.
Well, that's different from not understanding it, and putting it another time probably won't get you another answer, I don't think. But
If you don't have an answer, if you're not able to answer it, just tell me you're not able to answer it.
Senator, I just go back to my earlier answer that the terms and conditions are set out in the Remuneration Tribunal determination that covers members. So that's the starting point.
But there's no provision in that says in the event the tribunal is abolished, X happens. So it doesn't answer the question, Ms Harvey, with all due respect.
Pardon? Yeah, I think it does.
I know what they get paid. I know what the remuneration is if the AAT is in existence. But if it's abolished, tell me.
So, Senator, the Remuneration Tribunal determinations include loss of office provisions, which could apply, but there's a policy decision to be taken by government around those arrangements. Correct. So there's a legislative...
There's a potential alternative, but no legal entitlement to it. But perhaps if you can take it on notice and answer me on notice.
We'll take that on notice, Senator.
All right. Perhaps to you, Registrar, you indicated that one of the issues the AAT, in answers to Senator Scarr, has faced is, a surge in cases in the disability space. Not in just won't work. I'm sorry, on the transcript.
Oh, sorry.
Yep.
Sorry, the question, Senator.
You indicated in answers to Senator Scarr that one of the reasons which explains that the continuing existence of a backlog in the AAT is a surge of cases in the disability space, and that's had an impact on caseload. Do you recall those answers?
Yes, I do. Yep.
Yeah, but I'm looking at your annual report for the last financial year, for 2021-2022, and that indicates actually in the last, between 2020, 2020-21 and 2021-22, there's been a substantial drop-off in the number of cases, far from a surge, but a drop-off in the number of cases. In fact, the high watermark for the number of cases for the AAT was actually in 2018-19, where there was a high watermark of some 60,500 cases lodged. It actually collapsed down to 37 cases, probably pandemic-related in 2020-21, and is only sort of struggled up to 44,000 cases in 2021-2022. So in fact, your data in your annual report is directly contrary to the impression you were seeking to give in those answers, isn't it? Your caseload has dramatically reduced, not increased.
I might defer to my colleague on the NDIS specifically.
Well,
Senator, just to provide a little context. So in terms of, as you say, the lodgements in the tribunal increased from 2015-16 to a peak in 2018-19, and then a reduction 2019-20, 2020-2021. So the increase in the earlier years was particularly in the Migration and Refugee Division. So the number of lodgements in that division doubled almost in 27-18. And so over the course of that period, when we weren't able to finalise as many applications that were lodged in that period, the backlog kind of grew in that period. Then in more recent times, in the National Disability Insurance Scheme jurisdiction, the number of cases has increased from 2,160 in 2021 to 5,918 in 21-22. So in terms of, there has been an increase in that particular jurisdiction over more recent years, and that's added then to the backlog of the tribunal in that.
Whatever may have happened in Division A or Division B or Division C, there's been a dramatic reduction in the caseload in the AAT, and that has not shown up in anything like the same dramatic reduction in the cases on hand. So far from a model of efficiency, the data in your annual report would suggest quite the opposite. A dramatic reduction in caseload and very stable number of cases on hand. And so I'm going back to you, Registrar. The impression you gave in the answer to Senator Scarr was that the reason why there is such a stubborn number of cases in backload was because of an increase in cases in some divisions. But if you look at the overall caseload to the AAT, it it suggests that that is a misleading picture that you give.
So, Senator, I would clarify that remark by referring, in fact, to the type of caseload that we're doing. So in MRD, for example, during COVID, we were able to do a number, and before COVID, we were able to do a number of probably low-hanging fruit decisions that didn't require in-person hearings. Now, of course, since COVID, the protection caseload in particular has increased, and as a consequence, which require in-person hearings, so the caseload has actually become more complex, which has had an impact on the number of decisions we're actually able to make.
You had 23,000 less cases filed in 2020-21 than you had in 2018-19. You had 16,000 less cases filed in 2021-22 than you had in 2018-19, and you had 6,000 cases less filed in 2019-20 than you had in 2018-2019, and yet your backload remains stagnantly high. That is far from a model of efficiency, Register.
Yes, Senator, but as I've just explained, it comes down to the complexity of the caseload that we're dealing with.
They suddenly got more complex in 2021-22.
In the protection caseload in particular, in the refugee caseload, we're dealing with a much more complex caseload because we are now reverting back to in-person hearings. And the number of clearances we had during COVID and just before COVID, we dealt with, I'm very complimentary of my predecessor in the role where we were able to pivot so quickly to being able to, within weeks, to be able to clear cases by provision of computers to all of our members, to be able to do cases by telephone, by Teams, but as a result of that, the resultant caseload has become a complex one that requires in-person hearings. And as I said, it's particularly so in the refugee caseload.
Could I go to your appeals data? You set a benchmark of, and I'll read from your report, we aim to have fewer than 5% of appeals against our appealable decisions allowed by the courts. Was that the benchmark? 5%
Less than
of appeals
5%, correct.
against our appealable decisions allowed by the courts. Where did you get the 5% benchmark from?
That's a benchmark we set ourselves.
No, but that doesn't really answer the question. If you got it from an internal meeting, that's great. But a benchmark normally is benchmarked against comparable jurisdictions. It's benchmarked against something tangible. I'm asking where you got the 5%. What did you benchmark it against?
Short of an answer from my colleagues, I'll take that on notice.
And is it...
I just draw your attention to the time, right. Senator Shoebridge.
All right.
Got a few more minutes.
Thank you. Could I ask you then about the matter involving the AAT member Mineta? You recall I asked you some questions about that on the last estimates?
We did, Senator, yes.
And I asked you if there was a complaints process undertaken, what the nature of that complaints process was undertaken, and you provided some answers on notice. Do you recall that?
I did, and I think those answers were tabled on the 30th of January 2023.
Yes, and you said this. Member Michael Mineta is a part-time member of the AAT assigned to the Social Services and Child Support Division. The cases allocated to member Mineta were changed from reviews of Centrelink decisions to child support decisions in September 2021. Do you remember that?
In my answer, yes.
Yes.
Yes, Senator.
And I asked you why that happened, and I still don't have an answer.
Senator, I think if you go on in my answer, you'll see that I explained that there was the matter was referred to the President, who in turn caused an external investigation to take place. As a consequence of that external investigation, the President at the time suggested, or in fact implemented, a external mediation that took place, and as a consequence of that, the member is now hearing those cases again.
Well, I still don't know why he was taken off, but I'll go to the further details of the answer.
Sure.
You said that the President directed a process be undertaken. You then say an investigation was undertaken by a former Superior Court judge and a confidential report prepared for the President. Is that right?
Correct.
Who was the former Superior Court judge?
Justice Jennifer Boland.
Was there a reason why you didn't provide those details in your answer?
No, no reason.
Did you provide a copy of the confidential report to the Secretary?
I did not. No,
Did
it's,
anyone-
it's a confidential report, Senator.
Well, sorry, confidential from the Secretary of the Department?
Your last question, Senator Shoebridge. If we need to come back to you, we can.
I will finish it up.
Sorry, why would I provide it to the Secretary of the Department?
Who has seen the confidential report apart from the President?
The President has seen it, and in the course of providing the answer to your question, I have also seen it.
Was it provided to Member Manetta?
It has not been.
Was it well, I'm going to ask you now, will you provide a copy of what you assert to be a confidential report to this committee?
I'll take that on notice.
As
to the confidentiality issues.
What were the findings of the confidential report?
They're confidential, Senator. That's why they haven't been disclosed.
Why do you assert that this confidence protects you from providing answers to parliamentary budget estimates and questions?
Because the report was provided to the President in confidence, prepared and provided to the Senator. To the President in confidence.
I'm going to ask you now, what were the findings of the report?
I will take that on notice.
And again, I'm going to ask you, will you provide a copy of the report to this committee?
I will similarly take that on notice, Senator, as to the confidentiality issues.
And I'm going to ask you, did you provide a copy of the report to the Attorney?
Senator Shoebridge, as you would be aware, Registrar, there's a public interest immunity process that you can
Which I'll discuss with the Attorney.
Yeah. So I appreciate that
was my
might
next.
be.
That was my next answer, Senator.
Yeah, no, I understand, and I thought that might be where you're going.
Yeah.
That might assist Senator Shoebridge as well.
How could Mr Manetta, Member Manetta, have fairly taken part in the external mediation if he didn't have access to the report that was provided in relation to what happened to him?
That was a decision taken by the President. Senator.
No further questions?
Thank you, Senator Shoebridge. Oh,
Thank you, Senator.
thank you.
Thank you, Chair.
Senator Scar, you have the call. The next agency we're dealing with is the Australian Law Reform Commission, and we've got some questions for those. So.
The last agency I have questions for this evening.
Yeah,
so
other
I'm
senators
keen to
have
get to
questions
them.
for others,
Yeah,
including the
okay.
Royal Commissions, which I'm
Okay.
sure you are aware of. Thank you.
No problem. I just want to ask some further questions in relation to some of the questioning from Senator Shoebridge in particular. Ms Harvey, my understanding is, and by benefit of my understanding, by benefit of my phone, that there's actually, in the Remuneration Tribunal, there's actually a provision in relation to the loss of office in the event a statutory office is abolished. Is that correct?
That's correct, Senator.
So isn't it plainly the case that if the AAT is abolished and a member seeks reappointment but they're not reappointed to the new body, whatever it is, that their office has been abolished and therefore that provision applies?
Senator, the policy around what will let me start again. Senator, the decision about what will happen is what is currently under review, but you are correct in that there is that remuneration tribunal determination has that loss of office provision in there.
Because, Ms Harvey, I looked into that because you yourself referred to the terms and conditions being in the Remuneration Tribunal determination. So shouldn't that, from a legal perspective, be an end to the matter, that is the process which applies, that has been determined independently by the Remuneration Tribunal?
So, Senator, the members will have the opportunity also to apply for roles in the new body.
Correct. But in the event that a member applies from the AAT and is unsuccessful, and I note the comments by the Attorney General in his media release, which isn't going to inspire confidence with respect to the categories, the cohorts he mentions, and those members are unsuccessful and their position on the AAT is abolished, doesn't it necessarily follow that the relevant term and condition, as you refer to it, of the Remuneration Tribunal determination that applies is abolition of statutory office?
So, Senator, not trying to be difficult. The decision about what will happen at that time is what is currently under consideration.
I think there's an exclusion event and a variety of issues under the exclusion event which may have a significant impact in it. Just looked at this.
Under the remuneration. Okay, well, it'll be interesting to see what in fact happens. Is the task force being contacted by members of the AAT asking what applies?
I'd need to take that on notice, Senator. I'm not immediately aware of any direct contact to the task force from a member in relation to that issue.
Registrar, are you receiving queries?
Obviously, Senator.
Yeah, obviously. I would have thought so. I want to move on to the selection criteria, Ms Harvey, which you referred to. Firstly, so there's the chair, which will be the secretary or the secretary's delegate. Just secretary, in that circumstance, your delegate would be someone else within the department. Is that typically what you would do?
It would probably in all likelihood be the Deputy Secretary, so Tamsin Harvey.
Okay.
Because we're obviously, there are quite a large number of appointments that are going to need to be considered, so there will be a lot of work associated with those processes.
Okay, I appreciate that. Then there's the AAT president. So who's the current president is an acting president, is that correct?
That's correct, yes.
Right, or their delegate, correct? And then we have this one member nominated by the Attorney-General. Has that member been, is there any selection process for that person who's going to be nominated by the Attorney-General? Is that going through a public advertising process, a selection process with some independents involved in it?
Senator, in terms of the standard approach for statutory appointments, it is it would not generally be something that you go out and do an expression of interest in being on a panel. It is something that's a matter for the relevant minister to give some direction on. So that is going to be the case here.
So, Ms Harvey, are you aware as to whether or not that person's been identified yet?
No, Senator.
No, the department is preparing some options for the Attorney-General's consideration.
Okay. In terms of the operation of this panel, I note from the media release issued by the Attorney-General, which I've tabled and I quote from it, by appointing as many as 85 former Liberal MPs, failed Liberal candidates, which is a particular phrase I touched upon earlier today, former Liberal staffers and other close Liberal associates without any merit-based selection process, and so it goes on, end quote. So there's obviously some pretty strong language in relation to a material cohort of current members of the AAT. Have protocols been discussed in relation to circumstances in which the attorney or the attorney's delegate should recuse themselves from the panel when dealing with that cohort?
Senator, what I would say is that there would be a very strong expectation that anyone on the panel approach their responsibilities with absolute objectivity and with the highest levels of integrity that you would expect of any appointment panel. And that's certainly something that we will take all necessary steps to ensure.
And Secretary, you're of course aware that in terms of bias, there are two types of bias. There is actual bias, but then there's apprehended bias. Given the Attorney-General's media release, do you see the significance of potential apprehended bias in terms of the operation of this selection panel? Do you think that's something which members of the panel need to carefully consider?
I think just as a general principle, it is something that members of selection panels should always concern themselves. Senator, as someone who is a very frequent participant in selection panels, it's something that we always very strongly turn our minds to. Okay.
In terms of Just a comment you made, Minister, just triggered this question in my mind. Has the attorney conducted any community survey to see what the views are in relation to the community vis-à-vis the AAT? So we've seen the objective evidence contained in the Administrative Appeal Tribunal's annual report. Has the Attorney-General conducted any survey that you're aware of?
I don't know if the Attorney-General has conducted any survey. I wouldn't think that's something that he normally does, but I certainly know as a Member of Parliament, he's someone who's very active in the community and in legal circles. So I'm sure he takes on feedback as he moves around the community, as all good elected members do and ministers of this government.
Senator, I would probably just add to that that of course this Parliament undertook an inquiry relevant to the AAT and made some recommendations about that, but obviously that inquiry took into account various views and I assume you're familiar with it, but
There was a dissenting report too, that's correct, isn't it, Secretary?
That is correct, Senator.
Yep. Registrar, just in relation to this issue of vacancies, are associates covered within that definition of APS staff or APS?
Yeah, unless they're contract labour.
Unless they're contract labour. How many vacancies are there at the moment? Do you have any figures in that regard?
Vacancies?
In terms of different functions within the AAT?
I'd have to take that on notice, Senator, sorry.
Okay. If you could take that on notice, that would be good.
Senator Scarr, how much longer do you have? I appreciate you don't have further questions for agencies, but the officials and staff of those agencies are waiting to be asked
No, I'm
questions.
aware of that. I'm moving as quickly as I can, and I will try and bring it to an end as quickly as I can. So if you can give me another 5 minutes, I'll see how far I get through in 5 minutes, Chair. I am doing my best. There are many issues raised by this, as I'm sure you're aware.
I'm totally aware. I've got my own questions, but I'm encouraged by the many officials that are waiting to be asked.
No, I'm keenly aware of
and
that.
that we've kept here until very late.
That's a collective result, I guess. Can I just ask, in relation to Mr Patrick Keane's role, Ms Harvey, are you involved in terms of liaising with Mr Keane, a great Queenslander?
Senator, I'm not directly involved, but my colleagues here will be able to assist you.
Okay, and what is Mr Keane actually doing, or the Honourable Patrick Keane?
So he's chairing the expert advisory group that the Attorney-General is establishing to provide advice on the reform.
Okay, so what advice is being provided in relation to the new tribunal that's being set up, in relation to how they're going to make determinations as to assessment of people's performance at the AAT? What's the ambit of that role?
It's a wide-ranging approach, so we're taking a very broad view of the future policy setting in relation to the new body, its legislation and other policy and supporting arrangements.
Okay. And just in that regard, is there anyone else who's performing any other senior extrajudicial figure who's performing a key role in terms of assisting the Honourable Patrick Keane?
So we are in the process of settling the membership of that group.
Okay, so you're in the process of that. So you've identified a number of potential candidates?
Yes. So the Attorney-General also consulted with a range of stakeholders on potential nominees for that group.
Is the Honourable Duncan Kerr one of those candidates you're considering?
I think whilst the actual membership is under consideration by the attorney, I think it wouldn't be appropriate for us to talk about potential names that are on the list, but I would expect that in the very near future an announcement will be made about that.
Okay. In terms of the launch of the new tribunal, Minister, what's the expectation with respect to timing? Is there any expectation in that regard?
No, I think the department have outlined the process that we're going through. I don't know if they have any update on what we would be looking at in terms of timing.
Okay. The only other question, I'll put my other questions on notice, but two final areas. Clearly in the guidelines, Ms Harvey, that you spoke to, there is absolutely no reference with respect to prior political allegiance. These are all objective guidelines with respect to the performance of an individual member. Is that correct?
There is no reference to prior political allegiance in the guidelines. No.
So it all comes down to the objective performance of each of the members as will be assessed by the panel. Is that the intention?
So the panel will assess applicants in accordance with the selection criteria.
Which does not include prior political allegiance, correct?
So no, the guidelines don't refer to prior political allegiance, and the selection criteria
Does not refer to prior
either,
political
no.
allegiance.
No.
Right, okay. I want to go finally to the circumstances in which the ex-president left, Ms Maher, Fiona Maher, Justice Fiona Maher, and there was a story that occurred that was published, and I can table it or we can just keep going. I'm sure the minister's aware of it and probably everyone's aware of it. So just to give context, the Australian Financial Review published a story in which it was said that the attorney had made a phone call to Justice Fiona Maher on 12 November, which was the day after Justice Fiona Maher had released a statement about significant inroads made at the AAT since her appointment in April, and she detailed in that statement the work undertaken since her appointment in April 2022, and then it was announced on 1 December that Justice Fiona Maher had resigned and would continue to serve as a full-time judge on the Federal Court. Are you aware, is the department aware of the phone call being made by the attorney to Justice Fiona Maher on 12 November?
In terms of any specific phone call, I can't speak to that personally. I think, Minister, it may be something that we need to take on notice for the attorney himself to answer.
Minister, do you have any knowledge with respect to any phone call or any other subsequent phone call to Ms Fiona Maher? And on a general basis, I'm just concerned to know the circumstances in which Justice Fiona Maher on November 11 released a statement about the significant inroads of the work she'd been undertaking at the AAT, and then the fact that after receiving what the AFR refers to as a please explain call, on 1 December it was announced that Justice Fiona Maher had resigned. What interaction was there between the attorney and Justice Fiona Maher between those two dates?
I'd have to take it on notice.
Okay, if you could take that on notice, I'd greatly appreciate it. Okay, thank you very much. Thank you, Chair.
Thank you. I want to ask one follow-up to that as we close out. Who was on the independent selection panel under the former government?
The independent selection panel for
independent
which position, Senator?
Senator Scars asked you some questions about the composition of the independent selection panel that's being formed. Who was on the independent selection panel under the former government?
So there was a protocol in place. I don't have the details in front of me, but one of my colleagues may, that set out how appointments to the AAT were made, and that was in broad terms, as I recall, on recommendation. There'd be a discussion recommendations from the President of the AAT to the Attorney General. And then a decision
there was no independent
in
selection
accordance
panel,
with the
was
protocol.
there?
In recent years, there hadn't been in place an independent selection panel. The process, the protocol was, as Ms Harvey lined out, there was a capacity for people to put in expressions of interest in relation to becoming members, as well as recommendations from the President, but there wasn't an independent selection panel in place.
And in terms of the guidelines that have been developed, those are new as well?
Yes, Senator.
Yeah, there hasn't been guidelines before. There's been a protocol and a process, but not a series of guidelines that set out exactly how the appointments should be considered.
I'm not aware of previous guidelines. Certainly
Thank you.
aware of the protocols beforehand.
Thank you. I think that is all the questions we have for the AAT. Senator Shoebridge, I didn't do the questions well enough. So
I can't recall if there are any questions taken on notice about the entitlements to tribunal members, but you were quite right, Ms Harvey, in terms of the determination largely answers it. So if there were any questions taken on notice, I no longer require them taken on notice. The determination, as you correctly indicated, broadly answers it.
Thank you, Senator.
It's the minimum 4, maximum 12, but yep.
Thank you very much, Senators. Appreciate that. And thank you, Registrar, and to the AAT. I now call officers from the Australian Law Reform Commission. And just for information of those in the room, we have let the Disability Royal Commission know that we won't need to ask them some questions tonight. I was going to go to Senator Antic first, Senator Scarr.
Oh.
He's there.
I might, do you mind if I do
Please. Can you do short blocks?
I can.
No,
you go.
If I can, you best.
Nice.
I defer to you.
I know. You. I'm just, yeah.
I defer to the Deputy Chair.
Just get everyone to the table, Senator, and then we can ask those questions for you. Okay. Senator Scarr, you have the call.
Okay, thank you. Mr Corrigan, in the absence of a president, you're the lead representative of the Australian Law Reform Commission, is that correct?
Good evening, Senator. It's Mr Matt Corrigan, General Counsel at the Australian Law Reform Commission. We have an acting president, but he is Justice Mark Mashinsky. He's a full-time federal court judge, so he's unable to attend.
Okay. I have some questions about the Religious Educational Institutions and Anti-Discrimination Law consultation paper, which I understand it was released on 27 January 2023. Is that correct?
That's correct, Senator.
What representatives of the, and feel free to take some of these questions on notice if you don't have data with you, what representatives of the religious school sector were invited to provide submissions to this paper?
The consultation document is a public consultation document. All individuals are invited to make a submission.
Well, was there any particular... sometimes when we conduct an inquiry, we actually actively, as a Senate, with the assistance of our wonderful Secretariat, we actively reach out to stakeholders and ask them to make submissions. Was that process undertaken?
Senator, the ALRC's process is to undertake in-person consultations. As part of that process, we notify people that the consultation paper will be released and encourage them to make a submission, but we don't formally invite anyone in particular to make a submission.
Okay. Do you have could you take on notice to provide a list of the representatives of the religious school sector who did provide submissions either in person or in writing thus far?
We haven't received any submissions. We've undertaken consultations.
Okay. Can you take on notice to provide a list of those you've consulted with?
I can, Senator. They're on our website, so I can provide that very quickly.
Okay. Sorry, I didn't have a chance to look at your website.
Is this about consultation on the consultation paper for the purpose of consultation? Is this about pre-consultation on the consultation paper? Is that what we're talking about?
Senator Shoebridge, can you just allow Senator Scarr to ask his questions? You might not agree with the content, but the faster he asks them, the faster we can get to the questions you want to ask.
I'll resist responding to Senator Shoebridge, Chair. Do you believe that the Australian Law Reform Commission has taken on board the views of religious schools in their 4 propositions, which are detailed in the consultation paper?
Well, Senator, what we have done is prepare a consultation document in accordance with the terms of reference, and we are seeking submissions on that document. So we are seeking feedback.
Did the Attorney-General approve the consultation paper prior to it being released?
No.
Did the consultation paper go to Cabinet prior to it being released?
No.
Are you aware of the significant concerns from faith-based schools about their ability to practice their beliefs and deliver the education parents expect aligned to their faith under the proposed changes?
I'm aware, Senator, of articles in the Australian Today in that regard.
Okay. I actually have I was contacted following a line of questioning. Did you see my line of questioning earlier today, General Counsel?
I saw.
Did you have a day job to do?
I saw part of it, but I was
You
travelling.
saw part of it.
Yep.
I hope you saw the highlights. But
there were some very particularly good highlights I did see.
Oh, stop. It's 10:30.
it's not going to help you,
Please.
General Counsel. It's one ex-General Counsel to another. It's not going to help you.
Anything
I've
at
actually got a
10:27.
copy of the
You're a
letter
lawyer, Paul.
dated Senior Mining Executive. I've actually got a copy of the letter dated 13 February now, which was referred to in that article. So I might seek to table that if I could. Have you actually received a copy of that letter? Have you seen a copy of that letter from faith-based leaders dated 13 February 2023 to the Honourable Mark Dreyfus MP, Attorney General?
I don't have a copy with me, but I have seen it this afternoon, yes.
Okay, so I'm going to give you a copy.
That'd be great.
And I should say, just for the record, that this letter is signed by the Right Reverend Dr Michael Steed, Anglican Bishop of South Sydney, and then there's 2 pages of other co-signatories, which include senior representatives of the Catholic faith, Greek Orthodox, Jewish faith, Anglicans, Presbyterians, people of Muslim faith, Maronites, other faiths, and non-government organisations. So you've got that letter now? I want to take you to the second page of that letter, and I'm going to read you a paragraph. For the benefit of Hansard. After having carefully considered the proposals in the consultation paper, we are doubtful that the ALRC process can reach any balanced outcomes as contemplated by the terms of reference by starting with these proposals, and those are the 4 proposals I referred to. We agree with the comments from the National Catholic Education Commission that the proposed reforms fail to provide real protections for religious schools to effectively operate and teach according to their religious beliefs and ethos, and that if the proposed reforms were adopted, it would be a major blow to authentic faith-based education in Australia. Mr Corrigan, how do you respond to that paragraph?
Senator, there are a number of the signatories to that letter who've reached out to the Commission and to Justice Rothman directly, and as he has said to them, I would say this is a consultation process. It is a genuine consultation process. The ALRC has a proud history of over 40 years of consultation, and we would encourage all of those interested stakeholders who have concerns to submit to the consultation process.
Mr Corrigan, it's consultation, absolutely I accept it's a consultation process. One of the things that concerns me, which I raised with the Minister at the table, that these concerns are actually a manifestation of a lack of confidence in process, that the process has gotten off to such a start that leading senior members of their respective faiths have a lack of confidence that the consultation will actually be an effective process for their views to be considered. How do you respond to that concern with respect to process?
Senator, I'm not aware of what the particular concerns with the process are.
Well, they're saying that they're concerned with respect to the results of the process because of the original propositions that it's starting with, that it almost seems like a predetermined outcome. And I should note in that regard, Mr Corrigan, that there's a lack of reference absolutely to the Ruddock Review into freedom of religion. Isn't that their concern? That they're looking at the propositions and they're saying, well, if this is your starting base, this appears to be a fix. I mean, it's a predetermined outcome and it's not a legitimate consultation process. Isn't that the intent of what they're saying?
So you're not suggesting that of the Australian Law Reform Commission?
No, I'm actually putting a question that's trying to articulate what's in this letter, Senator Shoebridge. So, as I'm interpreting this letter, Mr Corrigan, they're actually concerned about the efficacy of the process and whether or not, given where it started from in terms of this initial consultation process, it's going to be an effective consultation process. Do you understand that concern?
Senator Sky, you're putting forward your interpretation of what you think the letter means. I think the General Counsel has said that they're encouraging those people who have put their names to this letter to engage in consultation, which is exactly why the process was established in the first place. I think we covered these topics earlier today. I'm happy to let Mr Corrigan add anything if he wants to, but I think he's dealt with these issues that were raised in the letter in an appropriate way.
Okay, I'll move on. Do you have anything to add, Mr Corrigan?
I would just say that those individuals that have written to the ALRC and the Commissioner have been encouraged to talk to us. We want to understand what their concerns are with the process. We are open to this being a genuine consultation process.
Mr Corrigan, there's a technical issue which is raised in the second last paragraph of this letter. Do you recognise the point, the materiality of the point that's being raised, that the way the law is applying in practice, the exemptions under the Sex Discrimination Act act together, or the way they interact with the state laws, certainly in Queensland and Tasmania, is such that you need to consider the nuances with respect to how the laws interact. Do you accept that as a proposition?
We're interested to hear more about this view, because certainly our understanding of the jurisprudence is that there is no High Court authority that supports that proposition, and certainly various representations have been made in relation to anti-discrimination reforms at the state and territory level that are inconsistent with that proposition. So we're very keen to understand the analysis that underpins that proposition.
Okay, I've got 3 more quick questions. Has the ALRC been consulted by the Attorney-General or his office following receipt of this letter in relation to the contents of this letter or any ancillary issues?
No.
Yesterday.
Okay. If the propositions in the consultation paper were adopted into law, and I just want to understand whether or not my reading of the propositions is correct, what freedom would schools have to require, say, for example, a maths or English teacher to subscribe to their school's faith?
I think you're putting forward a hypothetical situation there, Senator Scarr.
Well, it's one of the propositions, Minister Chisholm, in the consultation paper.
For consultation.
Well, I'm trying to understand what the proposition is that they're seeking to be consulted with respect to. So can we see if the General Counsel's prepared to offer a comment?
Senator, that is actually one aspect of the material in the Australian that I thought misrepresented the consultation paper. What the proposition is seeking to do, and the analysis, and I would draw you to paragraph 58. And that is,
what page are we on?
This is paragraph 58 of the consultation paper. It says the nature and religious ethos of the institution should be considered relevant to determining whether participation of the person in the teaching, observance or practice of the religion is a genuine requirement for the role. So the proposition is genuinely recognising that there are different types of schools and they have different practices with their religion, and that's a relevant consideration for the hiring of teachers.
And ultimately that would be a matter which, under this regime, a judge or a tribunal member would decide if there were a dispute?
Well, it would be a matter of fact, yes.
Right, as opposed to a religious leader making a determination with respect to their own religion?
Well, this is a question as to the nature of the role of the person being hired. It's not about the nature of the religion itself. It's an important distinction.
My last question. What roles at schools does the ALRC believe, under the consultation paper, the propositions which are being put, what roles at schools does the ALRC believe it to be acceptable for religious schools to give preference to prospective staff on religious grounds, and for what roles would it be unacceptable?
Well, Senator, as I just said, it would depend on the nature and the practices of the school in question. We don't think it's appropriate to have a blanket rule.
Okay, so refer to the consultation paper, that's the principle?
Well, no, I think the analysis in the consultation paper is that we are looking at this in a very contextual way, that there are schools that have different practices and it's important to take those into account.
Okay, but ultimately, my last question, Chair, is the ultimate determination under the propositions which are being put forward in the event there were a dispute would be by a judge or a tribunal member, not by a senior member of the religious faith. Is that correct?
Well, it would be a question of fact as to the nature of
the
the
role.
role.
Who would make the determination?
Well, in the first instance, the school would be making a decision as to the nature of the role and their practices.
But if there were a dispute, Mr Corrigan?
If there was a dispute, then in ordinary sense it would be a matter of evidence.
To be determined by?
A judge.
Thank you. Thank you, Chief.
Thank you. I love hypotheticals. Senator Antic, we're going to go to you. We've got 5 agencies to do in 35 minutes, so we're talking quick fire here, and then Senator Shoebridge is going to take us home with the rest of the agencies.
Yes, thank you, Chair. All right, look, it is. I want to talk about the same topic, this consultation paper, and yes, well, it's become quite contentious. I mean, and I take what my colleague Senator Scarr has said about the process, but if we boil this down, is it not the case that what we're really seeing here is the Albanese Labor government seeking to circle the wagons on Christian schools and adopting the mechanism of terms of reference put to the ALRC, who they know are going to pitch proposals that are going to simply clamp down on Christian schools? Is that a fair assessment?
No.
It's not. So the Albanese Labor government has no intention of trying to crush Christian schools?
No.
Right. Okay. Well, the Executive Director of the National Catholic Education Commission, who's a former Labor Senator, Jacinta Collins, said in a media release that these proposed reforms would make it, quote, impossible for Catholic schools to be Catholic. Is that a summation that you agree with?
No.
That's very, very comprehensive. Perhaps this one for the General Counsel then. My read of these proposals is that, in short, it would make it very difficult or impossible for faith-based schools to preference staff who profess and live out their faith of the school. Is that how you read the proposals?
No, Senator.
Do you think that these proposals would make it impossible for faith-based schools to teach traditional views of gender, sexuality, marriage and family?
No, Senator.
We're very comprehensive today, aren't we? Yes or no answers. We might have to delve into a hypothetical then. I want to give you a hypothetical about these proposals and what they would actually do in real terms. If these proposals were to be legislated, would a Christian school be able to have a statement of belief in which every staff member signs up to, which states that marriage is between a man and a woman?
It's not legislation we're talking about.
The proposals, if they were enforced.
It's a consultation paper.
Yeah.
And I think we've talked through the process about why we have gone down this path. It's open to consultation now, and we encourage people
the question
to
I've
participate
asked
in that
is if they
process.
were adopted as per the proposals.
Well, it's not legislation that's been proposed, though.
But they're proposals.
It's discussion paper, consultation paper.
So the modus operandi of the government is just to hide behind the process of this is a consultation paper.
No, the modus operandi is to deliver on an election promise, which is to bring legislation forward that deals with these issues in this term of Parliament.
Would the proposed changes make it lawful for a faith-based school to insist that biological males wear boys' uniforms?
It's a discussion paper, Senator Antic.
Yeah. So if the proposals were adopted?
But it's a
Are
discussion
you suggesting
paper.
these proposals won't be adopted?
Well, it's not the final form. It's a discussion paper. This is the process that the government has decided to go through. It's open for people, as the General Counsel has said, to put in submissions or engage in dialogue with the Law Reform Commission.
But what it really means, however, though, is that schools won't be allowed to choose their teachers. That is basically what we're seeing here, isn't it?
No.
That's not the case? So can the Albanese Labor government commit to protections for schools to be able to hire and fire as they see fit?
Well, what our election commitment was, that we would protect teachers from discrimination at work while maintaining the right of religious schools to preference people of their faith in the selection of staff. That was our election commitment. That is what we are committed to do.
And would it be a commitment of the government to enable Christian schools to have a statement of belief which every staff member signs up to, which states that marriage is between a man and a woman?
Well, that's again a hypothetical.
No,
we're
it's
going
not.
through the consultation paper.
No, it's not.
Well, it is what you're suggesting there.
No, it's not.
Senator
I'm
Antic.
saying, is that a position which the government would protect?
Well, it's a hypothetical that you put through. If you want to put in a submission to the Law Reform Commission, you're open to doing it.
Would it be a commitment of this government to protect faith-based schools who insist that biological males wear boys' uniforms?
Again, I think you're putting forward a hypothetical situation there, Senator
What
Antic.
has been the purpose of this exercise other than to dog whistle for the future, which is to attack Christian schools?
Well, that is just complete nonsense, Senator Antic. I know it's getting late. You're obviously getting a bit more unhinged. What I said with our
to keep my sleeves
election
rolled down all day,
commitment
which is more than we
was,
can say for you.
The government
you look more
made
unhinged than anyone, I've got to tell you.
commitments to prevent discrimination
public
against people
school
of faith, including anti-vilification protections, act to protect all students from discrimination on any grounds, and protect teachers from discrimination at work while maintaining the right of religious schools to preference people of their faith in the selection of staff.
Yeah.
That was our commitment to the Australian people at election.
I'm
That is
impressed by
what
that.
we intend
because
on delivering.
that was
in
more than a
government.
one-word answer, which has been an absolute rarity for you today. By the way, you're looking unhinged. So,
You have a couple of more minutes, Senator.
well, it hasn't been very helpful, so we might as well wrap it up. It's seemingly.
Questions have been pretty clear.
No, it hasn't been at all.
Answers
But
have been
thanks for the byplay from the chair. What guarantees can the government give that there will be adequate protections and consultation for Christian schools throughout this process? As Senator Scarr has just said, they do feel, as they have asserted to in the letter, that they are being ignored in this process. What guarantees can you give?
Because that was our election commitment, and that is what we intend on doing in government.
One of the most lacklustre responses I've heard all day, but not unsurprising. Thank you, Chair.
Could I just
Thanks,
add to
Senator.
the Senator's, can I add a response to that
Of
question?
course you can.
Senator, I just would note, and I will provide the full list of consultees, but a
Don't
number of
do
those signatories did meet, some of them a number of times, with Justice Rothman. So we are actively engaging with all faith leaders in this process.
Sure.
Thank you,
Leave it when I see
Senators.
it.
I can. Senator Shoebridge is the person that you're preventing from asking questions to other agencies. So if you want to,
2 minutes.
a minute, 60 seconds.
Okay. Mr Corrigan, are you aware whether or not any religious groups, school groups in particular, have withdrawn from the consultation process recently?
I know there have been discussions, but I don't know that anyone's formally withdrawn.
So you don't know whether or not someone's formally withdrawn, so you are aware that there are Christian school groups who are so concerned with the process that they've raised the prospect of them withdrawing. Is that correct?
That's correct.
Okay. And finally, are you aware that the Islamic Schools Association of Australia President, Mr Abdullah Khan, said he was happy with past suggested reforms from the former coalition government, but the ALRC's review had, in his words, gone too far?
I'm not aware of that statement,
Okay.
Senator.
Thank you, Chair. Thanks.
Thank you,
Senator Chisholm needs
Senators.
some sleep, I think. He's looking a bit tired.
Thank you, Senators, and Senator Antic.
He's looking tired, needs a rest.
That's unhelpful and doesn't reflect on you very well. Thank you very much, Mr Corrigan. Thank you for representing the Australian Law Reform Commission tonight. We don't require any more questions from you, so I call officers from the Independent National Security Legislation Monitor. Senator Shoebridge, I understand you have the call and we're in your hands in terms of timing to get to the next agency. So when you finish your questions, we'll move to the next agency.
Yes.
We're in your hands in terms of timing.
Indeed. Mr Knowlton, can you hear us clearly? You can hear us better than we can hear you at the moment. So,
Sorry,
terrific.
Can you hear me now?
Yes. I wanted to ask you some questions about the report of Dr Emily Corner into what was then the Department of Home Affairs, now the Attorney General's Department, tool for the assessment of future community risks of terrorists. Can you just briefly advise the committee how it was you came to be aware of this report?
I heard, my office heard that there was a report that had been done into the particular tool, the Vera 2R tool, and I actually Googled Dr. Corner, and it was identified on her website.
And did you obtain a copy of the report from Dr. Corner, or did you eventually obtain a copy of the report from Home Affairs?
Home Affairs. We asked for it.
And did Home Affairs provide you with an explanation for why you hadn't been provided with that report before that point?
I've had subsequent to receiving the report, I had a meeting with officers of the Home Affairs Department, and it was explained to me what their view of it.
Were you satisfied that there was a bona fide reason to not provide you with a copy of that report?
I was satisfied that there was not a bona fide reason.
Have you been provided with a copy of the affidavits that have been filed on behalf of the Commonwealth in the Ben Bricker case in relation to this matter?
My office in Canberra received them today. I've not personally yet seen them.
All right. If you could take on notice whether or not you believe that those affidavits are consistent with the advice that was provided to you by Home Affairs, I'd appreciate that.
Certainly.
Yep. We heard earlier today that what date do you understand the Corner report was provided to Home Affairs?
I don't remember the exact date, but it was May 2020.
Yep. We heard earlier today from the department that indeed there'd been a number of assessments undertaken of individuals using that tool since the report had been provided, but that the department was aware of only on one occasion, and it's a very recent occasion, that the persons undertaking the assessment were provided with a copy of the Corner report. And in each of those cases, the tool had been available for the assessor to use in determining the future risk. Do you have a view about whether or not that is a fair process for the assessment?
It's a totally unfair process.
Have you undertaken any review, or are you in a position to undertake reviews of the cases that have been assessed using the tool by assessors since the provision of the Corner advice? Are you in a position?
It's not my role to do so, and I haven't done so, but I would expect that the department has done so. Or is doing so.
Yeah. I just want to clarify to the Secretary, that's not occurring, is it, Secretary?
I apologise, Senator. I didn't hear the question that you put to Mr Donaldson.
Well, I asked whether Mr Donaldson was undertaking a review of those cases where the assessment tool had been used, the one that was critiqued by Dr Corner, since the Home Affairs Department had received Dr Corner's report, where the assessors had also not been provided with Dr Corner's report. I asked whether or not Mr Donaldson was in a position to undertake a review of those cases. For the obvious unfairness, he said he's not, but he assumed the department was.
Senator, if I might be able to assist. So the Corner report has been disclosed to relevant legal representatives in all previous post-sentence order proceedings. That's Mr Pender, Mr Benbrika and Ms Khan.
When was that disclosed? Before the assessments were made or after the assessments were made?
I mean, there might be sort of different timing of assessments, obviously, like there's a case that's a review at the moment for Mr Benbrika, so I'd have to check with that, but the dates were for Mr Pender the 30th of November 2022, Mr Benbrika 19th of December 2022 and Ms Khan 22 December 2022.
So that was only once the whistle was blown on it and it became apparent that there was this report out there that should have been provided. Dr Corner's report wasn't provided at the time the assessments were being made. That's right, isn't it?
That's my understanding. It was obviously the Department of Home Affairs. This department, when we became aware, have provided it to all of those legal representatives.
So is the department undertaking a review of those cases to determine how the impact of that unfairness played out in the cases?
So we're
Or are you
dealing
just
with
leaving-
that.
sorry, or are you just leaving it up to legal
We're dealing with that
challenge?
by providing all of the legal representatives a copy of the report. And as we discussed earlier, Mr Ben Bruker's matter is in fact under review at the moment.
Mr Donaldson, because we have so little time, I'll just ask you this as a concluding question. Do you believe that there are grounds for the Dr Corner, do you believe Dr Corner's report should be made public?
Yes, I do.
Thank you. There would be plenty more questions ordinarily, but we're so crunched on time, Mr Donaldson. And I'll just finish by thanking you for the work you do in this space. I think it's appreciated by many people across politics.
Thank you.
That's all.
Thank you, Senator Shoebridge, and thank you very much. I now call officers from the Australian Transaction Reports and Analysis
Oh,
Centre.
you don't need me anymore?
No,
Sorry.
thank you. That's all the questions we have. We're just trying to be very quick.
Sorry, I didn't mean to be rude.
No,
It's a very fair
thank you very
question.
much for hanging in there for us.
Not at all. Thanks very much.
I now call officers from AUSTRAC, and Senator Shoebridge, you have the call.
Oh, thanks, Mr Soros. This is nice to see you. It's so bright and early.
Yep, you too,
in 2015, AUSTRAC said, compared to other methods, money laundering through real estate, both residential and commercial, can be relatively uncomplicated, requiring little planning or expertise. Large sums of illicit funds can be concealed and integrated into the legitimate economy through real estate. Is that still the position of AUSTRAC?
Senator Peter Soros, Acting Chief Executive Officer.
We don't have a lot of time tonight. Sorry, just getting into it. Yep.
I think it's fair to say that money laundering through real estate is absolutely still a risk, not just in Australia, but it's recognised internationally as a risk. Yes.
Does AUSTRAC have any estimates on the scale of money laundering that happens through Australian real estate?
Senator, estimating scales like that are difficult, and but I note, so AUSTRAC, we wouldn't be in a position to give those sort of estimates or statistics, but I noted a recent Senate inquiry into AML-CTF legislation. The AFP gave evidence that about 56% of their confiscated assets related to real estate purchases. I know the ACIC also made some commentary at that Senate inquiry. So if that's helpful.
Yep. Does AUSTRAC support the implementation? Well, does AUSTRAC still support the implementation of Tranche 2 reforms?
Senator, their policy considerations for government. I think AUSTRAC has recognised that there are money laundering risks in those gatekeeper professions, but ultimately decisions on which sectors of the economy should be regulated are matters for government.
Do you accept, though, that Tranche 2 reforms represent the current global standard for combating money laundering?
Yes, those gatekeeper professions are the standard for the Financial Action Task Force's money laundering arrangements.
In terms of, comparable economies to Australia, would it be fair to say the overwhelming majority of comparable economies have actually entered into Tranche 2 reforms?
To be honest, Senator, I would not like to give a overall categoric question country by country, but my understanding of the FATF standards that many countries do apply those standards, yes.
Yeah, and that actually means, in the absence of Australia applying those standards, we become a target for international money laundering, doesn't it? As the rest of the world moves on and makes it harder to wash money through real estate, Australia becomes a relatively more attractive target.
There are a lot of mechanisms that make a country hardened against money laundering. Regulation is one of those, but vigilance of law enforcement agencies, the intelligence outputs of intelligence agencies are a lot of things. So I wouldn't necessarily say one follows the other. Australia has top-notch law enforcement agencies, great intelligence services, and so I wouldn't automatically say that we are a target just because of one element of our regime. We have lots of facets that, keep Australia safe.
In terms of the Tranche 1 reforms in the finance sector, how would you describe their success or otherwise for the purposes of targeting international money laundering in particular?
Sorry?
How would you categorise the success of Tranche 1 reforms in the industries which it covers, being largely the financial industry, the banks?
Yeah, well, I think it's fair to say that the financial services sector that are covered by this regulation do take their obligations seriously. They are carefully monitoring for financial crime risks and reporting to AUSTRAC and other law enforcement agencies risks of money laundering.
Yep. I note, of course, that AUSTRAC was instrumental in enforcement action against Westpac, and I think it was a record $1.3 billion
yes, that's right.
Penalty for Westpac for their non-compliance. Are you satisfied now that Westpac is complying with its obligations under Tranche 1?
I think it's fair to say that the financial service sector and the banks have significantly improved and invested in their financial crime detection systems. It's a constant evolution for these businesses to be vigilant and ready, but I think the banking sector has come a long way in improving and uplifting their financial crime controls.
And having the Tranche 1 obligations legislated and you being in a position to enforce them has had a meaningful impact on their compliance and upon stamping out money laundering in the finance sector. Would you agree with that?
Well, I think the enforcement and regulatory tools that we have ensure that the businesses in those sectors are complying with their regulatory obligations, yes.
And absent Tranche 2 reforms, those regulatory and enforcement measures are simply absent for the legal profession, the real estate industry and the accountancy sector. That's right, isn't it?
Well, under the current legislative regime, we're not, we don't have a mandate to regulate those sectors. That's
You
correct.
have no transparency over what money is washing around through those sectors.
Well, Senator, there are other mechanisms that concerned businesses can inform law enforcement on if they have concerns, but under AML CTF obligations, they're not required to comply with AML CTF regulations at the moment.
All right, I just simply note the time, Mrs. Horace, so I have to wind it up there, but thank you for your help.
Chair, are we looking to bring another agency on
Yes,
now?
we
Or
are.
do I have a chance just want to ask one question to AUSTRAC, if I could, just one? And it is a serious question. Senator Shoebridge, I think you might be interested in this. There were some very strong comments made yesterday in the Federal Court by His Honour Justice Michael Lee, and I'm just reading the article, in relation to the conduct of a case involving Crown Resorts, Star Entertainment and Sky City for what's referred to as innumerable breaches of anti-money laundering laws. Are you familiar with those comments?
Yes, I am, Senator, yes.
So you're familiar with Justice Lee's
Yes.
somewhat evocative comments in relation to the timetable of AUSTRAC that it appeared to be taking as long as the Congress of Vienna to bring forward the case. So I wanted to give you an opportunity to respond to those comments.
Senator, I wouldn't want to comment on an ongoing federal court case. We have great respect for court processes. All I can say is we take our obligations and our enforcement actions very seriously, and I can assure all of you that they remain top priority. But I'm not going to comment on ongoing court proceedings.
Fair enough. Thank you.
Thank you, Mr. Soros. Those are all the questions that we have for AUSTRAC this evening, and I now call officials from the Commonwealth Director of Public Prosecutions. And Senator Shoebridge, you have the call.
Thank you.
Chair. Scott Bruckard, Acting Commonwealth Director of Public Prosecutions.
Thank you for being here today. Senator Shoebridge has some questions for you.
Thanks, Ms. Bruckard. I'm sorry it's so late and it's going to be very, very quick, so we'll just keep it to one issue. When was your office referred a brief of evidence in relation to the potential prosecution of Ben Roberts-Smith for alleged war crimes?
Senator, that's not a question I am able to answer. It relates to matters that are the subject of investigation by investigative agencies, and in those circumstances, any legal advice that may or may not have been sought from my office are matters that you'd have to take up with the other agencies, particularly the OSI.
Is David McClure, SC, still engaged by your office in relation to that matter?
Again, Senator, I'm not at liberty to answer questions in relation to legal advice that's been sought.
I'm not asking about the advice.
On behalf of another agency.
I'm not asking about the advice. I'm asking about a matter that is previously on the public record about the appointment of David McClure, SC, in relation to that matter by your office.
There's been certainly there was media reports about the appointment of David McClure as a counsel for those matters. They were matters that were in the press, but certainly my office has not appointed any particular counsel to run those matters on our behalf, as we normally would do. If we seek legal advice from counsel, we do that on a case-by-case basis.
All right. What would be would a 2 year? Sorry. What would be the average time that the CDP would consider a brief before making a decision on it?
In terms of the average time, Senator, I'd have to take that on notice and get some statistics as to the time.
All right.
But you would appreciate, Senator, cases vary in their complexity very considerably. A matter that's referred to us with a relatively straightforward case, low complexity, where a defendant may have made admissions, can be processed much more quickly than a very complex case which involves consideration of evidence that might have been gathered offshore.
Well, there's material on the record that says that your office received a brief of evidence in relation to Mr Roberts-Smith in 2020. So I'm going to give you the opportunity to confirm or deny that.
Well, Senator, as I said in the answer to my earlier question, it's not appropriate for my office to comment on matters where we're providing advice to investigators before the matter, in circumstances we're providing advice to investigators in relation to a matter that's potentially privileged or subject to ongoing investigation.
Have you been referred any other briefs of evidence in relation to alleged war crimes by ADF personnel in the last 3 years?
We're certainly working closely with staff from the Office of the Special Investigator, and we're preparing ourselves for the referral of cases from the OSI, but that's ongoing preparation work.
Apart from the OSI, who indicated that they had in earlier estimates that they hadn't yet referred a matter to you, but were looking to refer one to you in the first half of this year. Apart from the OSI, have you been referred any other briefs of evidence in relation to alleged war crimes by ADF personnel?
We've also done work, Senator, with the AFP, but as I said, any matters that we've engaged with the AFP in relation to potential war crimes, it's in circumstances where there'd be a potential claim for legal professional privilege over any advice, and they're matters that you'd have to take up with the AFP.
All right, thanks.
Thank you, Senator Shoebridge. Senator Scarlett, really.
Well, Chair, I do have, and maybe now's the appropriate time just to ventilate this, I do have some questions for the Commonwealth Director of Public Prosecutions, and I do have some questions from ACIC. I've done my best to put everything on notice, but I do have some questions.
Some questions are going to have to go on notice, is what I'm saying to you. So if you, I mean, Can I just make this statement? We do have the Royal Commission for the Defence and Veterans Suicide as the next agency. I just wouldn't want any officials or members of the public to think that leaving that agency to the last minute with 3 minutes to go reflects what any senator behind this table thinks about the importance of the work that you do. We can go to that agency, or we will have to put questions on notice to the last two agencies
Or
remaining.
potentially have a spillover.
Well, if you would like to canvass that, I don't think,
I think
10:57 at night is the night.
I think it would be, sorry, Chair, had you finished?
No.
Yeah. I think it would be disrespectful to call a witness for less than 2 minutes of evidence, and I'm with Senator Scarr about the need for a spillover hearing.
Okay, I'm happy to proceed on that basis, Chair.
So senators can put questions on notice to the remaining two witnesses. We won't have time to get to them today. So we thank officials from the Royal Commission into Defence and Veterans Suicide, and we thank officials from the Australian Criminal Intelligence Commission and Australian Institute of Criminology. We did make a lot of effort to get to those agencies. We apologise for holding you here, and we hope to hear from you soon. Senator Scarr, you have the call with 2 minutes remaining.
Oh, so, okay. All right.
That's what you've asked for?
No, that's
Yeah.
fine. No. I'm not sure how far I'm going to get with my questions, but we can
ask what
we
you
can
can,
start.
and then
I asked some questions during the last committee hearing in relation to the Bernard Collaery case and whether or not the CDPP had been consulted with respect to the attorney's decision. Do you recollect that that question? And if you could just repeat your response in relation to that question as to whether or not the attorney sought the advice of the CDPP with respect to his decision not to proceed with the prosecution.
Yes, thank you, Senator. I do recall your question, and my answer to that question was that the attorney hadn't sought advice from our office in relation to that matter.
Okay. What are the considerations the CDP has in relation to whether or not a matter should proceed to prosecution? What are the key elements with respect to that decision?
Yes, thank you, Senator. In all matters that are referred to us, we apply the prosecution policy of the Commonwealth. It's a two-stage test that is set out under the policy. We look to see whether there's sufficient evidence to establish a prima facie case and reasonable prospect of conviction. And after being satisfied of that component, we consider whether the prosecution is in the public interest.
So, given the attorney didn't even consult you with respect to those matters, doesn't that effectively mean the Attorney-General overrode your discretion or your judgment, which you would make in accordance with that prosecution policy? Because he didn't even consult you.
Well, Senator, it's a separate process. The attorney has a power that's vested in him by the Parliament under the Judiciary Act, which he exercised, and my office was exercising the powers and functions that we had under our charter and under the DPP Act.
But even though it's a different power, the attorney could have still consulted you with respect to your view, isn't that correct?
I can't speak for the attorney.
Well, that's just a question of fact, isn't it? He could still have consulted you, but he chose not to.
It's a matter for the attorney.
Okay. Then it doesn't trouble you that he didn't consult you?
It's 11 o'clock and we will be concluding today's proceedings there. Thank you,
All right.
everyone. I appreciate that. I thank the Minister and the Department officers for their attendance. Especially want to thank Hansard Broadcasting and the Secretariat staff who've done a wonderful job over the past 2 days. We have a series of documents that have been tabled today, and I've just seek a motion to move that we accept those documents. Senators are reminded that written questions on notice should be provided to the Secretariat by 5 p.m. Friday, the 3rd of March 2023. The hearing is adjourned.